Before we start the marathon, I have an exciting announcement for you. After going through all these pouring comments on we want the chart books of CA Foundation Law, we have heard you and we want to give that to you for free of cost. You heard me right. All that you guys want to do is just comment the chart book and we will give you a link and we will forward the chart book to you. So why are you waiting for and what are you waiting for? So do comment chart book and get your chart book for free of cost. So enjoy the marathon and I wish you all the very best. Thank you.
So people, a very good morning. Welcome to your CA Foundation Law Marathon. So what is the takeaways from this particular marathon? The first thing is that syllabus coverage, I will try to do 100%. There will be no topics where I will say it is like this, it is like this. In marathons, we cannot cover. That I will not say. Whatever is possible, let us cover. Second thing, you as students will have some topics you feel very difficult. I would always tell you mark those topics. We will be meeting for at least 2 days, right? So mark those topics and keep those topics ready. So whenever probably in the break or something, you can let me know those topics so that when those topics come, I'll try to give maximum weightage and I'll try to go more in depth for that topics as well. That is second thing. And third thing is with regards to, remember we have around good 40 days left. Law is all about not knowing the concepts alone. It is also about being able to interpret. From today, make it a habit. Every day, you have to write and practice at least 2 questions. I'm repeating, you have to write and practice at least 2 questions. In addition to whatever you guys are doing in your life, at least 2 questions every day. And sir, where do I get these questions from? Do not depend on anyone. You guys log into your ICAI portal, take out the past papers. You will easily get 5 years ka paper or randomly Google. You guys will get the past papers. Take out the papers. Randomly start writing 2 questions from any paper. And the ICAI itself will give you something called as guideline answer. I hope we all know that. So in ICAI BOS portal itself, you will find something called as guideline answer as well. So make maximum use of all these resources that is available for you. Write these 2 questions. The answer key is also given there. Do not have to depend upon any third party. Compare your answer to what is given by the institute. Just compare and see, am I up to the mark where the institute is expecting me to be there? If the answer is yes, then macha, you will pakka clear. If the answer is no, there is a scope of improvement. You have another 30 days, 40 days. Do not get discontinued or demotivated within 2 days or within a week. Remember, the people who do it for a week end up in 30. The people who do it for a month will end up in 40 to 50. The people who do this consistently will definitely end up in 60 and above. And I'm again telling you, law, most of the people I'm telling you, if people are failing today, it is because of law. And is it really true, sir? Is it because of law they are failing? Is it because of the knowledge? Is it difficult? I'm saying no. I'm telling you the challenges that you will have in your exam now only. Be prepared. The first challenge you will ever face in your law is able to complete 100% of marks. Writing all the 100 marks in your exam will be the first difficulty you will see in your exam. You will find it very difficult. By the time you touch 80 marks or 85 marks, you will be done with your 3 hours. So going to that 100 marks, it cannot happen only that one day if you are writing. You should be having this practice much prior. So make that one habit. And whenever possible, all of you, especially the self-study people, if you guys are watching this marathon, remember, sign up for some test series. It will help you. Test series is always a reality check. So heart attack won't come overnight, it seems. It will have its signs. BP, sugar, some fluctuation will be there. That fluctuation and all you will get to know in test series. So I always say, if you fail it in a place where it doesn't matter. Test series are those places. Classrooms are those places. It's okay to failure. To failure only we are here. If we are passing here, then why will we choose classes or test series or anything? Am I making sense? So it's okay. Do not refrain from giving an attempt. Attempt is the first successful step you can take. Do not skip it. Sir, this attempt I am not so prepared. I will appear for the next attempt. Remember, attempts never matter. You do it second attempt, third attempt, it's okay. Never push your attempts. Are you getting it? So first difficulty you will find your exam is able to complete 100 marks. That's the first difficulty, and you guys have to manage that really better. The second difficult thing that can happen in your exam is being able to interpret, meaning understand the question. Sir, the question itself is for 8 lines, 10 lines. I am not able to understand what they are asking. For that, what is the easiest thing? See more questions. Whatever RTPs, MTPs are there, everything you guys should watch. Now you guys are sitting in a place where you guys search anything on YouTube. I'm not saying, I'm not coming here and promoting my content. You watch anything. There are hundreds of people who wants to make you guys pass. Every teacher out there are doing some or other thing, RTP, MTP, some or other thing they'll be doing. Watch everything. Watch RTPs, MTPs at least for the last 5 attempts. This is very important. Chances of questions coming from these things will definitely be there. At least some 15 mark questions you guys can definitely expect. And next, the third one. Sir, after you see these questions repeatedly, start framing them. Being able to write it in a right way, present it in a correct way. Understanding which chapter they are asking from. That will be a third difficulty. You will write something. They are expecting something. But you will expect that I have written everything, sir, but I don't know why I did not clear. The next thing is people able to write the correct thing. Are we writing that particular answer which they are expecting me to write? That is what I need to write. Right interpretation. So try to focus on these 3 points. 100 marks ka attempt. You need to go towards that. Do not stop at 75 marks. I attended for 75 marks, sir. I attended for 80 marks, sir. People, don't you think, then if you are getting 30, the 30 is not on 100. You are getting 30 on 80. So where is 100 coming? If you had written for 100, you might have got 45 or 50. 100%. Correct, right? And always remember, just now one student said, sir, 3 marks I missed. Never give up in the last questions. Push your limits. 3 marks. How does it sound? It pricks, right? So never give up in the last particular 1 hour. Your time has to be managed properly. First 1 hour, you should be able to complete 30 marks. By the second hour, you guys should be near 60 marks. By the last 1 hour, the God has given you talent to cover 40 marks. Pakka. Because I know you guys are writing in the last 1 hour even 50 marks also. But you also know, I also know. We are just writing for the purpose of writing. We are not writing what is needed. So reality check. Time should be a reality check. First 1 hour, 30 marks. Second 1 hour, 30 marks. The last 1 hour, we can manage 40 marks. Are we getting? And what are the red signals? Meaning this should not be there. This shouldn't happen at all. What? The first red signal is that never think that you should write in a order. I should go from first question to 6th question. You can shuffle it. Second one, never write a wrong section. It's a landmine. Wrong section, wrong answer. Are you getting this, all of you? So these are all red flags. And third one, going for paragraphs of answer. From here, from first line I will start. From the 10th line, 1 paragraph only. Everything is. No one will read. Split your answer into points, 2-line, 3-line points, split it. And wherever you think is the important one, remember for law, what matters the most is, all of you guys will ask, sir, I'm failing in law, not knowing what. Because you guys will start thinking, sir, am I expected to write whatever is there in the book as it is? Copy paste should I do? Of course not. They're not expecting you to be robots. But however, people, if you get fever, you try kashaya, you try that cold towel. I don't know what other traditional methods are there. You try, but paracetamol should be there. Paracetamol is your keyword. I don't take paracetamol. Much I will take some Saradan. And I'll expect to know, sir, I took a tablet, but I don't know why fever is not going down. Provision is that. Provision is a problem statement. That is your paracetamol. That's your dolo. Then what do? We give Saradan. Sir, take, sir, pass me. How well? It will definitely not happen. So, I'm not telling you to read the entire composition. I'm only telling you to concentrate on the word called keyword. And macha, the examiner is doing his job. Remember, the person is also human. As a student, we don't do mistakes, huh? We do or not? Then, as a person, can he do mistakes? Maybe. Why should it be my paper? Let me not take risk. If you think that's a keyword, underline and tell, sir, this is where the answer is. Why do you expect him to search? Wait, I'll go through from first word to the last word. I'll search where your keyword is. Why do you want to give him that pressure? Rather do it the other way, no? Are you getting it? All of you? So these are all the red flags generally people will do and do not fall for it. Clear? And the third thing, remember, never forget the weightage. Indian Contract Act is the king. If you guys are master of it, you guys can build the kingdom. Yad sir, Vijay Devarkonda. Allah. Yes, sir. Are you getting it? All of you. So with this, keep all these things in mind and we can start your marathon. We'll try to cover whatever maximum we can, and if you guys have any doubts, feel free to ask. Clear, all of you? Yes? Okay, done. So all of you done, na? And remember, na, marathons are not substitute for regular classes or for a full-time thing. Sir, if I pass, if I watch marathon, I'll pass. If you pass, I'll be the most happiest person. Yeah, but I'll try to cover, but of course it is not possible for me to take every example in as easy way as possible. Answer format I will tell you probably towards mid or somewhere. I'll tell you how to present your answers also. Keep that in mind. I will also give you an activity where I'll give you a question. You guys write it in the class and I'll try to see what you guys have written and I'll try to tell you where you guys are going wrong. That is one thing that I want to do it for this time, that check your answers and tell you if there is a scope for improvement. Second thing is that I'll try to get really good quality 50 questions. We will be discussing those 50 questions towards the end of the marathon. That is the second thing. Third thing is that whatever is the RTP that is applicable for your attempt, we will discuss that RTP also towards the end. Probably that should be Monday. Yeah, Monday also let us discuss for a few hours and that is where the marathon will end. Clear? Yes, sir. So with this, I think we should be able to cover the maximum content. Okay, perfect. So let us start with the chapter 1, people. Chapter 1 is Indian Regulatory Framework. So what is Indian Regulatory Framework? This is nothing but an introduction to your law. What is there in law? What is there in law? How is law made? And our entire system. 28. Keep of 32. It will become an oven. Huh? First bench, huh? You raised it, huh? Then? This is fixed, huh? It should not go more than 30 because that is what maximum AC can go. Huh? Okay. So, Indian regulatory framework. So, in this chapter, what we'll be seeing major things, three things. I'll tell you what type of question you can expect also. 90% is going to be direct question. You will have one question for sure. Easy to score in this particular chapter because this chapter makes a huge difference. Because there will be no indirect based questions from this chapter. So there are three main topics you need to concentrate in this particular thing. What is that? This is nothing but three organs of the government. A government functions with three organs. What are the three organs? The first organ is called as legislature. What do you mean by legislature? The law-making authorities. Now as citizens we have to follow so many laws, right? Now who makes all those laws? All these laws are made by either parliament or state legislature. So, what is parliament? We call it as Lok Sabha, Rajya Sabha. So, legislature, that's the first organ of the government. Today, if at all any new law is coming, who brings the new law? It will be brought by, in the center, it will be parliament. In the state, we call it as state legislatures. That's the first organ of the government. What is the second organ of the government? Second one is people, law is made. Will you guys follow it? No DL, no driving. No helmet, no driving. Triple driving, not possible. We shouldn't do. That's why, sir, we go 5 people in a bike. Huh? Yeah, I don't know, at times is it share auto na, bike. Share auto will be taking less people. I will be seeing near colleges, 5 people, 4 people. Macha, other backside person will be telling, Macha, go to friend, another friend is there, him also will sit. So, the second person is the most important person who says that if at all you guys are not following the law properly, I will come with a lathi, I'll hit you, I'll make sure that you are following the law. The second person is called as what people? Executive. There will be or there may be one question for you to explain the different executives that are there. Like, for example, in the center we have something called as security related laws. Capital markets we call it. Now, there are so many laws with regards to capital market. Are you guys following all those laws? We do not know. So, we have one police officer there also. Who is a police officer? The person who is a police officer there is called as SEBI. Now, if you guys do not follow, police officer will hit you here. Police officer will hit you there. Who is a police officer there? We call him as SEBI. Example, the person who took care of so many scams. Satyam scam, Harshad Mehta scam. During all this, who played a crucial role? SEBI. So SEBI is the most important authority in capital markets. The person who is making sure that the law is implemented properly. If law is not implemented properly, he will issue fines. Yes or no? Now you guys will park here. The police will come and say, it's no parking. What will you question him? Where, sir? Show me. Where is it written? You will not accept. Now what will you guys do? Police will not leave you. You will not leave police. End of the day, both of you will keep fighting there only. How long will it fight go? So they say, Macha, whenever you fight, both of you think you are right. In such case, come to a right place so that we can resolve your dispute. The third authority will come into picture. The third authority is called as judiciary. Judiciary is nothing but an independent authority who is unbiased. Correct? And we call them as what? Judge or a judiciary system. And that is only called as what people? Courts. That is where your third question can come. Hierarchy of courts or different types of courts in our Indian law. So these are the 3 types of topics and 3 types of questions you guys can expect. Clear? All of you? Okay. So that is what we are seeing here. One is legislature, one is executive, one is judiciary. Now sir, first one let us speak about law. That is, when I say legislature, how is a law made? What are the different types of law? A possible question. Anything can be asked. A direct question is, how do they make law? In simple, how do they make law? Let us imagine there is a law called as Companies Act. Now we need to make Companies Act. How do you think? Imagine the people sitting in parliament. You know, various types of people will go and sit in the parliament. Right from, Jaya Bachchan, or it can be Sachin Tendulkar, or it can be any such people, or our own people who we elect and go there. Now, do you think they will have all the knowledge about UPI transaction? Now, new laws are coming. What is that? Benami transactions, Companies Act. Do you think Jaya Bachchan will have all that insight to make sure, okay, macha, Companies Act, company should have 3 directors, independent director means, I'm saying, is it their expertise? Can you expect people there to come up with every line? Not possible. Then who do you think is drafting laws? Remember, how is a law made? First people, they will form a committee. There will be a specialized committee that will be formed, and that committee will take care of what people? That committee will take care of framing the draft. They are the people who comes up with the skeleton. Who is that? For example, if I have to tell you Companies Act, there was a person called as J.J. Irani Committee. Who is J.J. Irani? J.J. Irani is the ex-director of Tata's, TCS. You can imagine I'm telling who? Tata's ex-director was a contributor, biggest contributor of Companies Act. Now why did we take them? Think. Every day, day in and day out. You guys try to think who will be India's coach? A person who need to tell you how to play, correct? Why can't it be now India's cricket team coach? Why can't it be, say for example, Gopi Chand, who is a shuttle player, who is really good in athletics? Why can't it be him? Abhinav Bindra, who is really good in shooting. Why can't it be him? The head coach of Indian cricket team, why can't that person be a head coach? It is not his expertise. Same thing, people. When Companies Act is being done, who is the person who is dealing with this in the ground level every day? Remember, for today's Companies Act, lot of people have contributed, like J.J. Irani, Narayan Murthy, Kotak committees. Lot of people have contributed, and that is what you guys are reading called as Companies Act. Because they are working day in and day out in the ground, root level. They will know what is a drawback, what is an advantage. And the J.J. Irani committee gave a draft. Meaning they gave what according to them is good and needed. Now, as country, we should be okay with it, no? We should be okay with it, no? Yes or no? Now, is it possible to come and show it to each and every one of you? Is it okay with you, da? Is it okay with you? Can we give it to every one of you? No. But we give it to those people who are representing us. And that's why, people, the draft bill will now be presented in Parliament. Lok Sabha, first place, that book will be placed. Like you only, there also MPs will sit. They will say, this is the law. Every line will be read. If you guys are okay, they will give their consent. You know how they give? They bang their bench. It's an approval. Understanding? Now, once we get a majority approval in Lok Sabha, next we go to Rajya Sabha. Again the same process. Lower house, upper house. In both the houses, you need to get the majority. Once you get a majority in both the houses, someone has to sign it, no? Everyone has just banged it. Who has signed it? Someone has to sign it, no? So the final thing will be signed by President of India. Are you getting it? Yes, sir. Yes, sir. But do you guys know that it has been signed? Sitting in Bangalore, somewhere in Kormangla in one bench. How do we know what is happening in Delhi? Someone should put it in Instagram, no? Or Twitter, or somewhere, Facebook. Correct? Can you expect that from government? No, because it might be fraudulent people also. So people, government has said, I will keep one document for me. If it is published here, it is true. If it is not published here, it is not true. You can't expect me to put Instagram story and all, new update, cheese. You can't expect government to do that. Then where is government doing? Government doing through its own Facebook website. That is called as what? Official Gazette of India. Official Gazette is nothing but an official publication of the country. If it is coming there, it is legal. If it is not coming there, it is not yet official. Understood? Pakana, that is your source of law or process of making law. How the law is made? These are the steps. The first one is what, people? Committee is formed. Agreed? I will underline committee. Next I will say the bill, the draft bill on that subject matter will be placed before both houses of parliament. Which are the both houses of parliament? Lok Sabha, underline. Rajya Sabha, underline. I told you, macha, don't write in paragraphs. Same thing. Have written in points, huh? Yes, huh? This is how your exam answer should look. Okay, next one. Such bill now be assented by President of India, official gazette. Agreed? Yes. And the law making power is always divided into three things. One is called as union list, state list, concurrent list. What do you mean by union list? Union list is nothing but, for example, people, to avoid disputes, what they have done, they have put it in Constitution of India only. What are the matters on which central government can make law? In that, state government cannot poke its nose. If at all in the Constitution of India, if it is written, it is coming under central government. We call it as union list. For example, finance. Nirmala Sitharaman will be there. Will anyone go from state also? Huh? No. Whatever taxes we are paying is only because of Noda. For the system, we can't blame her alone. Of course. Now what and all is coming. But yes, we pay tax on what we eat. Cheese, popcorn, more. I don't know to what level we are going and paying taxes, but yes, depends. Every state we have our own army, huh? Why? No, there is a difference. Police will come here. Every state, you see, there can be little change in the color of the police uniform only. It will be khaki color, but one will be a little darker, one will be a little lighter. Why? State matters. Army, can we have our own navy? Can we have it? Sir, can we have it? No, not possible. So, it is always center. Next one is concurrent. Both can do it. People, how many of in a school? Which syllabus? State, all of you state, correct, that is called concurrent. State, macha, state is making your syllabus. Next one is CBSC, ICSC, center, everyone is same throughout the country. That is where we call education, concurrent list. Both of us can make law. Understood? Hello? Now understanding, that is how law should be seen. That is how you understand it. In reality, what is happening? In book, what is there? That is when LHS equals RHS. Yes? Okay. Types of law. What are the different types of law? One is called as criminal law. What is criminal law? Criminal law. A public offense. Criminal law is nothing but, people, where if, okay, how to identify what is criminal law? One, it's a public wrong, meaning a society is expecting you to live in such a way, but you are not living in such a way, and it is causing harm to the society. Now what do we try to do? We try to correct that harm. Now for example, let us imagine you guys paid fees to listen to my classes. And what I do, I will not take your classes. Is this a public wrong or is it a private wrong? Now just because I did not take classes, forget about you guys. Will it even bother the student sitting in the next class? So it's only limited to this class. These are called as private wrongs. Now how will the society correct me? Now for example, one of you, Chetan, will come and file a case on me. Sir, he didn't take my class, put him in jail for 8 years. I said, hey, why? Hang me only. Now whatever I did, ground root level, I'll ask Chetan, why are you demanding? Sir, I paid for your class. Now I'll say, Chetan, sir, I paid. How dare you not take? Now people, I'll say, okay Chetan, what do you want? You want your money back? Okay sir, give it sir, I'll go. So if I give his money back with some compensation for not being able to take class, imagine I'll add 1000 rupees. Now Chetan is the most happiest soul. He'll give me 5-star rating. Hey, best faculty da. Correct, no? No, people, this is what it's called as private wrong. It is between me and Chetan. It doesn't matter to the next person sitting to him. What will public lose because of me not teaching him law? We call such wrongs as what? Civil wrong. So what is called as criminal law? What is civil law? Criminal law is something where, remember, you have suffered something and you are going to the court asking for justice. And do you know what is your justice? Not the money you pay, not the money you get. Then what is your justice? The justice is you want revenge. Sir, I want him to see suffer. Put him in jail. Hang him. Take one lathi. Beat him. I'll see. I'll get popcorn. I'll get that pleasure. Correct, no? Yes or no? Now, for example, recently, yesterday's paper I was seeing, one small kid was kidnapped and they asked 5 lakh rupees. It seems that a person was a teacher. No, da. Father is a dean or a teacher or something. Correct, huh? Teacher, son, I don't know what. That's from that day. I'll not insist, right? Assignments and all. So much of violence. No safety as a teacher in this country. Yeah. Actually, see, Papa, they were ready to give 5 lakh back also. And these people have took that person and they've burnt him alive. Now you tell me, if 10 lakh is given, will the purpose be served? 15 lakh? 1 crore? Okay, let us give 10 crore as compensation. 10 crore. But just take a gun and just shoot it right here. Will the purpose be served? Nice, no? Give a loaded gun to the parents. Loaded. It should have at least 100 bullets. Every inch a bullet should penetrate. Will it give happiness? Yes. We would watch that live. We do not mind watching it. Correct, no? Criminal law. Justice is served. It's not money. Understanding? Then what is civil law? Civil law, give money, it is done. What Chetan did, breach of contract is called as civil law. Understood? Yes, and what is one more difference? Now, whenever this happened, who is fighting the case for those parents? Is it considered as parents versus those criminals? Is it how it is seen? Then it is seen as state of Karnataka versus the criminals. Remember, public wrong. Tomorrow, even I get scared for my son to freely roam around because of such incidents. Don't you think at least some 1 lakh parents will feel conscious? They will say no going out, no leaving alone. Don't you think people will lose faith over the system? We will first question, what is the system doing? How come you were not able to catch? Every question will come. That's why remember, whose responsibility is to correct the mistake? It is a responsibility of the state on whom you have lost faith. They will fight for you. They will correct the mistake for you. That's why always criminal laws, that is, whenever it's a criminal thing, the case will always be state of Delhi, state of Karnataka versus the criminals. They will fight for you because they want to bring the faith back. Sir, what if it's a civil law? It will be me versus Chetan. Names will be written. It is because he needs to fight for his justice. Karnataka government will not come and say, I will get you back your 6,000 rupees. It is me versus Chetan that the fight will happen. Understood? So that is how it will be. Clear all of you? Yes. So that is your civil law. Punishment will be always, imprisonment, jail, or capital punishments. That will be the punishment. Here it will be monetary. The next type of law is called as people common law. What is common law? It is called as people judicial precedents. Now what is that? Now let us imagine people, if at all there is a kidnap, if at all you guys do this, there will be a loaded gun given to the parent. They will make sure that you guys will shoot every inch in that particular person. Now once it is done, the next criminal will do now the criminal is okay. Yeah, what they will do? They will take me to jail 10 days here and there. They will do 7 years. They will keep me in jail. After that, I am a new citizen. It's just like taking bath and coming out. I am a fresh person from today. That is how system expects that they transform. They say jails are not the place to punish, it seems. It's the place to transform people. Very good. We appreciate it. Correct, no? Yes. So, what happens in a common law? Common law is, macha, tomorrow you kidnap, a loaded gun will be given. Next time anyone does it, do you think again we go through everything? No, it is clear. Loaded gun give, shoot. Correct, no? So people, that is what they are telling you. What do you mean by common law? Now throughout your your entire business laws, or your law completely, you guys would have seen so many cases, right? Any cases you guys can remember? Case laws in your syllabus. Salomon versus Salomon, Mohri Bibi versus Dharmodas Ghosh. What is that case law for? What is Mohri Bibi versus Dharmodas Ghosh? Contract by minor is void ab initio is what you are saying. Correct? Correct? No. Dharmodas Ghosh was a minor. Minor took loan and minor ever repaid. They said you cannot ask for the money back. Agreed? That is what was discussed in that case. Okay. Now any minors here? Here. What's your name? Samra. Now Samra is a minor. Correct? Huh? Now Samra will come and take some 1 lakh rupees from me. I will file a case. Samra has taken 1 lakh rupees from me. She has to repay this 1 lakh back. Who will win? Samra will win. She has taken 1 lakh from me. She is not giving it back. Who will win? You no loyalty people. Who will win? Me or Samra? On what basis you are telling Samra? Minor agreement is? This rule was derived from one case. Tomorrow same case happens. Judgment is same. We will not write one law again. Tomorrow one more incident can happen. This law will be same. And people, that is where we call it as judicial precedent. Meaning what? If one case has given us one fact, one format has already been done. If a minor takes it, if a major gives it, minor will win the case. Done, no. Again will you go and waste the court's 4 years time. These are called as judicial precedent, the third source of law. Mohri Bibi versus Dharmodas Ghosh is a source of law. Tomorrow if a minor borrows, you will not get back your money, is what is called common law. Common law is also called judicial precedent, also called case law. Clear? There is one article in Constitution of India. Article 141 of Constitution of India says, if anything is decided by Supreme Court, has to be followed in all the courts in India. So if Supreme Courts, the most highest authority, says something, all your district courts, all your high courts, that decision will be bound on it. You have to follow it, is what they are telling you. Where is that written? It is written in Article 141 of Constitution of India. Understood? Yes, getting it? Okay, next one is principles of natural justice. What are the principles of natural justice? What is the principle of natural justice? First thing, people, all our movies, there will be this, what? One hero will suffer something, what? His loved ones will be killed. That is how movie will start, no? Hero's loved ones will be killed. Now what will hero do? What will hero do? He'll take the revenge. Correct? They are telling, macha, you should not be a hero. You should just come to the police station, lodge a complaint, let the law not be taken in the hands of the person. We are there, system is there, everyone becomes one of one means, everyone Arjun Reddy only. Correct? No, that is what is natural justice. You shouldn't take decisions on yourself. Do not take the law into your hands. Do not be your own judge. Second one, whenever the court, even after CCTV camera proof is there, I have seen everything, recordings is there that you only did the mistake. Still, before we say you did the mistake, we will call you to the court. We will make you stand in the bar. Bar andre ಹೋಗ್ಬಿಡ್ತು ಸರ್ ಯೋಚನೆ somewhere thoughts ಅದೆಲ್ಲ ಬಾರ್ जो भी कहूंगा सच के सिवा कुछ भी नहीं कहूंगा is there no that only. So whatever I going to tell, that promise you are going to make, right? So there they will hear you out. One opportunity will be given. Macha, you come from a country where a terrorist who killed 300 people was still made stand there. A person, Sandeep Unnikrishnan, was all these evidences were that this was the terrorist who came in. We had close to 82 CCTV footages that he killed, but we still gave him an opportunity of being heard. Why did you kill? That is the power of opportunity of being heard. That is only called as natural justice. Understood? Hello? Okay. So this is what is called as people's source of law. Is this clear? Next one we will. Structure of Indian judicial system. People, if you guys have any problem, first to whom will you tell it to? For? If you have any problem generally as a person, no. You will first tell it to your friend. Hey macha, you know. First friend only, no. Your first next authority is your friend. Friend also is not able to solve. There is nothing like that where friend is not able to solve. 99% they will solve your issues. Friend gives a statement means everything is done. In fact, I'll be screaming here. One concept. Same concept, I'll be screaming. But a friend in front of me only, something in broken language, that person will be helping him. That person will understand everything. I will be telling Macha 3 examples. He is telling something, Macha, ange irkalla, ange dal. That's all. He will understand everything. That is the power of a friend. Correct, Noda? Everything he will understand. Correct, Noda? So, what is this particular hierarchy? If you have a problem, you will go to your friend. Friend not able to solve? Group of friends sitting. One sitting. Not that sitting. Generally group discussion. Next one, if they are also not able to solve, probably you will go to, let us take if it's a school, you will go to senior. Baba. Seniors only will create the problem. Okay. Next, senior also not able to solve, teacher. Teacher also not able to solve? Coordinator. Also not able to solve? HOD. Principal. Probably what? Highest authority is principal only or secretary? Principal. People, can it happen? Imagine you lost your pencil. You directly go and complain to the principal, sir. What irresponsible institution are you running? There is no guarantee for my pencil. How can I bring my life here? Can you guys go and complain? Possible? Not possible? That is what they're telling you. There is a hierarchy. If you guys have a problem in your real life as well with regards to someone cheating you or any reason, it cannot be directly taken to the Supreme Court, highest court of the country. There are steps. And what is the step? Imagine there are 4 floors. The first floor you come across is called as Metropolitan Courts. What is a Metropolitan Court? Metropolitan Court is only a court which is established in some cities. Not every city will have. If your city has a population of 10 lakh or more, your city may have a Metropolitan Court. Correct? Yes, they are established in metropolitan cities in consultation with the High Court. We will ask. High Court, now in Mysore, there are more people. The cases are also increasing. Now unnecessarily they are coming to Bangalore. Can we have a court there only? Probably if at all High Court feels it right and deems fit, we may have a metropolitan court. Next one, sir, is called as district court or sessions court. What is district court? What is sessions court? If you have any civil problem, civil what? I did not give him the classes. If it's a civil problem, the first court you will run towards is called as district court. Sir, if it's criminal problem, the first court I will run towards is called court of sessions. Sir, even there my problem is not solved. Even there my problem is not solved. The next court I go to is called as High Court, the highest court of the state. Sir, even if there my problem is not solved, I'll go to the highest court of the country, Supreme Court. Sir, even if there my problem is not solved, they say die. Yes, sir. Yeah, in 4 courts, you still think, oh, I am only right means? Of course, that is not the case. So, there is always this hierarchy. That is only called metropolitan, district and sessions, and next is High Court, and next is Supreme Court. Remember that. Sir, can I directly go to Supreme Court? Can I directly go to High Court? Only on one matter you can go, and that one matter is, if at all your fundamental rights are breached, you can go directly to High Court or Supreme Court possible. Only if your fundamental rights are breached. Sir, if fundamental rights are breached, first I have to go to High Court and then I have to go to Supreme Court. Illa, you can directly go to Supreme Court only. You can directly go to High Court only. Both are allowed. Sir, where is it written? That you have to directly go to Supreme Court. It is written in Article 32 of Constitution of India. Article 32 of Constitution of India says, if at all you guys suffer any fundamental breach of your rights, fundamental rights breach happen, you directly come to me, say Supreme Court. Same Constitution of India, Article 226 says, if at all your breach of fundamental rights happen, you directly come to me, says who? Says High Court of the state. Understood? Pakkana? 100%. So this is your source of law and executive and legislature. Clear all of you? Any doubts here? Any doubts? This clear? Yes, sir. Okay, done. The next chapter is called as people Indian Contract Act. Your Dilka Darkan. Yes, sir. So this should not stop. This is a chapter which will always help you to score. Clear? Sir, now first question I have, sir. In exam, I don't know whether the question is Indian Contract Act, Sale of Goods Act. That only confusing, sir. 99%. The question will have the chapter's name. 99%. Sir, you know us, no, sir. We are that 1% only. So if that happens, we will see how to understand. That is when you will understand when we see more and more questions. Clear all of you? Yes. Okay. So chapter 2, Indian Contract Act. Yes, people. First things first. What is contract? Agreement enforceable by law is called as a contract. So you said an agreement enforceable by law is a contract. Sir, first of all, for an agreement to come, should it be in writing? Agreement should always be in writing only, no? Or oral? Agreements can be oral or in writing. Can an agreement have only one party? It should always have 2 or more parties. Sir, next one. You are saying agreement. That is, 2 people are agreeing something. That's called as an agreement. Enforceable by law means? Enforceable by law means what? It should follow all the legal rules. So remember, people, you guys have agreed on something. Now, Chetan, and what is your name? Vasim. Praveen. ಹೆಸರು ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡೇನೋ? Oh, correct, sorry. Praveen and Wasim. Okay. Now Praveen and Wasim are friends. Praveen says, Wasim, Macha, in the break, we'll go to Udupi Upahara and have a nice gari masal dosa. Will you come, ma? Wasim said, yes, da, Macha. Extra ghee. He already put some 3 liters. Let us ask for 1 liter more. So people, Praveen and Wasim just now in our class, they were having like this, they were doing. So, simply build up. Yes, now people, Praveen and Wasim were having this agreement. Now after the break, people, Praveen Ange went to another, what are the other ones? Skanda Grand. He went and had idli and he came off. Papa Wasim is standing there only and waiting that this Praveen will come. He came after having idli. Right in front of Wasim, he came and did burp. Macha, idli was extremely good. Wasim is so irritated. Wasim wants to file a case on Praveen. Can he file or not? Why? No value for dosa? No value for dosa? This is called as what people? Their personal matter? Correct, personal matter. The personal matter in law is called as social agreement. A social agreement can never give you a right to fight a legal dispute. Correct? So, that is what is mean by enforceable. Court will listen, which masala dosa, with oil or without oil. Will they listen to all of this? No. Court won't accept these cases at all. When they are coming inside only, what is the case? Masala dosa, they'll kick you. There only you'll go out. They will not even admit you inside. Now people, this is only called as what people? Social agreements or domestic agreements. There is one case law here. What is the case law? Balfour versus Balfour. So whenever you are writing a question on which they are asking you about social agreements or domestic agreements, make sure you quote Balfour versus Balfour as a relevant case law. You will get that extra 1 mark. Clear? All of you? Pakka. Now another question that you guys will ask. Sir, when should we write a case law? When we should not write a case law? People, when I took money from her, I asked you who will win. You said she will win. I asked what is a reference. She said, sir, Mohiri Bibi versus Dharmodas Ghosh. Correct? Why not any other case? Why did you say that only? Story, cut, copy, paste. Now people are saying kingdom, cut, copy, paste, retro. They're telling you watch retro, no? It is like watching kingdom. I don't know, I'm saying. That is what is the review I heard. Correct? Exactly. You will use the case law only when the story is cut, copy, paste. You can't write, sir, illi namma manetranu same case happened. Kempanna versus Muniamma. Hey, that might have happened. All due respect. Kempanna and Muniamma exists. I'm not saying no. But that is your personal case. There it has happened. You cannot write whatever names you guys can think of. Are you getting it? All of you? Okay. Sir, now agreement. When will an agreement be enforceable by law? When it satisfies certain essential elements. Correct? So if all the essential elements are satisfied, the court will help you to fight your case. If these essential elements are not satisfied, court will not help you to win this case. Sir, what are these essential elements? Some essential elements are given under section 10. Some are not given under section 10. What is given under section 10 is our unit 2 and unit 3. We will see in detail. What is not given under section 10? Concentrate. First one, 2 parties. It can be company. It can be LLP. It can be individual. It can be anyone. 2 companies can enter into a contract. Yes. Intention to create legal obligation. So that is, you should have a, okay, Praveen and Wasim, they both in that paper, in the book last page, they entered, Macha break 2 masal dosa, extra butter, 1 chutney cup extra, you will come. Correct? No. He said yes. Praveen signed. Wasim signed. Now tell me. Now it is written. It is written. Now they did not go. Can they go to court? Written now. Written also now. Why? Exactly. In one exam they've asked you, husband promised to pay wife 500 rupees every month. This instrument was signed. Now if at all this money is not paid, can the wife go to the court? Now why no became silent?
No, sir.
Can the wife go to the court because husband has promised on a paper, signed? Can the wife now go to the court?
No, sir.
Why not? Remember macha, social agreements Allah, the main reason is they do not have an intention. When a husband is giving even on the paper written, does a wife, when a marriage is happy, do you have a thought, if this person doesn't pay, I'll take him to the court for that 500 rupees. Do you have the thought? That is the meaning of intention. Intentions mean when you are signing the contract. Do you have it in your mind? If the other party does not perform, I will take that person to the court. Do you have that in your mind? That is called intention. Even if it is written or oral, it doesn't make difference. Do not fall for it. Exam based question. So whether in written or not, it doesn't make much difference. Are you getting it? Yes? Okay, next one. Other formalities to be complied. Like for example, if at all you refer to Insurance Act, it says all the insurance contracts has to be in writing. But Indian contract says it can be oral. But something else is given somewhere, you have to follow. So it should be in writing. Okay, next one. It should be certain. Mean? It should not be vague. Give me 100 liters of oil. Is it a contract? No, because which oil? Correct, no, waste oil, coconut oil, groundnut oil, I don't know what oil. Correct, no. So unless and until it is specific, it is not a valid contract. Possible to perform. You jump from 4th floor. If you land safely, I'll give you 500 rupees. For what? Ambulance. So can you say if no, that is not possible. So possible to perform means it should not be impossible to perform. Magico, black magico, all that is not possible. Okay, next one. Given under section 10, we will see it. Unit 2 and Unit 3 is all about that. Correct? Next one, types of contracts. Types of contracts based on enforceability. Now we do not know what is a valid contract, what is a void contract, void agreement, illegal agreement, voidable contract. Let us get these things right. First one, what do you mean by valid contract? Agreement is there? Yes, sir. Essential elements, every essential element is there? Yes, sir. We call it as a valid contract, simplest contract. Done? Yes, sir. What do you mean by a void agreement? Void agreement means agreement is there. Some essential element is not satisfied. What is that essential element? Example, it says their capacity of the parties, competency of the parties. You should be a major. No, sir, I am a minor. Sir, agreement with a minor. Mohiri Bibi versus Dharmodas Ghosh is a void agreement. Understood? Understood?
Yes, sir.
So if at all agreement is there and if it is not enforceable by law because you have not satisfied some essential element, we call such agreement as void agreement. Understood? Sir, there is an agreement. Why? To go and kill a person. What type of agreement? Illegal agreement. Don't tell me, sir, it should have been void agreement. No. Why illegal? Because it is punishable under the law. If you do this, you are punished. That's why we call such agreements as illegal agreements. Next one is what? Next one is what is void contract? There is an agreement. Initially valid, subsequently invalid. When you entered, it was valid. After some days, it became invalid. Example, death. You enter into a contract with a film actor to do a movie. When you entered, he is alive. It is valid. After that, he is not alive. Something happened. Invalid. When you enter, it is valid. Later on, it becomes invalid. Such contracts are called as what? Void contract. Why do we call it as void contract? Void means invalid. Contract means it was valid. That's why it is called a contract. it was at least valid for some time. Correct? Remember, whenever a contract becomes void contract, whatever benefit you have received, you have to return it. Because the contract is cancelled, no. So whatever benefits you have received, you have to return it. Agreed? All of you? Pakka? Okay, the last one is voidable contract. What is voidable? Voidable.
One party, the contract becomes
People, when I say what is voidable, people will generally say, what? Sir, which can be valid or invalid is called as voidable. Correct? That is our regular interpretation. That is how we exchange words and you explain it to me. But that words cannot be written in the exam. What is a voidable contract? Voidable contract is a contract which is enforceable at the option of one party and not at the option of other. One person has a right to say yes or a no. Any example? So, voidable contract. Let us imagine people. Someone has taken my land by force. Someone has pointed a gun here and they said, if you do not sign, I will take away this land from you. Because of that force, I signed. But after that person left from my place, now I am regretting. I want to take some action against him. What do? I go to the police station. I complain. Sir, this so and so happened. Can you please get me back my land? The police will take an action. The case will be initiated. The matter will go to court. Agreed? Yes, Now people, let us take two scenarios. One scenario, the person went to police station. Another scenario, the person did not go to police station. If he went to police station, the police will call you. Court hearings will happen. You may win the case. So the entire land, whatever he made you sign, that entire paper will be torn so that you will get back your land. So the contract will become void. If you go to the court and fight for it. Let us imagine a second way. Sir, I did not go to the court. I did not go. What will happen? If any person just looks at this paper, will they understand your story? Will the world know all this happened in the background? Then for the world, this contract will stand valid. So it all depends on how you treat it. If you have the guts, come to the court. If you don't have the guts, leave it. So a contract which can be treated as valid or invalid at the option of one party, it is all about your choice, is called as what? Voidable contract. So a contract which is valid or invalid at the option of one party and not at the option of another. So only one can decide it. Both cannot have this choice. Is called as what? Voidable contract. This, any doubt? Unenforceable contracts means? Which is? What is unenforceable? So a contract is proper, but it has some technical defects like spelling mistake in the name. The document is understamped. The dates mentioned are wrong. Is called as what? Unenforceable contract. For example, I cannot have. Now me and Praveen, we entered into a contract. Correct, no? Correct only, no? Okay. Understood? Now this is only called as unenforceable contract. Now tomorrow I will take this to the court and I will say, sir, Praveen has to pay me money, sir. Praveen will say, sir, ask him only. I am not this person. You ask Praveen only. I'm Praveen. Unenforceable. With whom will I fight? Because India has a person, you will have a person for every name. I have to identify it as you. Only then I will be able to ask justice in the court. That's why these are called unenforceable contracts. Got a fair idea, na? Yes, sir. Yes, Devi. So it will be considered just as an agreement until you correct them. Clear? Okay, next one. Based on formation, the contracts can be express or implied. What is express? Whether oral or written, but conditions are expressed. You're talking, you're discussing, you're writing. It's called as express agreements, express contract. What is implied? Based upon the conduct of the parties, if a contract comes into picture, for example, a bus comes and stops in the bus stop, and every time you'll go in front of the bus stop and say, stop, huh? No, automatically it will stop, no. It is giving you an implied offer. A waiter, Anna, coming and standing right next to you, until you say one order, is giving you an implied offer. Hey, tell something, da. Don't just occupy one place. Correct, no? He's giving an implied offer. He says, tell sir, money irka, duddu irka, check. Has he ever said, no? Does he even know you can pay it? No, but trust, no. He's giving you an implied offer that, sir, you tell me, I will give you the dosa, you eat, but after that you need to pay. Is all this discussed there? Then? Correct, no. These are called implied. You not discuss anything. You take your ATM card, you go to a ATM machine. Is there someone behind that? Have you ever seen? Someone is speaking, no? Please enter your card. Someone will be there, you have seen it? No. These are called as what? Silent contracts. Tacit contracts it's called. Now what do you mean by tacit? It's a silent one. There is no two-way communication. You going and dropping 1 rupee coin in a weighing machine. Weighing machine. Correct, no? Today, of course, our generation it was weighing machine. Today your examples are updated. Vending machines. 7-up. That is 7th row, 8th column. I want that turn lay. A spiral, it will rotate, no? It will fall, no? Is anyone speaking there? No. But contract is entered, no. You will pay. You have to drop that can only. Correct, no? That is only called as what? Tacit contract. Where are you speaking? This is called as implied. Something you said? Sell? Okay. Understood, no? Yes, so these are called as what people? Implied contracts. Next one is quasi contract. Unit. We'll discuss there. E-contract. What is e-contract? Easy contracts. Allah. What is e-contract? Electronic contracts. You entering into a contract in electronic form. Example, sir. I agree. You don't know what you agree. Whenever you download any software, what you do? I hereby understand and agree that all the hereby terms and conditions given above are for me only. You put one tick mark and you say accept. E-contracts. You are accepting it, whether you read it or not.
Whether customs and usage will also come under implied contract?
Implied contract is nothing but in certain places wherever law itself has given power to customs. For example, can we pay remuneration to a partner?
If it is a custom.
Correct. So here it is not written, but law itself has given you the power. If that is the case, yes, it can. If not, no. Based on performance, executed means what? Done, no.
Both the parties.
Correct. You took a cheaty token, no. You gave it to Masala Dosa Anna. Masala Dosa Anna took it and poured it even on your face also. Decoration, oil. And he gave it, you had it, done, executed. Executory can be two types, unilateral, bilateral. Unilateral means what? You have paid the money, cheaty, token you got. Your obligation is done. Masala Dosa Anna's obligation is just pending. Correct, no? Unilateral. Bilateral means what? Both your obligations are pending. What is this? Cash on delivery. On Zomato, you have ordered cash on delivery. Dosa also yet to come, money also yet to be paid. But contract is entered immediately, no? Yes or no? Praveen is thinking, don't tell Dosa, sir, tempting. Understood? Yes or no? So unilateral, bilateral, no. Okay, next one, sir. Classification of offer, types of offer, express or implied. What is express offer? Anna, dosa, puri, idli, express. Clearly telling you what is the agreement. You are exchanging words. Implied means? Correct, Implied is bus coming and stopping. General offer? General. So, general offer is nothing but we giving a offer to everyone, world at large, big billion day. Anyone wants you participate. Special offer, specific offer means Given only to you. Mr. Praveen, this big billion day, only you can participate, no one else. Is called as what? Specific offer. Remember, in a specific offer, only the person to whom the offer is made can give an acceptance. Can you give me case laws for these two? General offer. Carlyle versus Carbolic Smoke Ball Company. The medicine now. She took that medicine and still she got influenza. Can she file a case on the company? Yes. Because in general offer, remember, whether you give acceptance or not, you following the conditions or you following the prescription is itself considered as valid acceptance. Next one is called specific offer. What is specific offer? Specific offer is nothing but an offer made to a specific person. What is the case law? Bolton versus Jones. The shop case, if you remember, I wrote a letter asking for some materials. The ownership of shop had changed. You remember? A new person will come. He will ask for. You guys remember or not? Okay. Bolton versus Jones. Generally, what happened? You can imagine A, B. A wrote a letter to B asking for some grocery items. Of course, all these are 19th century case laws. Don't think and say, he could have done Zepton or and all. 19th century, this is how the case used to happen. So he had written one letter asking for some grocery items. What B had done, B had sold his shop to C the previous day. The ownership of this shop has changed. A had clearly written in the letter to Mr. B, I want Horlicks 1 packet, Boost 1 packet, Mate Kellogg's 1 packet. So we have written everything. Now people, and he has closed the shutter, he has gone. Now people, the next day who came and opened the shutter? B had sold the shop to C. C opened the shutter. Opened, one postman came and gave this particular letter to him. Why? Because the address was mentioned was that. Now who opened? It was Mr. C. C saw the letter. Wow, morning, good boni. So he took all Boost to Horlicks to Kellogg's and all. He packed it and he sent it to Mr. A. And the next day, C went personally to collect the money. A said, I will not pay the money. A said, hey, what type of, C said, what type of human are you, da? Huh? So, he's asking the money back. Now, the question is whether Mr. A is liable to pay or not. Why? So, no matter how much emotions I feel, no matter how much portions of groceries I fill in this bag, don't think that, sir, no, sir, Papa, no, sir, he has taken, no, sir. Law is different, heart is different. As per your heart, yes, A should get the money. Means C should get the money. As per law says offer was specifically made to Mr. B. It is called as specific offer. They might have had 100 terms and conditions between them. Why did you interfere? You are an outsider. Why did you interfere into the contract? What is this called as? Doctrine of privity of contract. Two people, third party, don't poke your nose. Is what they are telling you. Understood? Stranger to a contract. This is only called doctrine of privity of contract. So whether C will recover the money? No. That's all there our Indian contract ends. Now you go home and you will go to depression. Ayyo, Papa C. You don't have to go to depression. C can file a case on B. They can settle it amongst themselves. Because probably B had to pay money to A. Towards that he has taken these goods. Now I have given the goods. So you pay me the money. I can't ask it from him. But can I take it? Yes, this dispute will go on. But that is not there in our case. If a hero has to go to villain's place, they will not show you from the moment he took the ticket to travel of 5 hours. Everything they will not show. They will show you he reached. Correct? No. That is what is this also. They will not show the other cases, what happened to him, what their grandchildren are doing today. All that will not be given to us. Agreed? All of you? Okay. Next one there. Counter of crossover. What do you mean crossover? Exchange of identical offer. A tells I want to sell my car to B. B tells I want to buy your car. Both say 5 lakh. But are they replying to each other? No. He is making an independent offer. He is also making an independent offer. Identical offers, if they are exchanged, we call it as cross offer. A cross offer is never a valid contract. Correct? Huh? Because there should always be an answer to a question. These are two questions. Will you sell your car? Question mark. Will you buy my car? Question mark. No one has replied. Hence it is not a valid contract. Counter offer means what? Counter offer. Papa, I want a Royal Enfield bike. Papa replies, pass CA, I will give you a counter offer. If they said, okay, macha take, that is only called as what? Acceptance. No, sir. CA distinction is called as what? Counter offer, negotiation. Getting it? So, whenever the terms are negotiated, it is called a counter offer. Tomato Anna said 1 kg is 20 rupees to our mothers. Our mother said maximum 5 rupees I will give. You will give or not? This is only called as what? Counter offer. Yes or no? So this is only called counter offer. Counter offer replaces the initial offer. Initial offer was simple. 1 kg tomato, 20 rupees. Counter offer, 1 kg tomato, 5 rupees. Anna will give. That's a different story. That's the powerful negotiation. Yes or no? For foreign ministries and all, we have to send our mothers. They will strike a deal. Trump and all. Hey, what a tax? 100%. I take 2%. We should send them as foreign ministers. Okay, next one is standing or continuing offer. What is standing or continuing offer? A general offer or an open offer. Meaning what, people? Whenever your institute says, do your registrations before August 10th, it's a standing offer. Correct? Yes, sir. They had given in one of the attempt, a person had given an offer. A has given an offer to B that you can give your acceptance. I want to sell you my car. The offer will be open until August 10th. He has given an offer. On August 5th only, people, he will revoke the offer. I told you in the first offer, the offer will be open up till August 10th. On August 5th, I revoked my offer. Now the question is this considered as breach of contract? Can B file a case? Damages. Can B file a case on A? One of the exam question. I hope you guys are understanding the question. I said the offer will be open up till August 10th. On August 5th, I revoked my offer. I said I am no longer interested to sell you my car. Is this considered as breach of contract? Why?
Because he hasn't accepted.
Remember, breach will come only when the contract is accepted. Standing offer is simple. I told you it will be open till August 10th. And we have one more topic in the same chapter. What? There is something called as revocation. If acceptance is not done, you can revoke your offer. You are free to do it. Is it considered as breach of contract? Answer is no. Remember, people, if you guys answer yes or no is never valid until your provision is right. Is this clear? All of you? Paracetamol. Yes, that is important. Okay. Next one, sir. Communication or completion of offer and acceptance. When is the offer complete? When is acceptance complete? Yes, Tanishka, correct. When is the offer complete? When is acceptance complete? When it comes to the knowledge of person to whom it is made. When is acceptance complete? For proposer, when acceptance is put in the course of transmission. For acceptor, when it comes to the knowledge of proposer, most of them will find it difficult. Once again, see it off. Whenever a person is making an offer, when is the offer complete? They're telling you, offer is complete. To whomever the offer is made, when he gets to know about the offer, meaning if I have sent a letter, I got a letter. Just because I got a letter, offer is not complete. I will get the knowledge of the letter when I read it. So offer is complete when you read it. Now acceptance when it is complete. He has replied, I want to buy this car. Yes. When is this complete? Now there are two ways. It has to be complete from my point of view, first point. From your point of view, second point. Now, for example, let us imagine tomorrow's class, I have posted what time it is. It does not reach you guys yet. I have intimated the team. There is a process. Now, can I say that is all? Acceptance is complete, huh? Think this only. Tomorrow's class, I will not tell you at what time. Tomorrow we have a class. Now I want to revoke it. Can I revoke it or not? I already know. I already said what is the time. I already communicated to the team. The team has not officially, formally communicated to you. Hello? Now I am the acceptor. Meaning I have given my acceptance. They asked me, will you take business law marathon? I said yes. And I have given my timings also. I have posted my timings. Done? Now can I take this back or not? Can I change the timing or not? Tomorrow's time can I change? Because you don't know it yet. So that is first one. When you do not know it yet, this is the meaning of course of transmission. I need to tell to the team. Team has to communicate it to you. There is time. Before you guys know about it, I have time to revoke. Yes or no? Correct? So that is what they are telling you. Acceptance is complete from one person's point of view and another person's point of view also. Are you getting it, all of you? Pakka? That is what they are telling you. Can this person revoke his acceptance? Is it possible? Is it possible? So before it, this person is aware of it. Now imagine in your WhatsApp groups, they intimate you tomorrow's class it's so and so time. It is said. Now I tell, hey, I have a concern, I have a little thing, can we change it? They'll say, sir, it is communicated to the student, sir. Then I'll say, okay, it is accepted, then leave it. So if it is aware to the offerer, meaning you guys got to know about it. My yes is communicated to you. I cannot take it back. If yes is not communicated to you, I can take it back. 100%? Convinced? Yes, sir. Okay. I know most of you will suffer in that. That's why I said okay. Revocation of offer and acceptance. Can we revoke our offer? Okay. How? First one. By notice. What do you mean by notice? I give you a proper notice and I say, people, the marathons will stand cancelled. I give you a notice. It's called as notice. By lapse of time. What is lapse of time? Except by CA registration, August 10th. You do not do it by August 10th. That's all. Automatic acceptance of, revocation of offer. By non-fulfillment of condition precedent. If you want free delivery, your cart value should be at least 500. That is the meaning of non-fulfillment of condition precedent. If you want to be getting a benefit of an offer, you have to satisfy some condition. The condition is minimum cart value of 500. If you do not satisfy this 500, you will not get free offer, free delivery. That is the meaning of condition precedent. For you to be eligible for an offer, you need to have some condition precedent. Initially they had OnePlus mobile if you want to buy, you need to have a pass. I don't know how many of you knew it. OnePlus mobiles are there now. When initially they came to the market, not everyone could buy. You need to have a OnePlus token or a pass. And how can you get it? Already an existing OnePlus user, initially they gave it to some 5,000, 10,000 people. They should give you a recommendation, like a referral. Only then you will be able to participate in OnePlus mobile. That is a condition precedent, not just because you have money. Go and buy Range Rover car. Try. Just try. Veda sir. Now veda. Tomorrow I will try. I'm saying Range Rover, they will not sell it to you if you want. Hey, you go and give 10 crore, they will not give it to you. Range Rover verifies your KYC. If you are a bad person, they will not give you the car. They think a bad person runs my car in the society. It is a reputational damage to my brand. They won't give you. That's why you think simply celebrities use it. You have to earn Range Rover, not pay. Condition precedent, have a reputation, pass the checks. You have to apply. If they approve, then you can buy a car. Nice, no? That is what it is. That is what is called condition precedent. Just because you have money, you can't get it. Hello? By death or insanity, of course, the offer will come to an end. By counter offer, 5 rupees. Non-acceptance in prescribed mode. I clearly told you, reply to me in email. You gave me in WhatsApp. I clearly told you reply in email. You gave me in WhatsApp. I have to say, because you did not follow the prescribed mode, I will not accept your offer. What if it is not communicated? It is considered as acceptance. So you have replied to me in WhatsApp. I have to tell you, WhatsApp is not accepted. If I do not tell that, it is considered as acceptance. That means you adjusted. The last one is called as subsequent illegality. What is subsequent illegality? When we entered into a contract, it was valid. Later on, it was invalid. Like change in law in Gujarat, dry state. You might have issued licenses for, dealing in alcohol. But they said going forward, it is a dry state. Now, what about all the licenses? That's what they are illegal now. You cannot sell it. Change in law. Contracts will come to an end. So, it is a valid end to a contract. The offer will revoke. The license will come back. It's an end. Understood? Huh? Yes, sir. Okay. What time you want your breakfast? You have to have or you had? You need to have? Okay. What? How much time you need? 1 hour? Half an hour? 30 minutes? Okay. Be back by 10. Go, put. Back all of you. Okay. Let's quickly start your next units. Agenda for today, finish off Indian Contract Act. Yeah. Okay. So unit 2 people, consideration. So unit 2, consideration. Legal rules regarding consideration. Now what is consideration, sir, in layman's language? What do you mean by consideration? Something in return. So can I say like give and take? Give and take is considered as consideration? Yes. And what is the legal terminology for that? The legal terminology is called quid pro quo. It's called quid pro quo. Correct? Quid pro quo. Correct? Yes, sir. That is called as what? Consideration. I'll see, Monisha, what can be done. Yeah. So that is called consideration. Now, legal rules regarding consideration. It must move at the desire of the promisor. Okay, yes people, back. Now, what do you mean by consideration, people? We said there is something called as quid pro quo, that is give and take. Something in return is called as consideration. So, basic thing is that you can never have a contract which is free of cost, or only one party is giving something and other party is not getting anything. If at all such things are there, we call such agreements as, let us imagine, there is if you go to malls and all, you will have samples being distributed. It can be sample for a coffee, sample for a tea, sample for a rasam, whatever. Yeah, now some rasam products and all are going on. They will give you free rasam also. So now in Lulu Mall, if you go, they are giving. So whether you want to try or not, Lulu Mall. Lulu is there, no? There. So they are giving. There is some new brand that has come with that rasam paste. So they are giving all that. So if you like it, they'll give you one sample pack. Now imagine you try that rasam and you're saying, sir, my God, not at all good. I'll file a case on you. Free of cost, no right. Always remember, if something is free, then you are the sample, not the product. Always remember that. So in the rasam is not the sample. You are the sample. You are the lab rat. If everything after drinking you are able to walk properly, then yes, rasam is working fine. Yeah. So if it's a free of cost, people, there is no contract or no rights that would arise from that particular contract. So that's why we always say there should always be quid pro quo. What if there is no consideration? If there is no consideration, one essential element is absent, we call such contract as void agreement. Do not use the word interchangeably. Do not say void contract. You have to mean it when you say it. It is a void agreement. Clear? Now, sir, what are the rules regarding consideration? The rules are, the first one is, it must move at the desire of the promisor. Meaning, I cannot do something voluntarily and I cannot expect money out of it. What do you mean by that? Let us imagine I go to a petrol bunk. One person in the petrol bunk sprayed like this. He cleaned the visor and he said, sir, 100 rupees. Can he ask money? Can he ask money? He can ask? He cannot ask. He can ask. Remember, the first thing is that people, there are two scenarios that can come here. One is, if they are generally given you somewhere on the road. Now, they have given you somewhere in the petrol bunk. Petrol bunk, it may so happen that you might think, okay, petrol bunk is doing it for their customers. Correct? Chance is there. But what is your first thing as a customer? To know that macha in this world nothing is free. You should tell him stop. You're getting some service free of cost. You did not do that. What did you do? Hey, see that here, there is still mark. It's clean here also. Now people, you remember and you also know, if something is coming to you, someone is coming and doing, it was your responsibility to stop. You did not stop. Now can that person claim money from you? Yes. Tell me under what provision he can claim money? This is the exam question. Tell me the provision for this. Implied contract. It's an implied offer. He's coming and doing it. You're allowing him to do. It's an implied contract and it's a silent. You guys did not express any words. It's an implied contract. Agreed? Yes, Now let us imagine people, I was on the road, traffic signal, no, there is no petrol bunk build up and all. You are not a loyal customer and all for them. Now a person started coming and saying, he started spraying. You said no. Now what will they do? People sitting there, sir, it's okay, I will do it off. Now they clean it. After doing everything, they are expecting money from you. Are you supposed to give? No. That is where this will come. A promise should always move at the desire of the promisor. Consideration must move at the desire of the promisor. I should have asked for it. I am saying I don't want. You did it voluntarily. You cannot expect money for it. And that is where this will come. Understood? So it should always move at the desire of the promisor. There was a case law also, Durga Prasad versus Baldio. What is this Durga Prasad versus Baldio case? So, shopkeeper. So there was one, in simple language if I have to explain you, there was one, you can imagine like a corporator for one particular city. The corporator said to one construction person, one constructor, that all your, this is old case law, that city people and all are going to the next village or next district to sell their items. You're having so much of money, you have so much of knowledge, why don't you construct one market? In fact, in the case, if you actually look at the original case that is given, the reference will be written as bazaar. That old case for this is. So the contractor would have told to the constructor, why don't you build one bazaar for your people? They are all going to the next village to sell their items. So the constructor built one, bazaar. Now people, this bazaar has shops. The condition to rent a shop in that bazaar was, you need to pay some rent for selling your articles in this bazaar. That is one thing. Second thing, people, because he built this particular shop for you, for every article you sell, you have to pay a commission of around 10% on all your sales. Meaning in the month, if I have made a sale of 10 lakh, I have to pay him a commission of 1 lakh. Why? Because I took the effort to build. No. So this was a condition. Now the market was built, the bazaar was built, the people started selling the items, this thing went on. It went on for 5 to 8 years. until one shopkeeper, he paid the rent and the commission both for 1.5 to 2 years. One day he felt, for taking the shop, for using his shop, we are paying rent. Why are we paying this commission for? I'm not understanding. This person stopped paying that commission to that particular constructor. He said there was a contract that you have to pay me what? Rent of so much and commission of 10%. There is a clear contract between us. You have to pay it now. Now people in this case, what happened? He did not pay. Matter went to court. Now you tell me. As per the agreement, he needs to pay rent as well as commission. Now you tell me whether who will win the case. This person will say, I will pay the rent, but I will not pay the commission, is what this tenant is telling. The person is telling, no, I have told you clearly you have to pay both, you have to pay me both. Who will win the case? The constructor or the tenant? Why tenant? Because they didn't ask for it. Who didn't ask for it? Consideration must move at the desire of the promisor. The tenant will ask only one thing. Did I come and tell you to build that market for me? Did I tell you? Then if I did not tell you, why are you charging this commission for me? You go and charge it with the corporator. Cleaning the glass. You did it. Don't ask commission for that. For using your shop, I'm already paying rent. I'm not staying here for free of cost. So people, this is where again the law came, and they said people, a consideration should always move at the desire of the promisor. Meaning I should have asked for it. If yes, I will pay. For something which I have not asked, I will definitely not be liable. Hence I will not pay. Was what decided in this case law. Understood? Yes, sir. Okay, next one people. It must move from promisee or any other person. Meaning what people? In short people, I can give or someone on behalf of me can give. In simple, I'll tell you, A borrowed money from B. Now who needs to repay? A has to repay. Sir, C repaid it on behalf of A. Is this valid? They're telling you yes. So contract is there. I have taken loan, I need to repay. But that repayment need not happen through me only. Someone else also can repay it on my behalf. It will still be considered as valid. Simple. There's one case law also. You guys would have studied that. Chinnaya versus Ramaya. The case law was what? There was one old lady. She promised to give to her daughter. She promised to give her properties. With one condition. The condition is that the daughter will pay some monthly pension to the mother's brother. So I will give you property, but he had one condition, that after I die, every month you have to give some pension to my brother. If you are okay, I will give all my properties to you. If not, I will give it to him only. She acknowledged, she told that person that I will give it to you, the pension as agreed with my mother. After mother died, the daughter did not pay the pension as promised. Now the question is, can the person hold the daughter liable? Now because this person went and filed a case in the court, the daughter is saying it is quid pro quo. I am giving you pension, what are you giving me? Hence there is no contract at all between us. In this case it was decided people what? Consideration may move at the meaning from promisee or any other person. Meaning here I am not giving you anything, but on behalf of me, my sister gave you something that will act as a consideration for my contract. So I need not give it every time. Someone else on my behalf also can give it. It will still be valid. And that is what is this case law. Chinnaya versus Ramaya. Case law, and one more thing is called acknowledgement. Later we will get it. I'll tell you what is acknowledgement also. This is clear? Yes, sir. Okay, done. Next one. Third one. Consideration may be executed or executory. Those are. It can be executed contract or executory contract. Executed means obligations are done. Executory means a promise. We are promising that we will deliver you the dosa in the next 30 minutes by a Zomato order. It's a executory. Meaning we are yet to do it. It's a future consideration. Contract is entered at 10 o'clock. Those will be delivered at 10:30. At 10 o'clock, it's a future contract. Correct? No, I'm buying some article on Amazon. It's a future contract. Amazon will deliver it to me after 2 days. The consideration is future. Correct? Huh? So consideration can be past, present, future as well. Next one, sir. It need not be adequate. What do you mean by that? It need not be the same. So for example, people, let us imagine whenever you go for this big billion day sale and all, the MRP of a product might be 1000 rupees. They might be selling it for 300 rupees. Now you cannot say that this particular contract is invalid because the price is so ridiculously less. The price is a subject matter of the parties. Whatever you want, you can decide. So 300, will it still be a valid contract? Answer is yes, because the price can be inadequate. Inadequate means what? It need not be the same as the value of the product. Product can be 1000 rupees worth, but you can charge less. 200, 100, 50, 10, 1000 rupees product. 1 rupee? 0? Okay. There should be 1 rupee at least. Correct? Huh? But of course, there are some exceptions. Without 1 rupee also it might be valid. We'll see when. Performance of what one is legally bound to? Example. Police, fire extinguisher, doctor. So for example, imagine people, you go for open heart surgery. They tell you the charges are 3 lakh rupees for operation. If the operation went successful, the doctor can come and say, yeah, hey, you're alive, pay me another 5 lakh. I thought you might not be alive. Huh? So, macha, operation and survival are part and parcel of your operation. You cannot charge operation separate, survival separate. Correct? What one is legally bound to perform, your survival is his responsibility. Agreed? Huh? Yes, sir. Okay. Next one. It must be real and not illusionary. In this case, one more thing. Okay, that firefighter also we had seen one example if you guys remember. Okay, imagine people, a firefighter, there is a fire breakout. So a fire is completely spread across this floor. We call a firefighter, they come and they extinguish the fire. The landowner said, thank you so much firefighter. Thank you for helping us. Today I don't have money. Tomorrow you can come at the same time. I will give you 10,000 rupees. I promised it today. I promised to pay. Next day I did not pay. Can the firefighter get this 10,000 or not? He can get or not? If you guys have already seen this example, then don't answer. He can get it or not? Yes or no? He can get. Why?
For past voluntary services.
For past voluntary services, it can be done.
When the other party says that I will give.
Correct. Remember, this was a checkmate in your exam. They wanted you to write as past voluntary services. This was, one is yes, technically it is past voluntary services. However, the duty of a firefighter is to come and extinguish the fire.
Not to expect anything.
You cannot expect anything. That is what you are legally bound to perform. Even if the other party said, I will give you money. Later on, if he doesn't give money, you cannot say, no, you promised, no, because law does not recognize it as a consideration. Whether firefighter will get the money, no. Just like surgery, if you are surviving, that means you have to give another 5 lakh means. Same thing, that is your job. This is your job. Same thing, police also will tell, I'll catch the thief. Do chain tera, do ring mera. Okay. Possible, will distribute. Possible, No, that is what they are legally bound to perform. You cannot take extra money for that. Yes or no? Sir, what, sir? If a firefighter takes, it's a gift. If police takes, it's a bribe. You unfair society. Yes or no? Yes or no? Understood? Past voluntary. You write this only. Yes. If you are claiming it as past voluntary, then it will become valid. Here, duty becomes one of the essential matter. What is the past voluntary service you are telling?
which was already done, like which doesn't expect anything in return, but it was done actually in the past. But voluntarily, the other person who got affected due to that will come and approach and say that he will give you something in return.
And it should be done
It
in
should be
front
done.
of the presence of the
person.
Yeah.
Correct. So the person should be alive and it should be promised to the person. It's called as past voluntary services. No. For example, let us imagine people. One person is committing suicide. Now Praveen is all seeing it. Praveen waited. He stood on the stool. He's still waiting. Still seeing. Kicked the stool also. Now Praveen will go and say, hey, why da? Now Praveen spoke to him for 30 minutes. We don't know what he spoke. Probably he sung some coolie song, movie songs or something. He motivated him. He showed some 3-4 podcasts of some Raj Shamani and Vijay Mallya and all. Now all of a sudden that person got interest in life. That suicide person. When he can only live, then I can also live, he felt. Now people, that suicide person promised Praveen that, thank you for saving my life. I will give you 1,000 rupees tomorrow. Praveen clearly got ready, suit and all, he wore. He went to his home. Next day he is telling people, hey, that was joke, da, prank. Now tell me people, he will get his money or not? Why da?
It wasn't his
Duty to save, da? So people, where is it written as duty? Your duty is to save people, da? Huh? Huh? Is your duty to save, So people, remember, whatever he did is a voluntary service. Correct. Now imagine, Praveen was wearing one white shirt, proper white shirt that day. New one, some brand, Louis Philippe. Now people, that day, that suicide person, now he's struggling. Now that stool went, he kicked it, it went outside the door. Now he cannot get it back. What did Praveen do? Praveen went and stood like this. So that person was wearing shoes. White shirt, no. Full went off. New shirt. Now my question is, can Praveen claim money for this? For shelter? Can he claim voluntary service? You did it. You cannot go and say, wow, so sure, no. Even if you put Ariel and Rin also, it will not go. You cannot go and cry there. Yes or no? Now this is called as what? Past voluntary service. Can I claim money for that? Can I claim a new shirt? No. But remember, if I given a past voluntary service, if the other party said, I will compensate to you, it will become a binding contract. Now he cannot expect money. Neither will the law tell him to give money. But the moment he says, I will pay you 10,000, this will become a contract. And that is what is called past voluntary service. If someone has voluntarily done something, but you recognize it later. Example, sir, someone finds your wallet. They take an effort to secure it and give it back to you safely. Has it happened? Now for me also it has happened. For example, last week, 2 weeks back, I'd been to this CTR dosa. So we were so excited in seeing that dosa. My wife left her mobile in cab. Now the cab was also, the cab was booked in my phone luckily. Now this person has not contacted. That day I realized, Ola help desk, I am not able to contact anyone. Once the ride is done, you cannot contact those people. You have to go through support ticket, 24 hours, 48 hours. All are okay. Only thing he will tell, sir, I don't know, sir. Some passenger might have come and had taken. I cannot hold driver liable. Ola will also not be liable. So what did I do? I am trying to find his contact. His contact is not there. That is when I get to know how helpless, useless our apps are with regards to help center. How you pathetic. If you want to speak in English, press 1. If you are feeling that this is where the service has to be, press 2. If I have to hit you, which one I should press? 9? I'll come and hit you. They will not take me to the person. I want to speak to the person. They will not take. First thing. Second thing, the number itself is not there of late. There will be no number at all. Agreed, no? Only thing that came to my mind is I scanned him, UPI ID. Your UPI ID will always be number at your bank. I just, one stone I tried, that number worked. Right side I translated, thank you. Anna, not wife's phone, my phone also I worried because wife's phone. My phone and all over. Yes or no? Now people, now that is where I said, now imagine this person was on a ride. He has accepted one more ride. He went, he came and he said, okay sir, I'll give it to you. He came back. Now people, I said, now he came back. I said, sir, thank you so much. Whatever is the money, I'll give you. 500 rupees, I'll give you. Now if you are interested, you can please give it to me. Now this person said, yes sir, I will bring it, do not worry. Now people imagine, if he had only found me, if he only had thought that okay, mobile is missing. Imagine he only came in search of me and he gave me back my phone. I will not be liable because I never asked for it. I only left it. I will say. Second one, he came back, past voluntary, both are voluntary only. But I said, sir, I will give you 500 rupees. The moment I said, I will be liable, now I am entering into a contract. It can be voluntary, but I said I will pay. I am liable to pay. Understood? Yes, sir. Pakka na. Okay. Next one, people, it should be not be unlawful, immoral or opposed to public policy. Of course, you cannot tell to kill someone and all that is not valid. Next one, people, doctrine of privity of contract. What do you mean doctrine of privity of contract? Doctrine of privity of contract means a third party can never interfere in the contract. We already saw also. When A and B are fighting, C cannot come and interfere in between. Not allowed. Correct? Yes, sir. Sir, for this rule, there are some exceptions. What is that? Sir, A and B entered into a contract, but C can take a benefit out of it. It is possible, it seems. Now, when is this scenario? When will this happen, sir? First one, people, in the case of beneficiary, in the case of trust, beneficiaries are entitled to take the or can interfere in the contract. For example, you are coming from so many colleges. Most of your colleges will be trusts. Who has created it? Some wealthy person who has money has created it. And he has appointed few people to take care of it. They are called as trustees. So the contract is entered between the wealthy person and the trustees. Now, if some problem is there, imagine some infrastructure is not good, some classes are not good, can you guys go and complain or not? But the contract is between the wealthy person and these trustees, right? How can you guys go and complain? Why should you guys go and complain? Because it is for your benefit is what the trust is made. You are an outsider to the contract. Your name is not written there. But for your purpose the contract is made. You can go and question. It is allowed. Beneficiaries is an exception. Second one, family settlement. What is family settlement, sir? What is family settlement? Generally in our thing is very common. Property dispute. Let us take for example A and B. Yeah, A sold his property to B. Yeah, now technically in this property, who and all has a right? Yes, legal heirs have right. Let us take for example, he has 2 children. They have a right. Now they will also sign. Sir, now what if even they have also children? Because this person has become a grandfather. Now people, whoever are the legal heirs, everyone has to sign. Now what is family settlement? Sir, in the contract only my name is there. Why all of these people are signing? Family settlement contract people or your basically family settlement contracts, or it is also called as property settlements in the family, whether your name is there in that or not, because you come from that legal heir, you are coming from that legal descendant and ascendants, you will have a right to take part in that property. Now I will tell you, there is one the guest character, they will not disclose every person in the movie. There is Pati, Patni or Wo. ಯಾರು ಸರ್ ಅದು ಓ ಇದೇ ಕೌನ್ ಸರ್ ಓ ಓ ರೇ Oh, correct, macha. Forget about father's generation. Go to grandfather's generation. Anyone here, I'm just asking out of curiosity. Any grandfather here has 2 wives? Okay. Yes, okay. 2, 3, that's all. Today, as we sit here, we have 2, 3. Just to go to great grandfather. Cricket team. Minimum. Yes, I'm saying as we sit, I'm telling you. Now I'm getting it, Yes. Now people, we have to take signature. Now actually I'll try to see it is related to your contract, it's related to the topic. Now my question, all of us have signed and we sold our property home to the other person. Now who will come? They will say even I have a right in the property. Tell me whether they have a right or not. Yes. Then that is where in India we are fighting for civil cases, land issues. This is the reason. वो डॉक्यूमेंट्स में नहीं होता है.
They are children, they are minors also, they are considered to be
Minors we generally not take, but whoever is a parent, we will take theirs also. As a guardian, we will take theirs. Yes, no family element. Is this person? She will come only after interval. Until interval, she will not be there. Until registration is done, she will not come. After that, macha, your life is gone. Whose life? Grandfather anyway is gone. The person who purchased is also gone. So, family settlement agreements. Now, whose name is there? No. Can she file a case? Yes. Beneficiary. Your name is not there. Privity of contract. You can't go and say, hey, do you know privity of contract? You're not there. Go. Can you say? No, they will hit you. Clear? Okay. Next one is marriage contracts. Basically, whoever are the bride and bridegroom, for your purpose, if the father and the father-in-law, if they are entering into any contract for the benefit of their children, if the contract is entered between them, if it is entered for the benefit of the children, they can anyways go and file this particular case and they can get it resolved. Next one is people assignment of a contract. What do you mean by assignment? Transfer. So let us imagine a negotiable instrument we'll be seeing now. In negotiable instrument, I'll tell you what is assignment of a contract. You would have seen endorsement. That is only endorsement. Acknowledgement or estoppel. Acknowledgement, you already seen somewhere where Chinnaya versus Ramaya. Once you said, you cannot go back. Once you said, you cannot go back. Sir, for friends, is it valid? Which one for friends? Covenant running with the land. What do you mean by covenant running with the land? Condition running with the land. A had 10 acres of land. A wanted to sell this to Mr. B. A told B, out of this 10 acres, 9 acres you do whatever you want, but 1 acre do not do anything. It has to be left to my son for farming. With this condition, if you are okay, I will sell my entire 10 acres. 9 acre you do whatever you want. 1 acre you should be collecting rent from him, but you cannot construct anything there. B agreed to it and he purchased it. Now B further sold it to C. Whether he communicated this, he did not communicate this, nothing will change. Whenever a property is sold further, the condition also is sold further. Now C is purchased, C also cannot construct anything in that 1 acre. That is the meaning of covenant running with the land. Covenant running with the land means people, condition that runs with the land. If the land changes hands, even the condition also changes hands. Clear? Yes, sir? Okay. Next one. Contract by agent. Agent is not, we'll be seeing agency, the principal agent and all, we'll again see in detail. Next one, sir. Validity of an agreement without consideration. Generally, people, a contract must have consideration. Quid pro quo is a must. However, there are some rules which say even if there is no quid pro quo, give and take is not there, it is still valid. The first exception is only people, natural love and affection. What is natural love and affection, sir? Ade sir, oh. Oh, what is natural love and affection? Natural love and affection is nothing but, now imagine people, Narayan Murthy, you know, Narayan Murthy recently has gifted, you know, his grandson, he has gifted something, what? 500 crore worth shares. Narayan Murthy has gifted his son 500 crore worth shares. What did grandson give? Nothing. But is the contract valid? Quid pro quo, no? Quid pro quo. Exception. The grandson naturally loves his grandfather. Correct, no? They always who only will not come there. Other letters are also there. So, other letter, they. Okay. Praveen answer Excel says there. Now people, understood, now people, remember, natural love and affection, grandson has not paid anything, but what law considers there as, Narayan Murthy has given shares, the grandson is giving one consideration, that consideration is love. And that is valid consideration under the eyes of law, but that doesn't mean that you go to a random person and you give one thing and say natural love and affection. It is not existing between everyone and anyone. Natural love and affection, people, should exist only between near relationship. Father, children, parents, grandparents, it is allowed. That is first thing. Second thing, people, it should mandatorily be documented, written and registered. It cannot be oral. And you have to go to the proper authorities. You need to register your instrument. If all these three conditions are satisfied, it will be considered as valid. What is that? Party should be near relationship. It should not be an outsider. Second one, it must be in writing. Third one, even if one is not there, it is considered as invalid. Clear? Next one, compensation for past voluntary service. Praveena. Shirt. White shirt, what is the conditions to be satisfied? Praveen should have helped voluntarily. Rendered for promisor, the person being hung. Promisor should be in existence when made. That time you are still there. He must have intended to compensate. I will give you 1,000 rupees. Correct? Next one, promise to pay time bar debt. What is time bar debt? In the law, you need to go and complain within a certain time. You cannot go whenever you want. Correct? There is something called as Limitation Act. Yes? Now, for example, imagine if A has taken loan from B. A has taken loan from B. Now, A has to repay this loan within 1 year. In 1 year, he did not repay. Court says he has not repaid, right? 1 year is done, right? You have 3 years time now. Within 3 years, come and complain. Within 3 years, if you do not come, the court will not recognize your case at all. You will lose the right to come in the future. Now this way it is written in an act called as Limitation Act. That every case should be come to the court. You have to bring it to the court within a certain period of time. You cannot say, sir, I will come, sir, 5 years, let it happen, sir. Already you only will cry. That, sir, the cases are going on in the court for 5 years, 10 years and all. Yes or no? Because in 3 years, 5 years, people, what can happen? Evidences will die. It will become difficult to prove the case. You can recollect what happened in yesterday's class. Can you recollect what happened in 1 year's class? Evidences will die. Memories will die. I don't know if you guys have seen that Hindi movie called Talwar. Okay, similar thing only. Evidences will die. So the police officers, they will have to file an FIR. They will have 24 hours time. Imagine. So they will go to the place in the evening. The murder would have happened. The police officers will push the incident to tomorrow morning. They'll say, hey, morning will come, why now night? People will be waiting for us at home. Murder it is. It is a real life incident. Arushi's case it is called. Yeah, it's a real life incident. So they will push it to the next day morning. And by next day, what will happen? The previous night, it will rain. In the terrace, the murderer's fingerprints will be there. Everything will go. And from there, the case will start. And that is one of the cases where even the parents were arrested for attempt of murder. And today, none of them knows whether did they do, did the outsiders do. What is the scenario? None of them know. But who were arrested? Parents were arrested. They say we didn't do. If you see the movie also, it will be shown that they were cornered and they were filed a case on it. Movie is called Talwar. Understood? Huh? So now imagine 3 years. This is one night. Evidences will die. That's why you have to come to the court within time. Yes, sir. So what if 3 years is done? Now? Gone, no. You cannot do it, no. But imagine people, A is a very good citizen of this country. He says, Macha, 3 years is done. Technically, if you see, you can't do anything now. You're gone. But A will tell, don't worry, I will give you one more check or one more contract. Again, I will promise that I will have to pay this 1 lakh rupees to you. Don't worry, I will give you a fresh agreement. A is giving it to you. A fresh agreement is coming, again 3 years will start. So if the person itself is promising to pay you the time bar debt, just Shashtanga Namaskara and say Namaskara Anna and say thank you. Yes, sir. In real life, whether it will happen, I don't know, but it is there. Clear? Next one, to create agency. To create agency, in agency chapter you will see this. Consideration is not required, it is not mandatory. Next one, completed gifter. Completed gifted, in wedding your friends will come and give you a gift and go. What will you give? Lunch, no. Correct, no? You will get gold, no? Imagine you would have given in your wedding, let us imagine. Now Praveen's wedding, Wasim gave gold chain. Thick friends. So Wasim gave good gold chain. After 2 days, people they fought. They fought, literally, brutally they fought. Wasim is now coming telling, hey, you're not my friend, give me back that gold chain. Now my question is, can he take back the gold chain or not? It is his only, not, bill and all he only has. Completed gifter transfers the ownership. You cannot claim back. So be conscious when you give. Next one is people, bailment. Bailment we will see. Unit is IRCO. Next one is charity. What is charity? So, people, is charity considered as a valid contract? Imagine I said in a place, I will give you 100 rupees and I don't give. Is it considered as a valid contract? So they say, remember, Kedarnath versus Gori Mohammed. In this case, what is the scenario? Let us imagine people, there is a construction of, in one of the case, there was a construction of a temple that was happening. So people were coming to door asking that whether are you interested to give donation. Now one person called Mr. A, he opened the door, the Josh. He said, sir, yes, write in my name 10,000 rupees. Is it okay if I give you later because salary has not come? I'll give you. You write in your book and go. Now they wrote in the book and they went. Now in 1 month people, the total amount that was collected was 10 crore rupees. Now Mr. A said, anyway 10 crore is collected, what my 10,000 will make difference? A went and said, sir, you cancel off my 10,000 because anyways your construction is going on. You collected 10 crore. I thought no one will give, that's why I said 10,000 I will give. Now my question is, can he cancel this 10,000? It's a charity. Can he cancel it? Because it's a contract, no. There is quid pro quo. I am giving 10,000. What is he giving me in return? Of course, prasada. But you can't say 10,000 expensive prasada. What is I getting in return? Then there is no quid pro quo. Hence there is no contract only. So A is telling I will cancel it. Yes or no? Yes or no? Can I cancel it? So remember, based upon your word, if the person who has collected the money, if they have undertaken any liability, meaning what? Now they thought the net collection they will get is 10 crore. Accordingly, they have planned this particular temple construction. If your 10,000 was not there, they would have just put cement. Now because you said you will get, they have put white cement. Probably tiles. Because you said marble has come in now. Now why do you want to take back 10k? Based upon your word, they have entered into a liability. Now charity becomes a contract. So whether a charity is a contract or not, it is all subjective. If a contract or if a liability has started, if the other person has taken up a liability, then your charity becomes an obligation. If the other person has not taken up any liability, charity does not become an obligation. Pakana? That's what. Now you need to question is whether is there any obligation. Let us imagine. Nowadays you guys will get this also, no? What is that? In your social media on Instagram, one small child is suffering from some cancer. Would you like to contribute 150? Now you have given it for a purpose. Based on that, that person will undertake an operation there. You are liable. You cannot take back.
This has to be in writing only, sir.
This one?
Yes, sir.
Can be oral also, but in reality, it is writing. But if you ask me from exam, oral is also allowed. Yes, sir. Is clear? Hello, Pakka? Okay. That is your quid pro quo. That is your exceptions. If you guys want, you can take a picture of this or something. Case laws. Now, same Samsung Galaxy S21. Visible, ada? Devasimo. Someone from here can forward, you know, da? All are independent people, huh? You won't talk to each other, huh? Generally, I'm asking. You all talk to each other? No? Disputes? They're online. If you guys got a better clarity, forward it to them. Then, people, third one, people, other essential elements of a valid contract. Okay, see here. People, other essential elements. Till now, we have seen agreement, two parties, consideration is done. Now, we are seeing capacity to contract. First one is simple. What? So, in marriage agreements, if parents can sue others for their children, will friends be able to do the same? No. Domestic agreements. And what agreement will friends come and do? In marriage, I mean, what agreements will friends have in marriage? Okay. People, minor agreements, minor agreements, what is the first one, people? All the minor agreements are void ab initio. Correct? That means what? They are invalid. You will not get any right over it. Next one, no ratification. What do you mean no ratification? Now, I cannot make it right or valid in the future. Correct? Imagine people, I gave loan to a person who is a minor, who is 16-year-old. Now if I go and file a case, will I win? No. Now what I will do, I will wait for this person to become 18. I make this person now sign one agreement. After you become 18, I will make you sign one agreement. What? Whatever money you have taken when you were 16, promise me again, sign me again and say that you will pay. That minor signed. Now tell me, can I hold the minor liable? So once invalid, always invalid. You cannot create further agreements based on that. Ratify means what? Whatever is done in the past, you cannot make it good in the future. Only one exception is there here. In partnership, there is one exception you will see. That minor agreements can be in one place. It will be like ratified. Where? I will tell you. Clear? Okay, next one. He can be a Beneficiary, correct? For benefits he is entitled to. Partnership only is the best example. Next one, plead minority, correct? Meaning I can file a case on him. In the court he can say, Your Honor, I am a minor. His estate is liable for necessaries. What do you mean by that? A has given loan to a minor, 16-year-old. This minor has taken this loan for what? Education and shelter, food, my expensive food, taking loan and eating, and hospital, anything. In such cases, people, the minor, will minor be liable? Minor's estate will be liable. Estate means what, sir? Real estate. Estate in simple terms means property. His property will be liable. Hello. Meaning what, sir? I have taken education loan worth 5 lakh. My property value is 3 lakh. The minor will be liable up to 3 lakh. Understood? Whatever is the value of my property, estate, to that extent my liability will end. Done? Okay, next one. Enter into a contract by guardian who paid all your college fees, signatures and all. You signed, parents signed. Guardian. So if you guys have to enter into a contract, it should always be through guardians. Correct? No? Open a bank account. Open a demat account. Somewhere they would have asked their signatures. Yes or no? Next one. No specific performance. What is specific performance? I'll tell you when we are doing damages part. Can be an agent. Correct? Cannot bind parent or guardian. A minor cannot enter into a contract and say, sir, my parents will come and pay. You cannot bind them. Correct or not? A minor cannot go to one shop. Okay. Now minor cannot go to a shop and minor cannot say that, imagine I will take some benefits, whatever are the consideration to be paid, my parents will come and pay. And if the shopkeeper also gave that particular product to the minor, you cannot hold the parents liable. Not possible. Unless and until parents have given a written acknowledgement or they have clearly told, anything my son or my daughter takes, you give it to them, I will come and pay. If it is said, it's a different story. If not, you cannot hold them liable. Understood? Next one. Joint contract. A major and a minor both borrow the money. Major will be liable, not minor. Surety will be liable. What is this? A minor borrowed money. There was a guarantee given by a major. If a minor does not repay, guarantee will be liable. Surety will be liable to pay. Shareholder, can he become a shareholder? Directly no. Through guardian, yes. Minor is liable for torts. Torts means what? Civil wrong. For abusing, for hitting. For all that, minor is liable. You cannot say minor is not liable and all. For that, he will be liable. He is liable for torts. Next one, people. Capacity of parties. The person should be of sound mind. What do you mean by sound mind? Sound. You should wear headphones. What is sound mind? A person should be mentally stable. So generally, people, whenever a person, imagine, is not able to understand the terms of the contract, that can be when a person is mentally unstable. Like for example, nowadays we have it, right? So many people come and say that this person is proven to be mentally unstable. Or say, for example, nowadays, so it has become a trend. There's antidepressant tablets they will take. Whenever it is taken, it is also considered that this person is not stable at this point of time. Yeah. So in such cases, if at all any contracts are entered, that means you are not able to understand them thoroughly. Yes or no? Now, for example, Yuzinder Chahal, recently in one of the podcasts, he says, I was under depression. I was taking these. I was also having suicidal thoughts. So I'm saying, are you in right state of mind? So now if you are entering into any contracts at that point of time, it can be challenged in the court. Whether did you enter it at the right point of time or not? What was your state of mind? That is the meaning of this. Capacity of mind. Sound mind means, are you able to understand everything I say? Getting it? Yes, okay, next one. Can a minor bind their parent by estoppel? Possible. If if parents have given acknowledgement that whatever my son or daughter will do, we will pay, then yes, we can hold them liable. Next one, when your Atma meets Paramatma, you're in sound mind only, no? Correct, no? Intoxication, alcohol, you're able to understand, walk straight, you will understand terms of contracts. Alcohol consumption, you're not in right state of mind. Where is sound mind? So that is called temporary unsoundness. You cannot enter into a contract when you are temporarily unsound. So end of the day, when you are sound, you can enter into a contract. Clear? Okay, next one, you should not be disqualified. Foreign sovereigns and ambassadors. Who are these? Ambassadors are they caro. What is ambassador? Diplomats. Macha, you cannot imagine you enter into, you walk in this Jainagar. One or the other person will come and say, sir, iPods beka, Apple. Earpods beka, Apple, original. You want iPhone? I'll give you 5,000. They'll keep selling one bag they will wear. Like this, one jacket, it will be there. Sir, want 200 rupees. Apple AirPods. Now people, imagine, I'm okay you going and selling it to one random person. What if you directly go and sell it to Trump? You look at the impression that you will leave on the country. It is not about that 200 that you are having an impact on, your dummy earphones. It is an impact that you will have on the country. See, recently, I was seeing one thing. This person called as Speed is there, that Speed person. In YouTube and all, he runs fast now, that person. He called himself as Speed something. He has gone to China, full, they have treated him like a VIP. VIP only, everywhere guest entry. He is no one, social media influencer. Full, they have given him access to all the places and all these things. Now he has a good reach and following in social media. He has gone and promoted China. It's very good. It's lovely. He has also finished China and come to India. No one has cared who he is. No one, literally. He goes and talks to people. Literally no one cares. And unfortunately, India is a place where until you do not show the right things, you will only see wrong things. So in this vlog, only beggars are there. Only beggars. And I don't know why. He has done vlogs. If you want, you also see. Somewhere he will rotate and he will go to slum only. He will go everywhere and he will end up in one slum. And see how important your relationship should be. What he has shown in vlog is India is a slum. India is an underdeveloped country. And that's the notion he goes and passes it on. And those vlogs have got what? Millions of views. I'm saying where you should be conscious. Imagine doing that with Trump. You have to show what you want people to see. You shouldn't show what people do not want to see. Correct, no? So, that is what they're telling you. Do not mess up relationship with foreign diplomats. Do not enter into contract. Don't do anything with foreign diplomats. If you want to do it after central government approval. CG approval, then do it. I don't mind. Without it, you cannot do. Because if anything happens, country's relationship will spoil. Understood that? That is why they are disqualified. Next one. Alien enemy. What is alien enemy? Direct Pakistan only. Alien enemy means war. If ever with any country, if we have a war, we call them as our alien enemies. Direct Pakistan. Third one is insolvent. Who is insolvent? A person who is not able to pay. So insolvent is nothing but a person who is disqualified under the contract because he doesn't have money. The fourth one is people convict. Who is convict? Convict is none other than if at all a case is filed against you and you are proven guilty, it is proven that you only did it. You are called as a convict. Remember, accused is never disqualified. Accused means a case is filed on you. But it is not yet proven. For example, all our politicians are accused. Oh, sorry, all Allah, some of them. Yes, they are accused, not convicts. Case is not proven. Yes or no? They are actually what? Innocents. What have they done, Papa? Next one is corporations. Corporation is nothing but dear people, ultra wires, which you will see in Companies Act. Ultra wires transactions can company do? No. That is what is corporations here mean. Within the power you can do, beyond the power you cannot do. It is considered as disqualified. Correct? Yes. Okay. Next one, free consent. The first one, coercion. A contract cannot be entered by coercion. What do you mean by coercion? Force. No one should have threatened you, forced you. Undue influence means what, Abba? Undue influence. What is undue influence? Dominating the other person is called undue influence,
Relation between
To dominate, using that position.
inducing someone to do something without their personal consent.
Free consent.
Using the doctrines to bring your subordinate to a contract.
Okay, it's called as undue influence. What all of you have to write only, people. What is undue influence? Remember, what is the difference between coercion and undue influence? For both, same answer only. First one, in undue influence, there will always be a relationship. In coercion, there need not be a relationship. What is this relationship? This relationship can be employer-employee. It can be a master, it can be a servant. It can be a student, it can be a teacher. Father, son. It can be a doctor, it can be a patient. There is always debtor, creditor. There is always a relationship. They are not two random people. So first is a relationship. And in everything there is one person in the top and the other person is always in the bottom. There is a one person taking advantage of his position. Unfair advantage. Remember, I am not saying a debtor and creditor cannot enter into a contract. I am not saying that. The problem comes when the creditor uses his advantage of the position, misuses it. That is where the problem comes. Creditor, debtor. There is always employer, employee. Student, teacher. Hey, student, teacher only 2 days. Yes or not? We are an inferior, you are an all superior now. Correct or not? Now, whenever the person in the top is taking an advantage of their position, we call it as undue influence. Understood all of you? Yes? Okay. Next one, sir. Fraud. What is fraud? Fraud means what, sir? Fraud. Sir, you know it is a mistake, you will again do the same mistake. It's a fraud. Correct. By knowing it, you are doing wrong is called as fraud. Simple people, you know it is false, but you still tell it is true is a fraud. What is misrepresentation? I don't know it is false and hence I will tell it as true is a misrepresentation. Got the difference? I know it is a false. I know. I tell it is a true. It is called as fraud. I don't know that it is false. That's why I say it is true. It is called as misrepresentation. The pen was in my hand. It fell down. I only put it down. I know. I know it might not function properly. But none of you saw it. Now I am coming and I am auctioning this pen. Does anyone want to buy? Now people, I know it is not working. But I am still telling that it is good. Now you only tell me people. It fell. I sold this. I did not tell anything. I sold this. Is it valid or invalid? It's valid. I know it has fallen down. Is it? It's the duty of the buyer to know. Caveat emptor will apply. Remember, as a seller, it is not my responsibility to disclose everything. Hey, you also check da. You also check. Understanding is what they are telling you. It is your duty to check. You be responsible. So a seller will not by default disclose the mistakes. It is not my responsibility, it is your responsibility to check as well. Agreed? So sir, but what is an attempt to fraud? I know it is not good, but I'll come and make a statement. People, the best pen, new pen, it is working all good. Now this is called as fraud. What is misrepresentation? I had kept the pen here. I went out. Now Praveen came here, wanted to see. He plays like this. He was doing, it fell. What does he do? First thing, he'll see. Run. Correct? Now Praveen actually put it down, but he kept it back in the same place. Now I came back. I don't know what happened. I'll come and do the same thing. People, this pen is for sale. It's working because I tested. I'm writing only. Now I'm selling it to you. Now this is called as what? Misrepresentation. I don't know all of this happened. That's the difference. Misrepresentation is, I don't know. I'm an innocent, but I don't know what is wrong. Even I don't know, like you.
If you don't check, also you don't know, right? Then also will it become misrepresentation.
If I don't check
In
is,
second case, you put it down and you didn't check whether it is working or not. So
I put it or his thing?
You put it down.
Okay, I put it down.
But you didn't check whether it is working or not.
Hmm.
So you don't know about its working condition.
Hmm.
Also, it is misrepresentation.
Yes. If at all even I am not aware of it, yes, it can be misrepresentation. That's why we say, if I know it is false and I claim it as true, is fraud. Fiduciary relationship. You would have seen something called as fiduciary. What is the fiduciary relationship? You can never do something fraud in certain relationships. What is that relationship? One is fiduciary. Fiduciary means what? A relationship of trust. A son or a daughter will always trust that my father will never cheat me. It becomes voidable. If a consent is not free, see, what do we say? It is your duty to check, correct. But I'm saying, whenever it is a matter of fiduciary, you have a trust, a blind belief on the other person. Now, in such cases, you can hold them liable under undue influence. That is your fiduciary relationship.
What is you stay silent?
Got it. Does mere silence amount to fraud? Now, I told you, I know it is not working. I'm telling you the pen is not working. I know. I will still not tell anything. I will sell this pen. Is it fraud? Is it fraud? That is where caveat emptor applies. I know it is not working, but I need not have to disclose. I will not disclose. It is your duty to check. It is your duty. It is caveat emptor. Unless there is an obligation on the seller to disclose. For example, when will that happen? In some contracts, even just remaining quiet is also fraud. What are those contracts? Contract of Uberima Fides. You also would have seen it as Uberima Fide. What is Uberima Fides? A contract entered in good faith. Contract of insurance. Even if you remains quiet, it is considered as fraud. Family marriage contracts. Even if you remain quiet, it is considered as fraud. Fiduciary relationship. Even if you stay quiet, it is considered as fraud. Where you have a duty to speak. Meaning, imagine, I am selling this to you. You specifically asked me, sir, are there any defects here? Now I have a duty to say, I will still keep quiet. Now this is fraud. Understood? All of you? Okay, fraud understood, huh? Misrepresentation, we saw false, true, true, false, without knowing. Last one is people mistake. What is mistake? By mistake. What is mistake?
Not know that it has occurred.
The parties might not know that it occurred is called as mistake. Mistake will always be of two types people. One is mistake of fact, mistake of law. What do you mean by mistake of fact?
In objective itself, there is a mistake.
In the objective itself, there is a mistake. Okay. Example?
Maybe the ship couldn't have come and reached, but there was a sale between there was a contract between a buyer and a seller for a port, which there is a ship coming in, but the ship got sink in the middle. No, both the parties didn't know that, so it is a mistake.
Okay, that is mistake of fact. Okay, mistake of law.
Maybe they misunderstand the law or interpretation of law, maybe wrong.
Okay, fair enough. So what is mistake of fact, people? Mistake of fact can be unilateral, bilateral. Unilateral means, people, the mistake is considered as valid. Bilateral means, people, mistake is considered as void. Taka see here. I went to buy a home, flat. The flat, people, they clearly have a, what do you say, the floor maps and all, they will have that catalog, no? In that they have written everything. So when, as soon as I went, the person there, whoever is a salesperson, the agent, he gave me the catalog. I said, catalog and all, I'll not read it, you show me directly. He took me to the home, he took me to a flat. I really liked it. I said, I want to buy this. He says, yes sir, you can see the catalog, you will get all the information. Hey, I said, I am seeing this now, what else I need to say? Who cares about document? I am seeing everything in reality. So people, I was okay with it, I went for registration, I registered also. But after registering, people, I get to know that this particular flat, I thought was a, what is that, A Kata. But I got to know it is B Kata. Kata they say, no? No? Property they say A Kata, B Kata. Okay, A Kata is like a developed one. B, you can imagine like a little underdeveloped. Not like that, but you can imagine on the layman. Okay, forget about that. A Kata, B Kata, little. Okay, let us imagine mine was not Vastu compliant. No Vastu. Now don't tell me as if you guys go inside immediately will know, sir, this is Ishanya, this is Mule. None of us will know. It will be 1 4 walls, that's all. Because even when I went, I did not know anything. They will say, sir, this is Ishanya Mule. Is it? That's how you will be. How will you know, right? In 4 walls, yes or no? So people, but I am telling you, for under our Indian thing, if at all your Vastu is 100% compliant, only then your flats get sold. Sad reality. If Vastu is not there, if value of the property is 1 crore, direct depreciation to 80 lakhs. Nothing, same cement, same brick. A reality. Now people, I didn't see. I said, okay, I want it. Everything is shown. One day one of my relative came and said, sir, why did you buy this? Why? Sir, door. If your door is there, that's all. You're done. Door can decide my future. It means I put somewhere. Kanna. So people, they said, Vastu, now I am calling the dealer. Which flat you sold? That time he said, sir, I told you, check the catalog. In that it is clearly written that this is Kubera Mole. This is Mole. Agni Mole. Yes, now it is clearly written there. Yes or no? Now people, this is called as what? Mistake of fact, unilateral. Seller was aware what he is selling. I was not aware. It is my mistake. Agreed or not? Hey. Okay. So seller was aware what he is selling. He was sure. Hey, go. Okay, understood? Yes, this is called as what? Unilateral mistake. Next one is people, bilateral mistake. What do you mean by bilateral mistake, people? Both of them are under a mistake. I am asking for a pen. You are giving me a pencil. So, I am having something in mind. You are having something in your mind. Now, for example, people, let us imagine the same day I checked 2 flats. I saw 2 flats. Let us give a number 118 and 128. I checked both. So I am telling the person and saying, sir, I like that flat, I will buy. I am thinking 128. He is thinking 118. This is called as what? Bilateral mistake. Bilateral mistake can also be even if you remember, what is that? Essential elements not given under section 10. certainty or vague. Same thing can come here also. Understood? Pakkana? This is called mistake of fact. Mistake of law means people, this will generally come people whenever there is international transactions, when a foreigner is doing a contract with you, or you are doing a contract with a foreigner in the foreign country, that time you will not be aware of all the foreign laws. Correct? So that is called as what people? Mistake of law. Mistake of law is always treated as what? If it is an Indian mistake, we will treat the entire contract as valid only. For example, sir, if I get into a train, I have to buy a ticket. I cannot say, sir, I didn't know. Contract is valid only. You have to pay fine. Sir, mistake of foreign law, do it one thing, treat it as mistake of fact. Meaning, if one person was aware of it, it is valid. Both of them were not aware of it, it is treated as void. Example, recently there was one transaction which now you see this. You guys know MDH? Hello? Any of you use MDH? Hey, you'll use that? None of us will use that. Okay, at least one of us will use because they claim to be India's biggest masala brand. Not even one of us will use. Okay. Everest. Okay. Australia had to ban. Everest and MDH is same only. Now we'll use. Yes, sir. Now see here. What happened? MDH people, they okay. Now people, MDH people, they had masala. In that masala people, there were some ingredients that were added. And we entered into a contract with one of our Australian buyer that we will sell garam masala. Garam masala, she got of the example. Now people, we agreed to sell garam masala to one of the Australian supplier. People, what will you think that will be there in garam masala? Some pepper, some chili, coriander, kothumri, something will be there, correct? Now people, in this, they do not know how Indians are made. We are tough people. INS regulator, INS indicator, I don't know what and all regulators. So they have put some 5 to 6 additional things which are nowhere required to make a garam masala. Now a supplier who gave a contract to Everest, he did not know that this will be added. According to Australian laws, the usage of, that is, I am not finding it. There is one particular thing. Ethynyl oxide, Ethynyl oxide, see, ethynyl oxide, we can eat. They can't eat all that. Poor people. We can digest all that. Ethynyl oxide. We will fill a macha, an extra item is added. Take. Buy MDH Everest, get ethynyl oxide free. We will take it. We digested it for years. They gave it there. They said it is banned. People mistake of foreign law. Papa, our Everest Anna didn't know that ethynyl oxide is, they cannot digest it there. Correct? Mistake of foreign law. Now how to treat it? What to do here? Who will bear the loss? Imagine we would have sent a containment of 1 crore packets. Who will bear loss? So now they are telling mistake of law. I don't know what is the ethynyl oxide acceptance there and here. Now we will ask one question. Did both of you knew? Did one of you knew? If both of you knew, contract is void. The entire loss is on Everest. If one of you knew the contract is valid, you need to pay. That is how you need to treat it.
Who's that one of them?
Now that is what? Anyone it can be. So even after knowing, I know that this is what it is. Now Everest can say that I know. You should be aware that whether it is accepted in your country or not. I will give it to you. So Everest will say you have to pay my money. Because he knows ethynyl oxide is put. Correct now? Hello? Yes or no? Understood? What? Ethynyl oxide. Clear? Okay. Legality of object and consideration. I'll tell you this mistake of facts, mistake of laws and all. We will not get examples. That is why in our classes you wouldn't have seen. Yes, I know. That's why I'm telling you. There are some 7 to 8 places in your entire business laws. You will not find examples there.
Examples we can create for fact, but for law,
100%.
no.
Yes, I know. Okay, clear? Legality of object and consideration. First one, people, it should not be basically illegal, correct? Your contract should not be forbidden by law. So you cannot have a child marriage and things like that. Next one, it cannot defeat the provision of any law. In Indian Contract Act, it is clearly given, minor agreements are void. You cannot say this clause or this particular law will not apply to our agreement. You cannot say that. Next one, fraudulent smuggling and all, you cannot do it. Involves injury to a person or property. I'm telling you, go and put a bomb on that house. Cannot have it. Immoral. What is immoral? What is immoral? Immoral is a grey area. What is immoral? Immoral is not written anywhere. Now imagine, is no smoking written here? Can you smoke? No. Immoral. It's a thin line of difference. Immoral is nothing but societal acceptance. Meaning society does not accept it. But if you are doing it, I'm not saying I can legally hold you accountable for it. Because it is not written anywhere.
This will come under criminal or civil laws?
Depends on what it is. Now imagine smoking it is. It will come under civil. Fine will be collected from you. But depends on what you have done. Correct? That is immoral. For example, A tells B to divorce his wife and come and get married. It has happened in India. It's not something new. Recently one murder also had happened in, where is it? Recently married couple had gone to, I forgot, Kashmir or, yeah. The wife has created an entire scenario, framed such beautiful story just to marry the boyfriend. I'm saying newly married couple within a week. Immoral, where is it written? Kill Allah, I'm saying. I'm saying this one. I will give you money, divorce your husband. Where is it written? Immoral. Raghuvanshi case, correct. Understood? Consideration opposed to public policy. What is the consideration opposed to public policy? This list. First one, trading with enemy. TikTok. Ban, no. Why is the ban immediately? Because of that. Trafficking of public titles and what is public offices and public titles. What do you want to become in life? Sir, Padma Bhushan. 5 crore, okay. Can we do it? What do you want to become? UPS, IS, police officer, commissioner? 1 lab. Possible, You cannot sell it is what they are telling you. Trafficking means what? Selling. Agreements creating monopoly. Can Airtel and Jio come together and start Airtel Jio? If they come together, we all will go for. They will come and tell annual package is 10,000. Where will you go? You should start using satellite phone. Macha, Roger that. Hello, Roger. That is what will be a scenario. We should use satellite phones only going forward. See, Jio only. Initially they said free. Now 3,600 rupees. And see how smart they are all. Initially, we had a monthly package means, according to me, month was 31 days. When did the month become 28 days? I don't know. They did it off. And we don't even know. You know what is the effect? Making it 28 into 12, 28 into 13 makes it 1 year. 1 month extra you need to pay. எப்படி? Our marketing people are extraordinary. You tell what, we will not know. They would have done something. They are genius. Yeah. Next one. Sorry. Another. Marriage brokerage agreements. Correct? We cannot have marriage brokerage agreements in our country. Of course, directly I'll tell you, Shadi.com, all those are exceptions because they are not marriage brokerage apps. They are just apps to give you the data. They take 500 from you. You use that app for 1 month. So whichever profiles you want, write it down and you call. You do your matches, you guys do. We will not play any role there. That's why they are valid. 2024 they asked this exam question. Is Shadi.com websites valid? People wrote marriage brokerage agreements are invalid. But in my class I would have 100% told you that. Difference. Yes or no? Shadi.com is different versus this. Okay. Interest against obligation. What is interest against obligation? Now imagine we appoint a government officer for him to make sure that, let us imagine government wants to take up a project. Now government will take up tender. Basically public, people has to start applying for tenders. No, whoever gives the least tender, the government should give the contract to them. But government will contract to whom? Commissioner. Commissioner will be there. Tejasvi Surya. Recently in Bangalore, there is one tunnel being constructed. Just to search Tejasvi Surya on the Bangalore tunnel, you will get it. So Congress government has given a budget, it seems, for construction of a tunnel. 3,000 crores something, which is more expensive than a highway that the central has done. That Leh Ladakh tunnel is there now. It is expensive than that. In Maharashtra, they have created that inside water. It is expensive than that. He is asking why. What cement are you using? What steel are you using? He has asked on public domain. He has asked. Why 3,000 crore? You guys tell me why. This is the. India is not for beginners. We know, but we won't tell you. We know. We won't tell everything. Why should we tell? Correct, no? We know, no? That is what it is. Meaning, interest against obligation. Your obligation is to find the best contractor, not to make your best interest out of it. Yes, that if you do such contracts, it is opposed to public policy. Consideration unlawful in part. I gave you on 1 acre land. In half acre, you did Kothumri soppo, coriander. In another half year, lawful in part, unlawful in part. Just because it is there, Kothumri soppu will not become waste. Kothumri soppu is legal. Machas, don't get inspired and all. If you get inspired, you will get expired. So remember. Yes. Okay. Only for class of fun. Yes. Interference with course of justice. What do you mean by that? Witness is there. A person who has seen the entire murder. I'll give him 500 rupees. Don't come tomorrow. You cannot interfere the course of justice. The case has to go on. You cannot influence them. Stifling prosecution. What is stifling prosecution? So, the legal maxim of it is also called as one should not make trade of a felony. Felony means crime. Trade means what? You cannot go and settle it. If a person has killed, I will tell to the family, I'll give you 5 crore, forget. The family should not take it and leave it. Criminal matters can never be settled. Civil matters can be settled. Meaning, a person comes and hits you in the car. There is a dent. Car completely went. Door only broke. It broke like they came and fell into your car. But yes, end of the day can be repaired. take 2 lakh rupees, be done with it. You need not have to go to police station for this. If the other party is ready to pay, why police case? But can't the same thing happen in murder?
No.
Family is okay. Sorry, anyways, he was okay. Can we say that? No, you cannot make a trade of a felony. Yes or no? Next one, people. Maintenance and champerty. What is maintenance and champerty? Maintenance and champerty means, people, whenever a person comes and tells you that I will help you in your legal case, A is fighting a case with B. A doesn't have money. C will come and tell you, I will give you money, you fight a case with B. Now, is it good or bad? Maintenance and champerty by default is good. You're helping someone. It will become bad when you have a malicious motive. Malicious motive means, people, bad intention. Your intention of helping is not to actually help. You want to take a revenge on the other party. Or, I'm telling you, I will give you this court fees. But if you win your property case, you have to give me 40% or 50% of your property. Reasonable, huh? Whenever the wants and requirements are irreasonable and irrational, such cases, people, again the result will be same. What? It will be considered as malicious. In such case, it is opposed to public policy. You help. You take back your money. A little extra is also okay. But at the end of the day, we gamble. Everyone start making this as one second mutual fund investment. Giving you best return. You give 1,000 rupees if you win for 40% of the property. Correct? No? That cannot happen. Agreed? Okay, that is maintenance and champerty. Next one, wagering agreement. What is wager? Betting. Betting is legal, illegal. RCB versus CSK. Who will win? They 1 year, they won. At least this year you say RCB. Okay. RCB, again I'll ask you. RCB versus CSK, who will win? Okay, no controversies. Okay, SRH versus ArivuPro, Mumbai Indians, who will win? Correct, Now people, Praveen says, sir, SRH will win 1,000 rupees. I will say, no, win 5,000 rupees. Can we do it? This is called as what? Wager. Wager means bet. Betting is illegal, void in India. Correct. So, Taka in 2 minutes I'll tell you of that. This is only for practical knowledge. Nowhere relevant for exam. Exam answer is it is illegal, void. Now in reality, people, remember betting and gambling, there are 2 ways to look at it. One, it is a state specific matter. I'll tell you one state. If I say betting is illegal, that state only will close today. It is called Goa. Why do you always go to Goa? What is your name? Haila. Haila, why will you go to Goa? Tell me. Think of it and tell. Enjoy. Haila, why will you go to Goa? Tell me. 3 things you will do in Goa. Tell me. Beach. Food. Okay. Next. You don't want Haila. Tell her why will you do that? Oh, he directly went on a brand. Right? Ultra strong. Yes, the people. Correct. Online. Stop your comments. It is going. Venda. हम वो नहीं देख सकते. Okay. They're telling what happens in Goa stays in Goa. What and all you guys are doing. Oh. Okay. Now much I don't know what I was saying. Now wagering, they casinos. It's a legal thing. The state itself runs it. You have 2 types of casinos. That's one thing. Correct? Anyone from Kerala? Every 3rd shop you'll get lottery ticket. Correct? I'm saying literally. Every 3rd shop. 1, 2, 3. 3rd shop you will get lottery ticket. And in that every 2nd lottery shop is run by government. Kerala government itself will run a lottery. And I'm sitting here and telling lottery is illegal. Why? That is what is not there in our syllabus. We are seeing one law. As I told you, hero will take a bus, they will only show you hero coming out. In between, macha, he would have taken Kadle Bija, Paya, everywhere will come. We'll show everything. Will not show everything. Correct? So, remember, there is something called as state-specific matters, meaning every state has their own law. In Kerala and in Goa, the lottery and betting is legal. You can do it. It's absolutely fine. It's accepted. In other states, it is void. You cannot do. Karnataka, you cannot do. No lotteries. But in my childhood, lotteries were there in Karnataka as well. Change of law. Void, in some states illegal also. It's all there. Gujarat, it is illegal. So everything is there.
Depends upon the
State. Every state can have their own law. But what is there in our syllabus? Void. Clear? So online apps, it's again a secondary thing. Now in India we have offline different law. Online gambling and betting is a different law. So according to that, if you guys are from state of Telangana, no one. Dream 11 will not open in your state at all. People will do it through VPNs because it doesn't open at all, just like your TikTok. Because the state does not allow it. So it's again a different law. Yeah. For our Indian Contract Act, just remember this and go, it is void. Clear? Okay. Promise to pay money or money is okay. Transaction similar to wager. Lottery, yeah. Yes, next one, crossword puzzle. What is crossword puzzle? Da? Sudoku and all that. Remember, if at all your winner is decided based upon skill and talent, it is considered as valid, provided the prize money does not exceed 1,000 rupees. If the winner is decided based upon luck, what is it, sir? Take 5 solutions, put it in box, galla galla galla, take one. Whatever comes, if that is how winner is decided, where is mehanat? What we need is luckidre. It is considered as wager. If not, it is considered as. Okay, next one is speculative transaction. What is speculative transaction? Basically, stock market transaction. You are sitting outside the stock market and you are betting. Macha, info will go up now. See, 50 rupees. Info will come down. See, 50 rupees. You are doing it outside. That is invalid. Do it inside the stock exchange. Valid. Tell me.
inside betting is not.
Inside betting alla. So insider trading is also insider trading.
No. Inside if they intentionally value the price high.
See, speculative transactions is nothing but a transaction which you are betting on whether it will go up or down. Uncertain. See, what is the end of the day wager? It's an uncertain event. Now, am I sure that Infosys will definitely go up?
No.
No, but still I am buying, right? We have options, we have futures, we are doing intraday. Now, is this valid? How?
Because we are considering facts.
Maybe, may not be also. But that's why there is a rule and a framework. If you are doing it within that framework, it is valid. Do the same thing outside the framework. I am saying same Infosys. Instead of buying it inside the stock exchange, you buy it outside. Now let us do it within us. I will tell Infosys will go to 1200. 100 is my bet. It becomes speculation because you are not able to now do it within the system. Correct? Next one, people. Horse race, opposite of your crossword puzzle. There, if it exceeds 1000, it is a bet. Here, if it is less than 500, it is a bet. What is horse race? One fellow became very famous for that. Vijay Mallaji. Yeah, race course. He is very fond of it. In Mysore and all, he has horse training. One big mansion only. He has taken it from the Mysore kings. They have that around 107 acres. Now the lease is done 10 years. United Breweries had it. Very full rich. Anna has lived his life. King life. I'll tell you how it is. That mansion, I had been there also. So I'm telling you, water, river and all. Sorry, forget that swimming pool will be in the horseshoe shape. Horseshoe will be there, no? That horseshoe shape, it will be there. Swimming pool, all wooden cottage, full wooden, zero cement. Full bar and all is there in that place. King life, Anna. Kingfisher. Prize money. Less than 500, void. 500 or more, valid. Less than 500, 499 is void. 500 and above is valid. Because only rich people should come. And remember, Contract Act 1872, 500 rupees. My dad's salary in 1982 was 500. So do not think 500 is less. The law is not amended, that's all. Law has been that and it has been that. So don't think, 500 and all, what they are doing, sir. Law is unamended, that's why it is sounding like that. It's the same, it's not amended. Understood? Okay, transactions similar to a wager but are not considered as void. One is chit fund, share market transactions, allowed, game of skill provided, does not exceed.
So even though it is about 1,000, it is still based on luck only, right? How they can
Which one? The crossword puzzle.
race horse race.
Horse race less than 500, right?
Even if it goes above, it is based on luck only they are building, right?
So, I can tell you two things here. There is one case which was decided. In that it was proven that horse race is not a matter of luck. It depends on how well built the horse is and how good the rider is. In one of the case it was decided. One more case also. This is in state of Telangana. It was proven that Rummy is not a game of luck. What do you want to say about that?
They say that dream
State of Telangana and Dream 11 also. That is also state of Telangana only. No, that is the state of Bombay. In that they said Dream 11 is not a matter of luck. Dream 11, you know that IPL. They said it is not luck. How can you say?
telling that you have to select the team members.
Perfect. You make a team player based on the pitch. Now boys can actually relate to that. They will think, sir, Jaddu has a very good record in this particular. You consider that. Then isn't it skill? And who said that?
Based on others' skill.
Perfect. You are doing it not as a speculation. Speculation is what? Andar bahar. Meaning you do not know, it is random. Anything can happen. But here you are using your skill, knowledge, you are assessing so many things and then you are doing it. Okay, done. Next we will contract of insurance, we will be seeing it in indemnity and guarantee. Next we will performance of a contract. The performance of a contract can be of two types. One is called actual performance, one is called as attempted performance. What is my actual performance? Ayo, so many papers you went. Actual performance means what, people? Both the parties perform the contract. Attempted performance means, people? Now when you are me in the class, our Flipkart and I went to deliver. We will not pick the call. What will happen? I might miss even my wife's call. I will not miss this Amazon person's call. They said, we tried delivering, you person with attitude, you did not receive. Correct, no? They will go back. Again I need to be behind them. Anna, please, Anna. We have to go and tell, please. Correct, no? So this is called as what, people? Attempted performance. From Amazon's point of view, his obligation is completed. I'll get a message. Hey, I tried. If you want, you will call back. If not, die. Now it is my headache to collect my parcel. Where is he concerned? Yes or no? Now I need to go and do. That is only called as what? Attempted performance. Attempted performance, whoever attempts is free from his obligation. His obligation is done. Now it is my headache to collect it. Agreed? Okay, next one. Who can perform the contract? Who should perform the? Promisor himself. I told you I'll come and teach. I should come and teach. Yes, that is the meaning of promisor himself. Remember, people, in some cases it may so happen. There is a singer who said I will come and sing. He should come and sing. What if this person dies? What if he comes and dies? Void. Why don't we know? Whenever a contract has a special skill, it's a song. So I can also sing. Correct. But the viewers also should be there. Correct, no? So based on that, you coming and singing, the other person would have sold tickets. That matters, no? So anything where special skill or talent is involved, we saw types of contracts. Void contract. When you entered, it is valid. After on, this person died. The contract will become void contract. In such case, whatever is the money received should be returned back. Now one question people will ask, who will return the money, sir? Who will return the money? Legal representatives or any person who is taking the possession of his properties. It is their responsibility to pay the liabilities also. You have to return the money back. Sir, let us imagine one person took the loan. A took the loan from B. A died. What will happen to the contract?
Surety.
Void contract only, no? A took the money from B. A died. What will happen to the contract? Void alada, valid. A's legal representatives has to pay. That is where the second person will come into picture. To repay loan, what skill you want?
Only inherited property.
Correct. You will be liable. Legal representative will be liable, but to the extent of the assets inherited. Meaning, if father has or mother has, whoever has given him money, you would have given not 2 flats, 1 car, something would have come, no, that will be liable. Sir, nothing I got, sir. When your assets you did not get, liabilities also you won't get. That is the meaning of it. Clear? Hello? Next one. So contract involves personal skill. Void. Any other contractor, representatives will be liable. Agreed? To the extent of? Agreed? Next one. Agent. What is the agent? I want to sell my car. I can go and stand on the road and say, car, sell. Or I can go and give it to an agent who will park it in these second-hand car showrooms and he will sell. I can sell my car either by myself or I can sell it by agent. Simple. Third person. A consideration memo from promisee or any other person. Chinnaya versus Ramaya. Agreed? It's not me who should always repay. Someone else also can repay. If the other person has agreed it, later on he cannot file a case on me again. Joint promisors. What is joint promisors? A, B together borrowed money from C. How much? 2 lakh. In this he took 1 lakh, he took 1 lakh. How much should we repay? We have to repay 2 lakh only. What if B becomes insolvent? A should repay 2 lakh. What if B dies? You get it, Legal representatives of B will have to pay along with A. Legal representative will pay 1 lakh and A will have to pay 1 lakh provided assets are there. Assets are not there? A, hane baraha, fate, you have to pay. Bad company. Clear? Understood? Pakka na? Okay. And what else we see in joint promise? If at all one of the parties is discharged, C tells B, Macha Goda. Why? Because B is C's uncle. So he'll say, Goda, I'll catch the other person, you go. If at all you have discharged one person, now you have collected everything from one party, B is still liable to pay to A. You might have discharged that person, that is okay, but within us you are still liable. Correct? Yes, Implied contract. It is also called a contract of subrogation. If I repay it on behalf, correct. Yes, in surety you will get it same. Correct? Yes, sir. Rules of joint promisor. Dies and legal representative. Okay, done. Next one, sir. Joint promisee. What happens in joint promisee? There is A. 2 people have given him money. Such like that it happened, Ada? For one person, two people have given him money. Huh? Friends, people, you can put here one person called as, here you can put it as,
Yes.
and you can put another 5 banks here. Not 2, sorry, 7 banks. It is called as syndicate consortium lending. Together, macha, we will all dive. If one fall, हम पूरा एक को पकड़ के ऐसा ही है. Correct, बड़ा? So we played a very good game. One bank didn't fail. All of us failed. We should be proud of it. As citizens, right to equality, our fundamental right. What if only SBI suffered? Isn't it discrimination? Is it no? We played right to equality. This is called as syndicate lending. Yes, but yes, coming to Indian Contract Act, if one promisee dies, other promisees can recover the money on your behalf. But in the case of corporates, it doesn't happen. It can happen in the case of individuals. Correct? Same thing, when joint promisor one person dies, the other person has to pay. In joint promisee also, the rule is same. When one person dies, other person will claim. Clear? Okay, done. Time and place of performance of the promise. Where should I perform? What time I should perform? Simple. First thing, people, in your contract, if the time and place is specified, do it at that time, do it at that place. If at all the time is specified, you have to do it in business hours. It's not like you come and knock the door at 12 o'clock, sir, Amazon delivery. You should do it within time. Correct, right? Sir, if at all the time is not specified, the place is also not specified, then people are telling you it is the promisee's responsibility to make an application, that is ask, because we have not agreed on anything. It is my responsibility to ask and say, sir, please deliver on this address at this particular time. That person will tell you if it is feasible or not. Correct? Okay, next one is reciprocal promise. What is reciprocal promise, da? What is reciprocal promise? Sir, I will wish to pay the goods on cash on delivery basis. You deliver, I will pay, because I have heard that you are a cheater. We say no. So, now I am not sure whether you are going to deliver the goods or not. Correct? Now, what is reciprocal promise is nothing but, people, future contract, where both the parties are agreeing it today, but their delivery is going to happen in the future. Both the parties. So if it is bilateral executory contract, we call it as reciprocal promise. I promise to pay you money, he promised to deliver goods, is called as reciprocal promises. Clear? Now, sir, in reciprocal promises, people, there are some rules. What is that? Promiser not bound to perform unless reciprocal promise is ready and willing to perform. I ordered phone on Flipkart. He's standing right in front of my house. He's waiting like this. Why? He's waiting for you to give cash. If you don't give cash, he will give phone. No. That is what they're telling you. He will not perform unless until you give him the cash. He will not give you unless until you give the cash for him. If one fails to perform, imagine I will not give cash. They will not give you phone. Simple. Order of performance. Should he give first or should I give first? Sir, you are not hogi, sir. Correct? Go as per the contract. If contract is silent, people, then follow the nature of transactions. You go to hotel. You either take cheety and then they put masala dosa on you, or you go to delivery section. You eat. Anna will come and stand next to you. He will not even check whether you have money or not. So in one case it is pay and eat. In one case it is eat and pay. So go as per the nature of contract when everything is silent. Next one, reciprocal promises which are illegal in part. Oh, ganja. Kothumri will be valid. Invalid. Correct? Liability of party preventing the event. Meaning, if someone stops you from completing the contract, I can always make the contract voidable. I can also hold you compensation. I can claim it from you. If at all you are stopping me from performing the contract. Next one, people, impossible act. Initial impossibility, of course, is void. If it is subsequent impossibility, void contract. What is subsequent impossibility? Change of law, death, operation of law, all these, right? Next one, effect of failure to perform. If time is essential. If time is not essential. What is time is essential? Now you entered into a contract for a particular thing. Now I think in our time is essential. Time is essential. So imagine people, let us imagine now Praveen only. Praveen ordered for Praveen's wedding is happening. Praveen wants a suit. Correct? No. Now it's okay that suit if it's given after wedding. No. Time is essential. Now Praveen casually ordered suit on Flipkart. Why? The prices were down. If the suit is delivered next day, what will happen? Share market will fall. Donald Trump will leave the presidency. No. That is what is the meaning of time is not essential. In some cases, time is important. Example, sir, I have ordered the Amazon because I want to gift it to someone. And wedding is today. If I get it tomorrow, you will cancel it. That's why in Amazon return you have it. I no longer need it. You have that option because you got it late. Then why did they have to add that option? Because they are late. Time is essential. Now when time is essential, they are telling you, you can cancel the contract also. You can claim compensation also. Now he had to get married without suit. Is it fair? No. Now depression only. Next 2 days he will take Saladin. Saladin also doesn't means Kothumbre. Okay. Time is not essential. It's okay. You correct. You cannot cancel the contract, but you can claim compensation because it is still a breach of contract. Correct. So I told you to give me the product. Amazon told me I'll deliver it to you by tomorrow. If they do not deliver, I can still hold them accountable. I cannot cancel it. Okay, next one, appropriation of payment. What do you mean appropriation? Whenever one party has taken multiple debts. You guys want a break? Okay, quick 5 minutes break. Go for it. Class is till what time? Okay, what time is your lunch in 12:30 to 1:30 is the PG time? Lunch? But how, if it is 1:30, then you will be able to manage with lunch? They will give you, is it? Okay, we'll finish a little early on it, it's okay. Because I heard that that's what it is. If there is something there, you let me know. Okay.
Sir, I have a doubt, sir. In one of the previous one MTP or something, sir, I saw a question when husband promised the wife that I will give you 10,000 monthly for chemotherapy upfront, sir, but he failed to pay that. So in that case, can the wife file a case?
No, it is still a social only.
No, sir, because she has undertaken a liability on his guarantee, no, sir.
So that becomes charity.
Okay.
So this is not charity.
Okay.
So it comes under domestic agreements. It is between husband and wife.
Whatever you teach now, you talk now, I understand that it's really easy to remember, sir, but contract act is really huge, sir. That whole 90 minutes is difficult to study and remember everything. So, any tips on how to study?
Multiple study you need to do. It will take time for us to understand the legal language and remember it. It is natural because you are seeing the law for your life for the first time. So of course, effort in this subject should be more compared to other subjects.
So, in one topic, if you take, there are 9 to 10 subdivisions. So, if I revise, yeah, if I read also,
One easy way I would tell you is open the book, open this marathon, sit simultaneously and read. Now imagine if appropriation of payment topic comes. You should be reading that. You should be watching it. The time will be less.
As you teach, I should read all those.
That's when you'll be able to remember faster.
Already I have books, I've done all those, except apart from the contract tax. So, all these 9 units, okay, I remember.
Take time. It will take time.
Sir, only study the important questions in each unit. Only contract items.
See, the only thing is, Noda, that might work. I'm not saying no. But it is always ifs and buts. What if they don't ask? So I cannot promise you a guaranteed attempt. For a confident attempt, you should always
At least remember the headings and fill the content in our own words. Let's say consideration, exceptions, charity, and when it comes to love.
keyword, if it is same, it's okay.
We are writing heading, sir. That is it.
Heading alone is not sufficient. In the answer also the required words has to be there. For example, in natural love and affection. Natural love, near parties, it should be in writing, near relations, it should be in writing, it should be registered. These are the keywords. Rest of it you write whatever you want.
So I have a specific like I think the Bolton is Jones. There's a guy a goods to have already have contract before that, and that new guy will take over the shop now. In that quantum merit will work on, sir.
Quantum merit. If you are accepting it.
If you are accepting the quantum merit.
Quantum merit, there is one more case where it will come up. You cannot take benefit of goods unless you are responsible for it. You need to pay.
That's
so quasi contract it will come. It will come.
Okay. Anyways, they have to pay in some grounds.
Right. Indirectly it will have to. I'll continue off on.
So accepting. Okay.
There is no break now.
No break.
Indian contract. How we should study it, like all at a time, or we should break it.
Meaning units.
Yeah.
See, towards the exam you are there. You have to study everything now.
No, I'm not asking like not living it.
We are studying this third chapter now. Third unit now. We are forgetting when we come to fifth unit.
See, always you should do cumulative study. What do you mean by that? You should do first unit. You will go to second unit.
Revise the first.
Revise first and go to second.
We're coming here, the 8th, and we're going at the 9th, 8th. We're not getting the effective study here.
Why here what is happening?
Sir, many distractions. They'll be speaking around and not just speaking, but getting so many.
Okay, this I'll try to understand. You let me know after that what exactly is here.
Sir, also I have got my certified copies, so can I show you?
Well, probably if not today, I see you only, right?
Yes, sir.
Monday I'll be here only.
Back Olivio. Back. Come. Yes, people. The next topic is, people, appropriation of payment. What is appropriation of payment? So if A has taken 3 loans, say for example 1 lakh, 3 lakh and 5 lakh. If A has taken 3 loans, now A is repaying, let us imagine 2 lakhs. Appropriation of payment means, people, if I have taken more than one loan from one party and if I am repaying some money, I need to clearly tell out of the 3 contracts towards which contract I am repaying this 2 lakhs. Now this is called as what? Appropriation of payment. The first scenario, people, it will be given first priority to the debtor to choose. Meaning A can tell, I am repaying it to the 1 lakh, I am repaying it towards 3 lakh, I am repaying it towards 5 lakh. It is my option to choose. Now people, if A did not choose anything, let us imagine how much is A repaying, how much A is repaying, let us imagine A is repaying 3 lakh. Now A did not say anything towards which loan I am repaying. I just gave 3 lakh and I left. Towards which loan you will take? You will take it towards 3 lakh, because the second scenario is what circumstances prove it. You are giving 3 lakh. There is also a 3 lakh contract. So that means you will understand based on circumstances the 3 lakh loan is repaid towards the 3 lakh obligation. That's the second scenario. Third scenario, sir, I repaid not 3 lakh, I repaid 2 lakh only. A did not say anything, circumstances does not prove anything. The next right is with the creditor. B can take it towards any transaction. It can be first, second, third. Like?
How will you separate?
You're saying like 1 lakh like this, 3 lakh like that you're telling. That's what. Now for example, B.
Equally, is it proportionate or?
No, you think what will happen? B will always want to finish off whichever is the loan that was taken first. Because this will become time barred debt in a near time. So I will take towards everything on first loan first instead of splitting it equally. So for me, finishing it off one contract is always priority. Sir, when debtor silent, creditor silent, go with FIFO method. FIFO is what? First in, first out. Which was the first loan taken 1 lakh. So it will be taken towards that. Next will be 3 lakh taken towards that. Clear? Done. Next one, sir. Contracts which need not be performed. What are the contracts which are exempted, waived? What are that? The first one, people, discharge of a contract. Everything will come under the same thing. The first one is called as by performance. A delivered the Amazon parcel. Amazon delivered the parcel and the customer paid for it. Performance is done. Contract comes to an end. So contract is discharged. Next, mutual agreement. Mutually we sit and discuss that let us put an end to the contract. Mutual agreement is given in section 62. Under mutual agreement you will see 3 things. One is called as novation, rescission, alteration. Novation means what? Already there was an existing contract. In its place you will replace it with a new contract. Is called as what, people? Novation. Novation, there was already a contract. In that place now you will replace it with a new contract. Is called as what, people? Novation. Remember, whenever change of parties happen, A comes and gives money to ArivuPro and they will take CA Foundation admission. Because of some reason, A is not able to continue. And let us imagine Arivu has a policy that we won't refund the money. Let us imagine. Now what will A do? Sir, it's okay. I will bring my friend in my place. Can you continue with him? I will collect the money back from my friend. Is it okay? Arivu says we don't have a problem. So contract is same we already had. But now in that, instead of A's name, in attendance and all, we have to include B's name. So in a contract, when a party's name alone is changed, you call it as what? Novation. It can just be A striked off and B written. It can be as simple as that for you. But if a party changes, you have to always call it as novation and not alteration. Do not get confused. Is this clear? What is alteration? Apart from that, in the existing contract, anything else you change, date you change, or interest you change.
Changing the course.
Yes, you change. Sir, I got admissions to this. I do not want to do this. I want to do another course. It is called as alteration. But if parties change, it is always novation. And the last one is recession. Recession means what? Both of us agree mutually. Imagine we called for a CA foundation batch. Only one person came. We said it is not making sense for us. Is it okay if we cancel? That person also understands. We mutually end this contract. It's called as what? Recession. We won't do, but I'm telling. Yes, sir. I see you. Is it, huh?
Yes, they cancelled bail. Chennai IC was cancelled.
Oh, is it? How many students were there?
Everyone has been. We have applied for the 4 of them from command.
So you had applied it there first. Okay. What happened later?
No, there was no residence available for students to stay.
Okay, okay.
Shifted here.
Okay, okay.
They give you
Praveen is like, sir, ಬೇಕಿತ್ತ ನಿಮ್ಗೆ? ಇಲ್ಲ ಕಣ, I'm trying to understand. Because see, with regards to batch, I can tell you, I have only thought there is one course called CSEET. Yeah, entrance test. In one batch, only one student applied. This was right after COVID. Only one student. No online also. Only one student. He used to come. He was from a place which is little not familiar. I'll not take the place name, but not a little unfamiliar place. He comes, directly he'll come and sleep off. Directly. Every teacher, it was a test of their mental patience. He will directly come and he'll be like this. And after some 2 days or 3 days, some one student or something, they joined online. So we neither can shut down the camera. We can neither tell them, Macha, you read this and go da. Social obligation. So that time we remember the cost of running this for this one student. Crazy, you can imagine. I also went and thought, cost on the company will be definitely there. So that's why I said. But this one I got to know. Residential they're planning, but residential will make sure it will work when we have a complete support from the PGs and hostels. So there was one tie-up that we had, but due to some food issues, now for example, now if it is there, you said 130 also, it's okay sir, we'll have. You will have? It will be there somewhere with a hope that it might be there. You can question them and or something like that. But what if it is not ICU? Will we have after 130? You will not have, especially if it's imagine if it's a weekend and all. You have something special. Where will you have? So that I'm saying we were able to. Now the next batches we are trying to have Arivu hostels also. It's in the pipeline. Of course, when there are so many numbers, don't we see that? But it's a very big responsibility. Now, I'll sit here and you'll be saying, sir, those are fully hit it, sir. Should I do contract? Should I do ID bat? Okay. So that is revision. Next one is people remission. What do you mean remission, people? Remission means people nothing but we give up. We give up our rights. When you give up, then there is nothing that you need to perform. And people, next one, promisor need not perform when promisee neglects performance. What is this? Promisee neglects performance. The teacher comes with all the enthusiasm and teaches. The students neglects to study. The teacher is discharged from the performance. Correct? So what is negligence? Negligence means people in a contract, because of one party's mistake. Now imagine, I'll call a carpenter, I'll tell that, sir, I have some work in this premises, we need to do some 2-3 benches. Or imagine, carpenter beda. So those walls have to be painted. I will just book for a labor. The material will be supplied by me. But because of some reason, I failed to procure the material on time. He has come. Now I am there. I did not get the material. Should I pay him or not? It is my negligence that I did not supply the goods required. That is what they are saying. Promiser need not perform when promisee neglects performance. I did not supply. Should I charge him? Should I pay him? Answer is yes. I cannot escape from my liability. Yes or no? Next one. Impossibility by performance. Impossibility by performance is nothing but your initial impossibility or subsequent impossibility. Initial void agreement. Subsequent void contract. Discharge by lapse of time. Within time, if you have not done, time bar debt also will come into picture. By operation of law, Gujarat becomes a dry state. Law only is putting an end to a contract. That contract need not be performed. Breach of contract, of course, is the next unit. Merger of rights is, what is merger of rights? Let us imagine A enters into a contract with B for renting a particular property as a tenant. A is a tenant. Now, Arivu is a tenant in this building. Now, Vastu became so good, it worked out really good for Arivu. Yes, sir, this was the first class. So, if Vastu became really good, Arivu puts a proposal to the building landlord. Sir, do one thing, you sell off this land. You give this particular building for us. We will pay you how much ever we want. Now, the tenancy we have, the rental agreement we have with him is 5 years. It's a lease. Now, in the third year, we are telling them, sir, sell off the land to us only. Because it is crazily working. I mean, imagine. It's not. Simply. Drishti. Yes, imagine it is not working. Now, people, we are doing this particular thing with the landlord and they says, okay. So, we end up buying this particular property. When? In the third year only. Now, people technically you see, A is a tenant. A is also the owner of this property. We call such a scenario as merger of rights. When two capacities collide, we call it as merger of rights. In such case, which one will prevail? Anything which is superior will prevail. Tenant is superior or landlord is superior? You will be treated as landlord. Tenancy will come to an end. Understood? Done. Next one, unit 5. Breach of contract. This ICU is available for inter also. Inter, proposal irukku. Should see. Okay. Types of breach. Actual breach, anticipatory breach. What is actual? During the performance. People, class is going on. A said didn't work. We got irritated. I said, hey, go on. I'll leave the class and go. Yes, I don't know if you guys have seen. There is one teacher, while the class is going on, the audio became very popular also. The teacher starts venting out all her, unvented emotions. She will start telling what management you are all, what principal you are all during the class. So, what is actual performance? When the contract is going on, when the class is going on, she gets irritated. She will cancel the contract during the class is going on. Now, what will you call such contract as? Actual breach. When the contract is going on. Imagine the painter came, half building painted, and he did gutka. Hey, goda. Now, during performance, actual performance. Correct? No. Next one is called as anticipatory. What is anticipatory? He's about to come. From there on he was coming like this. I said, hey, goda. It's called as what? Anticipatory breach. What is anticipatory? You can foresee it. So, for example, when was your batch about to start? So, when did they communicate it is not Chennai and Bangalore?
2 days. 2 days.
This is called as what, people? Anticipatory breach. What if they had told you on that day only? It is called as actual breach. Hey, but I should not explain this remedies for them, da? Okay. Yes, people. So, what are the remedies? If at all there is a breach, what are the remedies? Remedies are suit for damages. Hey, unlisten. Don't listen. Don't pay attention. Okay, suit for damages. What is suit for damages? The first one is general or ordinary damages. What is that? Now, we have clearly told you what is our purpose. If that purpose is not met, for that, whatever I need to pay, I will pay. Example here was Hadley versus Baxendale. There will be a floor mill. Imagine like one big plant and machinery. In that one rod will be there. that rod will not be working. So that rod's name is called as crankshaft. The crankshaft has to be repaired. No one in Bangalore will repair. We have to give it to Mysore, Pakkad the city. So how to take it there? It is happening in 19th century. So we have to go to one middleman who can take it to Mysore, get it repaired and bring it back to us. We asked him, how much time do you want to go give it there and bring it back? Forget about repair time. He said, I need 2 days to give and get back. Okay, then we agreed to give our, that crankshaft to repair to this person to take it to Mysore. Now people, after giving it, this person actually took 10 days to give it and deliver it back. There was no mistake from the service person. All mistake was this person's only. He did not do it on time. Now people, in this case, we want to file a case on this delivery agent, that is a courier company. We filed a case that because of you not giving us that rod within time, 10 days our factory was shut. Every day we will do a revenue of 5,000. So you have to pay us a compensation of 5,000 into 10 days, 50,000. Whether you will win the case or not. 8 days, correct. Yes. 8 days into 5,000, 40,000 discount. Whether you will win or not. No? Why?
He hasn't specified that he wants to earn.
So people, now the question is simple. Was this delivery guy aware that if at all I do not deliver this crankshaft to you on time, your factory will be shut? Was I aware of it? If the answer is yes, I was aware, it will be called as special damages. You have said special circumstances. I can hold you liable for that also. When special circumstances are not communicated, then you can hold him liable only for poor performance. The poor performance is, instead of taking 2, you took 10 days. For that I can hold you liable. What? Free delivery plus 1,000 rupees extra as compensation. That is okay. That is called ordinary damages. Special will come when there are special circumstances communicated. Praveen telling it is my marriage suit. Marriage suit noda. It's a special circumstance. Agreed? Okay. Next one people, vindictive or exemplary. What is vindictive or exemplary? Now people, because Praveen did not get his suit, Praveen said I will not get married at all. Now the girl went into depression. Girl wants to take revenge on Praveen. Can she file a case? In this case now can you file? Yes, the vindictive can be filed only in that case. In no other case. When failure to marry and wrongful dishonor of a check is the only ground on which you can file vindictive or exemplary. People, last bench Uttar Pradesh people, they are very far. Okay. Now people, remember vindictive or exemplary. Vindictive itself means revenger. Revenger. If you say that I will not get married on the day of marriage means, will she leave? Yesterday I was seeing one dispute. The girl is asking for maintenance. The girl is asking for 4 crore maintenance, and there are cars also with boy. She is asking for specifically BMW model should be given to me. It is given. It's a legal suit. Court hearings are there. You can see that. She is asking that I want BMW car and 4 crore compensation. Yes, alimony. Maintenance and alimonies. Nice, no? Okay. Now people, vindictive or exemplary damages, it can be only claimed when a breach of promise to marry, Praveen, wrongful dishonor of customer check. In my account, there is money. Hence, I gave a check. When the check was deposited in the bank said, Ayo, this person, no money in the account. My izzat, where is my respect? No respect. The banker is telling this account does not have funds. In the business circle, will they believe you? That's why you are taking revenge on the banker. That's why it's called vindictive. Even after having money in the bank, you are saying that the money doesn't exist. I can file a case on you for vindictive damages. Understood? Pakka na? Next one is called as nominal damages. Praveen ordered suit on Myntra casually. In everyday wedding, is an event planner or what? Now people, So he casually ordered. The suit was delivered the next day. Can he file a case on them? Can he file a case? It should have been delivered today, but it was delivered tomorrow. Can he file? Yes, time is not essential. You can still file compensation, but you cannot cancel the contract. Now they will give damages. How much? Even 1 rupee is also a damage only. If you actually read the law, Bare Act, even 10 paise is also considered as valid compensation. But of course for today 10 paise, I know it is not relevant, but it is a Bare Act. So they will give you something just to shantify your anger. Correct? You will be very angry, no? They will take little water and they will sprinkle on you. Tush, go. Understood? Yes or not? So nominal damage is nothing but people just to satisfy your anger. Something they are giving it to you. 10 rupees is also nominal damage. Sir, illa, we didn't understand. Imagine people, you order some dosa on Swiggy. Say that chutney is stale. They will give you back some 30 rupees, 20 rupees, 50 rupees. Or you say, on Swiggy, I don't know if you guys haven't, I don't know if you guys have tried it. You can complain on portion. You can click a picture and say, the portion in the picture and the portion that they have supplied is not matching. Don't exploit them. But when it is relevant, you can claim it. I think in class I had shown one paneer thing. I had ordered one, 3 pieces of paneer they have given. In that picture, paneer is outflowing. We should stop it from our hand. So I had taken picture. It is not matching the portion size. So you get a refund, but they cannot give you completely. They will give you some amount. Correct, no? That is called nominal, just to satisfy you. Next one is people, deterioration caused by delay. What is deterioration caused by delay? While he is coming, while he is on the way, the food is spoiled. In such case, what will happen? Who will bear the risk? If it is due to the default of the carrier, carrier will bear the risk. If it is default of the carrier, carrier will bear the risk. But there are some deliveries that you know it will spoil. And if you still order, then the risk is on the buyer. Example, sir, you guys order ice cream on Zomato. You do not need an Einstein brain to know that it will melt. You can't say I ordered ice cream, I got milkshake. It is inherent. Ice cream will melt. Any inherent risk will always be on the buyer. They will make their best thing to make sure you get ice cream only. But milkshake is a byproduct. Correct? Okay, next one is prefixed damages. One more. What is prefixed damages, people? What is prefixed? A has ordered some 1,000 shirts from B. The total contract value was, people, say for example 1 lakh rupees. One shirt was costing 100 rupees. Now this contract was given to B. B had to deliver it in 10 days. Now what happened, people? In the contract it is clearly given that if at any given point of time, if you are not able to deliver the shirt, failure, breach of contract, then the compensation, people, will be 10,000 rupees. It is written in my contract only. Now people, if at all there is a so if at all there is a compensation which I need to pay, now I need not have to figure out what is my compensation. Compensation is clearly written in the contract only, that if I fail to deliver, my compensation I need to pay is 10,000 rupees. It is written. Now this is only called as, people, prefixed damages. You know if you fail what you need to pay. Clear? Now imagine contract value is 1 lakh. Compensation is 10,000. Meaning what, sir? Let us imagine in your campus, they have put a notice board in your campus. If at all anyone is seen using your phone, we will charge a fine of 100 rupees from you. How your behavior will be? 100 done. So what? Correct? Yes, what if the amount becomes 500? Little scared. What if they put 10,000? What if they say direct phone to parent? Sir, gada. Correct? Yes, no. Now people remember, don't you think notice is not changing? People, notice is not changing. 500, 100, 50,000, 10,000, 50,000 parent direct call. Notice is the same. Communication is the same. Don't use phone. But the way you look at the notice is changing depending upon the amount there. Remember, we call it as prefixed damages as long as they are reasonable. If the amount in the prefixed damages is becoming very high, what is the logic? No logic, but it is very high. Sir, 10,000 is becoming 50,000. Sir, contract value is 1 lakh. Compensation will also be 1 lakh. Now, the way you look at the compensation will differ. Now, the same amount will be called as what? Penalty. Meaning what? The amount is same. Amount is not changing. But the reason for you putting that amount is to make him constantly think, if you miss, I will come in your dreams and haunt you. 1 lakh. It is creating sense of fear in you. That's why the law uses the word called as terrorum. The purpose of writing 1 lakh is not for compensation. It is to induce fear in you. If you miss, you are gone. That is what is the difference between prefixed damages, especially liquidated damages and penalty. Don't get confused. They are not two different things. They are both written in your contract first only. But the difference is the value reasonable or is the value nowhere, unreasonable? Reasonable, you call it as liquidated damages. Unreasonable, you call it as penalty. What is the purpose of having penalty? It is to create sense of fear, terrorum. Clear? Pakka na? Sir, in the court, what will we get? Is it, now imagine, now B did not supply the goods. Yeah, now because B did not supply the goods, A had to go and get the shirts from C. How much did C charge? C charged 1,05,000 for the same 1,000 shirts. Now how much money I had to pay extra? If at all B only had given, my contract value was 1 lakh. Now because I went to C, I had to pay 1,05,000. Now actual loss that has occurred to me is how much? 5,000. Now when I am filing a case on B to recover money, how much will I get? In my contract it is written 10,000. But actually I have suffered a losses 5,000. How much will I get now? Will I get 1,000 or 5,000? I mean 10,000 or 5,000? But in my contract we have written 10,000, right? Remember, court is not here to give you profit. Court is here to give you what you have suffered for. Hey, what are you doing? Go. Okay, understood? Even though we have written 10,000, Macha, if I give 10,000, court became a place of profit for you. Court is a place of justice, not profit. Justice is 5k, not 10k. Hello? What if C charged 1,25,000 from me? How much will court give you? 25,000 for 10,000. In my contract we have written 10,000. The loss I have suffered is 25,000. Will I get 10,000 or 25,000? Why? What I have suffered is 25 now. Court will tell, then you should think it proper. Why did you tell that maximum you will collect is 10,000 in your contract? Macha, it is not there. But for us I am writing. Always remember, agreed compensation, that is in your contract. Agreed loss versus actual loss. Agreed versus actual loss, whichever is less. If agreed is less, you will get agreed. If actual is less, you will get actual. Clear? Done? Okay, done. Next one, people. Contingent and quasi contracts. What is a contingent contract? That is quasi contract. Contingent means, people, a contingent contract is a contract which may happen or may not happen. You are not sure. Any example for contingent contracts? Insurance is not a contingent contract. Why? Why insurance is not a contingent contract? Now I take an insurance on my bike. If I meet with an accident, you need to pay the damages. So me meeting with an accident is certain. I'll pakka meet with an accident. So insurance is the actual example of contingent contract. Yes, sir. Tell me. Tell. Doubt should be first told. Huh? Processing. Okay. Oh, we saw only suit for damages. We didn't see other suits. Okay, sorry. Sorry. Yeah. Rescission of contract. Rescission of contract, people. Of course, other damages are there. What are rescission of contract means? You can cancel the contract when the person does not. For example, we saw it in the case of Praveen. If the person does not give the suit within time, that is when time is essential, he has a right to cancel the contract. He can cancel the contract, claim compensation. Suit for specific performance. Very good. Whenever the contract is involving any rare, unique or irreplaceable feature, or you have some emotional attachment over the product, in such case, compensation can never be money. What do you mean by that? Let us imagine A entered into a contract with B to buy one antique item, which is never, ever or rarely available in the market. You will not get it. Now B said, I do not want to sell it after the contract is made. Now A will file a case on B. For what? Technically breach of contract. You should get money. But because it is antique item, A can tell, Your Honor, I do not want compensation. I want the antique item only because I will not get it anywhere else. When a product is of some special importance, or it is of some special nature, or you have some emotional quotient attached to it, in such case, you can demand for specific performance. Next one, sir. Suit for injunction. What is injunction? Stay order. Meaning you can see it in buildings and all. The building will be done, but there will be a dispute. A and B. Dispute is going on over a land. A silently is constructing building also there. B will go and get an injunction order. Sir, case is going on. Tell him to stop from construction. Because we do not know who will win it. He's already started constructing a land on it. So court passes an order. That order is called as what? Injunction order. Injunction order is nothing but a remedy. Asking for you to stop the other person from doing whatever he is doing. Clear? Okay. Next one, people. Suit for quantum merit. What is suit for quantum merit? You take this entire room. We asked that person to paint, no? Yes or no? That is what? Half room he paint and then he used. Correct, no? So we said, hey, walk out. Should we pay him something or not?
Yeah.
Should we pay him?
Yes.
Should we pay him?
Yes.
Should we? Yes, people, because suit for quantum merit is nothing but you have to at least pay for as much as he has performed. He has not painted the whole class, correct? But has he painted at least half of the class? Answer is yes. You need to pay at least for that. Sir, what if he had already painted the full class, but sloppy work? Here and there he has done pan masala too. Now? So, for that I need to again spend one more can of paint. I have to deduct the amount to fix the damages. Whatever it is, I need to deduct it and pay it. Correct? Now, this is only called as what? If the contract is indivisible, of course, in this case what has happened? If at all the contract is done, the wall is done. Now he has done the painting, how can I deduct it? When the contract is indivisible, whatever is the money you need to incur to fix those things, get it fixed, that money you can deduct it. If it is divisible, half and half. How much ever he has performed, pay for that. Correct? Hello? Okay. Divisible and indivisible. Okay. Next one, sir. Contingent contract. A contract to do or not to do something. If some event collateral to such contract does or does not happen is called as what, people? Contingent contract. Now contingent contract means people it's nothing but an uncertain event. Agreed? Examples for contingent contract people, one is indemnity contract, one is guarantee contract. Indemnity contracts means people in a contract, indemnity contract is a contract in which one party agrees to indemnify the other person if at all he suffers with any loss. One party agrees to indemnify the other party to pay some money if you have suffered any loss. Indemnify means what? Make good the loss. If you have suffered any loss, I will make it good, don't worry. Examples are bike insurance. I am taking, A is taking an insurance from some ICICI. You have taken one insurance. If at all I meet with an accident, ICICI is giving me a promise that don't worry, whatever is a loss you suffer, I will make good the loss. I will pay for it. They are making a promise, no? Yes or no? Now people, this person is called as indemnifier. The person whose loss is making good, we call him as indemnified. Next unit we will get this insurance contract and all in detail. We have indemnity contracts and guarantee contracts. Correct? So there we'll be seeing more about it. Rules relating to the enforcement of contingent contracts. What are the rules relating to enforcement of contingent contracts? When is an insurance contract, when is it enforceable? When is an insurance contract even enforceable? When event happens? Okay, see here, on an event happening, meaning what, sir? Let us imagine two things. Let us imagine we have okay, first one, let us imagine we'll take an example of contingent contract, that is guarantee contracts. Now what is guarantee contracts? Let us take for example, A wants to borrow some loan from ICICI Bank. Now A said, sir, I want to enter into a loan agreement. ICICI took a paper, they all documented everything. ICICI said, sir, we will give you what, how much you want, 10 crore loan, we will give it to you. But you have to give us something called as collateral. Meaning you are taking 10 crore loan, what if you do not repay? We should have something called security. So give us some collateral. A says, sir, I do not have anything collateral now. Do one thing, I am importing some goods from Dubai. It is coming in the ship. It is coming in the ship. Sir, okay, ICICI Bank agreed one thing. Sir, do one thing. Let the ship come. We will keep the documentation ready. Now, whatever the goods you said, when it comes to India, you give it to us. Based on that, we will give you this loan. If at all a contract is entered between two parties, based on this scenario, now the ship has to come. In that, our goods are there. If the goods reach safely, I will get my loan. Agreed? Yes, sir. Now, when will I enforce a contract? Meaning, when will I get the loan? The ship has to arrive safely. Agreed? What if the ship sinks? What if the ship burns? The contract, meaning the ship will never reach. That means the condition is never met. Sir, what will happen to the contract? The contract will become void. Impossibility of performance. A ship that is sinking. In sinking, like that only sinking, it will come to India, na? No, it will sink there only, where it is sinking. So the ship can never return. So we call it as people void contract. So what is enforceability here? When can I go and ask for the money? You can go and ask for the money, people, whenever the ship reaches safely. That is the first way where you can enforce your contingent contract on an event happening. What is the event happening here? The ship reaching safely. So what if they put a time period also? The ship has to come in 10 days only. The ship has to come within the fixed time. If it comes after that, it is considered as a void contract. Yes or no? Now if we have a doubt, sir, if it is so uncertain that ship will come or not, to be safe, what should we do? Go and take an insurance contract. What is the insurance contract? Sir, whatever my consignment is coming, if it does not reach me, you will have to pay me money. Is it okay? Now insurance company will say okay. Now you tell me, if ship doesn't come, what will happen to the contract? We have taken an insurance contract. Sir, if ship doesn't come, you need to give me money. If ship doesn't come or if ship sinks, what will happen? Insurance company will give you money. That is what they're telling you. On an event not happening, a ship not reaching safely, you can enforce a contract. It can be enforced when event only becomes impossible. Ship sinks. Correct? Sir, next one. On an event not happening within fixed time, I am taking an insurance contract for 1 month. If it does not reach within 1 month, I can hold you accountable. I can ask you for money. Understood? So remember these two things with guarantee. Remember these two things with insurance. You will be able to recollect easily. In a guarantee contract, if the ship sinks, you called it as a void contract. In an insurance contract, if a ship sinks, it will become a valid contract. It will be enforceable at that point, immediately. Correct? Yes, sir. Okay. Impossible event possible. No. Initial impossibility, void agreement. Subsequent is void contract. Upon conduct of a living person, we will do it when we are doing sale of goods act. What is this living person? We'll be discussing more in detail there. Sir, quasi contract. What is a quasi contract, people? What is a quasi contract? See, contract means we know. Quasi means what? The word quasi means, people, something similar to. Meaning, sir, it's not a contract, but it is similar to a contract. Why are we not calling it as a contract? Because
It is not made with the legal intention.
you do not have, probably there is no writing. You might have not discussed anything with regards to consideration. Nothing is agreed, but still we are calling it as a contract. When law has said that it is a contract. Example of quasi contracts? Finder of lost goods. If you find a purse on the road, what will you do? Depends, sir, if I am walking alone or if people are there. If I am walking alone, then it is mine. If people are there, correct? No, that is only called as quasi contract. You are under an obligation to return it to the owner. Where is it written? Is it written in the purse? No, then that is what is called as quasi contract. Law says that if at all you are finding a goods, you need to return it to the owner. Case law. One case law is there. What is the case law? Finder of lost goods. There is a case law. Holland versus Howler. What is the case law? Diamond case. In front of a hotel, one customer finds a diamond. A finds a diamond. A go and he gives it to the cashier. Sir, I found a diamond in your hotel. Whenever the person comes, please return it to him. Cashier took it. Papa, cashier printed it also in one flyers, pamphlets and all. All over the hotel he has pasted. If you can prove it with evidence that this diamond is yours, you can please collect it at this particular place. Now this customer, after some 10 days he went. He asked, sir, did you find the owner? He said, no sir, no one came. After 30 days he went. He asked, sir, anyone came? No sir. So the customer finally said, sir, because anyone is not coming, then give back the diamond to me. The cashier said, how can I give it to you? It is not yours. Now they both are fighting. Customer and cashier. Who should keep the diamond? Customer only. Why? The law says whoever finds it will become the first owner. Just that if at all cashier has incurred any expense to find the owner, that expenses you need to repay. So the printing charges, whatever it is, you repay. After that, people, that diamond will be kept by you. Until when and all, we will see when we are doing finder of lost goods. Clear? When will finder of lost goods come? Bailment. That entire part will be doing it there. Clear? Okay. Okay, quasi contract, right is for money. There is no agreement. Rights available against particular person. What are the cases deemed as quasi contract? One is people claim for necessaries, minor, even though you have agreed or not. And even remember, their dependents also are covered. Their dependents are also covered. Meaning what? If there is a minor, on the minor, there is one grandmother who is dependent on that person. So there is A who is helping B. B is a minor. With minor's education, there is a grandmother that is dependent on this minor. She is 92, 93-year-old. This person is supplying medicine to her also. They're telling B is liable for both. That is your education as well as your dependents' necessities. But personally, yeah, Allah, that is same. How much? Up to the extent of your estate, inherited or assets. Clear? Yes, okay, next one. Payment by interested person. What is payment by interested person? Now, for example, people, you can imagine like this. This property, every year they need to pay property tax. If any year property tax is not paid, authorities will come and seize the property. Now, the property tax can be, say, for example, some 50,000 rupees. If property tax is not paid by the owner, this property will be seized. Now, owner only will suffer, huh? We will also suffer, no? What will Arivu do? Arivu will pay the property tax. Technically, who should pay? Owner has to pay. So, what do? We will deduct it in the rent we pay. The owner is telling, hey, how will you deduct it? You have to give me complete rent. We said, sir, it is you who had to pay. We paid on your behalf. He will say, did I ask you to pay? Why did you pay? The law will say, we are allowed to pay. Do not take it as voluntary. In this property, how much ever interest you have, even I have some interest because my classes are also running here. It will cause inconvenience to me also. If I make any payment on your behalf, I have a right to collect it from you later on. That is only called as payment made by an interested person. Arivu can recover the money from landowner. But did we agree on this before? No. But still can I recover? Yes. Next one, person enjoying benefits of non-gratuitous act. Meaning what, people? Now someone will come and say there, sir, there is a Zomato parcel for some person called as Deepak. Now in one class there can be 2 Deepaks, 3 Deepaks, possible, Now one Deepak will go and tell, Deepak, oh me only, give. He starts eating. Now can you do it? No. With Zomato order will come to you free of cost. If you have taken benefit, you have to pay for it. You can't say, did I ask you, why did you give it to me? Correct? People, this is where that will come. What? Glass cleaning. So, that person is doing for money, it is your duty to stop. Even after doing that, if they are doing, it's a different story. But you have to stop. Correct? Next one, finder of lawsuits will be doing it. Money paid by mistake. We have color, which color notes? Thinking of green, I gave blue. 20 rupees became 100 rupees. I don't know, now it is okay. Initially when it came, this was happening. Correct? No. When you paid extra, in such case, what will happen? Someone who has taken the extra money cannot say, hey, did I ask you to pay 100? You paid and went, go. You have a right to recover it. Money paid by mistake, you have a right to recover it. Clear? Yes, sir? Okay. Indemnity guarantee. Okay, fair enough. I think for today we'll end it up here. Tomorrow you guys again have class. I think you have it from 4. That's what they have said? Okay, 4 to 8:30. Okay, tomorrow we'll do it from 4 to 8:30. Okay, done. We'll catch up 4 to 8:30. Revise and come, read and come, so that you will connect better. Yeah? Yes, people. Good evening. Revise something yesterday. AC remote is with you. Turn it on. Okay. Online able to see here? Audible? Okay, done. So we were doing the Indian Contract Act. Let us continue with what? Unit 7. Did you guys revise or go through, or what is the status? Yes, okay. So before coming to any marathon, always revise and come so that you can understand better. Yeah, okay. So the next one, people, contract of indemnity and guarantee. We had started yesterday one contract called as contingent contract. Always remember, examples of a contingent contract is indemnity contract and guarantee contract. Indemnity contract example is called insurance contract. Agreed? Okay. So what do you mean by a contract of indemnity? A contract where one party promises to save other from any loss due to conduct of promisor himself or any other person. Meaning, if I only make something, because of that if you suffer any loss, I'm telling I'll pay you money. What do you mean by that? A enters into a contract with B. Let us imagine A and B. A is a supplier and B is a retailer. Now, I've clearly told, A has told to B that you take up contracts from customers. Now, if they want any bulk orders and all, you take up the order. That I will supply it to you, you can supply it to them. In this contract, if you suffer any loss, don't worry, I will be there. If A has specifically told this to B, and this is also called as what? Indemnity contract. So people will keep asking any other example for indemnity contract apart from insurance contract. Now this is also an indemnity contract only, where one person is clearly telling that if you suffer some loss, I will take care of that loss. I will make good that loss. Agreed? That is the meaning of promisor himself. If I only suffer, because of me only if you suffer some loss, I will pay. Or any other person makes anything to you, because of that if you suffer loss, for that also I will pay. The best example for any other person is insurance contract. Accident can be done by some other person, but I will pay for it. That is a insurance contract again. Understood all of you? Yes? Okay. Next one, parties in an indemnity contract. Indemnifier, meaning the person who is giving you the money, making good the loss, basically insurance company. Next one is indemnity holder or indemnified, the person, insurance holder. Special points, mode of conduct, it can be express or implied, because this can be implied. LIC not considered as indemnity, meaning life insurance contract cannot be considered as indemnity contracts. Why?
Because we cannot equal it.
You cannot compensate the life, right? Only money is possible. So what is an indemnity contract? Someone making good the loss is an indemnity contract. How will you make good the loss if a person is passing out? That is not possible, right? That's why life insurance is not a indemnity contract. Next one, it must fulfill all the other essential elements of valid contract, of course. Rights of indemnity holder when sued to recover from promisor. They can ask you a question here. They've asked this 2-3 times. That is, imagine people have taken an insurance policy. I met with an accident. I asked for the money from my insurance company. They did not pay. Now, what and all rights do I have as an indemnity holder? See, if you had given me money here only, that was the most easiest of all. Did you pay me money here? Answer is no. Now, because of that, I had to go to court and all. Agreed. Now, I have incurred more cost, lawyer expenses, mental trauma. What is mental trauma? Sir, we know Reliance Chroma. Mental trauma. Mental trauma means nothing but people, you had to suffer a lot of pressure, stress because of this entire scenario. And law will always quantify that. The court will quantify that. And based on that also, you will be given some money. That is what they are telling you. Rights of indemnity holder when sued to recover from promisor. What and all I can take from the insurance company. First one, damages compelled to pay in any suit. What do you mean by this? Meaning, if the court is clearly telling me that you have to pay compensation of, let us imagine, if the insurance contract is 40,000, the court will order people 40,000 plus mental trauma, another 10,000. Plus, what about my legal expenses? I have to pay my court fees, my lawyer, that all I will pay. Add another 5,000. So, sir, you could have settled it for 40 because you did not do it. Now, this person is entitled for 55,000. Understood? So, whatever I need to pay as per the contract, plus compensation, that is damages, plus any other additional costs like court fees, advocate fees, lawyer fees, as the case may be. Clear? Yes, done. Contract of guarantee. The next type of contract is contract of guarantee. In contract of guarantee, how many types of parties are there? How many parties are there? There are three parties. What is contract of guarantee? There is one borrower, there is one creditor. The creditor gives a borrower some money, whatever he wants to borrow. This entire contract has been given a surety by third party. We say that if the borrower doesn't pay, we will pay. Now this whole contract is called as what people? Contract of guarantee. So in a contract of guarantee, three people exist. That is, one is principal debtor. Principal debtor is a person who is borrowing the money. Next one is a creditor, the person who is giving the money, generally banks. The third party is a surety, the person who has given the guarantee. Now in the guarantee contract, how many contracts actually exist? 2 or 3? How many contracts actually exist in guaranteeing contract? 3, 3, So people, one contract is between the debtor and the creditor. That's a contract number 1. The second contract is between the creditor and the guarantee. This is the contract number 2. Now where is the contract number 3? The contract number 3 is people, if at all principal debtor is not paying the money, who should pay? Surety should pay. Hey, why should he pay for the loan you have taken? Today he will pay on a good note, on a goodwill. Because he has agreed to pay, he will pay. Papa, good fellow he is. But don't you think you are very bad person because for your loan you are making the other person pay? Isn't it your moral responsibility to repay the money? So this is called as third contract. That is called as implied contract. Someone who has paid money on your behalf, it is your duty to pay. And you have to make good that particular money that he has paid. And that's the third contract. That is called as implied contract. Understood? Principal contract is between debtor and creditor. Secondary contract is between creditor and surety. The third contract is between surety and the principal debtor. So I can recover the money I have paid. And what is this principal called as? The surety, if he is paying the money on behalf of the principal debtor, the surety can recover that money it seems. What is this principal called as? What is this process called as? Recovering the money from the principal debtor. Subrogation. What do you mean by subrogation? Once, if the surety is repaying the money, surety is paying the money to the creditor. I have the money, I have the right to recover it from the principal debtor. No. This process is called as subrogation. What do you mean by subrogation? The surety will be now treated as a creditor. What is subrogation? Subrogation means one person stepping into the shoes of someone else. Like Chandramukhi. She comes into someone else, no? Correct or no? Now is it Jyotika or Lakalaka? She is Lakalaka. Yes or no? Now that is what they are telling here. You will, once a person is stepping into someone else's shoes, that process is called as subrogation. The surety will be now getting into the shoes of creditor. The law will recognize you as a creditor who has given money to the borrower, which you can recover. Understood? Hello. Hello. Next one, essential features of a guarantee. In guarantee, what are the essential features? First one, existence of a principal debtor. Of course, if there is no borrower, obviously it is not possible. Consideration. Guarantee without consideration is void, but no need of any direct consideration between surety and creditor. Agreed? No. Tomorrow, creditor should not say, hey, surety will tell no. If principal debtor did not pay money, the creditor will directly go to surety. The surety will say, hey, what am I getting from you? Our contract, there is no quid pro quo. Why should I pay you money? That's what they're telling you. Direct consideration is not there, but consideration may move from promisee or any other person. Chinnaya versus Ramaya. Agreed? Yes, sir. People, can surety be a minor? Can a principal letter be a minor? Possible? Principal letter. Is it? Where did we see? We saw it there also, where the rules of minor contracts, we saw whenever there is two things we saw. If at all there is a joint loan, major and minor takes it. the major will be liable. In second thing, if the minor is a principal debtor and if the major is a surety, the major will be liable. Correct? 100%. Agreed. That is what we are seeing here. Surety is incompetent. Surety cannot be a guarantee, but surety can be a principal debtor provided the guarantee is given by the major. Agreed? Existence of liability, meaning, of course, surety to come into picture, there should be a loan. Without it, it cannot happen, and that loan should not be time barred. Yes. Okay. Next one. No misrepresentation or concealment. What is a misrepresentation or concealment? The principal debtor or the creditor should have not hidden any facts. What do you mean hidden any facts? A has taken some, okay, let us imagine this person is an employer. He's an employer. Now this person is an employee. Generally in some companies, people, you should always get into a company only with reference. Without reference, they will not take you. Sir, give us an example. Articleships. You guys will get into articleship. So they will there are so many people. Now you guys will message, sir, if there is any articleship, let us know. Now I'll only place people in my closed circles. Of course, we have friends. Same thing only, no. When we pass, they will also pass. Now they have their own partnership firms. They are working there. Wherever possible, on my Insta, I'll be posting ads. Whoever is interested, take it. And in some place, I will try to make sure I personally place them also. That is also there. And there are resumes where I only tell, give this person, weightage. This person is good. So I would have personally put a word on behalf of them. Agreed, Now people, this is also called as what? Guarantee only. Now, one day what happened, one employer told one of the student, hey, you have to go and get a declaration from your teacher that you are a good person. What do we know? They'll come, we'll sign, hey, yes, he's a good fellow. What else I'll know? I'll know you for 4 hours of sitting inside the class. Every document we'll sign, we'll send. Correct? No. But this one fellow, he went there, he started doing a little drama there. He'll not come once in a while, he'll not come. He started taking an advantage of all of that. Now, the person also will take their time. After some days, my friend directly called, hey, this person is not good. You sent a wrong fellow. I was like, ayyo. I think they did not say that, you're liable, you're accountable, all that. But now don't you think next time when I send a person, will he be received, will she be received with the same trust? No. Correct, no? So, what is misrepresentation or concealment, people? Let us imagine, if an employer has told his employee, you go and get a declaration. Now, my question, why did this person send him? Because in the previous month, this person has messed up one particular accounts. By preparing, his work is already bad. He is not working properly. He has done some misappropriation, meaning what? Going in a cab. The bill is 400, changing it to 600. Now, do you know all of this as an employer? Yes. Now, after knowing everything, you sent him to me to get a declaration. Now, I don't know any of these. Isn't it your duty to tell your student already has been working with me for the last 1 month? We have come across some scenarios like this. That's why we are sending him for a personal guarantee. Isn't it your duty to tell? Now, if you do not tell it, people, this is called as concealment. You should not conceal any facts while taking these guarantees. If you conceal, I will not be liable. You cannot hold me liable. Agreed? That is what they are telling you. Next one, need not be in writing. Oral is also valid, but of course depends upon different acts you guys are referring. Guarantee is not valid until some other person joins as co-surety if such condition is imposed by surety. What is that? If surety is telling, alone I do not want to give it. It is your duty as an employer to ask one more person's surety also. Alone I don't want to do this. If this condition is there, my liability will not come until another co-surety joins. If I have put that condition, clearly that there should be at least one more co-surety with me. Until that person joins, I will not be considered liable. Simple. Any doubts here? Done. Next one, types of guarantee. What are types of guarantee? There are two types of guarantee. One is called as specific guarantee. Next one is called as continuing guarantee. What is specific guarantee? Now let us imagine specific guarantee means, people, whenever a person specifically says A is borrowing money from ICICI Bank, one transaction, this transaction worth is 10 lakh rupees. For this transaction, only for this transaction, I am giving a guarantee. I will be considered as a person giving a specific guarantee. Only one transaction. This is done, my guarantee is done. The next one is called as, people, continuing guarantee. What do you mean by continuing guarantee? I will give a guarantee to a creditor saying that now this borrower may take money from you how many ever times it is possible. You give it so many times, but up to 1 year. In this 1 year, you keep on giving whenever he wants money. Generally, when will this happen, sir? It will happen in business transactions. So you keep on giving it up to 1 year, whatever the loan transactions. For that entire transaction, I will be liable. After 1 year, I will not be liable. Now, such type of contracts is called as what, people? Contract of continuing guarantee. Now, can you revoke continuing guarantee? Can you revoke continuing or a specific guarantee? Revoke means what? I have given. Now, can I take it back? Is it possible to take back a guarantee? Is it possible? How is it possible? Possible. Revocation possible. Remember, specific guarantee, can you revoke? Specific or continuing, people, only thing is the event should have not yet happened. If the loan is already given, machai or late, you cannot revoke, it is done. So you can revoke only those transactions which has not yet occurred or happened. So specific guarantee, let us imagine if the event has happened, loan is given, you cannot revoke. Loan is not yet given, it can be revoked. Second scenario, continuing guarantee, can I revoke? Same thing, if it has already happened, you cannot revoke. If it is not yet happened, you can revoke. However, remember, sir, I gave a contract for 1 year, guarantee was for 1 year. Sir, after 3 months, I would want to revoke. Is it possible? Whatever has happened in 3 months, not possible. Whatever is supposed to happen in 9 months, this can be revoked. Future transactions can be revoked. The past transactions cannot be revoked. Understood? All of you? Okay. Nature and extent of surety is liability. Surety is liable to what amount? Surety is liable coextensive with principal letter. What do you mean by that? If principal letter is liable for 6 lakh, surety is also liable for 6 lakh. The 6 lakh can be 4 lakh principal, 2 lakh interest. I will also be liable like that only. Sir, in the 6 lakh, what if the principal letter has already repaid 1 lakh? Even my liability will also reduce by 1 lakh. So my liability will also be now 5 lakh. That is the meaning of coextensive. Coextensive means whatever is his, mine also will be equivalent. Clear? Okay, next one. Liability of surety is secondary in nature. Agreed? Why is it called as secondary? Perfect. Primary liability is always on the principal letter. If he doesn't pay, I need to pay. No? That's why it's called secondary. Third one. Liability arises immediately on default by principal letter. What do you mean by that? I will wait until the maturity date on which the principal letter has to pay. On that day he has not paid. Now it is my duty, my wish. If I want, I'll come and ask money from debtor. If I want, I'll directly come and ask money from surety. You will be liable because your contract was simple. As on the date of maturity, if I have not yet received money, you need to pay. Agreed? All of you, that is what they have given. Next one, defect in document, both of them are discharged. This we have seen in unenforceable contract only. If you remember, technical defects or understamped or spelling mistakes, date is mistake, you have to alter them and you have to make them valid. If not, it is an unenforceable contract. Creditor can sue surety directly. This is what I told you. If at all upon maturity, money is still not paid, The creditor will directly go to surety, valid only, or directly go to debtor, valid only. Both are valid only. Agreed? Hello, last bench, Uttar Pradesh. Next one, discharge of surety. When will surety be discharged? One is by revocation. Revocation means what? Taking back. Can we take back? We have already seen this. What? Of continuing guarantees. Only future transactions. Whatever has happened cannot be taken back. Next one, death of surety. Upon death, what will happen? It will get revoked. What about the already transaction which has happened? Imagine in continuing guarantee, if death happens, it's easy. Upon death, after that, no transactions will be liable. Before, so the liability will still be there. His assets will be liable. Correct. That means inheritance. The legal representatives will be liable. Okay, done. Next one. By novation. What do you mean? Whenever there is a replacement of a contract, old contract is replaced, then again the surety will be discharged. Next one, by the conduct of the creditor. What do you mean by conduct of the creditor? Without telling it to the surety, if you change any terms in the agreement, then the contract will come to an end. Alteration. This part is not relevant. You can strike it off. For your syllabus, it's not there. Is it there in the act? Yes. In your syllabus, it's not there. Yes, meaning, okay, no, don't want. By release or discharge of principal debtor, enters into a fresh contract with the principal debtor or does any act or omission, legal consequence of discharges principal debtor. What is it, sir? Meaning the principal debtor and creditor, they are entering into subcontracts. Without telling me, they are agreeing something else. That is, end of it again, alteration only. Without telling me if you guys do something, of course, as a surety, I am discharged. Next one, creditor compounds, gives the time or agrees not to sue principal debtor. What is that? Compounds means what? Compound. What is compound? Additional? Compound means nothing but people compromise. Now, Vijay Mallya is there. Vijay Mallya had to pay 5,000 crore. When Kingfisher had to pay some 5,500 crore. He said, if I am not able to pay 5,000 crore, I will go for a settlement. I will say I will give 2,000 crore. You should not file a case on me. I am going and settling the matter. You will settle it with the debtor. Meaning with Vijay Mallya you will settle. You will come and finally hit my head. As a surety. You are letting that person go. But you are coming and eating my head. Why should I be liable? They are telling you if you are compromising with him, even I am also discharged. If you are giving him more time, even I am also discharged. If you are writing and telling I will not file a case on you, even you should not file a case on me also. That is what they are telling you. Compounds, gives time or agrees not to sue principal debtor. Even the surety is also discharged. I hope you guys know Vijay Mallya why he is liable, why the entire story of Kingfisher came is Kingfisher Airline borrowed money. The guarantor was Vijay Mallya for this entire transaction to the banks. With Vijay Mallya, 4 more people were there. That is why banks are telling Vijay Mallya has to pay. That is where every liability started. Who took the money? Vijay Mallya Allah. Kingfisher Airlines borrowed. For that contract, the guarantee was given by Vijay Mallya was a guarantor. Surety. See? Because of lot of other reasoning. Other 3 are corporates only. The corporates are none other than their holding company, United Breweries, which are already liquidated or in the stage of liquidation. So 2 people were there. Of course, the other person is also being tortured only, but not to the extent of Vijay Mallya. But recently, I hope you guys saw that Vijay Mallya's podcast. Government has officially issued a circular saying that successfully Indian government recovered 14,000 crores from Vijay Mallya. That's an official declaration given in Supreme Court. That's the total debt that has been recovered from Vijay Mallya. 14,000 crores. That is why now he is coming and saying, I am challenging everything. What more you want? Yes, sir.
Both surety should be equal proportion, sir.
That we will see. That's the last thing if I am not wrong. We'll be seeing this. This only, no? We'll see that. Okay, creditors act of omission impairs surety's eventual remedy. What do you mean by this, people? Let us imagine the principal letter had given some gold to the creditor. Principal letter has given some gold to the creditor. Now surety is also given guarantee that if he doesn't pay, I will pay. What did this guarantor do? When the gold was taken, while the process of safekeeping of gold happened, the guarantor actually lost the gold. So principal debtor did not repay the loan. When the creditor said that surety has to pay some money, how much money was liable to be recovered? The total loan transaction was people 10 lakh. The same 10 lakh was asked by the surety to be paid. The surety filed a case. The gold was also there, no? My liability has to be reduced by that amount. The guarantor said that that is something between me and him. You agreed to pay 10 lakh, you pay 10 lakh. Because you agreed to pay 10 lakh, no, as a surety. You paid 10 lakh. Gold is my responsibility. You leave that. Now, in this case, it was held that people what? Whenever you lose any asset of the debtor, which even I had a remedy, because I could have at least recovered that money from principal debtor. Now, you lost it. My liability will also reduce by that amount. What is the amount of gold? Imagine the amount of gold is 4 lakh. My liability will also reduce by 4 lakh. That is what they are telling you.
Even if he didn't get, but he refused.
Like?
The creditor refused to take that amount. Even then, the liability will reduce to surety.
Correct, yes. Because it gets into the insolvency status. Meaning, I will be liquidating all your assets. I will definitely get your right. We will be seeing that. Right against principal debtor. We will be seeing that also. Okay. Next one, people. By invalidation of contract of guarantee. Meaning, misrepresentation, concealment. Whatever we saw. So, when the person is concealing, of course, my surety guarantee is discharged. Agreed? Yes, sir. The last one, sir. The rights of a surety. What are the rights of the surety? The first right is people against the principal debtor. So, people, surety has right against people, 3 guys. The first guy is called as principal debtor. The second guy is called as against the creditor. The third guy is called as against the sureties. Meaning co-sureties. Others are there now. Against all of these people, what is my right? Correct? The first one, against principal debtor. First one is right of subrogation, which you already seen. Agreed? That is whenever I pay money, if you do not against, in your place, if I pay the money, I have a right to recover that, no? That is only called as stepping into the shoes of creditor. Next one, sir, against the creditor. What are the rights I have against the creditor? Just now I told you. What? Right to benefit of creditor's security. What is that? If creditor loses gold, then surety is discharged to that extent. If gold value is 4 lakh, my liability is also reduced by 4 lakh. Right to set off. What is right to set off? Sir, the principal debtor has taken total loan of 10 lakh. The surety has also agreed that I will repay whatever he needs to pay. The principal debtor has paid 2 EMIs. That is, sir, he has already paid 2 lakh. Whatever the principal debtor has already paid, my liability will also reduce by that amount. That is the meaning of right to set off. If he has paid, my liability will be reduced by that amount. So 10 lakh minus 2 lakh. That is my right to set off. The third one, sir, is called right to share reduction. What is right to share reduction? Sir, let us imagine, sir, if the principal debtor became insolvent, that time what will happen? Principal debtor has some assets, some car, some bike, some gold. You will recover that, no? Whatever you are recovering, you have to pay me that. As a creditor, he will file a case in the court. He might recover some money. Now today I might have paid this to you. From that, what you recover, I also have a share. You have to pay me also. If at all I have paid his debt. That is what they are telling you. Now let us imagine a debtor becomes insolvent. What will a creditor do? The creditor will go and file a case in the court. Now the creditor has also recovered the money from the surety. Now 10 lakh is already recovered. You have also filed a case in a court on him, that is insolvency. Now whenever a person becomes insolvent, what is the first thing that will happen? They will appoint a liquidator. What will liquidator do? He will come, he will sell all the assets of the debtor. We were able to recover some 3 lakh. Now what is the role of the liquidator? He will recover that money, he will pay it to all the creditors that this debtor has to pay. So he will tell all of you to stand in line. They're telling you even surety has a right to stand in this line to recover whatever he can recover. Understood? Huh? That is the meaning of right to share reduction. This happens when principal debtor becomes insolvent. For our understanding, I'm telling you, this is nothing but to share it from the assets. Clear? Yes, the third thing people is called, whenever there are more than one surety, we call it as co-surety. They are liable to contribute equally unless otherwise agreed. What do you mean by that? The borrower has taken 10 lakh as loan. There are two sureties for this contract. Nothing is agreed. Both of them are liable 50% each, 5 lakh each. Sir, no sir. Co-sureties have different sums. Meaning what, sir? There are 3 people, 3 sureties. The total money that was borrowed by the principal debtor is 6 lakh. Sir, the co-sureties has given guarantee like this. One has given 3 lakh, one has given 2 lakh, one has given 1 lakh. Now, whenever there is a default, let us imagine people, 6 lakh is the total money given. Now, the principal debtor in total has repaid 1 lakh. What is the default amount? 5 lakh is the default amount. Now, they are asking you, how will this 5 lakh be distributed amongst the sureties? How will you distribute it? How much? Okay, first you will have to divide it 1, 1, 1 and then 1, 1. This is correct? Yes? All of you agree to this? Or any other calculation? All of you? How will you distribute 5 lakh? 3 is to 2 is to 1? All of you? That is how we do it? 3 is to 2 is to 1? Remember, this is the answer. It will be 2, 2 and 1 lakh. Whenever there are different proportions agreed, I understand you are thinking, sir, that person 3, this person 2, this person 1. We have to distribute it in the ratio, no sir. You of course cannot say all of them are liable equally. People remember, you have agreed to pay 3, 2 and 1. If there is a 5 lakh default, why should one person pay 80,000, another person pay more? You have anyway agreed to pay up to 1 lakh. Up to 1 lakh, all of us are equal only then. Why should you pay less then? Are you hearing what I am saying? Let us imagine people. You give me, you only try to think. Sir, the total default is 3 lakh. The ratio is 3 is to 2 is to 1. How will they share the profits? I mean, how will they share the losses? All of them 1 lakh? All of them will pay in 3 is to 2 is to 1? Can you tell me if, okay, can someone tell me if it is 3 is to 2 is to 1, how much will be the ratio? How much each of them will have to pay?
1.5 lakh.
First person?
1.5 lakh.
Okay.
Second person 1 lakh.
Okay.
Last person will be like 50.
Correct, huh? Now my question to you. They all agreed to pay 3, 2 and 1. Agreed? This person, now let us imagine A, B and C. Why is this discrimination you guys are making that when the liability is 3 lakh, why are you collecting more from one person, less from one person? Why? See, when everything is default, I understand. You apply ratio. I have agreed more, he has agreed less. But when the liability is equal, you guys have to make sure that spread also is equal. Why you are taking more from one person, less from another person? Why? Logical. That's why the logic is, if at all the amount you guys have given if it can be spread across up to the amount covered, you need to share it equally. That means what? It should be one and one only. Wherever possible, you have to distribute it equally. Imagine 5 lakh happened. Now C said maximum I can pay is 1 lakh. His obligation is done. Now another 2 lakh we have to spend. Why should we increase it on one person? Again distribute it equally. Now still 1 more lakh. That is when this person will come. So to whatever extent possible, you have to distribute it equally. Got it, huh? One last time, you guys going to think and do. 2 lakh is a total default. How will you distribute it?
Each.
66k each, huh? Correct, huh? Okay, 4 lakh. How will you distribute? This is correct. 66k each. Nothing. 2 lakh divided by 3. That's the answer. That's all.
1.34 each.
1.34
lakhs each.
each.
1.1.
C says maximum is 1 lakh. How will you do 1 point? How much that? 2 lakh? 2 lakh, 1 lakh, 1 lakh? 2 lakh, 1 lakh, 1 lakh? 2 lakh, 1 lakh, 1 lakh? Or it is agreed? All of you? I think we have taken audio breaking. Now is it clear? Online is it clear na? Sunday no. So is it clear now? Audible?
First, we should set up the least amount of payable to the person, then we should separate it again.
So do it like this. Whatever you can distribute it equally. Up to that extent the now it's clear? Online now is it clear? They online no. Okay, whenever it is happening like that, let me know the next time. So whenever it is possible to distribute it equally, first do it off equally. Equally once done now one person's obligation is done leave him. Now C was up to 1 lakh. After you cannot give it. Now put it only on A and B. Now B is also done then come to A. That is how you need to do. Clear? Okay, done. Next unit people, unit 8 bailment and pledge. What is a bailment? What is a pledge? What is bailment? Bailment means what? Delivery of goods to another person and receiving back. Okay, see again, remember bailment means transfer of possession and not the ownership. Yes, that is bailment. You need to remember it like that only. Transfer of possession and not the ownership is called as what? Bailment. Examples of bailment is people. Now my mobile is not working. I give it to a repair. Am I selling my phone to him? No. After the repair is done, that person will give it to me. No. Yes or no? Then in college, one macha will give his bike to another macha. Bailment only, no. You are selling off your bike or what? Are you giving your bike permanently or what? No, no. So it is always a temporary thing. Once your purpose is served. What is the purpose? Whatever, one wheelie macha inge hogbittu we should come back. Once the purpose is served, you will give back the bike. That is only called as what? Bailment. Purpose is served, you will give back the possession. Bailment can be two types. One is for money and not for money also. Both the things can exist. Agreed? Now phone repair, for money only, no. One macha to another macha, money will be taken, He's like, yes, I will charge, sir. You'll charge her, Your friend missed your class. One class your friend missed. Your friend will ask, can I borrow your notes today? I'll copy and get it tomorrow. You'll give no. You'll charge, Yes, sir. Yeah. Yes or no? These are called as what? Remember, bailment can be two types. Gratuitous bailment, non-gratuitous bailment. Gratuitous means free, meaning gratuity, gratitude. You are doing it with gratitude, free. Next one is non-gratuitous, no free. You are doing it for panam, kasse. Correct, Hello. Yes, sir. Okay. In bailment, what are the parties involved? Bailer, bailee. Who is the bailer? The person who is transferring the goods, delivering la, transferring. Okay. Now, who is the bailee? The person who is getting the possession of the goods. What is the difference between transfer of possession and transfer of custody?
There won't be complete transfer of property. That is transfer of custody.
Okay.
That case of examples in the book. Like Goldsmith one. That one is like transfer of the second thing.
See, in law, first thing, never remember examples. We remember examples only. That's why I say in law, you all know the concepts. You know the examples. The problem comes there. Your thinking capacity will be only if that example comes. In the goldsmith, if I put to coppersmith, sir, who is that, sir? This is not in our syllabus. Out of syllabus, this question is. That is where it will come. What do you mean by try to understand? What is the difference between delivery of possession and delivery of custody? What is the difference?
You won't give full possession to them. That is custody.
Complete possession means you will have one hand, he will have one hand.
Giving the gold,
The word is control. Who is having the control over the goods? Now imagine I'll give my mobile to repair. Don't you think the complete control of the repair is with the person? I am not, do I say, macha motherboard, soldering, put two wires, do I say something? No. Am I controlling it? No. Will I say it? I want it to be done within 2 hours. He says, sir, it will take 2 days. You will say, no, do half today, half tomorrow. I'm okay if left part of my screen works. Will we say that? No. Then that is called as what? That is called as bailment, because you are giving complete control to the other person. What do you mean by custody? Custody means people. Now you have lot of gold. You have lot of gold at your home. What will you do? Sir, any day, any theft, anything can happen. I will go and open one locker in a bank. I keep all that in that particular bank. Now, have I sold it to the bank? No. Can I take it whenever I want? Yes. Now you tell me, is this a bailment or not?
Not a bailment.
Why? Understood what is control? Can that person take the gold from one locker and keep it another locker?
No.
Simple. That much also you can't do it. From as a bank, can't you just take in one and can't you put it in another locker? That much, the simple thing. Then what control you have? That is called as what? Custody. That's the difference. In bailment, you will have control over the goods. You take a bike and you will do wheeling. You have a control. In the case of custody, you will not have control. Understood? Custody. Now take for example, imagine if Mukesh Ambani has a driver. The Mukesh Ambani is dropped at his office. Now the driver is driving the car. Is it bailment or not? My car is with the driver. Is it bailment or not? Why? Why not bailment? Bailment or not? It's a bailment only, no? Yes or no? Okay, now my question. Mukesh Ambani says go at 20 kilometers per hour. Will he go? Think and tell. Mukesh Ambani is telling his driver go at 20 kilometers per hour. He'll go. You literally think and answer. Mukesh Ambani will say, you push the car, he will push. Forget about driving. If I tell him to get down and push, he will push. Okay. Mukesh Ambani will tell, don't take this route, take this route. Will the driver listen? Mukesh Ambani says, come and pick me at 9 o'clock. Will he come and pick him at 9 o'clock? Mukesh Ambani says, you be available at the office the whole day, don't go anywhere. Will he listen? Is a car under your control or Mukesh Ambani's control? Clutch, brake, accelerator is in your control, but car is in my control. Is it considered as custody or possession? Now imagine you go and hire a Zoom car for rent. You tell me, is it a bailment or custody? Bailment, Zoom car. Bailment or custody?
Because they only said that one until that limit only you should drive. You should not go above this speed limit like that. No, they said.
So you're saying custody only. People, Zoom car says you're not supposed to travel above 120 or 100 kilometers. Depends upon the car. People, 100 is not considered as controlling you. In Bangalore traffic, 10 kilometers you go. And then we will speak about 100. First thing. Second thing, do I tell you which route you should take? No. Zoom car asks you because to charge you. Is it within the city or beyond the city? Now, if you say beyond the city, can you take it beyond the city? Yes. Correct? Now, will they tell you how, what, no. This is possession. This is called as what? Bailment. Understood? Pakka? Okay. Meaning of parties of essential elements of bailment. Contractor, delivery of goods. Correct? It should be given to the other person. Transfer of possession should happen. Next one, possession. Having just custody is different from possession. And after the purpose is done, you have to return the goods. Contract of bailment is two types. One is free, one is for consideration. Gratuitous, non-gratuitous. What are the rights of the...
So is there a difference between bailment and renting, sir?
Yes. Renting, what exactly? Tell me. What are you renting?
The term renting.
Okay, only the term renting. Bailment is used for movable goods. Even if it is renting also, it comes under bailment, it comes under non-gratuitous bailment. But if at all it is for immovable goods, we cannot call it as a bailment. Now imagine Arivu has taken this building on lease. After 5 years, we have to return back. But is it a bailment? Answer is no, because it doesn't come under Indian Contract Act. Bailment is only and only for movable goods. It has to be movable goods. Immovable, we won't call it as bailment. We call it as lease. Clear? So, if your question is rent, bailment, yes. Movable, yes. Okay. Rights of bailer. What will be the rights of bailer? Who is the bailer? The person giving it. So, what will be his rights? People, remember in exam, if at all you are going blanco, if you are not able to remember any points, macha, rights of the bailer will be duties of bailer. What are the rights of the bailer? After the purpose is done, I have a right to take back my phone. If the repair is done, I have a right to take back my phone. That's my right. What will be the duty of bailer? Once the purpose is done, to return the goods. The other way also, if it is a duty of a bailer, it will be the right of the bailer. What is the duty of me? To pay money for whatever the services cost, yes or no? What is right of a bailer? To collect the money. So remember in your exam, my voice is still not clear. Is it? Online, all of you are finding it difficult, voice? I took steps also, Naya. Illa? Speaker is making this noise, Is it? Online, is it better now? Online. Is this better now comparatively? Now it is better? Yes, okay. If you guys again get it, let me know. We will see what better thing can be done. Okay. Okay, people. First one, to terminate the bailment if bailee acted inconsistent with the terms of the contract. What do you mean by that? I have a right as a bailer to cancel the contract. When will that happen? Now I gave my bike for service. That fellow is using it for pickup and drop, Rapido. I can cancel it, of course. Premature termination means I've given it to you for 3 months. Can I cancel it before that? depends upon whether your bailment is for money or free. If it is for money, you cannot prematurely terminate. Before 3 months, not possible. If it is for free, you can terminate. Meaning, I gave my friend asked me a bike for 3 months. I gave him my bike. After 1 month, I need it back. Can I ask it? Yes. Free. I have a right more superior than what you have. But in the case of money, I cannot. Until 3 months, I am bound to your contract. It's a contract, no, end of the day. Quid pro quo is also there. Of course, right? Next one, suit against wrongdoer. What do you mean by that? Imagine I've taken Zoom car, I go and hit a person. Or that, okay, let us look at other way. He only comes and hits my car. Who will fight a case? Me or Zoom? Both can fight. Remember, I also have a right because I also have a legal right as I was a person involved in the incident. Second one, end of the day, it is his property. He can also fight. Both of us are having a right to fight. Next one, right to sue the bailee for. I can file a case on the bailee for what? Compensation for loss by negligence of bailee. Meaning if I suffer any damages, I have a right to recover it from you. Second one, compensation for unauthorized mixing of goods. If at all my goods and your goods are mixed, I have a right to recover that particular cost from you. Compensation for unauthorized use. Rapido. You are taking my bike or you are doing Rapido services. To demand back the goods. After the purpose is done, I have a right to take back my goods. Right to accretion to the goods. What does this right to accretion to the goods mean? Whatever is the profit that you have earned on my goods, that also belongs to me. Correct? Huh? In your book, in your exam, you would have seen some funny examples. Yes, sir. What does accretion on goods mean? Imagine if at all cow and a calf. So if at all you are giving a cow to your neighbor, village, proper village setup, try to imagine it like this. So you want to go on world trip. Oh, farmer Anna. So now who will take care of the cow? Farmer Anna gave the cow to the nearby neighbor. Maja, please take care, especially my cow is pregnant. Now people, when I gave it and went to, it was only one. But after I came back, people twins. That means 3 are there. The person is returning only one. Macha, you gave the big one, I'm giving you big one back. Possible, huh? So I'm telling you, whatever is accretion in the goods I gave, that belongs to me only. Yes, you can put it in many ways also. Sir, if third person made damage, then bailer can sue who? It depends upon a contract, but bailee is liable to the bailer. That is by default. But to the third person, both of us can fight. That is possible.
Sir, in case of Zoom car, the insurance will be taken in the name of the person who is renting or on.
So whatever, it will be in the Zoom car's name only. But whatever charges you are paying, it will include your insurance charges also. So for everything, there will be insurance taken. So even if you hit also, it will not make much difference. The charges are already collected. So it will be in the name of Zoom only.
If there is any personal damage to the bailee, sir, that is while driving the car, the driver gets any damage, will Zoom car pay some money which they have received from the insurance to the bailee?
No. The personal damages will not be covered in your insurance unless and until the third party insurance is covered. Now who will have to pay? The third party has to pay. That is the person who has made all this happen. Yeah? Okay. Correct. Next one, about duties of bailee. What are the duties of bailee? Opposite. That's why we have seen in the same. Correct. Opposite of it is duties. Any specific point you have here, or we'll just run through? We'll just run through. Okay. Take reasonable care of goods. Not to set up adverse title. Meaning don't go and sell it off to someone else. Not to make inconsistent use. Don't use it for rapido. Return accretion. Cow, calf. Return the goods. After the purpose is done, don't say it is yours only. Give it back. Not to mix the goods. For example, one movie is there. In that, what happens? Papa, one friend, to help his friend in the exam, he will say, Macha, show me fifth answer. He'll be showing. He will say, Macha, I'm not able to see. Show me properly. He'll papa push it like this and say, see da. He said, Macha, I'm not able to see. Do one thing. You give me the paper, I'll copy and I'll give it back. He will give the paper, he will take it, he'll pin it and he'll give it back. He will go and submit the paper. That is what they're telling you. Return the goods. Yeah. Bailment only, no? Not to mix the goods. Correct? Don't mix it. Macha, your paper different, my paper different. Okay, so you're not supposed to mix the goods. This will happen in the case of all provisions, all such cases. Okay. Next one, people. Finder of lost goods. What is the finder of lost goods? Is finder of lost goods also considered as bailment? Yes. Finder of lost goods. Correct. So when I find your wallet, there is a possession of your wallet with me. So I am not the owner. I have to give it back to you. And that's why we call this contract also as a bailment. Understood? Okay. So fine.
What if the goods has defects?
Like?
If a good has a defect but the bailer didn't disclose it.
You have to disclose. That's your duty, right? Duty to disclose defects.
There is a difference in gratuitous and non-gratuitous.
Okay, see, whenever, okay, remember.
I wanted to know that this, if it is gratuitous or not.
Yeah. See, one thing, whenever, let us imagine, let us imagine like this. Zoom has given you the car. Now, Zoom is a bailer and we are the bailee, correct? Now, there is a defect in the car. What? Brakes are not working. Now, I have taken it. I was driving it, brakes didn't work and hence there was a damage that was occurred. Now, my question is Zoom liable to this particular accident that has taken place? Are they liable? Zoom is telling we are not sure. We have serviced the car.
We have paid.
So, whenever the contract is non-gratuitous, that means whether you know it or you do not know it, if there are defects and if I have paid money for using that particular product, you are liable as a bailer. Now, look at the other way. One macha gave his bike to another macha. Of course, bikes of machas doesn't work brake and all. Either it will do screaming sound. Because 2 years, 3 years back the service would have happened. Yeah. So, of course, then how will we stop? We will stand on that brake. That's how we'll stop it. So, one macha gave the bike to another macha. Free of cost only. Did he disclose this fact that the brake is not working? No. Macha went on wheelie. He did like this. Ange he fell back. Yes, sir. Brakes are not working. Can I claim damages or not?
Yes.
Now, whether I knew whether the brakes were not working, did I knew? Was I aware of it or not? So remember, if at all gratuitous, if at all you are aware that there is a defect, you will be liable. If at all you are not aware, you will not be liable because you are helping it. I can't tell you, bike nande, wheelie nande, meaning you can't say that defect is also mine and compensation is also mine. If I am aware of it, I will be liable. If I am not aware of it, I will not be liable. It is all about whether you have paid for it or it's free. Clear? Okay. Now the finder of lost goods. He has no right to sue the owner for compensation of expenses incurred voluntarily. Correct? You cannot file a case. But when can you file a case? If at all any reward is promised. If at all I have found a wallet. Now imagine people to find the owner. I have spent around 400 rupees people to find the owner. I go to the owner. I'll say, sir, I have spent 400 rupees. Can you please give me my 400 rupees? I'll give you back your wallet. He says, I'll not give you. I'll not give it a 400. Did I ask for you to come? You should have come by walking. Why did you come by cab? I will not pay you. Now, what is the right that I have, the bailer? You can retain the goods. I can say, first you pay, you take it. If not, I will not give you the goods. Can I say it? Yes, you can. I get in the point. But can I file a case on the person to recover the 400? Why? Can I not file a case? Voluntary act, macha.
He didn't mention that he will give money.
Desire of the promisor. A consideration must always move at the desire of the promisor. I'll just say, did I ask you to come? He will say, I only dropped it there. Where will you go? Correct, no? So I will not be liable to pay. I will not be, you cannot file a case on me. It's not a contract at all. But imagine on the phone I said, thank you so much for finding my purse. I'll give you 1000 rupees as reward. Now it becomes a contract. Now can you file a case? Yes. Do not get confused. Remember, if at all I have not promised any reward, you cannot file a case on me. But can you retain the goods with you? Yes, you can retain. Are you getting the point? But if at all I have given a promise to reward, on that I can file a case on you. Get it? Now people, can I resell these goods? Can I not resell? Not even one exception? Yes, if at all, as exception only, no? So correct, there are two exceptions. You can resell also, macha. Resell. Meaning what? People, we found one paneer packet on the road. What you will do? You will put one one Times of India ad. One paneer packet found 120 grams. Whoever is the owner, please come and take it. You will tell, no, how long will you wait? Correct, no? Perishable goods, all this will come to an end. You just put a reasonable effort. If at all you think it is not possible at all, then you are free to resell the goods if they are perishable. Understood all of you? Next one. The amount that is incurred to find the owner is 2/3 of the value of the product. Meaning the value of the product is 1000 rupees. I have incurred 800 rupees to find this fellow. He is telling I will not pay you. Then they are telling me you are free to resell the goods. You do whatever you want. Because the value is only 1000. You have already incurred 800. And you have also denied making the payment. Now you are free to resell it. Clear all of you? Pakka? Sir, any other perishable goods? Everything, da milk, curd, vegetables, fruits. Sir, can we eat it? Okay, you can eat it. Don't ask me how and all we can eat it or not. Okay, they are perishable, lawful, understood? Yes, okay. Turn off. After, in the break, get the remote from them. Without remote only this will happen. Yes, sir. Hello.
Yes, sir.
Rights of bailey. Same, All the rights of bailey to deliver the goods to any of the joint bailers. If two people had given the goods, I can return it back to any one of them. Right to indemnity, meaning this is what you guys said. If bailer has no title and bailey delivers them back to the bailer. Right to indemnity means what, people? Someone gave me the bike for service. We have all at least seen giving the bike for service. All of you have seen. We go with our parents and all. Now we give generally to a person who is nearby our home. Not all of us will go and believe in the showroom. You only do no. We believe in Anna who is in our neighborhood. Yes or no? Now will he ask for RC card and all when he is giving? No. Will he check whether it is your bike or not? Yes or no? I don't know if you guys know it. In Darshan's case, recently one of the film actor who was into this murder case and all. Yeah, Darshan case. In that, when generally people accused we call, no? Whenever we file a case on someone, we call them as accused. We call them as accused 1, accused 2. You know who was accused number 20 in the case? Accused 20 was people, a cleaner. Which cleaner? Car cleaner. You know why? Car cleaner. He is nothing, he is having a carriage. Where you go give 250 rupees, he will do water wash. He is accused number 20.
He didn't check.
Who will check? I'm saying he did his job, but just to clean the car, accused number 20. What does he know? Just put 2 rupees clinic plus shampoo. Who knew that this life would change so much? Why? Because it was considered as erasing of evidence, fabrication of evidence. Because now the body was taken in that vehicle, blood. Gone no. Footprints gone no. Fingerprints gone no. Then no, Papa no. Anna, garage Anna. Can you file a case? That is what they are telling you. You have a right to indemnity. You cannot check. Now someone came, they gave a vehicle, I cleaned it, I gave it back. Now the actual owner is coming. Hey, why did you give that? It was my car or my bike. Why did you repair? I said, Anna, how will I know? Everyone will come, I'll repair and I'll give it. But if that person is filing a case on me, I have a right to recover it from the first bailer. Macha, because of you I am suffering all this. But whether will you be able to catch hold of him or not is a secondary story. Law at least tells you can recover. Understood? Okay. Third one. Claim compensation, which we already saw. What is this? Zoom car. Next one. Claim extraordinary expenses. What is extraordinary expenses? I'm using Zoom car. Engine, there is a problem. Now I'm already on a highway. What should I do? Of course, I'll take a screwdriver, spanner, I'll do something, it will not fix her. Now I'll go to a nearby garage. I need to spend some 5,000 from my pocket. Why should engine cost come on me? Ordinary expense, I understand. Petrol is me. Why engine on me? It is yours. I have a right to take it back. Next one, right to apply to the court to decide the title of goods. Meaning, sir, Scorpio they gave to me to clean it. Who gave it? Say for example, Praveen came it. Now, Praveen gave me the car to clean. Wasim is coming and telling it's my car, don't give it back to him. Now, should I give it to Praveena, who gave it to me? Or Wasima, who is actual owner? I am not able to decide. Do one thing, file a case in the court. Court tells you to give it to Wasim, give it to Wasim. Give it to Praveen, give it to Praveen. But that cost, you can recover it from the bailer. Wasim, understood? Hello? Right to lien. What is lien? To withhold the goods. We'll be discussing more about lien in Sale of Goods Act. We have it. We'll see there. Next one, people, duties of bailer. Same thing, cut, copy, paste, opposite. To give was his right. Duty to take back the goods. Duty to indemnify any loss suffered. Correct? Next one, duty to disclose faults. Brake not working. Pay necessary expenses, engine, indemnify bailiff for premature termination. If at all I have taken for 9 months, if I terminate in 3, I have to give it whatever the cost for 6 months, correct? Okay, done. Next one, termination of bailment. How can a bailment be terminated? On expiry of fixed period. If at all I have said it is valid for 1 month, 1 month. On fulfillment of purpose. Repair. By notice. How will the termination happen? I have appointed you as my bailee. I am giving you a notice with a gratuitous. Any time I can tell, give me back my goods, I can cancel it. Non-gratuitous, you can never cancel it before time. Only time you can cancel the contractors if the other person has done inconsistent use with the goods. Meaning, I have given it for service, he is using it for Rapido. That time, yes, you can terminate it. If not, if it's a money, then you can never pre-terminate it. The next one, people, by death or the death of bailee or a bailer. Of course, contract will come to an end. Next one, on destruction of subject matter. Meaning, if the bike only gets destroyed, who will be liable? Imagine the bailer has given something to repair. What? Let us imagine the bailer has given a phone to repair. So, the bailer has given the phone to a bailee. The bailee is working. While the bailee is working, people, all the phones are there in that place only. Earthquake came, earth split, the phones went inside, earth came back and sticked. Now who will be liable? Bailee or bailer? Who asked bailee? Should I pay for that? The phone went inside now. Charger also went inside. Tell me, who will be liable? Bailee only? Act of God, no one will be liable?
He takes reasonable care, he is not.
Okay, let us imagine the shop was there. Someone came in the night. Some thief. He took a glass cutter or fire cutter. He cut the shed. He opened it. He took all the phones, some 15 phones, whatever he could pick it, he picked it and he went. So Bailey's phones were also there and his phone, Baylor, his phone also was there. 14, 15 phones went. Now my question is, the Baylor came and asked for my phone back. He said, Ayana, so sorry, the thief took it. Now the Baylor is asking, give me my money. Give me that, whatever is the cost of the phone, you pay me for it. Who will be liable or who will bear that loss? Baylor or Bailey? Bailey? Bailey, that is the showroom person. Yes or no? Pakka no?
Even though they are taken,
Because the possession is with him. That's why service person, the Bailey is liable. Agree, no? ಅದೇ ಯು ಶುಡ್ ಟೆಲ್. ತಗೊಂಡಿದ್ರೆ ಆಗತ್ತಾ ಇಲ್ವಾ? ತಗೊಂಡಿದ್ರೆ ವಾಯ್ಡ್ ಆಗುತ್ತೆ. ಕರೆಕ್ಟ್. ನಾವು ಪೀಪಲ್ whenever it is all the matter of whether reasonable care was taken or not. The person, midnight 12 o'clock, what, shutter was open, light and all was kept, door was open, Bunny please, garland, did you welcome him? Thief? No. You have taken reasonable care of securing the phone. You have kept all your phones also there. 13 other phones, you have kept it there. The other person's phone is also kept there. And clearly the door was locked, shutter was closed. And still if you lose with people, they tell, as a Bailey, I have taken reasonable care of the goods. Now if I still suffer, if I still lose the product, according to the law, I am not liable. The garage, the showroom person is not liable. The bailer has to suffer the loss. And remember one thing, never get confused between our reality and law. In reality, the other person promises you. It works on a different way. We will hold it in a different way. We will clearly tell, if it is in your hand, it is your mistake. That is how we take it. But law doesn't take it that way. Are you getting the point? Now imagine in reality the same thing happened. If you both go to the court, the showroom person will win, not you. Understood? When the disputes happen in the ground level is when these things will come into picture. Hello? Pakkana? Okay. The last one, sir, is called pledge. What do you have pledges are? Pledge is nothing but people. Bailment for a security is called as a pledge. Meaning pledge is also bailment only. What is a pledge? Darshana? What is considered as bailment? What is a pledge? Pledge is nothing but bailment for a security. Example, Muthoot Manappuram. What does Muthoot do? They take your gold. They give you loan on your gold. Now giving gold, they will keep it until you repay the money. Your gold is with them. It's bailment only, no? But why did you give your gold to them? As a purpose of security. So bailment for security is called as what? Pledge. In pledge there are two parties. One is pledger, pledgee. Correct? Yes, sir. Now duties or rights or everything will be just like bailer, Bailey only. That will not change. It's the same. Agreed all of you? Remember that, write it here. It is still valid only. Whatever you write it for Bailor and Bailey, because they are the same only, no? They are pledger, Bailor, Bailey only. So it will still be valid only. Correct? So what is pledge, people? Pledge is nothing but bailment for security. It will always be movable goods. Yes? Clear all of you? So this duties and rights, same thing, no? We need not see it again, same thing. Okay, done. Last one, sir, pledge by non-owners. We'll be seeing this anyways in the Sale of Goods Act. There also we have it. Correct? Sale by non-owners. We'll be seeing it there again. We'll repeat the same procedures there. The last one, people, is called as agency. Now, agency is nothing but, people, what is an agency? Whenever there is one party, he will appoint someone as his agent to do every activity on his behalf. Now I have a car. I do not want to sell. I do not know where to sell. I will just appoint another middleman on behalf of me. He will do the entire thing for me. He will sell it. Now the person whom we appointed here is called as what, people? Agent. Correct? Yes, sir. Can an agent be a minor?
No.
Can an agent be a minor?
Yes, sir.
Can a principal be a minor?
No.
Agent can be a minor. Or principal can be a minor. Agent can be a minor. Agent can be a minor. So remember, why do we say agent can be a minor? See, technically you shouldn't be the law says, okay, anyone can be a minor. I mean, anyone can be an agent. Now why? The reason also they are telling that is, if a minor is an agent, if agent does anything, the liability or the right both belongs to the principal only. So whatever agent does, the liability is always on the principal. Correct. So this person can be a minor or a major. It doesn't make difference. End of the day, the responsibility is on the principal only. However, where does the difference happen? If at all the principal has a car, I'm clearly telling you, do not sell my car for less than 5 lakh rupees. I've clearly told you. Now imagine if my agent is a major and imagine if my agent is a minor. Two scenarios. In both the scenarios, the agent sold the car for 3 lakh. I clearly told don't sell for less than 5 lakh. They sold it for 3 lakh. How much loss did I incur? 2 lakh. Now imagine if at all the agent is a minor. Agent is a major. If agent is a major, I clearly told you not to sell for less than 5 lakh. You sold it for 3 lakh. The 2 lakh, the law gives me a right to recover it from you. Minor. He sold it for 3 lakh. Can I recover? Illa. You cannot hold the minor personally liable.
Even as the estate?
No, not possible. For everything, principal only is liable, no. That's always the risk with minor being an agent. Clear? Hello? Okay. Done. So, principal, competent, agent, incompetent is also okay. Next one, how is an agency created? First one is express by words, vocal, written, anything. Implied, based on circumstances. What do you mean based on circumstances? So let us imagine now me and Praveen will go and drink a tea. Let us imagine. Now we take tea, Praveen will pay for both of us. Next day also we'll go. We'll take tea, Praveen will pay for both of us. Third day also we'll go, we'll take tea, Praveen will pay. Next day I'll go, I'll say Praveen only will come and pay. After me, Praveen will come. Actually, they will say, sir, he had come. He said, you will pay. Praveen said, yeah, I'll only pay. Praveen paid. Fourth day, Praveen paid. Fifth day also, Praveen paid. I said, he will come and pay. He paid. Sixth day, people, there is a agency created. What is that? If at all I tell Praveen will come and do, Praveen will come and do. Now, the next day, what I will do? I'll start upgrading. Sir, I have a small catering order. On the 50,000 rupees value, money, Praveen will come and pay. People, this is only called as what people? Agency by implied. That means what people? You're meaning based on circumstances. You are putting it in their mind. These things can be read together. Estoppel and implied authority. You could have said no. You started giving an impression to them, if that person does something, I will pay. Now when the date comes, you have to pay, you have to pay. You have created that in their mind. That is only called as estoppel, that is only called as implied authority. Understood? Yes, sir. Next one, necessity. What is necessity? In case of emergency. What is an emergency? What is an emergency? Emergency means what, sir? Emergency. Okay, emergency means nothing but people. You should have been stuck in a particular scenario and you are not able to go ahead. Let us imagine we are traveling. Okay, we have appointed a ship. We are exporters. So we have appointed one shipper to carry our goods and deliver it to other country. So the boat or the ship becomes the master of the ship becomes our agent. We have told him where to do, how to do, everything we have told. But in between people, because of some emergency, the ship gets stuck in the that particular ocean. Now, because of any reason, they are not able to go and reach the destination. Now, they will have to take a halt because there is some problem in the ship. They go to another country. Now, they said it will take another 10 days, 15 days time to repair it. Now, our C person is trying to, contact me. Hello, Anna? Hello? Not reachable. The people, that person should have tried to contact you, and if it is still not reachable, they are telling you people, then at that point of time, whatever our agent, our ship driver, captain, whatever is the action he has taken, you are bound by it. Meaning, imagine if you were exporting apples, 10 days will apples be? No, I will sell it there. That is the commercially that day, that is the best decision I could take. And if I have taken that, you are bound by it. You cannot come and renegotiate it. You cannot say, agent, you are liable for that. That is only called what people? Agency by emergency, necessity. So you should have tried calling your principal. Principal is not reachable, and the agent should have taken the best alternative possible. If that is proven, then who will be liable? Principal will be liable. Hello? Last one, sir. Ratification. What is ratification now?
It is regarding agency creation, right?
Hmm.
Then where is created during the emergencies? It has been before it has been created.
No, now that is what imagine. Now you have told a person to go and deliver the goods from here to here. Now he is not your agent. What he is doing is shipping business. But when, I don't know if you guys know it, let us imagine if ship is becoming an overweight, ship is sinking, or if the ship is undergoing a huge turbulence, meaning too much of waves are there. The captain has a right to push the goods into the ocean. What if your container is pushed? Is this right? That day, the commercial thing says that is what I could do. You can't say, why did you do that? He will become a deemed agent. The circumstances are saying that he's acted on behalf of you. Him doing is like you doing only. So you are liable. You cannot hold him accountable for all of that. Understood? Yes, sir. Okay, what is ratification? We have seen this also in minor thing and all. What is ratification is nothing but when you did it, you do not have a right, but later on you have a right. Example. Now imagine people, Praveen has one good three-floor building. Now Praveen is an NRI. So good building is there. Praveen asked Wasim, Macha, I will not be there for next 3 years. Can you please take care of my building? Wasim said, yes, why not? I will take care. Praveen, Macha, nothing, clean it properly once in a month. Appoint someone. Keep it clean, that's all. After 3 years, I will come and I don't want anything else you to do. He said, okay. Now, Wasim people, after 2 days, 3 days, after Praveen going to US, Wasim came there and started saying, hey, it's such a beautiful property. It is in the heart of the city. If I give to rent, each floor is going for 1 lakh. That is 3 lakh per month. That is 36 lakh per year. What is the number of years Praveen is coming? That is nothing but around 1 crore. Now people, 1 crore rupees. Now what did Wasim do? Wasim did not even ask Praveen. He gave that property on rent. After 3 years people, Praveen is coming back. The building is a little bent like this. Whoever used simply telling gate people rusted, it is closing, it is doing a sound. Full, full, big banners and all have come. Now people, Praveen got irritated. First Praveen saw any other, my building is behind this or what. Now people, the question is Wasim liable for all these damages? Gate, building tilted, building has gone a little under the. Too many people stayed in that. Now, is Wasim liable for all of this or not? Technically, yes. Now, Praveen was telling, he is calculating for the gate 1 lakh, for the building to be made straight 5 lakh. So, he is counting, repainting is another 6 lakh. To remove the nails and all 2 lakh. So Praveen said, I'll file a case on you, repay all of this. When Praveen was telling these people, what did Wasim do? Wasim took 1 crore and kept it in the hands of Praveen. Praveen ange fell on Wasim's feet. Sir, how are you? All good? You want sweets? Any? Tea, sugar? No, people, because of this, what Praveen did is called as what? Agency by ratification. When the house was given on rent, Wasim did not have power to give it. I never authorized you to do all of this. But once I came back, I took the 1 crore briefcase in my hand. That means I am saying yes to everything you did to my building. I am liable for that sound. I am liable for that 1 floor going under the earth. Everything I am liable. I cannot recover extra cost from you for that. It is my responsibility. I am taking benefit. I have to take a little responsibility also. Now this is only called as what people? Agency by ratification. But remember, you can never ratify a illegal act. Meaning what? Wasim, because anyways the building was big, he started growing. Oh, creeper no. So if you made money on that you cannot ratify. Illegal activities and all can never be ratified. Is it clear, all of you? Yes, that is one. Correct. So that's why I said, anyways you will not do, you cannot ratify it. Agreed? Okay. Next one, appointment of subagent. So there are 2 types of people. One is called as subagent and substituted agent. What do you mean by subagent? Agent. What is it? Damsarajda? Sir, Hindi. Okay, one is agent. This is subagent. So subagent is nothing but people. When principal delegates the job to an agent, agent further delegates it to another person is called as subagent. Always remember in law, there is a maxim that delegatus non potest delegere. What do you mean by that? Generally, the person to whom the work is delegated cannot further delegate it again. It is delegated to you, you should only do. You cannot give it to anyone else. That power you don't have. Agreed, huh? So, sir, that is a generic law. A delegatee cannot further delegate. However, there are some exceptions to the rule. So, generally, subagent is not valid. It is void, generally. But this rule has certain exceptions. Now, what is that, sir? The first one is people. Term of appointment allowed it. Meaning, while appointing only, I told you, sir, you are appointing, you are giving the work to me, but I cannot do it, sir. I'll be further appointing someone else. Is it okay? He said, okay. Now, whenever terms allowed it, people, then okay, we do not have a problem. Second one, people, custom of trade provides for appointment. What is custom of trade provides for appointment, people?
Traditional practice.
So that is how that agency, that is how that industry works. That's a traditional practice. Everyone knows about it. Now, there is nothing, that's something you do not know. That custom only works like that. Like, sir, now I go and give, now for example, now say for example, Praveen is getting married. Now that suit. Now, how do you want to get married, sir? Like this. Okay. Where, sir, I don't know all of that. I'm giving all the work to an event planner. Correct? What do you call event management? I will give everything to event management. So, Praveen first on the day of wedding, he's checking everything, whether everything is happening properly or not. He first went to kitchen to see who is cooking. Their event manager is not there. Immediately he called, hey, event manager, come here. You said you will do everything personally. You are not cooking. What are you doing there? He said, sir, how can I cook, sir? You give me work, I will get the best cook and I will get it done. Okay, next people, he went to the stage. He's seeing who is singing. What, something Sangeet and all happen, no? Again he is not there. Again he called. Hey, where are you, da? You said you will do everything. You're not singing also. Now people, this is only called, custom. In a event wedding, in a event planner, he will take lump sum from you. He will further appoint people. Catering will be different. That is a custom that you also know. Yes or no? Yes. You don't think that he will only go and cook. Of course we know that. But it is not expressly given. Have you ever, you would have given at least catering once in your, you would have seen giving in your life. Correct? You will see one person coming and talking, negotiating it with you. Do you know whether same person has cooked? On the day of giving you the food, will that person only come? Then it is called as what? Agency. I will give it. They will further give it to someone else. And I know that is how this industry will work. The last one, people, unforeseen emergency. Emergency you can always delegate. Next one, people, is called as substituted agent. What is my substituted agent? Sir, I give a work for you. I will come and tell, sir, I do not know how to do this work. You do one thing. I'll give you one reference, contactor. You contact him, sir. He will help you in everything. So when the agent's name is referred by the agent, it is called as what? Substituted agent. Meaning what? I have my goods at my home. I want to sell them. I want to auction them. I will contact my advocate. Hey advocate, there is some goods, can you please sell it on behalf of me? He says, sir, this and all I do not know. You do one thing, I'll give you one very professional contactor. You contact him. Now people, based on your guarantee, I am contacting him. Now this is only called as what, people? Substituted agent. Substituted agent is, I am asking you whether can you do. You are telling, I don't know at all, sir. You contact another person. Is called substituted agent. Understood, all of you? What is the difference in substituted and sub-agent? Sub-agent is generally void. Substituted agent is valid. And in sub-agent, there is no privity of contract. For whatever agent does, principal will not be liable unless and until it is validly done. Whereas in substituted agent, there is a direct relationship. For whatever the substituted agent does, the principal will be liable. Understood? And one more thing in substituted agent is that the sub-agent responsibility is to take a proper care while giving the reference of a contact. If you have not taken reasonable care while giving the reference of the contact, if something goes wrong, you will be liable for giving a bad reference. Understood, all of you? So here, advocate gave the name of that auction person. If that person goes wrong, I will be responsible for giving you a bad contact. Understood, all of you? Okay, done. Next one, sir, rights of an agent. Turn on for some time. Rights of an agent. Right to remuneration. Of course, for working, you will get money. Right to retain out of sums received on principal amount. Meaning, sir, if I have spent any money for the business, I have a right to recover that money from this particular business. Next one, agents lien on principal's property. What do you mean by lien? So imagine I need to get my salary. Now I am selling the principal's car. I did not get my salary. I will not give you the car until my salary is paid. That is only called agent's lien on principal's property. Until my money is paid, I will not give you back your goods. The next one, people, right to indemnity. What do you mean indemnity? Sir, because of you, if I suffer any loss, then you will have to indemnify me, make good the loss to me. Simple. Okay, next one, duties of an agent. What are duties of an agent? Duty to execute mandate. I clearly told you, Macha, you are keeping the car in your godown. What if earthquake comes, car goes inside and earth comes back and stitches? Correct? To be on a safer side, always take insurance. If I have given you a mandate, it is your duty to follow the mandate. If you do not follow, and if at all I suffer any loss because of that, it is the agent's responsibility. Even if you have taken reasonable care. Correct? Because I have told you, in spite of telling, if you don't do, then who will be liable? You will only be liable, no? Yes or no? Yes, sir. Next one, duty of reasonable care and skill. Obviously, you have to take reasonable care, meaning you should not act negligent. Next one, duty to follow instruction or custom. What is the meaning of duty to follow instruction or custom? Now imagine people have appointed a agent in my business, like a cashier. I've told you, Macha, don't do credit sale. I've given you clearly an instruction, don't do credit sale. If you do credit sale, if the person does not come and pay, I will deduct that money from your salary. Agreed, huh? Hello? Yeah. Yes. Next one, avoid conflict of interest. What is this? I told you government, you remember, huh? I appoint, government appoints an officer to make sure you take a tender, give it to a tender to a person who gives you the least option. But whom will they give it to? Yesterday we saw, huh? In which point did you say? Where did we see it? What is the provision? We remember the example, not the provision. Interest something. Interest something. Where did we see? Under which provision did we see? Opposed to public policy. Interest against obligation. Avoid conflict of interest. Cut copy paste. Communicate with principal in difficulties. Meaning depression or pressure and all. Communicate. Difficulties here means nothing but that boat. Hello, Anna? You try not to make secret profits. What if I am doing another work? You should never make secret profits. To render proper accounts. Ola bill is 200, I'll say 400. Not to delegate. That means sub-agent is generally not valid. I told you, right? Generally not possible. Exception is what we saw. Pay some receipt for principal. I have taken money for you. I have to give it to you then. Correct, no? Not to use confidential information. Blackmail. You will know. You will have every information against him. No. Principal agent's liability to third parties. Principal liability for acts of agent. Agreed? Whatever agent does, who will be liable? Principal will be liable, provided it is within the scope. Don't sell my car for less than 5 lakh. If he sells it for 3 lakh, agent will be liable for 2 lakh. That is the meaning of within scope. Agent is not personally liable by contracts on behalf of principal. Agreed? Who will be liable for any contract done by agent? Who will be liable? Principal will be liable. But there are some contracts where agent can also be held liable, it seems. When? Exception. First one, pretended agent. I am going to the world and I am telling you I am Mukesh Ambani's agent. Is it true? No. We call such people as pretended. You are not. But you are pretending to be an agent. In reality, are you? No. In such case, of course, how can I hold Mukesh Ambani liable? Agreed? Next one, foreign principal law. Vijay Malyana. Person here only we are not able to catch. Principal is abroad. Agent is in India. Whom will we catch? Of course, agent only. Third one, agent does not disclose name of the principal. Something has happened. We have entered into a contract. Now they have done a breach of contract. We are asking, hey agent, tell us the principal's name. He is telling, no, I will not tell. We tied him to the chair. We hit him. He did not tell. We took his nails and all. We pulled. He still didn't tell. What else we can do? Then we will hold you only liable. Correct? No? Incompetent principal. In such case, of course, agent only should be liable. This is actually not possible. In not only minor. When will this scenario come? Imagine if a person becomes unsound mind. Lunatic. What will you do in such case? A person when the contract entered was good. After it became unsound mind. Then only person I can catch hold of is agent only, no? Next one, principal's liability when agent exceeds authority. Agreed, huh? I told you not to sell my car for less than 5 lakh. You went beyond. If the contract is separable and non-separable, what do you mean by that? Imagine people, look at the other way. I asked my agent to buy a car for me. Car should not be more than 5 lakh. Now he got a car. The car value was 7 lakh. You tell me, to what extent I am liable? 5 lakh? Yes? In a car, how will you make this 5 lakh, 7 lakh differentiation? For the front part, you are liable for the. How can I say that? So remember, if the contract is separable or non-separable, car can I say, yeah, 3 tires is mine, 1 tire is your. You use whenever you want, I'll use 3 tires. Can I say that? No, full liability will be on the agent only. No, sir. I told my agent to buy certain raw materials for 5 lakh. He has purchased for 7 lakh. Can you separate the raw material? Yes. We have purchased, I told him to buy 500 kg. He has purchased 700 kg. Can I divide it? Who will be liable? We are telling agent will be liable for excess. For whatever I have authorized, I will only be liable. Any notice given to agent is giving it to principal. So the people, now whenever you go and buy a second hand car, will you call the owner? You will not even know who is the owner. Whom are you contacting with? You're contacting is the middleman only, agent only. So communicating to an agent is like communicating to the owner. Next one, effect of misrepresentation or fraud by agent. Now people, I went to buy a car. The agent told me, people, sir, this is a beautiful car. Not even once accident, nothing, but accident had happened. They have all painted it. And he's telling, sir, mileage, I asked mileage. Mileage, sir, this will give 40 only, go. Yes, the people, after buying it, people, it is giving what? 4 kilometers it is giving. Now people, can I hold the principal liable or can I hold the agent liable? Agent, not the principal. Agent or principal? Remember, you can hold the principal liable provided you had authorized the agent to sell your car. How he sells it, you are liable for it. Then why did you appoint him? If you had trust issues with him on how he will sell the car, you shouldn't have appointed him. You are liable in the scope of the business. For selling of the car you are appointed. Whatever he tells, you are liable as a principal. That's why, macha, be very aware when you are appointing your agent. Don't randomly say, inky pinky ponky, macha, you are the donkey. We can't appoint our agent like that. Agreed? Yes or no? That's what they're telling you. See, within the scope, principal will be liable. I told you to sell my car. He will be liable. Understood? Okay, rights of third party. Contract by undisclosed agent. If agent does not disclose that he is an agent, if principal is disclosed before the contract is completed, the third party may refuse to fulfill the contract. What do you mean by that? Agent is not telling who the principal is.
Agent is showing us he is the principal.
Correct. No. Undisclosed agent means if agent doesn't disclose that he is an agent. Correct. So he's not telling to the world that I am an agent and some principal is there. Meaning he will never come and tell I am doing a contract on behalf of someone. He's buying as if it is for him only. But in reality, it is buying it for his principal. If the third party gets to know, it is for the principal he is buying. If he gets to know, the third party always has a right to cancel the contract if the contract is not yet completed. Because I have some disputes with him, I don't like him. So, can you cancel? Answer is yes, you can cancel. Clear? All of you? Now, one example if I have to give you. Let us imagine one student, because of some, discipline issues and because of certain issues, Arivu rusticated him. Meaning we will not give you our videos. We do not want to sell this because discipline matters for us. Now he is an online student, let us imagine. He buys it in the name of, imagine his name is X. He buys it in the name of Y. Or if he is coming and paying, we will get to know. He is sending his friend to make the payment. Macha, you go and do, you give it in your credentials, I will watch at the home. If we get to know it is not for you, it is for him, we have a right to cancel the contract. This is called as what? Undisclosed agent. Clear? Make sense? Performance of contract where agent is supposed to be principal. What do you mean by that? Performance of contract where agent is assumed to be principal.
Same only.
Both are same only. Where the third parties can hold you liable if at all you are interpreting to the third party that I am only the principal. If you are telling that, then you are only liable. Option of third person to sue the agent or principal. Meaning where, sir, wherever the agent is personally liable. Where and all agent is personally liable? When you exceed the authority, when it is a foreign principal, incompetent principal, in all such case, third party may file a case on principal or on the agent only. Next one, consequence of inducing agent or principal to act on belief that principal or agent will be exclusively liable. Now, third party needs to file a case. Should we file a case on agent or principal? They are telling you, you can file a case on agent only. When the agent only has clearly told you, sir, if something goes wrong, don't go to principal, you come to me, I will fix and give you. When you have only told, sir, don't go to principal, come to me, don't go to principal, come to me, he will come to you only. That is what they are telling you. Where he has clearly told, I will be liable, you can hold him liable. Understood? Yes, sir. Last one, sir, termination of agency. When and all agency will come to an end. Once business is done, car is given to be sold. Expiry of time, I have appointed you for 1 year, 1 year is done. Principal becomes insolvent. Of course, ultimate liability is his only. He only became insolvent. Agency will come to an end. Revocation by principal, meaning I have given you an authority, I am taking it back. Macha, if you take it back, my ego got hurt. That's why he also has a right called renunciation. Renunciation means people give up. Revocation is a right with the principal. Renunciation is a right with the agent. You have given me agency, I am giving it up. But remember, if both of them have done it for 1 year each, if you are revoking within 1 year or if you are renouncing within 1 year, it is still considered as breach of contract only. You are liable for any damages, if any. Because it's a breach only, no? You said I will be an agent for 1 year. So if you are ending the contract before that, you are still liable. Agreed? Last one, sir, death or insanity of principal or agent, you are definitely coming to an end as an agent or a principal.
On expiry of time means, does the agent didn't do the work on time or?
Now say for example, I am telling you, you have to buy me the raw materials as an agent for 2 months. Now 2 months is done.
Okay.
So that tenure is complete.
Positive.
Correct, yes. Last one, sir, effect of termination, people. When will the termination come to an end? Whenever you have communicated to the agent, whenever he gets to know, that day it comes to an end. What about third parties? Whenever they get to know, it comes to an end. Yes, sir, they can build you a case-based scenario here.
For third party or not?
Now imagine principal has communicated to the agent from 3rd August 25. We do not want your agency, we want to revoke it. When did he get to know? He got to know on 3rd August. So, for an agent, the agency is coming to an end on 3rd August. Now, principal also communicated to the third parties, outsiders, with whomsoever we are doing contracts. We communicated to them also. When did we communicate? We communicated on 8th August. So, for outsiders, agency is coming to an end when they get to know. Where exam, there will be case-based question. What if there is any contract done between this period? 4th August, 5th August, 6th August, 7th August, if there is any contract done, principal will be liable. Because the third parties do not know about this yet. Clear? Yes. Okay, go for a break and come. Issues are all there, huh? You're there, huh? Good. Okay. Chapter 3, Sale of Goods Act 1930. Sale of Goods Act, people, just for our information, no? Sale of Goods Act was once a part of Indian Contract Act only. It was a part, it was one chapter. With time, in 1930, they just separated both the acts. Indian Contract Act became Indian Contract Act. Sale of Goods Act was an independent act going forward. Even Indian Partnership Act was also one of the chapter in Indian Contract Act. Later on, they again took it, they made it a independent act altogether. That's why whenever you are reading Sale of Goods Act or Indian Partnership Act, you should always have the knowledge of Indian Contract Act. Because now in the Sale of Goods Act, they will not again tell you two parties are entering into a contract. That's all they will say. They will not tell you the two parties should be a majors. Just because they have not told it here, that doesn't mean two minors can enter into a contract. And don't think that is for that, this is for this, Gatam is Gatam and all that. Nothing. It is relevant here also. Agreed? Hello? First, goods. What are the okay, first thing is Sale of Goods Act. The first thing itself, people, what is goods? Goods ka definition they have given now. Goods means all kinds of movable property. So immobile property is out of this chapter. Only movable property. Other than actionable claim. Why actionable claim is other than here? Actionable claim will come in the last chapter. Negotiable instrument is called as actionable claim. Any document based on which you guys can take an action for money is an actionable claim. Example, promissory note, bill of exchange, etc. Next one, people, money in circulation. Other than money in circulation, your 10 rupee note on which Gandhi Tata is there, is it considered as goods or not? 10 rupee note on which Gandhi Tata is there, is it considered as goods or not? No? No? Yes, people, it is not considered as goods because that money is in circulation today. What is not considered as goods? Money in circulation today is not a goods. Sir, what if money is not in circulation today? Meaning antique coins. Antique coin. Yaar sir, antique coins are. Antique coins are considered as goods. Why? Correct, no? I don't know if you guys know. We have auction houses all around countries. We have places where your coins can get auctioned. When even in my childhood, I had that a huge madness towards collection of coins. I have some crazy coins. I don't know that is true or not. But if you say something, I don't know, archaeological department all comes means that can also happen, no? Actually, I have a coin which is at least 800-year-old, built with proper copper. I have one of that. She's like, sir, with the build up you said, I thought it is a gold. Copper, yeah, I have that one, and I have one bronze. Easily, one coin will be around 40 grams. One coin, it will be this much only. 40 to 50 grams. Yeah, so I was very mad on the coins. How we used to trade, we used to go to places. I used to invest 300, 400 and all. So now if I am willing to sell that coin, I know people can easily buy it for 8,000, 9,000 if I go to auction places. Good investment. So I always thank me as a child. Well done, the beta. Yes or no? So that is what they are telling you. Money in circulation today, basically your 5 rupee, 2 rupee, 100 rupee, 500 rupee, they are not considered as goods because you cannot exchange. If you give 100, what will you get? 100 only. No sir, if I give 100, I'll get 80 means you are mad. Of course, no. Sir, next one, sir. It also includes stock and shares. Macha, stock and shares means what? Stock and shares is nothing but your stock market. It is considered as goods. Just for your information, FII, before SEBI came into picture, buying and selling of shares was handled by SOGA, Sale of Goods Act. SEBI came in 1992. This came in 1930. But this chapter was there in Indian contract in 1872. So if a person wants to sell his share, which act will you follow? That's why goods were considered, shares were considered as goods. Understood? No, nice, no. Next one, growing crops. Palak shoppo, carrot, radish, bendekoi, grass, cattle feed. All that will come here only. Things attached to land and agreed to be severed. However you want, you can say. Now tell me, what does this severed means? Separate. Meaning, sir, there is one tree growing. One person comes and does like this. It is called as goods. Correct, huh? Meaning what? Anna comes and sees means teggedele. He will come and take. Correct, na? Yes or no? Sir, this is only called as what? Goods. Meaning, as long as the tree is inside the land, will it move? Will it move? It moves, no, sir. Hey, that's not a movement, Allah. I'm telling you, will it move from one place to another? So, when the tree is inside the land, we consider it as immovable goods. It's an immovable property. But the moment a contract is made to cut it, we will call it as movable goods. Why? What do you mean by things attached to land agreed to be severed? We call it as people timber. Yaar sir, the timber? Timber means people. What is timber? Timber is nothing but a wood grown for the purpose of to be utilized in construction, wood, furniture. We grow that for that only. Sir, what is the we grow that for that only means? Teak wood, sandalwood. Then you get some fruit from that, huh? No. That wood only is the wood. That is why we are growing it. Yes or no? Teak, you know the money. Then that is what is called as goods. So that's the definition of the goods. Clear up. Next one, classification of the goods. Goods can be classified into existing goods. Again, a little confusing topic, huh? Illa, this is crystal clear only, no? Okay, what is the goods? Goods can be classified into existing, future, contingent. Existing goods can be further classified into three things: specific, uncertain, ascertain. What do you mean by specific goods? Sir, I want one Natraja pencil. You go give money, Anna will give you one pencil. Correct? So the goods are existing when the contract is made. Now these type of goods are what? It's called as specific goods. Sir, I go to a shop. I take one lace, whichever I want. I go and say, cashier Anna, I want this. I will pay 10 rupees. I'll go. This is called as specific goods. Basically, what do you mean by specific goods? Definition: the goods identified at the time of contract. Which packet you are going to get, you know it at the time of entering into a contract is called specific goods. Now, what do you mean by uncertain goods? Uncertain goods means people. Imagine you guys are ordering goods online. You are ordering, say for example, some phone. Do you know which phone you are going to get? Of course, sir, the one I booked only I will get. No, in that they might have 10 pieces. 9 pieces has no damage, 1 has damage, you will get that only. But you do not know out of 10 boxes which one you will get, no. Now that is what is called uncertain. Uncertain means what? When the goods are in the bulk, we call all that is uncertain. Uncertain means nothing has been separated, everything is in the bulk. So, goods in the bulk is called as uncertain. What do you mean by ascertained? After the contract of sale is made, Amazon, you click enter. Out of 10 phones, 1 phone will be separated. Coolie ka logo will be put. It will be sent to you. That is only called as what? Separated. That is called as ascertained goods. Understood? He is like, yen sir, you are doing coolie promotion, son. Illeta. Okay, understood? Future goods. What is future goods? Anything which is going to be manufactured, produced, acquired after the contract of sale is called as what? Future goods. Example, cultivation of crops, sculpture or furniture. They will take an order from you. They will tell you to come back after 30 days. So when the contract was made, was the furniture there? No. He is going to now do it. That is only called as what? Future goods. Yes or no? Next one is contingent goods. So what is contingent? Anything which is uncertain is called as contingent. Example of contingent goods. Ship coming in contingent goods, that also can. Correct. So contingent goods is again, you can say goods coming by a ship or somewhere where the ownership depends upon a particular person. Now, for example, I think we had seen in the class also what now imagine I want to buy a particular painting. So I do not know how to get the painting. So what do? I go to a middleman. I will say that I want a particular painting. Can you get it for me? He will say I will get it, provided first I need to go and ask the owner. If he agrees, I will give it to you. If he doesn't agree, I cannot give it to you. But I will give if I get it. Now this entire sale depends upon whether this person will give it to us or not. Such type of goods are called again contingent only, uncertain.
Agreement to sell.
So what you have entered is agreement to sell. But whether it is certain or not, you do not know it yet. Such type of goods are also contingent only. Can you please explain uncertain? Okay. See, uncertain means nothing but when you are going. Let us imagine I am going to a shop to buy some rice. You remember the old Kirana shop where the rice will be kept in front of you. So our parents will go, they will take all the raw rice that will be kept in the bowl. They will eat. I don't know what taste they will get in it, but they will eat. They will say this idralli palav madidre, they will imagine it and they will say pack 25 kgs. Correct? Now Macha, have you seen in the background if you turn mute, there will be at least what, some 50 bags. In that 50 bags, do you know which bag you will get? You do not know. So when the contract is made, I say I want 25 kgs. Contract is done. He said okay. I said 25 kgs iruka. Usne bola iruku. Now that's all. Contract is made. Offer acceptance done na. Now Macha, the question is out of the 25 bags, do you know which one you are going to get? Contract is done, but the good is not yet identified. We call that bulk as unascertained. Because the goods are still not selected or appropriated. Now after you say yes, he will go back, he will pull one bag, he will just put it right on your shoulder. Inge. You will do like this and you will carry it. Correct? No? Yes or no? Now after the goods, after the contract is made, now the goods are selected. That is called ascertained. From the bulk, if one particular thing is separated, we call it as ascertained. Ascertained means nothing but appropriated, nothing but selected. Clear? Okay. Okay, next one, delivery. Macha, delivery can be three types. The first type is called as what, people? Actual delivery. What is my actual delivery? Actually delivering. Actual delivery. Actual. What is constructive? Constructively delivering. Actual means what, people? Tere haath se mere haath lo. That from my hand to your hand. Macha, understood? So people, actual means people, give me your hand, Isa. I'll keep it in your hand, Isa. That is only called as what, people? Actual delivery. Where there is a physical delivery directly made to the buyer. The next one is called as what, people? Constructive delivery. We are not directly giving it to the buyer. Everything is happening on a phone call. Meaning, let us imagine if there is one go down. In the whole go down, there can be, some full goods. Let us imagine like this. There is a whole go down of stock. Some stock. This stock is being auctioned in some other place. So the owner of it has also come to another place. So an auction is happening in a different place. Now the entire go down, the whole stock has been sold for 2 crore in the auction. Who is taking care of this go down? One manager. Now he will leave anyone inside, that will be only the owner. No one else he will leave. Who is the owner? A. Now in the auction, who won the auction? B won it. A calls the manager and says, "Hey manager, from tomorrow, the owner of this go down will not be me, it will be Mr. B. What did manager say? Okay, sir. A will say, I'll give you his number also. You also talk to him once. The manager says, sir. Manager reporting, sir. He will say, okay, sir. Whenever you come, I'll allow you, sir. Now, people, goods did not move an inch. But did the delivery happen? Yes, is called as constructive delivery. When the goods are in possession of a third party, the ownership transfers on an acknowledgement. Hello. Pakana. Symbolic means what, people? Symbolic. ABD Villiers. Sorry, Anna is not there. Now people are Virat Kohli. Illa. Dhoni. Okay. Now Dhoni hits sixes. Now they'll come, Dhoni, please come, we'll give you check. They will show on the check 1 lakh rupees. But did you see money went to his account or not? Then what is the guarantee? Now people, this is a symbolic delivery. Sir, today, just to take it for the camera. In your bank account, we'll credit it later. So symbolic delivery means what? When you want to give something, we will give something else as a token of delivery. If I take a car, what? Should I tell you, sir, stand from crane will put on your head? How will you give the delivery? Key. Now, key is the symbolic delivery. Correct, huh? Yes or no? That's what I'm saying. Just like you took one rice bag. Can you tell her, sir, car inge vechika, sir? And say, illa, no. Yes or no? Okay, next people, there are two types of documents. One is called as document of title. One is document showing title. What is document of title? Document itself is ownership. Example, you go for shopping. Before you enter into shop, if you have a bag, you will go and keep it in a counter. Anna will give you one token. Now imagine you lose the token. I find it. I go and give it to the Anna. Anna will give me the bag or not? No, macha. Who you are, who am I, who the goods are, nothing. The token is the ownership. Whoever has it is the owner. Agreed? In shopping complex, now that is how it happens, Roda. Now that is only called as document of title. You lose this token, you lose the ownership of the goods. Hello? Another example, bearer check. Whoever finds it is the owner. Negotiable instrument, you would have seen, no, bearer instrument. Whoever finds it is the owner of the instrument. That is also an example of what? Example of document of title. Understood? The next ones are document showing title. Your DL. Imagine anyone who doesn't have DL here. Okay, what's your name? Shweta. You have a DL. Driving license. Okay, you don't have. You have. What's your name? Nidhi. Now Nidhi lost her driving license. Shweta found it. Does that mean Shweta learned the DL? No. That is what is. DL is just a document showing title. It just says that, okay, Nidhi is the owner. Now imagine you have a bike, you have a RC card. Just because Shweta finds that RC card, that doesn't mean that the owner of that bike becomes Shweta's. That doesn't happen like that. That is the meaning of document showing title. Example, share certificates. Whosoever name is written on a share certificate, it is just an indicative thing. We are just saying that they are the owners, that's all. If you find it, you will not become the owner. That is the meaning of document of title, document showing title. Next one, contract of sale and agreement to sell. We'll see the differences and all are there. Now tell me the difference between sale and what else? Hire purchase. What is the difference? Here ownership transfers on the first payment only. Or irrespective of the payment. Hire purchase, ownership transfers last. Risk transfers immediately. Risk transfers at the last payment. Here subsale possible, meaning I will take it from you. I can further sell it. Here not possible. Correct? And what else? What else difference? Okay, next is sale and bailment. What are the difference sale and bailment? Permanent transfer of ownership and goods. There is no concept of returning it. Here, temporary, and it's always, it has to be returned. Temporary transfer of possession only. Ownership will not be transferred. And remember, sale is always for consideration. Money is mandatory. Bailment, gratuitous, non-gratuitous. Correct? Yes, sir. Okay, and what else we have? Sale and agreement to sell. What is the difference? Sale is immediate transfer of ownership. Agreement to sell, you are entering into a contract today, but ownership transfers in the future. Example, future goods. we are entering into a contract to imagine for him to prepare a sofa. Sofa is going to be manufactured in the next 30 days. Ownership will not get transferred on the day one. Ownership will get transferred only after the goods are manufactured or upon certain event, whatever you guys have discussed. Agreed? That is what is agreement to sell. Hello. In sale again, risk transfers immediately. Ownership transfers immediately. In agreement to sell, risk and ownership is still with the seller. Agreed? Buyer will get the ownership only after that particular manufacturing or something is made. Until then, seller only will be the owner. Agreed? Insolvency, there is always a risk. Here, that is okay. Agreed? Hello? Pakkana? Okay. And mercantile agent? Agent working in a business is called as mercantile agent. Correct? Middleman. Okay, done. Any doubts you had in unit 1 now? Next one, people, conditions and warranties. What is condition and what is warranty? Whenever a sale is being made, the seller will make 100 stipulations. Hey, one more thing, we had the price. So, in valuation, that's what price. Now, people, whenever in a sale, how is a price determined, people? Price can be determined by, see here, first one, by contract between the parties. In the contract only, you will say, the price of the goods are 1 lakh. Done. That is how you determine the price. First way, easiest way. Done. Second way to determine the price of the goods is by course of the dealing between the parties. What do you mean by course of the dealing between parties? Whenever it is a long-term contract, imagine a farmer enters into a contract with Big Basket, Blinkit, Swiggy, Zepto. Every morning you have to go and give them carrot to onion, no? Where are they getting? They are clearly writing in their app, directly sourced from the farmers. But today carrot is 500 grams is some 25 rupees or 30 rupees. Tomorrow it is 45 rupees. That means every day they are entering into a contract. No. That is the meaning of course of dealing. We have entered into a contract today that farmer has to give all the carrots that he grows to Zepto, Swiggy, whatever is the app. You have to give it to me only. We are entering into a contract. Price will be decided based on that day's price. If that day is high, it will be high. Low. That is the meaning of course of dealing, meaning it fluctuates. Hello? The third way of entering into a price is a sale has happened, but both the buyer and the seller did not discuss the price. In such case, the buyer has to pay what is reasonable. Do not get confused here. In exam, you guys will write, if the price is not discussed, it is a vague contract. Quid pro quo is not there, and hence it's not a valid contract. People will write it. Remember, as per Sale of Goods Act, if at all the sale is made, if the price is not determined, the buyer has to pay whatever is reasonable. Hello. The next way is called as valuation. What do you mean by valuation? The third party. Now let us imagine, people, I want to sell my law classes to you. At what price I don't know. I'm just a teacher. My commercials I'm not very sure. I think what can I sell it at 200? Say no, increase sir, you should say. 500? 5,000? 10,000? No, okay. Greedy you should not be. Too much? Not too much. Okay. Now people, what did we say? Shweta says, sir, you are saying a too higher price. You have to keep it somewhere around what? 2,000. Okay, Shweta says 2,000. I say, Shweta, I need to pay one EMI. Keep it at 5,000. She says, no, sir, it is still high. We'll do one thing. Shweta will do one thing. Let us give this job to ArivuPro. whatever ArivuPro says, if I am also okay, then we will make the sale. Is it okay? Shweta says deal, I also say deal. Now ArivuPro is called as what? Third party. They are only called as valuation agencies or valuers. Understood all of you? So the price can be determined in any of these ways. Hello?
So in this case, if valuer refuses to say that.
What if valuer is refusing to give that particular thing? If the sale is not yet made, the contract can be avoided.
That is one previous year question like this.
If the sale is made and if the valuer is not able to determine the price, buyer has to pay whatever is reasonable.
To sale is made, sir.
Sale is made means, imagine you have given me the goods, we have agreed and you have transferred the possession to me.
If not transfer means it's so.
The contract can be avoided. Avoided means what? Cancelled. Yes, sir. And whichever party is preventing, imagine I said whatever Arivu says, that will be the final one. Now what I am doing, I am trying to influencing it. They will ask me, sir, can you give us all the videos so that we will evaluate and we will do the pricing? I am stopping. I am not giving videos on time at all. So I am okay with Arivu doing, but I am only stopping everything from happening. Now they say in such case, the party preventing will be liable upon if she files a case. She can avoid the contract. She can also claim compensation if someone avoids the valuation.
The owner refuses to give to the valuer so that they can't make the price.
Correct.
So in that case, they can buy the good or they can.
So if the goods are not yet transferred, then you can avoid it, meaning you can cancel it. And the person who is preventing.
The person needs the good. But for say emergency purpose, they need a good. But the owner refuses to give to the valuer so that they can't determine the price. In that case, what we can do?
See, if at all the value is not determined and the sale has not yet happened, in such case the contract will come to an end. Yes. If not, the reasonable price will come into picture. Right of lien can be applied if sale is made. Yes. Clear? Hello. Done. Okay, done. Conditions and warranties. What is this, sir? Whenever in a sale, whenever there is a stipulation. What do you mean by that? In a sale, the seller will directly tell you people. Imagine if boys are going to try something. Darshan goes to buy a jacket. Now Darshan wears a jacket. The sales guy, sir, Hrithik Roshan, sir. Sir, Shah Rukh Khan, sir. Correct, huh? Now people, whenever a sale needs to happen, he will say, sir, pakka fit. Perfect. Correct, no? You will say different color. No, sir, this color only will suit you. Why? Because they do not have other colors. Correct, no? Now people, in a sale, the seller makes 100 statements to convince a buyer to enter into a contract. These statements are called as what people? Stipulations. These statements can be classified into two. One is important to my contract, not at all important to my contract. Act through. It's okay if that's not there also. Whatever is important to a contract, you have to fulfill. If that is not fulfilled, the contract can be avoided. Darshan goes and says, I need a jacket which can keep me warm. I'm planning to go to in the Himalaya. I get a result at 2 o'clock. I'll be in Himalaya at 3 o'clock. Now Darshan is telling, understood? Now he is going and preparing first only. I need a jacket which can, understood? Now people, Darshan wore the jacket, sat in the first bench. This AC only is feeling cold. Forget about Himalaya. Now, the whole purpose of him buying that. Of course, when you are checking in Bangalore, even if it is little thick, you will find it warm. Now, how can I say, should I go and sit in the fridge for 5 minutes? How will you test the product? Now, it is impossible. Now, you believe in what he says. Now, few people will tell. Now, I was seeing in one Instagram ad, one pant is claiming that you own a black pant, it gets faded away. We solved your problem. A pant which never gets faded away. Black pant. They are advertising it crazily. I don't know if you guys watch Shark Tank and all. You guys watch? On that one, an ad had come. I forgot the name of the shirt. Wrinkle free. Dhoni uses it. And that is what he comes and pitches there. Dhoni uses that. Wrinkle free shirt. Wrinkle free shirt. You think, you as a buyer, if you buy that, what you will do first? Hey, see, have wrinkle irko, correct? Stain free. You will try, put coffee. You will try. Of course, no. Then these aren't these promises being made then? What if the promises are not served? My question, you have 500 shirts in the market. Why did you buy that wrinkle free shirt? Understood? Stipulation. Shirt you have 500. You are buying this because he made a promise that it is a wrinkle free. Now wrinkles happens are, you can go and put it on his face, you can give back the money, and you can also ask for compensation, mental trauma, how much stress you took to dress. Yes or no? Yes or no? So sir, remember, if at all it is a breach of condition, important, wrinkle free, important. Now in such case, people, remember, you can cancel the contract, ask for compensation. Sir, I purchased a shirt, sir. One button is doing takita. Loose. Button is loose. It's okay. You put one thread, it will fix it. You can't go and say, sir, I've used one, sir. Take back and give back my money for one button. Maximum, okay. Warranty period is there. If they are claiming, nothing will happen. Okay, go and get another button from them. Max to max, you can do that. Hello? Yes, sir. Actually, that happens. Now, recently, I'll tell you my scenario only. Imagine I got a car. Now, first day, people, you will be very sentimental, no? At least a little. I'm trying to close the door. Door only is not closing. Now, my immediate reaction was, hey, give me another car. Na? This car is not closing properly. After RTO registration, after everything has happened. Now, what will they say, sir? You don't worry, sir. We'll fix it. Now, people, it is a responsibility to fix it. Now, you tell me, because a car door is not closing, can I return the car? Hey, take the car and give me another car, can I say? People, they can repair it. That is called warranty. That is what they say in the market. 3 years, 5 years, anything happens, you come. Are you getting it? Hello. That is called warranty. Essential condition, non-essential warranty. Hello? Sir, when can the warranty be treated as condition? Condition be treated as warranty. Warranty can never be treated as condition. But breach of condition can be treated as breach of warranty. What do you mean by that? It was something important to you. It was not met, but you were still okay. You did not return the goods. Is called as breach of condition, treated as breach of warranty. When is that? When buyer waives off the stipulation, give up. How many of us know that we can go and fight for our right? So we all fall here. Treats breach of condition as breach of warranty. Meaning what? I will say, I'm happy with what I got. You just take care of repairs. Correct? Now imagine, people, on Amazon, I ordered a top grade quality of sugar. The sugar price was 100 rupees per kg, but what they delivered me is one level below the top grade, 80 rupees. But after using it, I got to know, hey, there is no difference at all. Both are same only. Now what did I say, Amazon? Amazon, technically speaking, I'm paying money because it is top grade sugar. So my main condition is top grade. If you did not serve that, I have a right to return back the goods. But I'm using it because I'm happy with it. But that doesn't mean that extra money you only keep. I will claim for a refund. I'm treating my breach of condition as breach of warranty. I'm asking for my money back. Understood? Third one, contract is non-severable and buyer accepted the whole. In a product, it may so happen that people, one part of it you will like, other part you will not like. But what you like makes you compromise on what you don't like. So you are treating, you have to either give it back or you have to accept it. So you are treating breach of condition as breach of warranty. Meaning you can ask for the repair or you can ask for some compensation. But you cannot say that I just take away the not good part and give me only the good part. You cannot say that, right? Yes or no? When will these non-severable things and all happen? Imagine if you buy a bike. I asked for a bike with a good mileage. Now they suggested me what? Ninja Kawasaki, which will give me so much of mileage that I can just go to petrol bunk and I can come back home. Now people, my purpose is not served. But when I sit on that people, background, that doom, automatically that music comes. Correct, no? Yes or no? Now people, I like the touch, feel, comfort of the bike. But macha, my main purpose was mileage. I like the but I don't like mileage. Now what to do? कुछ पाने के लिए कुछ खोना पड़ता है. To get something, it is okay to forego something. So I want touch, feel it. I should be okay with the mileage I get it. Clear? Yes. Next one, sir. Fulfillment is excused by law, meaning change of law. I would have said I want a particular, say, set of grade of something. Now, say in the case of Gujarat, we would have said I would want a license. I would want it here. I would want it to deal in this particular alcohol products. Change of law. Now I can't do anything there. I cannot go and file a case that, hey, give me compensation, give me everything. Breach of condition. Basically, we are entering into a contract because of that only. But because of change in law, it will come to an end, and I cannot do anything about it. Correct? Yes, sir. Okay, done. Now, people, the conditions, the stipulations can be of two types. One is express, one is implied. Express is whatever you discuss there. Of course, that we cannot write. But what is the next one is implied, meaning you have not discussed, but law assumes it to be there. That is called as what people, implied condition and implied warranty. Now what do you mean by implied condition, sir? Implied condition, first one, people, as to the title. Whenever you are selling it, people, I am assuming that you are only the owner of it. That is only called as what? Implied condition as to the title. Next one, sir, implied condition as to the description. What do you mean by description? Whenever a person is selling any product with a description, it is your duty to meet with the description. What is a description? Description can be anything. If you are claiming it as strain-free shirt, you're calling it as wrinkle-free shirt. It's a description. I'm calling something as a Mysore silk. You cannot just put some silk and say Mysore silk. Description is there. Agreed, right? Now, whenever you go to a bakery, the first thing we ask him, sir, bread fresh idya? He will say, sir, just now. Oven in the inge kaidi. He will do like this. Correct? No. This is a regular set of questions, sir. And they will also say, sir, fresh, sir, ippo da pannirke. No, same questions, wherever, that's the same thing only. Now, all these are descriptions you are saying. Agreed? No. It has to meet with the description. What is sample? In the bowl, when you tested rice in the bag, it should be same only. Difference shouldn't be there. Agreed? Sale by sample and description. When you say it's a basmati rice and you keep some normal rice there, is it right? Answer is no. You are calling it as basmati. Sample you are giving something, but you are also calling it as basmati, right? It should be basmati and the sample should also be basmati. Next one, sir, quality or fitness. What is quality or fitness? Fitness here means, people, nothing, not fitness. Fitness here is whatever is the purpose I communicated to you. Is your product serving my purpose? Example, mileage will come here. Darshan's jacket should be able to take the Himalaya weather. That purpose will come here. Now we will see whether the product is fit for my purpose is what we will see. That is the meaning of fitness here. Understood? Pakka na? So remember, whenever the buyer has communicated the purpose to the seller, and the buyer relies upon the seller's communication in the choice, and if that particular purpose is not met, I can hold the seller liable. Now I am asking you for a thick jacket. If it is not being served, I relied upon your judgment. I can hold you liable. I can come and give back the goods. I can take back my money. Clear? Yes. Hello? Next one is merchantable. What is merchantable? Merchantable means nothing but people, the goods has to be free from defects. I get a phone, the full glass is gone, full pudi pudi. Can I take it? No, of course it should be free from defects. Next one, wholesome. Wholesome means what people? It should be free from defects. Understood? Sir, then both sound similar only. What is merchantable? What is wholesome? We use merchantable for non-edible items. We use wholesome for edible items. Wholesome, we use it for bread. We use it for milk. We use it for whatever it is. Basically, I'm telling you, it should be free from defects. Here means I'm speaking from edible items. Here, okay, done. Next one, implied warranty. First one, people, warranty has to undisturbed possession and non-existence of encumbrances. A sold his bike to B. A sold his bike to B. Now on this bike, people, A has taken loan. Was this communicated to C? Answer is no. Now Papa A gave, C gave the money to A and got the bike. But after he started using people, A did not repay the money to the bank. Now the banker started calling. Wherever C is there, they will start coming and taking away the keys. Now is he able to enjoy the goods he has purchased? That is the meaning of warranty as to undisturbed possession. C has two rights. Pay the money, get it from A, or call A and tell him to clear the loan. Both the rights C has. Understood? If C pays the money and can he recover? Yes. It can also be considered as payment made by a interested person. Where did you guys see that? Which topic? Payment made by an interested person.
Section 69.
What is the topic? Quasi contracts. Non-existence of encumbrances. Understood? What is encumbrance? Encumbrance means loans. You shouldn't have taken any loan on that particular property, product. Encumbrance means loans, pledge. Agreed? Next one is quality or fitness by usage of trade. What is quality or fitness by usage of trade means? Example. Again, one topic where we don't find examples. Umbrella example. Understood? In one scenario, what is quality or fitness by usage of trade? Now, why will you guys use umbrella for? Rain, no. Why? Who said you should use umbrella for that only? Who taught you like that? I'm saying who taught you like that? No, I said umbrella. Why do you guys say that it is for this only? You can see these umbrellas, See the cost.
1 lakh.
And you know the beauty of this umbrella? It will not stop rain. Nice, no? See, what does it say? No, full read. Gucci it has rupees 1 lakh sun umbrella, may be stylish, but not waterproof. Have you heard any umbrella which is not waterproof? This is only called quality or fitness.
Purpose.
That is only called as quality or fitness by usage of trade. Umbrella is used for rain by usage. People have used it for. That's all. No, who came and said umbrella should be used only for rain? That is only called as usage or trade. Now, if a seller or a manufacturer, if at all he is diverting from that, it is your duty to disclose. You have to tell that I'm not, or I'm selling a product which does not solve your purpose. Understood? If it does not solve my purpose, you have to pay compensation to me, is what they are telling. Understood? Again, this is one example where you will not find an example. Clear? Okay. Next one. Disclose dangerous nature of goods. Pufu will kill you. They will put no. Yes or no? Keep the medicine out of the reach of children. Deodorant, highly inflammable. Yes or no? They'll put no. Deodorant they put no, highly inflammable. So caveat emptor, exceptions people. Whatever we saw in the top, same thing will come. Fitness as to quality or usage. Goods purchased under brand or patent name. Goods sold by description, merchantable quality, sample description, trade usage, seller actively conceals a defect, nothing but fraud. Correct? Hello? Done. Third one, sir, transfer of ownership and delivery of goods. Passing of property. Remember, in Sale of Goods Act, property means ownership. Property here does not mean immovable goods or movable goods. Here property means ownership. Now, when will the ownership transfer in case of a sale? It depends upon what type of goods it is. If at all it is specific goods or ascertained goods, they're telling you the ownership will transfer when the goods are in deliverable state. What do you mean by deliverable state? The goods are ready. Everything is finalized. Tag, pricing, what you need to pay, everything is finalized. If the goods are in deliverable state, whenever the contract is made, the ownership will pass. Whether the goods are delivered or not is irrelevant. Whether the money is paid or not is irrelevant. The moment the goods are in deliverable state and the contract is made, contract is nothing but offer, acceptance. The moment this is there, that's all. The sale is made, ownership is transferred, risk is transferred. Understood? Hello? Pakka? Okay. Next one. The goods are to be put into deliverable state. Example. Now imagine people, I'll say this. Anyone wants to buy this mic? I'll say the price is 500. Now Shweta says, I want to buy this mic, sir. Yes, Now people, sale is made. Yes, sale is made. Now people, it is right here. Now you know in our examples what will happen. Earthquake will come, earth will separate, mic will fall, earth will come. Now my question is, who will bear the loss? Is it Shweta or is it me? You only, not me. Now the question is, sir, did I give this to her? Answer is no, it is still with me. But did we agree on the contract? Yes. I said 500, she's okay. She said, okay, sir. Now has she paid the money? Answer is no. Money is not paid. Goods are not delivered. But still who will bear the loss?
Buyer.
Buyer will bear the loss, because remember, if the goods are in deliverable state, whether price is paid, whether the goods are delivered, it is irrelevant. Ownership transfers the moment she said yes for 500 rupees. Who will bear the loss? Shweta will bear the loss, because the goods are complete. It is in deliverable state. Clear? Okay, next one. The goods are to be put into deliverable state. What do you mean by that? Now, whenever I go, I shop for a belt from a shopping complex. I see that one turning thing will be there. I'll find one belt, I'll take it, I'll try it, it will not fit me. So we'll call Anna, come here. Anna will get one cutting plier. Sir, okay, but I'll do it. Hello. Now what they're telling you people? Ownership. The goods are identified of all the belts, unascertained goods. You have picked up the belt which you need, ascertained goods. The goods are identified. Now is the ownership passed? Ownership is passed. The answer is no, it seems. Why? Because the goods are not still complete. When will the goods become complete? When that hole, the punch is made. The goods are put into the deliverable state, meaning something is yet to be made to the goods to make it complete. Hello? Pakana, understanding? When will the ownership pass? When the goods are put into the deliverable state. Are you getting it? Pakka. You can take example here of tailors, and even tailor also same thing happens. No, you take a cloth, you give it to them, you give your measurement, they will stitch it and they'll tell you, sir, it's ready, ma'am, it's ready, you can pick up your cloth. So when will the ownership pass? When the goods are put into deliverable state and you have been communicated. Sir, what if the goods are stitched but have not yet been communicated? If it is not yet communicated, the ownership doesn't pass. Hello? Okay, third one, goods in deliverable state. Seller has to do something to ascertain the price. Meaning, sir, I need to count, I need to measure. Meaning I go to a, old shop, I do not buy ready-made shirts. Imagine I take one particular cloth. So they will measure. They will say, sir, this much I want. They need to take it. They will cut it. They will say, okay, you need 2-meter shirt piece. Now when will the ownership pass? They are telling you which color I want is identified. Correct? Now when will the ownership pass? After the cutting, after the seller does something to ascertain the price. What is the seller doing here? Measuring. 2 meters is what I need. After that is when you will know that you need to pay this much. After that only the ownership will be passed. Clear? Hello? Done. Unascertained or future goods. When will the ownership pass? If it is an unascertained or a future goods, the ownership will pass whenever the goods are ascertained and appropriated. What do you mean by that? Imagine I go to a tomato Anna. One Anna is selling tomatoes. Huge heap of tomatoes. Correct? There is tomatoes here. Now people, I am saying I need 1 kg. I asked him what is the price. He says 1 kg is 10 rupees. 10 rupees per kg. Now I am said I am okay. He asked how much you want. I said 2 kgs. People offer. I want 2 kg. Acceptance 10 rupees. I said okay. Offer plus acceptance made. Goods are in front of me only. Is the ownership transferred or not? Why? The goods are still in the bulk. I do not know which 2 kgs are mine. Now the goods has to be separated. A cover will be taken. The tomatoes will be hand picked. Now my question, who will pick it? If seller is picking it, buyer should be okay with it. Why? Because tomorrow you will blame. You gave me all bad tomatoes. I should have given you my acceptance. I am okay if you select it. I am okay to use it. I should have given my acceptance to him. Or I am picking it. He should have given his acceptance to me. It's okay. I will give you the leverage of choosing your own tomatoes. So, appropriated in an unascertained goods. The goods should be separated from the bulk. Who will separate it? The separation can happen from the buyer or it can happen from the seller. But each other, they should have given consent to the other party. If seller is appropriating, buyer should have given consent. Buyer is appropriating, seller should have given the consent. Clear? Hello? Next one, sir. Sale or return basis. What is sale or return basis? I buy goods from, say, Amazon. When will the ownership pass? Whenever you expressly give your consent. Hey, Amazon, what shirt did I loved it. You're calling him and telling her. Calling is of course not possible. So what is this? Nothing but review. Second only you are giving a review. That means you have accepted, no? Okay, second way. How else the acceptance is made? There is something called as return period 10 days. You keep the goods beyond the 10 days period. That means you are giving an implied acceptance. Third one, I am taking it. I am gifting it to someone else. I will gift it only when it is mine, no? Hello? You are doing something equivalent to an acceptance. 3 ways in the case of sale or return basis. First of all, what do you mean by sale or return basis? Sale or return basis means a seller gives you the goods with a particular condition that, sir, you try using it. If you do not like it, you give it back to me. People, if at all in the 10 days, something happens to a shirt, who bears the risk, people? Let us imagine, you buy it from Myntra. They put a tag and send, no? You should not cut it. Something like that? Hello? Now imagine, someone, say for example, Darshan only ordered a shirt from Myntra. Yeah? The tag is there. He has not yet removed the tag. The buttons are there. He wore that particular thing. And he stood in front of the mirror. One button and it went like a bullet. Now my question is, the button is gone. Who bears the risk of this shirt? Myntra na or Darshan na? In reality and in theory. Tell me both. Reality it is Darshan only, yeah? In reality, people, as long as tag is there, what will Darshan say? I have received a defective goods. In reality, no. Because tag is important. It is not yet cut. Look at the other way. Cut. Now you see button is not there. Macha, we assume that you have used it. Reality.
While delivering, they have checked that, but it's everything.
Where? Who will check? Out of all the lakhs of order today, who will check? Yeah, I'll tell you recently only one incident happened. I purchased one phone on Flipkart. In Flipkart, there is something called as, what is that? Open box delivery. They will give you an OTP. That phone will be delivered to you. You need to open it in front of the delivery guy. You see whatever you want. Dent, scratch, fade, mark, whatever you want. Of course, we saw everything. Everything was clear. After we took it, when I went to put a screen guard on it, that time the person is saying, sir, there is one scratch here. If I see there is a clear scratch which was not at all visible. That was, I'm saying, immediate evening. I called Flipkart. So there's a scratch on a new phone. Phone is expensive. I said, sir, can you look into it? They said only one thing, sir. You gave OTP, it is done. Flipkart can't do anything in this issue. It is assumed that you did the scratch, not we. That's all, no? Now, for them also it was a need of the hour. What and all people did. If you go back 5-6 years, what and all they did. They opened iPhone, they replaced parts and all they gave. They returned the product. So today, at least for some time, return was not there. Replacement was there. Now replacement also is not there for phones and all. Correct, huh? But remember, in a sale or return basis, until the acceptance is made, the responsibility is on the seller in that period, in the 10 days. After 10 days or after acceptance, it is on the buyer, provided Darshan has to take proper care of the shirt. In the 10 days, you cannot go and wear it for a function, hide the tag. Correct, no? Yes or no? People will do it. I have seen people do it also. Imagine you are wearing a blazer. You order a shirt. Anyways, tag is inside. Wear blazer on it. Sir, you are saying what to do, what not to do. I'm saying what not to do. Clear, huh? Okay, next one. Who can transfer the title? This is where I told you. We'll be seeing it. Where? Pledger. Who can create a pledger? We saw there now. I told you we'll be seeing it. Who can transfer a title? Generally, who can transfer? The owner can transfer. But this rule has an exception. That's why we call it as nemo dat quod non habet. What do you mean nemo dat quod non habet? No one can give what they do not have. If I do not have the ownership, how can I give you the ownership? So technically, who should transfer you the ownership? Only the owner can transfer the ownership. However, this rule has exception. First one, mercantile agent, correct? Car was sold by my agent. That is equivalent to me selling it only. Agent is not the owner, but he is still transferring valid ownership to the buyer. Agreed? Next one of the joint owners, correct? If the product has two owners, one of them is selling it. If he is having the possession of it and if he is selling it, it is considered as a valid sale. Third one, sale by person in possession under voidable contract. What is this? Imagine people, one person forced another person to sell his bike to him. And he made him sign all the, documents. He forced him, he literally threatened this person. He threatened. Now I made him sign all the documents. I took that document, now I'm selling it to another person called Mr. C. C took all the documents. Yes, everything is fine only. Now the question is whether this person got a valid ownership or not. I took it from one person by force. I'm further selling it to another person. The question is whether this person got a valid ownership or not. Why? Hey, let us imagine good faith. I do not know anything this happened. Whether C got a good ownership or not. Why?
Who transferred it, right? He is not the actual owner. And the original owner can take back the goods and the C can ask for the amount from the.
Correct? No. Remember, all this depends upon whether this sale happened within reasonable time and this person, whoever was forced. Yesterday I told you in voidable contract, Macha, do you have guts? Come to the court and cry today only. If you do not have guts, the world will not know all this happened. In that case, who will be liable? In that case, you will be liable. This sale will be considered as valid or invalid. It will be valid. Because this person, how will you know anything based upon the document? Document, everything is good only, no. Story is bad. That story we will get to know when you come and tell it to the court. Agreed? Yes, sir. That is why it is coming under exception. Sale by a person in possession under voidable contract. And the contract is not yet cancelled. That means that person has not gone to the court and taken any action. Then it is valid. Next one, sale by person obtaining possession before passing of property. Meaning sale or return basis. I purchased something on Amazon. Up to 10 days I have a return period. So up to this 10 days, who is the owner? Amazon is the owner. On the 5th day, I gifted this goods to someone. Is it possible? Yes. Amazon is still the owner. But can I gift it? Yes. That is what they are giving an exception. Sale by a person who has got the possession of the goods before they got the ownership. I got the shirt. My ownership, it will take 10 days. Now in the 5th day only I gifted it. I will gift only that something which belongs to me. Now is it valid? Answer is yes. Sale by a non-owner. Understood? Next one. Sale by person who has already sold the goods but continues in possession. What is this? Example? What is this? Now let us imagine. Okay, once again, see. Yes, sir. People, does anyone want to buy this mic? Okay, Praveen wants it. 500 rupees. Praveen, okay, na?
Yes.
Okay. Now, is this a valid sale or not?
No, sir.
Why?
So that property is
No, mine only. Is it a valid sale or not? Yes, sir. Now, people, what did I type, you know? Someone online said, sir, will you sell me your mic? I said, yes. They offered me 400. I said, yes, I'm okay with it. Can I come and pick it up tomorrow? They asked. I said, okay. That's what I said and I clicked enter. Now, is this, you tell me, uncertain goods, ascertained goods, what type of goods? Existing goods or future goods or what it is? Existing goods. In case of existing goods, when will the ownership pass? Whenever the offer and acceptance. Delivery and price is irrelevant. Agreed? Now online person saw the mic. I said yes, I entered. Price agreed. 400. Ownership is transferred or not? Yes or no? Now who is the owner? The person attending online, Sanjay. Sanjay is the owner. Yes or no? Who is the owner? Sanjay. Now did Praveen get the valid ownership or not? First I clicked and then I asked Praveen. Now you tell me. Praveen gave 500. I gave mic to Praveen, done. Contract is done. Whether Praveen got a proper and valid ownership or not.
No.
Good faith. Praveen got it. Praveen got it. Then what about Sanjay?
The mic is still with you, sir. So
Correct. Agreed. So that is only called, now read this, sale by a person who has already sold the goods, continues in possession and further sells it. Buyer acted in good faith. Is it a valid sale? Yes. Why? Macha, he has seen me using this for the last I don't know how many years. Now he knows it is mine. And I'm telling I'll sell it to him. And the property is still with me. The goods are with me. And if I'm telling Macha, come and take. Obviously, how will he know all this has happened? The law will favor him. Now what about Sanjay? For Sanjay, it's a breach of contract. Now can Sanjay file a case on me? Yes. For what? Damages. What damages? Ordinary damages. I have agreed to sell. I did not sell. Now Sanjay will go and search for a similar mic. For Sanjay, it might cost 700 rupees. At what price did I agree? 400. What is the loss he suffered? I need to pay. This is that hero coming in bus and getting down. All this is not there in our syllabus. Clear? Macha, estoppel. What is estoppel? Estoppel is nothing but once you have promised, you cannot step back. What do you mean by this? Imagine people, Shweta is coming here and standing and saying to Praveen, Praveen, you want this mic? Praveen said, yes, I want. Praveen asked Shweta, what is the price? Shweta says 1,000 rupees. I'm also watching simply. Oh, 1,000? Okay. Praveen is telling, will you take UPI or cash? Shweta says UPI. Praveen says, I'll come and give it to you tomorrow 10 o'clock. Is it okay? Shweta says, okay. What am I doing? I'm just watching this. And I then left. Next day, Praveen came with 1,000 rupees. Now, you tell me, should I give this particular mic to Praveen or not? This is, yes, sir. It is mine, Shweta agreed for everything. When you have a duty to speak, speak. If you do not speak,
Mere silence amounts to acceptance.
mere silence does not amount to acceptance. As per the rule, no. Okay. But here, I had an opportunity to say no. I did not. Hence, I created a contract by estoppel. Estoppel means what? If you have agreed something, you cannot step back. You cannot go back. While everything was happening in front of your eyes, you could have said no. Did you do? No. Now can you go back? No. Understood? Unpaid seller, next unit. Other acts. Any sale made under other acts. If it is valid there, it is valid here also it seems. What is the sale which is made under other acts? In Companies Act, whenever you become insolvent, a liquidator will come and sell all your goods, no? Liquidator will come and sell all your goods, no? Liquidator is selling, no? Possible, Yes. Non-owner, possible, yes, because that act has given you right. Acha, paneer, can I eat, Indian contract has given you the right. Sell by pledge, Muthuta, you have not repaid the loan. They will keep that gold there only as showpiece. They will sell it. They will recover their money. Are they owners? No. Can they? Yes. Understood? Next one, the rules regarding delivery of the goods. Buyer to apply for delivery, meaning by default, the seller will not come and deliver it to your home. He will give it in the shop. If you want, go and collect it. Illa sir, I want delivery, meaning apply for it. If the seller is the okay, seller will give you the delivery. If not, the goods will be delivered wherever the sale is made, meaning the shop. Next one, place of delivery, that only. Wherever the sale is made, that is where the delivery will be made. If not, if you guys are agreeing something else in your contract, it will be as per the contract. Time of delivery, always reasonable time. What is reasonable depends upon case to case. Ice cream, you will get faster. Dosa can take time. You have tried, time for tender of delivery, meaning within what time they need to come and deliver. It should always be reasonable time only, no? Effect of part delivery. If I am ordering phone, charger comes first, plug comes next, box comes next, camera. Part delivery not possible. It should always be the complete product. Agreed? Actually, that is not part delivery, installment delivery. You can never take the goods in installments. Meaning, that's what? Camera, possible, not possible. Part delivery means what, people? At times it may so happen that the goods are of a huge quantity. Meaning, imagine if I have purchased 2 tons, 3 tons of tomatoes and onion. Can it fit into one truck? No. We need to split and take it. So, can part delivery happen? Yes. Answer is yes. but it is all subject to your contract. Unless otherwise agreed. That is one common word that will be used for your entire Indian Contract Act and Sale of Goods Act.
Perishable goods.
Which one?
So for tomatoes, if you are taking part.
Correct.
In that case, you may have a loss.
Okay. What is your name?
Charan.
Charan. Okay. I heard steroid. Serious. Okay. Okay. Charan. Now Charan says, sir, it is a perishable goods, no sir. I see the sell. Okay. The buyer asked for 3 tons of tomato, sir. Papa, the farmer has kept the 3 tons ready. It's a perishable goods, sir. If the buyer bought a lorry which can take 2 tons, now 1 ton if it is kept here and he goes, anything happens then I should bear the risk. Now the farmer Anna will tell one thing. Macha buyer, listen carefully. You asked me for 3 tons. I have kept the 3 tons ready. Now whatever happens, Macha, it is your fate. If you want to keep here and go, but you pay me for 3 tons and go.
Put into deliverable state.
Then
it is
effect of
buyer's
part delivery as full delivery. What do you mean by that? Even though only the 2 tons are being taken, 1 ton is left back, but I'm transferring the ownership for the entire 3 tons. Anything happens to 3 tons, the rest of the 1 ton here, the responsibility is yours only. No sir, farmer Anna is very, very friendly. It's okay, now you go, we will see. When you come back again, I'll again take fresh tomatoes and I'll pick it one by one, I'll clean it and I'll throw it to your truck. Now people, you are considering part delivery as part delivery. 2 kgs is considered as 2 kgs. Voice is breaking now. Online, no? All of you? Voice is breaking? AC is colder. Online? Online? Yes, sir. Hey, yes, sir, it's for online attendance, huh? Now it's clear. You guys are there now. Nothing I changed. Vastu, throat, voice, sound, everything is same. Okay. Now understood, huh? That is only meaning of part delivery is equal to full delivery. Part delivery is equal to part delivery. If at all the meaning the seller is telling, I have given you 3 ton. Ownership is also transferred for 3 ton. If you take 2 ton, it is your karma. I can't do anything. Next scenario, I have given you 3 ton. You take 2 ton and go. And I will say, okay, ownership I'll give it to you for 2 ton only. It's okay. 1 ton you keep here and go. If someone else comes, I'll sell it to them. Next week I'll give you a fresh stock. Now this is considered as what? Part delivery only. Ownership is transferred only for 2 ton. If anything happens to the 1 ton in your godown, that risk will be on whom? That risk will be on the seller when you treat part as part. When you treat part as full, I have given you 3. I have given you 3. Buyer. So when I have given 3, you take 2. But I have told, I have given you entire thing. It is your headache. Anything happens to the 1 ton in my godown, the responsibility will be on the buyer because I have given you the ownership for the complete thing. Agreed? Okay, last one now. Goods in possession of third party, which we saw. What is this? Symbolic delivery, constructive delivery, acknowledgement. Delivery is happening based on acknowledgement. Next one, delivery to a carrier. Delivery to a carrier is always delivery to a buyer. If you give it to a carrier, it is like giving it to a buyer. Deterioration during transit. I told you yesterday, if the goods are at a distance place you need to deliver, or the nature of the goods that it will deteriorate, the risk is always on buyer. Example, ice cream. When you order on Zomato, it will melt. Correct, no? Buyer's right to examine the goods. Open box. So when you get the goods, you have a right to inspect because you have not seen what was packed. So you have a right to examine the goods when the goods are delivered. Agreed? Okay, the last one, sir, unpaid seller. Who is an unpaid seller, sir? Who is an unpaid seller? Voice is again break day. Who is an unpaid seller? Sir, we have sold the goods. The goods worth is 100 rupees. And how much did our buyer pay? The buyer paid 90 rupees. 10 rupees is not yet paid. Am I an unpaid seller? Okay, 99 is paid. 1 rupee is not paid. Macha, the word used is until the whole of the price is not paid, I am an unpaid seller. Whole is 100. Until the complete money is not paid, I will be considered as unpaid seller. Understood? Okay. If you are an unpaid seller, you have certain rights. What are the rights? One, you have a right against the goods. Next one, you have a right against the buyer. Now, first one, sir, what is the right against the goods? I'll explain you of everything here only. See here. Right against the goods. You have 3 rights. What is the first right? Right to lien. Now, what do you mean by right to lien? Right to lien means until the money is paid, I will keep the goods with me only. Now, for Sanjay, online, I agreed that I'm okay for 400. He said I will come and pick it up tomorrow. Now, people, ownership is transferred. No. What will I do? Until Sanjay sends me that 400 rupees, will I give this goods to him? Of course, no. This is only called as what? Right to lien. Even though the ownership is transferred, I will not give him the delivery until the money is paid. So this wire, I'll keep it like this. I'll hold it. I'll not leave this wire only. Until when? Until money is paid. This is called as what? Right to lien. Understood all of you? Right to lien is nothing but a right to retain the goods. RETAIN. It was with me. It will be with me until the money is paid. Understood? Now, sir, Sanjay is living in. Sanjay, where are you? Where are you from? Let us imagine somewhere. Tell quickly. Thuthukudi. Okay. Now he is from Tamil Nadu. Now, people, what will I do? Sanjay said, sir, see, Google Pay. I am sharing you, sir. Give me a number and all. I found it very reliable. He said, sir, give me your number, give me your scanner and all. I said, okay, then he will pay it off. Immediately I booked Danzo or whatever is the delivery app. I just took it.
Removed the wire. I gave that particular mic to the delivery guy. Now it is going. Sir, you forgot to put it back. Listen, now this particular mic has been taken. I have given it to the delivery guy. The delivery is going. He is on the way. He has reached the signal. He is taking right. Now Sanjay's friend Ramaswamy is there here. Ramaswamy will
come and say, no, sir, don't give the goods to Sanjay, sir. Sanjay has become insolvent. Now people, that person has already reached the signal, but not Thuthukudi yet. What will I do? Singam, I'll take ange bike, ange overtake, ange get down and say, yes, stop da. Give me back my mic, correct no? Yes or no, I will do it or no? Now people, this is only called as what people? Next right, right of stoppage in transit. The goods left me, the goods are no longer with me. The goods went away from me, but it has not yet reached the buyer. I will go and I will get back the possession. That's why we call it as regain the possession. What is the difference between right to lien and right to transit? Right to lien means people, right to retain the goods. Right to sit means right to regain the goods and retain until the money is paid. Right to stoppage in transit starts when the right to lien ends. Allo. Pakana. Shara. That is called as right to lien. What is considered as transit? What is transit? Transit is nothing but the place until when we deliver the goods to the buyer. So when does this transit come to an end? Of course, when this delivery guy goes and delivers it to the buyer, Sanjay, delivery comes to an end. That is what is called when buyer or bailee obtains the delivery. When Sanjay gets the delivery, transit comes to an end. Whether it can be exactly at Tutukudi or it can be on the way at Hosur or Krishnagiri. On the way, he's coming. He also knows that your sir will come and take it back. He is also chasing it like Spider-Man. Like this, he comes and he takes off the mic. Correct? Huh? Hello. Yes, next one, sir. Carrier or bailee acknowledges the buyer that he holds the goods for him and seller has not reserved the right of disposal. What do you mean by reservation of right of disposal? I will put a condition. I will tell this carrier that, Macha, remember, until Sanjay gives the money in your hand, do not give the mic. Until Sanjay gives the money in your hand, do not give the mic. This condition is called as what, people? Reservation of right of disposal. I am telling you, until something is done, completed, do not deliver the goods. So until that is done, it will not be delivered. Agreed? All of you? Okay, sir. Now, sir, what they're telling you, carrier or bailee acknowledges the buyer. The delivery guy has directly called him. Sir, I have reached your location. Technically, now he has reported to him. Acknowledgement. Remember, warehouse, go down. You have called him now. You have told it, sir, I have reached your place. Now, who is the owner? He is the owner. Now, he is no longer listening to me. He will listen to him. Hello? Third one, goods delivered to the carrier hired by the buyer. Correct? Now, Sanjay sent Ramaswamy only to get the mic. Ramaswamy will believe him or me? He will believe him only. He will act as per his instructions only. That is the meaning of it. Carrier wrongfully refuses to deliver the goods. What do you mean by that? I have given it to my delivery guy, but he neglects giving it to the buyer. It is his mistake. So if by mistake, if you are refusing to deliver the goods, we will assume that the delivery is made. Meaning the contract, the law assumes. Law assumes. What do you mean by that? Let us imagine Flipkart, I got a message that today my product will be delivered. I am at home. At times, I know it would have happened with you also. They will say that we tried delivering you, but you were unavailable, hence the package was returned. You guys got it? Now you tell me, did they rightfully refuse to deliver or wrongfully refuse to deliver? You are there at home. They are telling that we attempted to deliver. I am saying I am here only. When did you attempt? You neither called me also. This is called as what? Carrier wrongfully. Why? Because he is tired. Because he is not able to. That is the only reason, nothing else. Now what will happen? Law is telling, we will assume that the ownership is passed because it was a delivery guy's mistake. Now imagine I became an insolvent. Can the seller take back the goods? Answer is no, because ownership is passed. Transit has come to an end, is what they are telling you.
But it is only this mistake, right? How can the risk be fined?
Meaning?
It is carrier's mistake.
Correct.
How can the buyer bear the risk?
That's why they are telling you, buyer is not the risk here. The risk is at the seller's end.
Okay.
Now you are telling, ownership is transferred to the buyer because you refuse to deliver.
Ownership is transferred to
Buyer.
Then risk is?
Risk is whose?
I didn't get the goods, right? I only
Correct. So you understand this way. Now, technically you should have got the goods. You did not get. Correct?
Yeah.
That means transit is still not come to an end. Correct? It should be still on the way only. Now I got to know you became an insolvent. Flipkart has still the right to call back the goods. Correct? Now because they did not rightfully refuse to deliver. How did they do it wrongfully? They did not intimate you, it was not your mistake. The law is protecting the buyer, saying that because it was our mistake, we will assume that the ownership is transferred and hence the seller cannot recall the goods. It is yours.
He can't do the right of leave.
Correct. Right of transit. Because transit has come to an end. Understood? Okay.
In that case, the possession of the goods is not with the buyer.
Correct. It is still with the carrier. That is the delivery guy.
What if they made the payment already there?
That if payment has already been made, this right to stoppage in transit will not come into picture at all.
No, sir. Okay. In case if we have to sell that goods to someone else, and we are incurring loss because of that. So we have to sell to them. And
Okay, you give me a scenario. You have purchased something from a seller.
yes, sir.
The delivery guy has not delivered the goods to you.
Yes, sir.
You are telling you have paid the money for it.
No, sir. That part I understood, sir.
Okay.
Now I have to sell it to someone else.
You have to further sell it to someone else.
Yes, sir. Now, because I am not selling to him, I have incurred a liability.
Basically, you are talking about subsale.
Yes, sir.
Subsale, we'll see. We have it. This one, we have it. We'll see. Then, part delivery, whatever we saw. Part delivery considered as full delivery considered normal. Correct? So, if you have considered part delivery as whole delivery, then transit has come to an end for the whole delivery. If you have considered part delivery as part, I have given you 2 tons, hence the ownership is transferred for 2 tons. The rest of the 1 ton you can exercise sit. Clear? Okay. Goods delivered to the ship chartered by the buyer. Whether I send you vehicle or a ship, logic is same. Ship will come into international transactions. Road will come into local transactions. Law is same. If you are giving your goods, seller is giving the goods to the delivery agent who is appointed by the buyer. The law is telling stoppage in transit will come to an end because the delivery guy will listen to the buyer and not the seller. Clear? Okay. Next one, sir. Effect of subsale or pledge by the buyer. Now, what do you mean by subsale, people? Now, listen to this. Sir, there is a seller. There is a buyer. Sir, there is another buyer. Let us assume this person as a wholesaler, or let us assume this person as a manufacturer. This person is a wholesaler and this person is a retailer. Correct? Agreed? Now people, there is a manufacturer, wholesaler, retailer. Now what do you mean by subsale? Manufacturer has agreed to give the ownership to the wholesaler. Now wholesaler has not paid the price to the manufacturer. Now the question is, if wholesaler has taken up the contract with the retailer, but retailer has paid for it, but the wholesaler did not pay to the manufacturer. The question is whether the manufacturer still has a right of lien. Does he still have a right to transit? I'll again repeat. I have agreed to give the goods to the wholesaler. Wholesaler has further entered into a contract with retailer. Now retailer has given money to the wholesaler, but wholesaler has not paid to the manufacturer. Now the goods are still with the manufacturer. It is in the manufacturer's factory. Now the question to you is, still does manufacturer has right to sit, right to lien? Does he still have it, or it has come to an end? Come to an end is what you are saying. Okay. What do you think? What is your name?
Pranav.
Pranav. Yes, Pranav. What do you think? Pranav is like, that was my question, sir. You ask my question back to me and say, what do you think? Means you should say. Okay. What do you guys think? He still has a right of sit and lien? He still has it? Remember, end of the day, rule is same. Nemo dat quad nan abed. What do you mean by that? I have a right. Just because you have not, what is that? If at all, just because you have received the money and you have not paid to me, that is mean. Whether you receive the money or not is irrelevant to me. Did I receive? No. Law protects me. I still enjoy right to lien. I still enjoy right to sit. Hello. Now look at the scenario 2. Here, whether will I be able to exercise? Answer is yes. Look at the scenario 2. Sir, the wholesaler told manufacturer, sir, please give me the goods. I will further sell it to the retailers. They will give me money that I will pay to you. Is it okay, na? The manufacturer said, okay, I don't have a problem. Now people, manufacturer gave the ownership to the wholesaler. Wholesaler gave it to the retailer. Meaning everything is still contracts only. Retailer paid to the wholesaler. Wholesaler did not pay to the manufacturer. So now tell me, sir, whether does manufacturer has lien and sit? Does he have? Answer is no. Because if you have agreed, whether directly or indirectly, because you clearly gave a green signal, no. You go ahead, you sell it to the retailer with whatever money you get, you repay it to me. You have given a green signal, no. Once you have given your yes, sir, then you cannot enjoy lien and sit. Lien and sit comes to an end. Understood all of you? So if you have agreed, your lien and sit comes to an end. If you have not agreed, you can still enjoy lien and sit. Hello? This concept is clear? That was a question now. Okay. Next ones are, the third right, sir, is called as right to resale. What do you mean by right to resale? Sir, I got back the goods. You are saying right to sit means what? Whatever is the goods in transit, I went and I brought it back. What will I do it with it? Will I keep it in my godown and keep waiting for him that he will come, he will come, he will, yeah, when will he come? The third right is people, right to resale. What is resale, sir? You can further sell the goods. Let us imagine if at all you are selling it for a profit or a loss. The actual contract value was 10k. If you are able to sell it at 12k, if you are able to sell it at 8k, macha, you sell it at profit, it is yours. You sell it at loss, you can recover it from the first buyer. Whoever failed to pay, you can recover the money from him, provided you give him a notice of resale. What do you mean notice of resale means? Sir, last and final call for you. If you do not pay, I will have to sell it further. Now even if he doesn't pay, now I have a right to further sell it to anyone else. Loss, I can recover. Profit, keep it. Hello? This is called as what? Right to resale. Now however, Pranav has a question, what? Sir, perishable goods, paneer. I can ask him, hello, macha, are you well? Now within this time only, paneer will go, sir. Now remember people, perishable goods, no notice required. Hello. Pakkana? Yes, sir. Okay. What are the rights against the buyer I have, sir? One is goods. Against the buyer, what do I have? First one, of course, you can recover the price. Whatever is the money. I have given you the ownership. If you do not give me the money, I can recover the money. Next one is damages. Whatever we saw in section 73. Ordinary, special law, same thing. Repudiation of contract, meaning I will cancel. Going forward, I am not liable to give you the goods. I will cancel the contract forever. Last one is suit for interest. What do you mean by that? Macha, if you had given me the money that day only, I would have got 10,000. You are giving me the money after 6 months. In the 6 months, if I had invested this money in bank, I would have got some 10% rate of interest. So I am eligible to get a reasonable rate of interest on the money that I have to get it from you. Hello? Next one, sir. Right of buyer, meaning you have right against the buyer. Even the buyer also has a right against the seller now. What are the rights he has? First one, if the seller does not deliver the goods, I have a right for asking for damages for non-delivery. Next one, suit for specific performance. Yesterday we saw specific performance will be ordered only when the goods are antique, special, emotional attachments, etc. Suit for breach of warranty, meaning you have given me the goods but faulty. I have a right to ask for compensation. Or you take Praveen's case, he ordered suit but the suit was not delivered in time. I can cancel the contract. Last one, if I have paid any advance, I am eligible to interest on it. Just like you were eligible for interest, I am also eligible for interest. I'm also eligible for interest on it. The last one is called as people auction sale, section 64. What do you mean by auction sale? Whenever the goods are sold by a bidding process, whosoever bids the highest price, the ownership will be passed on to them. Now, if I want to auction this particular antique old remote, starts at 1,000 rupees. Who wants to buy? Okay, Praveen wants to buy. What price, Praveen? 2,000. Praveen says 2,000. Pranav says 5,000. 10,000. Once a day, three times. Done. Now, people, the price is done at 10,000. Now, people, this is only called as what, people? The acceptance is the third time. If that is my particular way of contract, or whenever I say accepted, so remember, people, the acceptance depends upon the way the people follow it. It can be gavel. Gavel is nothing but called as hammer. Few people use a bell. Few people ring a plate like a dong. So every people will use it in a different way. So that is called as what, people? Acceptance. Now, people, remember, in an auction sale, if you want, you can select the products one by one, or you can sell it in lots. Meaning, I will auction first the mic, and next the camera, and next the monitor, or I will say, macha package 1 lakh. That is also possible. This is also possible. Agreed, all of you? Sir, in the auction, can the seller himself participate? Seller or an agent appointed by the seller, can they participate? Yes, just that you need to disclose and participate. Agreed? Sir, in an auction, always the price starts from a particular number. I told you, the number I have in mind is 1,000. Agreed? That is called as what? Reserved price or base price. Sir, can someone, now Praveen said 1,000, Pranav said 5,000, Praveen said 8,000, Pranav said 20,000. And Papa Praveen said 22,000. Pranav now kept quiet. Now the question is, can someone do a bidding just to increase the price? Can they do it?
No.
Just to increase the price, can they do it? This is called as what? Pretended bidding. If you get to know, you can consider the contract as void. It is a fraud end of the day. Agreed? This whole thing is auction sale. Goods can be sold in lots. Completion can be fall off hammer. Right to bid may be reserved. So if you are agent or if you are seller of an agent, meaning if you are agent of a particular seller, if you want to participate, you can participate provided you need to disclose and participate. Next one, reserve price is nothing but base price. Pretended bidding is always voidable. If I get to know someone did it wantedly, I can consider it as void. Clear? Hello? Okay, 8:30. Okay, chalo. Let us continue here. Tomorrow, 8:30 in the morning. Probably we'll see. I think we should be done within 4 hours, 12:30 max. But we'll see. Yep. Chalo, see you all tomorrow. Bye bye. Yes. So we had to start with Indian partnership. Let's quick. Let us keep it quick, so we can spend some more time on Companies Act and all that. Okay. Indian Partnership Act, general nature of partnership. As I told you, people, even Indian partnership is also derived from Contract Act only. It's not a secondary thing. It is also considered, it is also derived from Indian Contract Act only. So when they are speaking about two parties, the two parties here are competent to contract. They are majors. The same thing, cut, copy, paste. Every concept will cut, copy, paste apply here also. Agreed? Yes. Okay. So what is the definition of partnership? It is a relationship between persons who have agreed to share the profits. Share profits of the business. Losses? So can one partner take all the profits? Can one partner take all the losses? Because of definition. Definition says that you should only share profits mandatorily. So is it okay for me to skip losses? Absolutely fine. Sir, there are three partners, A, B and C. A is taking all the profits. B and C only liable for, A is taking all the losses. B and C are only eligible for profits. Such type of partnership is good is it valid? Answer is yes. Sir, A and B are taking all the losses. C is only getting profits. Sir, is this type of, A, B and C, they are sharing profits, but losses is shared by only A and B. Such type of partnership can exist? Yes. What do you call C as? Need not be minor. It can be a major also. Partner in profits only. That is the meaning of C. Getting it? Example we see is minor, minor, minor. It is interchangeably used, but it need not be. Anyone can be that. If you have said don't give loss, only be part of profits, he will be called as partner in profits only. Agreed all of you? Okay. So carried on by all or any of them acting for all. Now in this definition, if we break it, we will be able to see these many important words. What is that? First one, there has to be association of two or more person. One partner cannot enter into a contract. That is not possible. The two or more person can be. Companies can enter into partnership. Company A, company B can come together. They can enter into partnership. That is possible. Can two minors come and enter into a contract? Is it possible? Possible? No. Remember, we should have at least two majors. The third partner, you take it as minor. That is okay. But we should have majors to contribute to the partnership. Agreed? Yes. Okay, next one. What is the minimum number of partners required to start a partnership? 2. Maximum 50. Agreed? This is as per Companies Act. Remember, the maximum number of partners is not given under Partnership Act. It is given under Companies Act. Because according to Companies Act, if at all the people exceeding 50 are entering into a partnership, it is called as illegal association. If more than 50 are there. Understood all of you? Yes? Okay. Next one, agreement. There has to be an agreement, people. Should it be writing or oral is also okay? Both are okay. But remember, to be on a safer side, always writing is preferred. Sir, business. Remember, this is essential. There are many cases where two people will be earning money together, but not every earning is called as partnership. For example, A is there. A has two children, B and C. A died. A had one property. Now the properties, of course, because of legal heirs, being legal heirs, because of inheritance, B and C become the owners of the property. The property is given out on rent. Hello. Now the rent is shared between B and C. Now they are claiming that this is partnership. Is it a partnership? Why? They are sharing no profits. Then is it partnership or not? There is no business involved. Why? Every day what are you coming and doing business with the tenant? Macha, come here. How is it all going? All good? Are you doing business here? Are you using your mind here? No. Just letting out the property on rent. That's all. Where is the business happening? No business, and that is why we call this type of profit sharing as co-ownership. Understood all of you? Pakka? Yes. Now like this there will be a lot of instances. Now A would have given money to B, as some money would have been given, and there is a fixed interest that is paid to A. Now with the money, B has started one business. Now business is there. Are A and B considered as partners? Is this a partnership form? Business is there. Money is also shared. I am sharing interest every month. Then what is this called? This is nothing but what? Debtor-creditor relationship. Interest is being charged. So remember, not every money being shared will be considered as partnership. Business is important. At the same time, why you are sharing the profits is important. Everything will play its own role. Agreed? Okay. Next one. Can you have a partnership for doing non-profit business? Meaning, can I run a charity house in the name of partnership form? ABC, Old Age and Co. Old Age Home.
Can be a member in a section 8 company.
That is possible. See, you are telling partnership can be a member in a established Section 8 company. Is this allowed? Yes, it is allowed. Now my question is, can partnership itself be a charity or non-profitable organization? Can it be? It has to be only for profits. Non-profit organizations can never exist in the form of partnership. Remember this. Clear? Okay, next one. Agreement to share profits, which we already saw. Business carried on by all or all of them acting for all. I mean, any of them acting for all. Now, what is this, sir? If at all there are three partners, A, B, and C, in a partnership firm, all three people can sign the contract. The partnership firm will be liable? Yes. Sir, only C went and signed the contract. Will A and B liable? Answer is yes. So even if one signs, the entire firm is liable. If all of them sign, also the entire firm is liable. But depends upon, there is one more topic called as implied power. Correct? Meaning certain contracts you alone cannot sign. What are those contracts, if you can remember? Meaning if one person signs, it does not bind the entire partnership firm. We call it as, if it is binding the entire partnership firm, we call it as implied power. If it is not binding the entire partnership firm, that means we have to take the approval of everyone. One person cannot take a decision. Any?
Termination of a partner.
Termination of partner, okay. Majority of them, correct, okay. And you add the implied power entire conditions also. Entering into a partnership, opening bank account in the name of a person, selling or buying of immovable property, withdrawing suits, admission of claims. You have an entire topic, meaning what? If I want to sell my partnership's property, imagine there is a land. If I want to sell, only one partner cannot take this decision. It's a major decision. Everyone has to participate. One person cannot say it's my power. You cannot call it as all of them acting for all or any of them acting for all. So one person signs, it's a valid contract. No. That is only called as what? Absence of implied power. Clear? Hello? Okay. So, business carried on by all or any of them acting for all. The true test of partnership, people, there has to be an agreement. There has to be sharing of profits, which we saw, meaning co-ownership is not possible. Interest paying, he'll be considered as lender. Master paying money to a servant, we call it as remuneration. Agreed? Receipt of annuity by a widow. Imagine one person has passed away, employee has passed away. Employer is paying their family some 5,000 rupees for their expenses. Just because we are paying 5,000 rupees for their expenses, the family is not becoming part of our partnership firm.
Yes, sir.
Agreed? We will call this as what? Annuity. In our regular words, we call it as pension. Agreed? Yes. Receipt by previous owner as a consideration for goodwill. So, what is this goodwill? If I am acquiring someone else's business, for that if I am paying any consideration, me and him will not become partners. I am acquiring his business. I am paying this money for buying his goodwill. So this will not be considered as what? This will not be considered as partnership. Okay, next one is mutual agency. Mutual agency is nothing but this. All of them acting for all or any of them acting for all. Mutual agency means what? If I peel down and if I say mutual agency means if I am signing a contract in A, B, C, if B is signing a contract, he's binding A as well as C. Agreed? That means what? B is representing A and C. Agreed? That means A will also be principal, C will also be principal. B's capacity here will be like an agent. Whatever agent does, principal will be liable, no? Yes or no? That's why B is the agent of A and C. A is the agent of B and C. C is the agent of A and B. That's why you are my agent, I am your agent. That's why we call this concept as mutual agency. Hello? Done. Case law Santiranjan Das Gupta versus Dasiran Muzamul. In this case, nothing what? There was a test of partnership. Whether was there partnership between them or not. Because sharing of profits were happening or sharing of money was happening. In this case, Supreme Court looked at lot of issues. They did not maintain any proper accounts. No separate bank account was opened and it was not registered. So they looked at lot of parameters and finally they said that there is no partnership that is existing between these people. Why? They have not maintained proper accounts. Have they maintained proper records, communication? Nothing is there. Is there a different bank account opened in the name of partnership? No. Is it registered? No. When it's a no for everything, in this case it was decided there is a certain things that you need to have a valid partnership. All these things were absent here. Hello? Clear? Yes, sir. Okay, what are the kinds of partnership? Partnership for fixed period. What do you mean by partnership for fixed period means? If at all while opening the partnership only we say that our partnership is for 5 years. It is called as partnership for fixed period. What will happen after 5 years, people? Dissolve, huh? It is their choice. If they want after 5 years, they can dissolve, or if they want, they can continue. If they continue, it will become partnership at will. What do you mean by partnership at will? No fixed period, okay. Well, how will a partnership at will come to an end? By mutual agreement. Remember people, even if one partner communicates his will to the partnership firm, macha it is done. Let us dissolve it. Even if one partner communicates his will, it is called as partnership at will. If you do not want it that way, then clearly mention it in your partnership deed. Are you getting it? All of you, hello, Pakka? Okay, done. Partnership at will, partnership for a fixed period. Next one is particular partnership. What is particular partnership? A, B and C come together, they start only one cafe. It's called as what? Particular partnership. Meaning when group of partners do only one business or a defined business, not everything. It's called particular partnership. General means we will do cafe, education, finance, hospital, everything under one name. In such case, it is called as what? General partnership. If I have to give you an example, I think you guys have heard of a company called ITC. ITC is a company, but just to take as an example, what and all ITC does? Ashirvad Atta, Classmate book, Pufu, and Sunfeast, Ippy noodles, hotels, everything is ITC only, no? They are into FMCG. Now this is called as what? General partnership. Upon I'm only one person into many business is called as what? General partnership. Agreed? All the partners are liable for overall profits and losses of the firm. Just because hotel is in profit, one partner will not get more money. You have to take the overall profits and losses of the firm. Agreed? Yes, sir. That is called as what, people? General partnership. Now imagine if India makes a pufu as illegal. Should the partnership come to an end? Should the partnership come to an end? So remember, again, correct. So separable, non-separable. And if it is a particular partnership, you are only doing pufu, then it will come to an end. In general partnership, that department will come to an end. Other departments can still continue to function. Hello? Perfect. Types of partners. Active partner, who? Me. Sleeping partner, who? You. No. Okay, what is active partner? A person who is actively involved in the business of the company. Meaning people, every day he will speak to the suppliers, he will speak to the vendors, he will speak to the creditors. His face is looked from the outside world. Such partner is called as what? Active partner. Sleeping partner means person who has just invested money and just expecting profits. I will not actively take part in the business of the company. Is called as what? Sleeping partner. Nominal partner. Who is a nominal partner? A person who just lends his name. What is the difference between sleeping partner and nominal partner? Sleeping partner, no one even knows that this person is there. Nominal partner, they publicize, they put it in a banner. This person is also a partner because it is like a sense of achievement for us. It's a proud feeling for us because that person is a partner here. Are you getting the point? Yeah. If he is not getting profits also, then what is the use? No. They are brand ambassadors. They are getting paid for that. But can you become, now for example, Hardik Pandya is one of, you can consider him as a sleeping partner of Soul Store. You know Soul Store? Yeah. Hardik Pandya has investment there. Now will he work? Answer is no. But is he showing his face to the world and telling you to buy it? Yes. Getting it? So Hardik Pandya as a person has weightage there. Yeah. Now other way what happened? Audio launcher. This hero they will come, that hero he will come. That is not considered as partnership. Clear? Just because now imagine I'll ask Amitabh Bachchan to come and act. He doesn't become a partner. I hope it is clear. Yes. And remember, if active partner is retiring, active partners face the entire world as seen. It is a responsibility of the active partner to tell to the world, I have resigned from the company. Sir, what if I don't tell? Your liability will continue until you tell. Case-based scenario may come here. So public notice is important. What do you mean by public notice? Put it in the newspaper that I am retiring from a partnership firm. I am resigning. You have to intimate. Getting the point?
In case of death also the same, right, sir?
In death, you need not have to intimate. Because the responsibility will now not be on the person. It will be on the legal heirs. That's why, when will the partnership come to an end? Meaning, when will a partner stop to be a partner? One is on your resignation. Next one upon a death. On that day only you will cease to be a partner. Next one, when else you will cease to be a partner? Insolvency. When will you be ceased to be a partner in case of insolvency? What is the time? Time, sir, 9:30. Rahu Kal agirutte. That is during injunction. No. After? After the court's adjudication, you have to go to a court. Court has to declare you. They will pass one order. In that order, it will be written that yes, macha, this person doesn't have money. That's why we call them as adjudged insolvent. Or you should be adjudicated as an insolvent by the court. By the moment they pass an order, from that day, that moment you are considered as insolvent. Not when you stop having money, not from that day. After you become an insolvent, your properties are no longer liable for the partnership. Before that, you are liable. After that, you are no longer liable. Clear? Next one, partner in profits only. We saw A, B and C. A, B and C are sharing the profits equally. But only A and B are sharing the losses. C is considered as partner in profits only. It can also be minor. Minor is one of the example. Incoming partner, incoming. Outgoing partner, outgoing. Meaning admission, no, retirement, resignation. No. Partner by holding out. In our case, example, yesterday, Shweta started selling the mic right in front of me. Did I stop her from selling it? No. I kept my mouth shut. I allowed her to make her statement. Agreed? So, imagine the same in a partnership firm. A, B and C. C is telling to the entire world that I am a partner. But is he actually a partner? No. Does A and B know that C is claiming to be a partner? Are they aware? Yes. In front of them only he is making a statement. Now, macha, tomorrow whatever he does for all the contracts, A and B are liable as partner by holding out. That is the meaning of estoppel or holding out. Any doubts? Okay.
Sir, if it is a mutual agency, no?
Correct.
C is pretending partner. So you will be like pretending agent, no, sir? In case of pretending agent, he is liable, no?
Pretending agent, correct. But the principle is aware here, no? Pretended agent will come when I come and say I am a agent of Mukesh Ambani. My question, Mukesh Ambani is aware of it? No. In this case, are they aware? Yes. Did you had an opportunity to say no? Yes. Why did you not say no? Are you liable? Yes. That's the only difference between holding out. Holding it out is, see, it's simple. It's a responsibility. When you see a wrongdoing happening in front of you, and if you do not stop it, you are responsible for it, is what they say. Clear?
To speak in
Correct. When you have it happening in front of you, it is your right, it is your duty to stop it. Okay, next one people, relation of partners. We'll do first unit 3 and then come to unit 2. Okay, first we saw partners, now we are seeing registration of partnership firm. How does the registration happen, sir? The partnership firm, what do you mean partnership firm, da? Huh?
When all three partners are called as firm.
Okay, remember Maja, one person is called as partner. If I have to refer to all 3 people, I will refer it as firm. That's all. That's why we say partnership firm does not have a separate legal entity. Firm here means I am not referring to some artificial person. I am still referring to those 3 people only. Not like a company. In a case of a company, you are referring to the company. ArivuPro is a company. You guys don't even know who all the founders are. So when you say ArivuPro, you are referring to ArivuPro, not the founders. So here ArivuPro means what? It's a company. You are referring to another category of a person. He is a different person. But when you are referring it as a partnership firm is not a different person. Agreed? That is all the partners together we are referring to as partnership firm. That means what? Imagine I have to call 3 people there. Praveenu, Darshano and one more person. Correct? What is your name? Sanjay. Ajay. Now I have to call Praveen, Ajay and Darshan. I have to say, hey Praveen come, hey Ajay come, hey Darshan come. I will say, hey firm come here. That's all. That's the difference. I am not calling an entity here. I am calling them only. Do not get confused. Are you getting the point? That is why we say partnership firm is not a separate legal person. It is group of people together referred as firm. Agreed? Okay. Now the firm, that is all these people, whether in person or by post, by paying certain fees, and they give all the statement like name of the firm, place of the firm, date of joining of the partners to the firm, name and address of the partners, duration 3 years, 5 years, all this we file in a statement. We file it to registrar of the partnership firm of that particular area, because every state, every place will have a different registrar. You have to take all of this. You have to get your instrument registered, your document registered. If at all the person is convinced, he will maintain one book. The book is called Register of Firms. In that your name will be written A, B, C and Co. In this, who are the partners? Mr. A, Mr. B, Mr. C. Their details will be written here. Understood? Yes, sir. Now this is only called as what people? Registration of partnership. Sir, when should we register a partnership? Imagine we were established in the year 2010. But are you registered? Not yet. Can we register in the year 2025? Is it possible?
Yes, sir.
You were formed in the year 2010. You want to register in the year 2025. Is it possible? Possible? Is it possible? Yes, people, remember, you need to pay something called as late filing fees. And how much is that? Rupees 100 per year. 15 years you are late. You need to pay 100 into 15. 1500 will be your filing fees. Hello? Understood? Huh? It's the same amount only. Clear? Yes, sir.
In that case, we should enter year as 2010 or 2020.
You will be entered as 2010. Basically, you will be called as you are formed in the year 2010. To make good only, we are giving this 100 rupees. To write it as 2010 only, that 100 is not bribe. It's a legal fees only. Getting it up? Hello? Okay, so I will enter my name in the register of firms. Now going forward, I will write myself as ABC registered and co, or ABC partnership firm. We will use the word registered. First of all, is registrations mandatory? Registration of partnership, is it mandatory? No. What is the disadvantage of not registering the partnership firm? No. Suit on third party. A, B, C. Third party. The third party has purchased materials from us. He has not paid money for it. Now can we file a case on this person? Answer is, are you registered, unregistered? Unregistered, you cannot file a case. And no suit for settlement, meaning
Partners cannot suit another partner for it.
okay, amongst us, we cannot file a case, but we can go for dissolution. Now imagine I'm not okay with what C is doing. I feel C is doing all fraud or misappropriation. Can I file a case on him? Answer is no, if at all it is unregistered. But can I ask for a dissolution? Answer is yes. Even if you are unregistered, it is still valid, possible for you to still go and ask the court for dissolution. That is possible. But can you file a case on another partner? Answer is not possible. And what else? What is the drawback? If there is any disputes between the partner, you cannot go to you cannot file a case on another partners, and third party can sue us. We cannot sue them. Perfect. And something called set off and all you would have seen. What is set off for? Now, sir, imagine A, B, C and Co has taken some, okay, let us imagine A, B, C and Co had given some money to Mr. D. We had given him some 10,000 rupees. D has also taken some raw materials from us. Yeah? Okay, or let us imagine like this. ABC has given some loan to D. How much? 10,000 rupees. ABC partnership firm has taken some raw materials from Mr. D. What is the value of raw material? 50,000 rupees. And we did not repay this 50,000 to Mr. D. Now what will D do? D will file a case on our partnership firm. Are we registered or unregistered? We are unregistered. Now the question is, can he file a case on us? Yes, sir. Yes. Now D filed a case on us for 50,000 rupees. ABC is telling, sir, we admit that we have taken raw materials from him. We admit that the value is 50,000. But he has also taken loan from us, sir, 10,000. You adjust that. And you pass an order that we have to pay 40,000, not 50,000. The court asks you one question, what? Macha, are you registered or unregistered? If you are unregistered, you do not have an option to claim set off. What do you mean by that? Whatever is the money you paid, whatever is the money you need to get, those things will not be adjusted. You do not have a right to adjust at all. The partnership firm cried in the court. How can you be so inhuman? Now they said, okay, don't cry. How much I have ordered you to pay? 50,000, sir. You inhuman. Okay, do one thing. Reduce it by 100 rupees. You just pay 49,900 rupees. Now okay, Now are you happy, Happy or not? Now that is what they are telling you. Again, these limits are unaltered. Long back it was there. It is the same. Is this clear, all of you?
Subsequently, can we register and then set off?
Possible. Remember, people. Now his question is, sir, we are unregistered firm. Now can we file a case? Answer is no. Sir, we will do one thing. We will go to the partnership firm registrar now. We will go register our partnership firm now. After getting registration certificate, can I go and file a case on the third party now? Answer is yes. Subsequent registration is still valid and allowed. Hello? Pakana. Sir, what if A, B and C, we have registered. So in the register, it is written as A, B and C. Whenever there is a change, should we register that also? Whenever there is a change in partnership form, let us imagine A is going out. C, okay, or another partner, D is coming in. Whenever there is a change, should we register this also? Is it mandatory? Hello? Remember, Macha, even if going out is not registered, it is still okay. It is still okay. I am not saying you shouldn't register. You have to register. But still B and C can still file a case on outsiders without intimating that A has gone out. It is still okay. But if a new partner has come in, it is considered as a new firm altogether, reconstituted firm. Until this particular information is intimated, their partnership firm will be considered as unregistered. I am repeating, if an existing partner is leaving even if this is not intimated, you are still considered as a registered partnership firm. So you can still file a case on the third parties. But if at all an outsider is coming in, and if this is not yet registered, they're telling you people, it is considered as unregistered partnership firm. You will lose a right to file a case on the outsiders.
What if the case is going on and D comes in? Whether D is also liable for the shoot?
No, the case is already filed. That is okay.
So A, B, C is liable.
Correct. Now your question, let us imagine, sir, A, B, C, there is already a case going on. D is coming in today, but the case is already going on in the court. After he comes in, the court will pass an order that you guys have to repay 1 lakh rupees. Will it be shared between A, B and C or A, B, C and D? D? D also is liable? If D agrees, D will be liable. What is it called?
New partner agreeing for existing liability.
New partner agreeing for existing liability. What will happen to the agreement? What? See, original? Novation. First it is written that A, B, C are liable. Now D is telling, sir, how can you leave me? Put my name also. I will also be liable. I have must money. So A, B, C and D in the existing term, even if one party is getting added, we call that as novation. Hello? And I told you, now partnership firm, D has joined. Later they passed an order. Why are we still telling only A, B, and C are liable? Why not D? Always, whenever a new partner is coming in, their liability starts on the day they enter into the partnership firm. For the previous debts, they are not liable. Okay, now my question to you, A, B and C, the case is already going on. A left the partnership firm. Now the court's order is passed that this partnership firm is liable. A has left by then. Now my question, is A liable?
Yes.
Is he liable? He has left it. Remember, A is liable for all the contracts that he entered while he was a partner, even after he ceases to be a partner. If it was entered when you were partner, you are liable. Hello?
Yes,
Agreed?
A, B, C are doing partnership and D is incoming partner. When D is incoming after the admission, they have incurred some liabilities. They are not paid that liability, so that the opposite party sued them. And they are not registered after the admission of D, sir. And in court case, D is claiming that I am there. When I admitted, it was not updated in the register, so I am free from liability. He can tell that.
See, a partner is always liable not from the day it is registered, from the day you come in. That is what is written, no? An incoming partner is liable from the day he becomes a partner. And we know that registration is optional. So your liability has nothing to do with your partnership is registered or unregistered. Good question.
However, he may choose to be liable even before. However, he may choose to be liable for the acts done from before his admission.
He will be liable, is what you are saying.
Yeah, the new partner. He can be even liable for the acts done.
Correct. It is his choice. You cannot say it is mandatory. If I want, I can be liable. But you cannot say that you will be liable. That is not possible.
What if he is a sleeping partner that no one aware that
Even then, you are a partner only, right? Sleeping partner has no other benefit. Only thing is when you are retiring, you need not tell to the world that I have retired. Public notice alone is exempted for a sleeping partner. People, you know how actually it works in industry, real life. Now let us imagine I have money, but I will not be able to work. Someone is able to work. So how do we divide it? I will say I will invest capital, you do the function of the company. So my contribution is money. His contribution is work. Correct? No, that is a contribution. So he is also liable, I am also liable. Both of us will be liable. Even just because I am a sleeping partner, that doesn't mean that I am not liable. I am liable.
creditors doesn't know that he's there.
Correct.
But,
My name is not known.
in partnership it is there.
Correct. As long as you're a partner, you are liable. There is you are no running away from that liability. Clear? Next one, sir. Modes of dissolution. There are two types of things. One is called as dissolution of firm, dissolution of partnership. What do you know dissolution of firm? Whole firm is dissolved. Dissolution of partnership? So A, B and C. C leaves the partnership firm and he goes away. This is called as what? Dissolution of partnership. Dissolution of firm means a permanent end to the partnership. Dissolution of firm may or may not result into dissolution of partnership may or may not resolve into dissolution of firm, but dissolution of firm always leads to dissolution of partnership. Agreed? In dissolution of firm, we are doing something called as realization of assets. In dissolution of partnership, we are doing revaluation of assets. What do you mean by realize? Selling away the assets, getting the money. When will you do that? When you are shutting down the business only, no. That is why you do it in dissolution of firm. Dissolution of partnership means one partner is going. When we purchased one land, the land was 1 lakh. Now he is leaving today. I can't give 30% in 1 lakh. I have to give him the land value, whatever is today, in that I have to give him 30%. I have to revalue the asset. Probably today it is worth 1 crore. He will get 30 lakhs, not 30,000 what you initially invested. Agreed? Yes, sir. Pakkana.
Revaluation, the assets given to the outgoing partner is taxable or not, sir?
It is treated as an income. 100% taxable. It is an income only, no? Next one, sir. Dissolution of firm may or may not need a court's approval. But dissolution of partnership does not need a court's approval. Agreed? Okay. Now, dissolution of firm, there are two types. One is called as voluntary dissolution. Next one is dissolution by court. Voluntary dissolution, sir. First one is by agreement. All of them agree, done. Easiest way. Next one is compulsory dissolution. When, sir, when everyone become insolvent. Or there are 5 partners, 4 of them become insolvent. In such case, it is a dissolution that is compulsory. Mandatorily, you have to dissolve. Next one is happening of any event which makes it unlawful. We were running on one business, ITC. One particular business becomes, Pufu is now banned by the government. Now, obviously, I cannot run it anymore. I have to shut down my business. Meaning, I am telling in all these cases, I need not go to the court. It will be dissolved here only. Understood? Next one, happening of any contingencies, meaning we have written in our agreement, after this we will dissolve. After it, you may dissolve. Example, fixed period. 5 years we said we will be valid. After that, you have an option to dissolve. Next one is completion of specific business. Say Bangalore government and BMRCL and L&T, together they have come together and they are doing this metro work as a partnership. Once metro is done, they will still be partners. No, they will come to an end. That is the meaning of completion of specific. Death of a partner. Remember, it is optional. A, B and C are there. C dies. It is an option and you refer to your partnership deed. Just because it is a death, you need not have to dissolve your partnership firm. You can still continue your partnership firm. Hello? Yes. Next one is adjudication of partner as insolvent. Is also one of the ground. Next one, dissolution of by notice if it is a partnership at will. What is that? If one person communicates, that is considered as dissolution. However, if the date is mentioned in the notice, if the date is not mentioned in the notice, what is the effective date of dissolution? The partner has clearly told, dear partners, I would like to bring it to your notice that I am interested to dissolve this partnership from the effective date 30th August 2025. The date is mentioned, that will be effective from that day. The date is not mentioned, it will be effective from the day the notice is communicated. What do you mean by that? Letter is written. Whenever the partners sees it or whenever the partners discuss about it, that is the day it will be considered as effective date of dissolution. Next one, dissolution by court. When will the court dissolve people? One, insanity or unsound mind. When will this happen? Whenever the active partner whenever the active partner becomes a permanently unsound mind. It is not like for one night it was unsound, sir, I do not want to do the business with him. Permanently you have to be unsound mind. In such case, people, whether the partners or the whoever is the unsound person is relative or a friend, they can come and tell, we want to dissolve the partnership firm, it will be dissolved. Next one is people, permanent incapacity, meaning a person met with an accident. A person is no longer able to function. In such case, again you can go for permanent dissolution. Next one, misconduct. What is misconduct? A person has done something in the society because of which the partnership is suffering the loss. Agreed, huh? What is this? Can my personal life affect my partnership life? Or it should be the, whatever misconduct I do, should it be in professional life only? What do you think? I've done some misconduct in my personal life. Is it okay?
So if it is illegal in nature, then
Personal life.
yes, sir.
So can the partners take that as a ground and can they remove him? Is it possible?
Yes, sir. It is legally.
That is what is called as people misconduct. Misconduct means people, because of your personal life, if the business is getting affected, can I remove you? Answer is yes. We have seen various scenarios like that, no? Now, for example, recently also, expulsion is removal. This is automatically. You will say we do not want to do the business with this person. So you are dissolving the firm itself. Now that's what I was saying. Now, for example, let us imagine there was these scenarios you will see in Bollywood. There was one time there was a movie of Alia Bhatt. I think what is it? Razi something is like that. It's there. Razi, it's there. So when that movie came, people, YouTube first time saw that the number of dislikes are way crazier than number of likes. Crazier. And the dislikes are more than views. Yeah, people have not even seen. Directly disliked. Now why? Because that was a time where people spoke about nepotism. It was at its peak. People started coming up with this boycott. And one more movie also got affected because of the same thing. Lal Singh Chadda, Amir Khan's movie. Just because it was Amir Khan. Why? Because he made some statements. Hello?
Yes, sir.
Agreed? Pakka? Now recently also, during this Thug Life, I hope you guys agree. Because of Kamal Hassan's thing, movie did not release in Karnataka only. One person, whole unit suffered. Now the unit can come and say, we do not want him as our partner. Now this is only called as what people. I'm giving you a real life scenario so that you can understand personal life can affect the product. Are you getting it? That is what is the scenario they're telling you. Misconduct. Whether right or wrong, we are nothing. I'm just giving you an example. That's all. Clear? Now don't start controversies. Examples alone I'm giving. And why movie? Because relatable. Okay, next one. Breach of agreement relating to management of affairs. What do you mean management of affairs, da? It is your duty to maintain proper accounts. You are maintaining erroneous accounts. Meaning what? Fake, fraud. If at all you are doing embezzlement of cash. Embezzlement means what? Pickpocket from the cash counter. So that is meaning of embezzlement. Next one is holding more cash than allowed. Generally in partnership firms they say you cannot hold more than 10,000 rupees as liquid cash. Why? More cash transactions, more possibility of fraud. Correct? No? Yes or no? Now so many of you have done admission with Arivu. Has anyone paid in cash? See? 100% accuracy. Remember, Arivu has a no cash policy. We won't accept cash. No physical cash at all. Across branches, same rule. Even one admission till today cannot happen in cash. We are teaching you ethics. If we take cash means
There's a disclaimer. Cash transactions at your own risk.
that is what they say. That means what? Now what if someone comes and Meaning what? Let us imagine some employee comes and say that, sir, please, sir, take it, sir, and you guys will give. Now, will we know it? Tomorrow, if something happens, we can always show it as a proof. Sir, see, I've sent you the money. You would have shown. Cash, what will you show? Cash is always good temporarily. Permanently, it will always kill you. Clear? Yes. And we also come and teach you law. We say that don't do black money, tax and all that. And we only will come and do means, can't we do logically think? We will take cash from you. That entire thing will be passed on to the teachers. Done, no. I need not have to pay income tax. You need not have to pay GST. Easy, no? Yes or no? But then what will we teach? Okay. Refusal to show accounts. When I come and ask for accounts, you are not showing it. One of the grounds. Transfer of interest to third party. We'll be seeing this in the next one. Assignment of a transfer partnership. Continuous or perpetual losses. Meaning people, A, B and C are a partnership firm. For the last 5 years, it's a continuous loss. One of the partner is telling, going to the court, sir, we want to dissolve our partnership firm. The court may, if it is convinced, pass an order for dissolution. May. All these are may. I'm not saying it is mandatory. It will happen. But one of the partner can go and request the court. Possible. Last one, people. Just and equitable grounds. Just and equitable grounds is nothing like etc. I can't write every ground. So few grounds are like etc. It can happen. And can more happen? Yes, more things can also be there. Example. A deadlock of management. What do you mean deadlock? Sir, 4 partners are there. 2 people say yes, 2 people say no. Deadlock. What do we do? At least one of them should compromise. Next one, people. Management not in talkative terms. Hey, macha poda. You go, I go. If you guys are not talking, how will the business happen? This is nothing but people disputes. Next one is loss of substratum. The purpose for what you started your business for. That purpose itself is gone today. For example, we started our business as a typewriter firm. Now I cannot continue typewriter. My purpose is gone. Either I need to update it or I just need to close it. Correct? Next one, people. Gambling by partner on a stock exchange. Of course, not possible. Always riskier investment. Agreed? You want swing? No, it's not in swing. No, but see. You want swing means it will be like this. See. Up only. Okay, na. It's cold, Okay, na. You're also feeling cold, All of you are feeling cold. That is because of you are feeling cold, Fifth bench is telling you, yes, sir. Oh my God, sir, Kashmir only here. Okay. Let us look at the second unit. You guys had your breakfast? So you guys will have out, What? Okay. Unit 2, relation of partners. We'll finish this and we'll take a break. Relation of partners to one another. General duties, people. You should be faithful, you should be loyal and all that. Duty to indemnify means what? Because of you, the partnership suffers any loss, it is your duty to compensate it. Rights and duties of the partners decided by them as per the contract. But can we vary those duties and rights? Possible, provided all the partners have to agree for it. Agreement in restraint of trade. Can we do it? While A, B, C are doing partnership firm, can we have a clause that C cannot do any other business? Can we have such clauses? Answer is yes, possible. Clear? Yes. Next one, conduct of business. Who will conduct the business? All the partners will take part unless until you do not want to. And you have to do it diligently, meaning no negligence. Any difference of opinion will always be sorted by majority of votes. For change in the nature of the business, we were doing finance till today. We want to become educational. All the partners' approval is required, not majority. Every partner can inspect and take the copies of books except transferee. We'll be doing when we're doing assignment of a contract. Mutual rights and liabilities. Can you get a remuneration, people? Can you get remuneration? If it is given in the deed, what if it is not given in the deed? Not at all possible. But there is one exception. What is that? Can be given if agreement provides or if it is customary. What do you mean by customary? Meaning we have been paying for the last 70 years. It's been a part of it that we pay some 10,000 rupees for every partner. If it has become a custom, now even if it is not there in your deed, it will become valid. Clear? Yes, okay. Right to share profits. We'll share it as per our agreement. If not, we will share it as per our capital contribution. No. Remember, equally, they may ask you a question. Interest on capital, you will only provide when the agreement provides, or if it is trade or customs, or if it is any other statutory provision. Income Tax Act allows you to pay 6% rate of interest on all your capital you have brought in. Income tax is allowing it. You can provide it. It is okay. Next one, interest on advances. What do you mean by advanced? Money given by a partner over and above his capital is called as an advance, like a loan. Can I take interest on it? Yes, possible. Up to 6% per annum, it's possible. It seems. Clear? And whenever, remember, because of your fraud or negligence, if the partnership firm suffers any loss, it is your duty to indemnify. And whenever, because of the firm's negligence, someone has done a negligence, the other partners suffered loss, it is their right to get indemnified. Correct? Now C did a fraud. Should A and B be liable to an outsider? Are they liable?
Yes.
They are liable. Mutual agency. If C did something, A and B are liable. But don't you think I have a right to get it indemnified from C later? Yes. That is what they are telling you. A person who does fraud is having a duty to indemnify. The person who is not doing anything has a right to get indemnified. Hello? Partnership property. What and all is partnership's property? The initial capital you bring in is partnership's property. Later on, whatever you acquire during the course of business, reserves, revenues, capital that you acquire and you invest in land and all, it's again partnership's property only. And goodwill is also considered as partnership's property. Agreed? Okay, next one. Personal profits earned by partners. What is personal profits earned by partners? While I am in ABC, A is also having his own business. First question, can he do it? First thing, a partner can never make secret profits. Disclose it and do. You take their approval. If they are okay with it, you can do. If not, you are not supposed to do. Agreed? Next one, a partner can never have a competing business. Similar business. What if I have a similar business? Sir, this is also a printing press. Even I am also running one printing press. Similar business. You are accountable for all the profits you make. You have to give it to the entire partnership firm. Sir, third one. Whenever A is using the partnership's network, partnership's name, or partnership's property, and if he is making any money, he is liable to give the profits back to the partnership firm. What do you mean by that? Now the tuitions, morning to evening the classes will be there. Night the class will be there. At 10 o'clock, 11 o'clock, 12 o'clock it will be there. I will come and start one night tuition. Same, anyways I will think, hey, it is anyways ideal, Noda. I will take classes here during the night. Now I am using the tuition's property. If I am making any profits, I am accountable to the tuition. I have to pay money. I have to share the profits is what they are telling you. Understood? I am going to one college nearby and I am telling I am from ArivuPro. I am using the firm's name as an ID card to get inside. If I am doing that, I am accountable for any profits I am making here. I have to come and share it with the partnership firm. So that's the meaning of if you use firm's property, firm's name, firm's network, and if you make any money, you are accountable to give it back to the partnership firm. Clear? Partner earns profit for himself from transaction of the firm, meaning you take some commission or you're using firm's property, tuition or night tuition or firm's business connection or firm's name. I go to that college and enter into a tie-up. He shall pay such profits so on to the firm. Competing business, I need to give it. Always note, a partner can never make a secret profit. Liability to third parties, partners are by default jointly liable. However, if at all there is any wrongful act of a partner, what do you mean wrongful act? Imagine negligent. If at all A, B and C are a partner in a partnership firm and there is a negligence on one partner. What do you mean negligence? Let us imagine C has to take care of everyday operation in a factory. So there was one plant and machinery. It was C's duty to make sure that that plant and machinery is properly covered. He did not properly fence it. One of the employee D, by mistake while he was working near the plant and machinery, his hand fell there, hand went into it, hand got cut. Whose responsibility was it? It was the responsibility of C to make sure that that department is taken care properly. A took care of sales, B took care of finance, C took care of operation. Now whose negligence was this? C's negligence. Who will take care of this? It is whose responsibility to pay to D? C or the entire firm? It is entire firm's responsibility. You need to pay. Negligence. There is a difference between fraud and negligence. Fraud you knowingly you do. Indemnity will come. In negligence we will never speak about indemnity. We cannot even say that C has to pay the money for it. In fraud, it is C's duty. C has to indemnify the firm after I pay for it. In negligence, I cannot say that. It's a business transaction. That's all. Hello? Next one, sir. Liability of a firm for misappropriation. Sir, A, B, C and co. C went and borrowed money from one of the bank, ICICI. He took the money in the name of the firm. He ran away. Is partnership liable to repay this loan? He never got it to the firm at all. But he signed it in the name of partnership firm. He took 1 lakh and he ran away. Is the firm liable to repay this loan? Is the firm liable? Liable, Yes, people. Why did you send C? Why did you take him as a partner? It is your responsibility, macha. Mutual agency. That is only the meaning of what? If at all there is a misappropriation of money, the partnership firm is still liable to the outsider. But later C has to indemnify A and B. But when it comes to repayment, we as a firm, we are responsible to repay. Agreed? Hello? Okay. Next one. Relation of partners to third parties. Of course, partner is an agent of the firm. Implied authority, which we have already seen. Correct? What is implied authority?
In many situations,
Now, for example, I'll tell you guys, organize one, say for example, one award function. I will tell you, for example, what is your name? Jeevan. Jeevan, I'll tell you, you have to organize one award function. For what? For students of ArivuPro. I've given this responsibility to you and I will go. But whatever you do, I'll pay. I've said. Now you tell me, Jeevan, what and all you will do for managing this award function, organizing award function, what and all you will do?
So we will select students.
Okay, you will select the students and
Place.
You will select a place, stage and all. Okay.
Chief guest, awards and some chief guest.
Awards.
and chief guest and food and decoration, correct? And anything else? The people, inauguration dance, and the people, Jeevan gave me, and he came and gave me the bill of 1.5 lakh. I said, Jeevan, hey, I said one award function, one award is required and student is required. What and all have you done? Now my question is, am I liable for whatever Jeevan has done? Now people, I did not give him power for Jeevan. You can book food. Jeevan, you can book award. Jeevan, you can call people. You can go and rent a place. I did not give him power for every small thing. I just gave him one power to go and organize a function. Whatever he can do under that is called as implied power. We are telling A can take care of sales. In sales, if at all he is appointing someone as a brand ambassador, it is his implied power. We cannot give another sales. In that, what and all you can do. Every point we cannot write in the agreement. Hello? Understood what is implied power? But in implied power, you cannot go and just sell off the entire academy only. But you have certain power. That is what we saw. What is not covered under implied power? You cannot sell a property. You cannot buy a immovable property. You cannot withdraw the case filed on the third party. We have filed a case on someone. We cannot withdraw that case. We cannot admit the liability in the court. We cannot open a bank account in my name. All this you do not have an implied power. That you cannot do. Are you getting this point? All of you understand what is implied power? Okay. Next one, sir. In implied power, it can be... okay. See if you guys can interpret this. See if you can interpret this. Can anyone interpret? What is that? Can someone say?
Suppose the partnership agreement says that.
I'll write down whatever you say.
So, suppose the partnership agreement says that any partner cannot take a loan for more than 10 lakh rupees.
Okay, they have said one partner cannot take loan for more than 10 lakh rupees. Okay, and
this was aware by the creditor also.
Okay, D was also aware of this. Okay.
But still, C asked for 15 lakhs and D gave 15 lakhs.
Okay, C still went and borrowed 15 lakh and D actually gave 15 lakh.
Now the firm is liable to pay only 10 lakhs.
The firm is now liable to pay only 10 lakh and not the rest of the 5 lakh.
Yes.
Correct? Yes. Perfect. This is called as what? Restriction of implied power. Very good. Very clearly given example. What is that, sir? When I have clearly restricted my partner's power in my agreement, I have written clearly 10 lakh. If the outsider is still giving that particular 15 lakh to the firm, it is your fate. Even after knowing, why did you give? Now, what if D did not know that 15 lakh restriction is there?
Then the
firm is liable to pay. That is what you have written. Third party knows, third party doesn't know. Got it? Hello? Very good. Partners authority in emergency. What is partners authority in emergency? Yesterday we saw, no? Shippo. So what is partners authority in emergency? It is like agent only. Whatever an agent can do in emergency, everything a partner can do. And is a partnership firm liable? Answer is yes. Sir, I am doing more than what I am allowed to do. Still the partnership firm is liable. Agreed? Yes, provided you should have acted in good faith. Next one, sir. Transfer of partners' interest and transferees' rights. Now what is this, people? A simple thing. What? Can an existing partner A, B and C. Sir, C wants to sell his share to D. First question, is it possible? Can existing partners sell their shares to an outsider? Is it possible? Is it possible? First thing, people, directly you cannot do. You have to first take the consent of A and B. That means what? First you offer it to them. If they are not buying, then you can sell it to an outsider. Directly you cannot sell it to an outsider. That is why they say you have to take the consent from the existing partners. This is clear? Pakka na? Okay, sir, the D is coming in now. Now what are the rights D will have? If A and B are so graceful, they will treat him also just like them. Meaning in reality, I have a right to, conduct the business. B has a right to conduct the business. I will give the same right to D also if I want. But if they do not want, what does the law say? D will never enjoy the same rights as the other partners. You cannot involve in day-to-day affairs of the business. You cannot demand for accounts. Whatever they pay as share as profits, you just have to accept that. You cannot demand anything in specific. Understood? So a transferee can never demand for anything in specific. He cannot demand for accounts. He cannot get involved in day-to-day affairs of the business. Now you guys can question, sir, in that case, why will D even function, sir? See, remember, before coming in only you know this. They have written it in the law. If you still come in, it is your fate. Sir, I have a doubt, sir. C will ask A and B. I want to sell my share. You guys want to buy. A and B does not have money. Now A and B cannot stop C from selling his share to an outsider. Because you did not buy. You cannot stop him forever. Agreed? Pakka na. Now sir, D came in. D came in. But A is not okay with it. B is also not okay with it. They do not want to do the business with D. What can they do? Do they have any right? What right they have? Dissolution by order of the court. Go and file a case. That is where we saw. I told you. I explained this scenario when we are doing assignment of a contract. Whenever the share gets transferred, you can go and say, I want to cancel this contract, sir. I want to dissolve this partnership firm. You can go and say it so. They online or where were you guys done? They online or? Online? Online or?
So, with this, D is given the rights of the normal partners. Does it mean that he becomes a partner automatically?
Yes. If it's given, he becomes a by default partner just like you and me. In reality, what happens? If D doesn't get that, why would D invest? I will demand for that equality. In reality. Where are you guys online now? This part is clear, huh? Hello? So the new partner during continuance of partnership cannot interfere with conduct of the business. They can ask you a question here. Next one is require inspect accounts. I cannot demand accounts. Next one is only entitled to receive profits. Upon dissolution, I am entitled to the entire share of the assets. Upon dissolution, I am entitled to account from the date of dissolution. Online, what happened now? Was there any miscommunication or something? Online? Online. Perfect. Noted, Damacha. This will be uploaded in the YouTube also, so do not worry. So it will be uploaded in the YouTube. Do not worry. We will see what best can be done. Clear? Anyways, partnership is going on. After that, you guys can also join with that particular thing. Minor admitted to the benefits of the partnership firm. Minor admitted to the benefits of the partnership firm. Sir, minor, sir, what will happen till the minor's complete thing? When a minor is admitted to the benefits, what will happen? He can share only the profits. He is not liable for losses. And remember, Macha, it is the entire partnership firm's profit you have to take. That is nothing but net. Meaning, if ITCA, there is classmate doing profit. If it is the hotels doing profit, Pufu is doing loss. You cannot say the minor will get only these benefits. Minor will not get this. You cannot say that. You have to take the entire P&L as a net. If it is in profits, then the minor will get money. If it is in losses, then minor will not get money. Is clear? All of you? Okay. And upon the age of maturity, the major has to take, the minor, once he become a major, he needs to take a call. What is that? Upon I become an 18, or maximum they give me time is 6 months from the date of becoming maturity. Whenever I get to know that I am a partner, or within 6 months from attainment of maturity, whichever is later, but subject to a maximum period of 6 months from the date of majority. I need to make sure I give a public notice. Basically, I need to intimate whether I want to become a partner or I do not want to become a partner. What if I don't reply? You are deemed to be a partner. Clear? Sir, if I am saying yes, I want to continue as a partner, your liability will start from when? From the date you were admitted to the partnership firm as a beneficiary. You remember I told you yesterday, whenever you're doing minor contracts, ratification, minor agreements cannot be ratified. I told you one exception you will see, and that exception is in this particular partnership firm. Is this clear? All of you? Okay. When he becomes a partner, he becomes personally liable to third parties. From the day he was admitted to the benefits of the partnership, his share remains the same. Next one, when he does not become a partner, until the date of the notice, that's 6 months, he will still be treated as a minor only. From the date of notice, his share shall not be liable. He can sue partners for the property and profits only from the date of dissolution. What do you mean by that? Imagine during the continuation, if at all the partners have not given him the right profits, can he file a case on the partners? Answer is no. He gets a right to file a case on the partners for the profits or the share properly, if at all not given. He gets a right only while he is dissolving, meaning while he is leaving and going. While he is continuing as a minor, he will not have any right. Understood? Hello?
Unregistered firm, we can sue.
If it is an unregistered partnership firm, yes, possible. And there is one more thing also. Even if it is an unregistered partnership firm, let us imagine A, B and C. C dies. C's legal representative should get a share. Yes or no? As a legal heir. People A, B and C are unregistered partners. Partnership firm. C dies. Now C's legal heirs has to get that share. A and B did not give that. Now the question is, can the C's legal representative file a case on this unregistered partnership firm? Is it possible? Yes, it is possible. Remember? Yes? Okay. Legal consequences of partners coming in, going out, we have already seen. Admission of a partner. From when will your liability starts? From the date of becoming a partner. Agreed? But can I be liable for the previous debts? Possible. Novation. With my approval, with creditor's approval. Everyone has to agree. Then I can become. Same thing, people, retirement. A person leaving and going, he will continue to be liable for all the things that were done while he was a partner. Again, subject to novation only. Meaning all the partners agrees. Creditor also agrees that my name need not be included. If they are agreeing, then people, my name can be removed. Again, novation will come into picture. And remember, if you are a active partner, your liability continues until the date of public notice. Do not forget that. Correct? Okay, next one, people, expulsion of a partner. What do you mean by the word expulsion? Expulsion means removal. Can we remove any partner whenever we want? Yes, provided we need to satisfy some conditions. What is that? The right of removal should be present in the partnership agreement. In that agreement, it should be written that partners have a right to remove other partners. What if it is not there? If it is not there, people, you cannot remove the partner. Second one, majority of the partners have to vote. Sir, what if 5 people are there? 4 people are saying, no, we want him. Only one person is telling that this person has to be removed. Such case, you cannot remove. Majority of them have to vote in favor. It should be exercised in good faith. Meaning what? Your personal vengeance and all cannot be taken care here. Agreed? Sir, good faith means what? It should be in the interest of partnership. A notice of removal should be given to the partner. Give him an opportunity of being heard. Listen to what he needs to say. If these conditions are not satisfied, such expulsion is null and void. Sir, insolvency of a partner ceases to be a partner. The day you become insolvent, when adjudicated, meaning court's order is passed. Death, whenever a person dies, on the death of a partner, his liability ends. Agreed? And remember, upon a death, what happens, people? A, B and C. C dies. His legal heirs has to be given the compensation immediately. What if the compensation is not paid and A and B continues to do the partnership? Whatever are the subsequent profits they earn, in that they still have to give the legal representative the profit share. Or what if no profits is made?
They have to give it as a loan.
They have to give it like an interest, 6% per annum interest will be paid to them. Understood? Hello?
can choose between both.
Choice is one. What if, see, you will pay profit when the partnership firm makes a business. What if a business itself is not made? I should still give you, no. That is why we give you 6% rate of interest.
That is the choice that legal has.
Correct, yes.
Whichever is more, he can.
Yes. Clear? Understood? Okay. So we covered everything. What is the difference between partnership and all that? We will do once we do company as well as LLP. Done? Okay. Go for a break and come. You guys want to have breakfast? Okay, half an hour. Can we be back by 10:25? Okay. Back, all of you. Okay. Let us start the next chapter, sir. Okay, we'll do of Companies Act. Okay, yes, people. Companies Act, let's start. Now, the first things are, yes, features of a company. What are the characteristics of a company, sir? The characteristics of companies, people, first one, separate legal entity, or we also call it as separate person, artificial person. There is a person who can enter into a contract, who can sue, be sued, they can enter into contracts, they can hold properties in their own name. All that is possible in the case of a company. That is their character. Next one is called separate legal entity. What is the case law you guys would have seen? Salomon versus Salomon. In that case, it was held that what? Once the company is incorporated, even though you are a shareholder, you are still considered as a separate person. You are nowhere related with the company. Company is a different entity and the person is a different entity. If you guys have seen the recent podcast of Vijay Mallya, in that he said he will question Raj Shamani. What is that? He will say, be aware. He says, Vijay Mallya did not borrow 1 rupee loan. It was borrowed by another person, and the another person is called Kingfisher Airline. I did not borrow. Correct? You guys have to question Kingfisher Airlines and not me. Who says? Vijay Mallya says. Agreed? No? Now that statement. Correct. So after looking at that podcast, you will find what corporate will. What's that? It gives you a good insight. Now people, of course it is just a version and a perspective. His perspective he has explained there. Now, separate legal entity or corporate will. So what is this? Here it is nothing but the shareholders are different and the company is different. Now, in the break, he had a question. The case was what? State of Gujarat versus Raman Lal. In Indian contract also you have that question. You have that, that case law, you have it in the partnership also. In that case, what had happened? A, B, C was a partnership firm. In this, there were 3 partners, A, B and C. Upon the dissolution, the partnership firm is coming to an end. Whenever a partnership firm comes to an end, what will happen? After they realize all the assets, they will sell all the assets, they will repay all the liabilities, whatever is the excess left, that will be shared amongst the partners, right? In the profit sharing ratio as per your partnership deed. So in this case, what happened? After selling all the assets, after repaying all the liabilities, the profits were shared with the partners. There was an income tax officer who wanted to tax this particular transaction because the profits are being distributed to the partners. Now, whenever there is a profit, now imagine if at all I have taken gold for 10,000 rupees. After some 5 years, I am selling it to you for 20,000. I made a profit of 10,000. Under Income Tax Act, it is taxable. I have to pay tax on this 10,000 rupees profit. Yes or no? Yes or no? Now people, because of that, in this case what happened, an income tax officer said whenever this transfer is happening, you need to pay tax on this particular sale that or transfer of the profits you guys are making from the partnership firm to the partner. Whereas our complete law has told us one thing, what people, there is no difference between partnership firm and the partners. They are one and the same. They are not two different people. When they are not two different people, then where is the concept of transfer from one person to another person? Agreed? Where is there a transfer? If I give mine to you, is where there can be a transfer. If it is within us, if I transfer my property to me only, should I pay tax on it? No, the same happened here. Partnership firm is not a different person. It is not a different entity. It is partners themselves. Correct. There are no two person. So partnership firm cannot be identified as a person in the eyes of law. Sir, now cut, copy, paste. Let us imagine there is a company here. Company is getting wound up. Upon the end of every liability is paid, the assets are now given to the shareholders. Should I pay tax on it? Answer is yes. Now it is taxable because company is a different person in the eyes of law. So it will be considered as a transfer from one person to another person and hence taxable. Understood? That is the case, and that is this concept of separate legal entity. You are considered as a different person. Clear? All of you? Okay, done.
Purchased in the name of the partnership firm will be counted as business expense.
Correct.
But when it is being transferred, it is the asset of the...
So, when it is purchased in the name of partnership firm, it's a business expense which we have paid from the partner's pocket only, not from the firm's pocket. There is no difference between partner's pocket and the firm's pocket. It's the same. Whereas in the case of the company, the shareholder's pocket is different, the company's pocket is different. We have a different bank account for the company. And in the eyes of law, company is a different person that has life. That's why we call it as a artificial person. Company is a artificial person. We are considered as what? Natural person. Understood? Pakana? Okay.
Then can we make partnership and make sales between property sales between partners and then we can dissolve?
Like?
So he's saying that...
A is transferring to B.
No sir. We create a partnership for sale of property to evade tax. Can we make this legal?
See, let us imagine there is a person called as D. He would have sold some property to ABC and Co. On this transaction, would you have paid tax or not? You would have paid. Now, instead of we buying it from our pocket, we have purchased it in the firm's pocket, on which there is already a tax paid. Where are you evading tax?
If we write off the tax with the business expense like that.
This you cannot, because on this you would have paid tax. The taxability has already come. It has arisen. Now there are two scenarios. You can imagine like this. I can either, now people imagine, I want to buy a bike. I can directly buy in my name, or I can buy in the name of partnership's name. What difference will it make? Money is the same. The ownership will be in the firm's name, meaning it will be like a joint name. You are not evading any tax. Because that also is me only. This also is me only. Just that it will be in the name of all three partners. That's the only difference. And if you ask me if there is any other advantage, yes, advantage is there. What is the advantage? Tax. Second thing is you can claim depreciation. Now if I buy bike in my name, there is no what depreciation is there. Nothing is there. But if I buy it in the name of the partnership firm, if my profits are say 20,000, I can claim a depreciation of 3,000. So I will pay tax not on 20,000 profit. I will pay tax on 17,000 profit because depreciation I will get a right. So these are all not considered as loopholes or tax evasion. They are not tax evasion. They are tax planning. If you can have it, you can do it. Correct? Yes, okay. Next one, perpetual succession. Correct? If a company has three shareholders, A, B and C, all three of them die, what will happen to the company? Nothing will happen. Company will go on for ever and ever. Ratan Tata died. Tata came to an end. Dhirubhai Ambani died. Reliance came to an end. No. Mukesh Ambani, Anil Ambani, or whosoever after Tata, anyone who's taking care of it. Tatas are going forward. So, sir, a person dying does not put an end to the contract, does not put an end to the company. Company will go on forever. Agreed? Vittal Malia died. Kingfisher came to an end. United Breweries came to an end. No. Vijay Malia's father was Vittal Malia. It went on, no. Carried on, no. Okay, next one. Limited liability means what, people? The liability of the shareholders are limited. Whereas in partners, if at all there is, imagine, we have all put in 5 lakh capital, but the partnership firm has almost 10 lakh, 15 lakh losses. If partnership firm money is not sufficient to pay, the partners will have to pay from their pockets. Because we are time and again telling you, there is no difference between partnership firm's pocket and my pocket. So if the partnership firm's pocket is not sufficient, they will put money from your personal pocket also. There is no difference. Whereas in the case of company, we have put in a capital of, in our class I would have told you, you know a company which has not repaid a loan of 5,000 crore, 5,500 crore. That is Kingfisher. We all know about this company, but we do not know about so many companies that have to pay even more than that, who are dying every day. We do not know about those companies at all. Example, say Videocon. Videocon has a total loss mounted up to 70,000 crores. Where is Kingfisher? Where is Videocon? You guys don't even know about it. Then what is the difference? And the shareholders of Videocon, are they poor? No, they are very good. They are doing good. They are rich. They are all happy, fair, healthy. Absolutely fine. Are we asking them to pay from their pocket? Answer is no. Then, so remember, a company will always be shielded with one of the best protector for you. That is only called as limited liability. The shareholders are liable only to the amount of capital they have invested. After that capital is done, my liability is limited. I am no longer liable. Understood? That is only called as what? Limited liability. My liability is only to the extent of unpaid calls, if any. What do you mean by that? There are 10 shares I purchased. The face value is 10. Company has called 6 rupees. 4 rupees is uncalled capital. Up to I pay this 4 rupees, my liability is still there. Once I pay the entire 10 rupees, my liability is done. Understood? Next one, artificial legal person, which we already discussed. Next one, a company should have a common seal, yes or no? No, it's optional. Sir, if a common seal is not there, then on behalf of the company, who will sign? 2 directors, and if a company has CS, it shall be 1 director and 1 CS. Correct? So this is on the, if common seal is not there, then this is the option. Is this clear? Okay, done. Next one, sir. A concept of lifting of corporate veil. What do you mean by this? Whenever, now, this is how Indian government did. The loan was taken by who? Taken by Kingfisher Airlines. Then why are we behind Vijay Mallya to repay the loan? Why are we asking him to repay the loan? So this is only called as what, people? Lifting of corporate veil. Concept of lifting of corporate veil. Generally, whenever there is a company, we clearly say that whenever there is a company, there are shareholders. In between the company and shareholders, there is always one cloth, one dividing line between the company and the shareholders. Whatever the company does, the shareholders are not affected by it. Whatever the shareholders does, the company will not get affected by it. But there are scenarios where if the company does anything, it will be treated as if the shareholders only have done it. Now what is the scenario, sir? Example is Vijay Mallya's case, where they are telling that the company borrowed loan. In the name of company Kingfisher Airlines, the money was borrowed. But where was the money utilized? They are claiming that the money was utilized for various other purposes, like YAO, RCB, sponsorship. Where are you getting money? IPL. Hello. Remember all the points. If you do umpires and all, even today it says what is that? Kingfishers. Umpires uniforms are see every team is going behind one particular brand which is sponsoring a team, but you need to give a credit. One common person who will never change his umpire, and this fellow sponsored the umpires. That is his brain. I am telling you, he went through a lot of it, but no brain can come near Vijay Mallya. That is how brainy this guy is. Hey, every other brand wanted someone else as ambassador. For which, if you look at Byju's, they went to Shah Rukh Khan, Messi and all. How much they paid? $2 million was what paid for Messi. Now Virat Kohli, how much are you paying for Boost? MS Dhoni, how much? In recent interview, Ravi Shastri has said the earning of a cricketer from endorsement will start somewhere between, if you are doing good, your endorsement will start at 150 to 190 crore is what your endorsements will start with. Who is paying all that? Company. Company who is paying? You only. When they say boost is 100 rupees, in that 10 rupees is what? Endorsement cost only. Yes or no? Vijay Mallya was so smart to say, I am no less than any endorser. Why do I need an endorser? Why Kohli, why Dhoni? Vijay Mallya built Kingfisher brand, keeping him as a face of it. He walks, advertising happens. Credit to be given for a person to think all of this 40 years back. Yes or no? He's a wonderful business mind. Wonderful business mind. But yes, scenarios and of course ifs and buts, all the stories and perspectives. We cannot give real thing to it. That is where I say. And all the shirts will have logo. But you see all the players ka pant. It is Kingfisher. Common. Then, yes, no. It is. Anna wanted something and all. There are a lot of perspectives. But yes, he says he has not done anything, but we say everything he has only done. But yes, let the courts decide that. So let us imagine Vijay Mallya's case only happened. Where we are blaming him that he has taken 6,000 crores which he never repaid. Now in that case we will tell Vijay Mallya cannot say, sir, that money was taken by that person is Kingfisher. You ask from him, why are you asking from me? So law will come and say, whatever is a line we have drawn, we will remove that line and we will say, you both are one and the same. Whatever he has done, you are liable for that. This concept only is called as what people lifting off corporate wheel. Understood? Pakana? Yes. Lifting off corporate wheel, when and all it can happen, sir. The first one, to understand whenever, if you are trading with an alien enemy. Case law, Daimler Company Limited versus Continental Tires and Rubber Company. What happened in this case law? There was a company called as A. There was a company called as B. A was supplying tires to company B. The contract was for 3 years. Company B, once the contract started, imagine after 5-6 months, they wanted to end this contract. They said, we do not want to continue this contract going forward. The question asked, why? They said, because if we do the contract with you, it will be against our law and hence we do not want this contract with you. A company said, no, we have a contract for 3 years, you have to buy the tires. They did not buy, the matter went to court. A company filed the case on company B. Now in the court, people, what was the argument? The company A said, sir, there is a contract and company B is denying to take the goods from us now. Company B said, sir, do you know who are the shareholders of company A? Do you know who? Sir, our companies, both A and B, they are registered in the UK. A company is also registered in UK, B company is also registered in UK. But where are the shareholders of company A? Where are they from?
Germany.
They were all from people Germany. So what? What if they are from Germany? When this entire case was happening, people, it was a case of that during World War. World War was happening, which at that time Germany had declared UK and UK had declared Germany as what? Alien enemies. Are you getting it? Now, when we had declared each other as alien enemies, now what will happen? Now, always we saw it in contract also. You cannot enter into a contract with your alien enemy. Now, sir, company A said, sir, that is our shareholders are in Germany, but we saw the nature of the company. What does it say? Separate legal entity. I have taken birth in UK. I will be considered as a person belonging to UK. Why is this Germany coming into picture now? The control is with Germany, sir. If we give business to A will earn must profits, sir, and the entire profits will go to the shareholders as dividends. Sir, and company A will do whatever the shareholders from Germany tell them to do. Sir, end of the day, don't you think everything, karta, karma, kriya of company A is happening from Germany? Sir, whatever cannot be done directly, cannot be done indirectly also. They cannot directly enter into a contract with us. So they cannot even do this indirectly as well. This is what was discussed in the case of Daimler company. Understood? Hello? Pakkana? Okay. Second one, people, to evade taxes. In Dinshaw Manekji Petit's case, what is this Dinshaw Manekji Petit's case? Called as? It is also called as Dinshaw Manekji Petit versus Commissioner of Income Tax. There was one person. One person gave money to 3 further companies. He floated 3 more companies. This person had 1 crore. He gave 1 crore to 3 other companies. What did these companies do? These companies further invested into various other companies. They did not do any other business. They further invested into various other companies. Now, whenever these various other companies, let us imagine like ITC, Bata, Bajaj Finance, imagine whatever, Reliance, Divis Lab or something, all other companies, Infosys, all these companies are doing good. Now, what will they do? They will start giving dividends, no. They will start giving interest, no. So people, these companies, company A, company B, company C, started earning good profits. They started earning good profits. Now, as per Income Tax Act, what does the law say, people? Whether an individual or a company, whoever makes profit, you are liable to pay income tax. Now, people, company also has to pay income tax. Now, what did this person in the top do? The person in the top, whatever profits these companies were making, imagine 2 lakh, 5 lakh, 1 lakh, all this money was taken by this person as loans. So in total, how much? Now he has taken 8 lakh loan from all these companies. End of the day, whose companies are all that? It is his companies only. Now he took these loans and he never repaid these loans. Now because of that, what happened? The companies never had profits at all. All the profits became debts and bad debts. End of the day, you will never recover the money, and neither the company had to pay tax. Now this person, you think from his capacity, he is getting loan. On loan, anyone will pay tax. Doing this, people, this person, his name is called as Mr. Dinshaw. He literally evaded taxes for years by keeping the company as a mask. So what did the authorities do? Authorities came and they did something called as lifting of corporate veil or a corporate mask. They saw who is hiding behind these companies. Who was hiding? Our fellow called as Dinshaw was hiding behind these companies. And they said whatever profits the companies made, you are liable to pay tax on it. That is only the case of Dinshaw Manekji Petit. Clear? Yes, sir? Doubt, sir? Clear? Okay, next one, people. Subsidiaries to act as an agent. In one case, what happened? There was a company that was registered. The company wanted to do one logistic business. Packers and movers, you tell, no, like big trucks and all, you put luggage or you send. So they had around 20 trucks, people, but which did not comply with the regulations of the country. Like it has been overused, emission tests was not good. So technically those vehicles were unfit. So this person applied for license approval with their RTO. We have RTO, no? Same way they also have RTO. We call it as Transport Commission. So this company applied for licenses for this trucks with this RTO office. Hello? Now, sir, the RTO office, after looking at the condition of all these vehicles and all, they rejected this license and also said, because for doing such things, this person was also disqualified from applying the license for certain period. Like say 1 year, 2 year, he was disqualified. Now, what did this company do? They want to do the business. They formed one more subsidiary company. And they applied license again with this RTO. Their idea was, if the license is given to this subsidiary, they will transfer all these 20 trucks to this particular company and they will shut down this holding company. So in this case, people, when they interrogated, RTO got to know, hey, again 20 lorries, hey, again same business. How can same scale again come within such a short duration? How can a second business come? When interrogated people, they got to know the holding company is none other than the same company which they had rejected the license for. They formed a subsidiary company just like a mask. Hello? Yes, sir. So in this case, it was decided, people, even the subsidiary company will not get the license because they could not do it directly. They wanted to do it indirectly. Of course, law does not allow you to do so. Hello? Case law, people, Merchandise Transport Limited versus British Transport Commission. Clear? Next one, sir, to avoid legal obligation. What is this to avoid legal obligation? In one case, what happened? So there was a company. There was a company called Company A. Wherever the Company A was situated, there was a law there. What? Whenever a company earns good profit, it is because your workers have worked hard. You need to give more and more bonus to them. If your profit increase, their bonus also will increase. Company A, apart from their own work, Company A had also various other investments, like they had invested in another company called Company B. They had invested in another company called as Company C. They had made lot of investments. Now, whenever you have made investments, you will of course get what? Return, you will get dividends, you will get interest, yes or no? Hello? Now, whenever you get dividend or interest, people, don't you think your profits will go up? Whenever your profits will go up, what does the law say? The bonus will also go up. The money earned by the company goes up. That means even the money earned by the employees also will go up as per the law. Now, what did Company A think? Hey, why are we giving them so much of profit that are not required? Let us open one dummy company. And what will be the job of the dummy company? The dummy company, people, they will take away all the investments that we had in the Company A's name. They transfer everything in the name of Company D. They sold it to Company D. Now, who is the shareholder of Company B? D is the shareholder of Company B. Sir, C. D is the shareholder of Company C. Now, dividends started coming to Company D. That means what? The profits of Company A started going down. Last year we got 5 lakh extra. This time the 5 lakh went down. Indirectly, bonus of the employees also went down. Of course, they waited for a certain period. After that, they filed a case. When the case was filed, they got to know that they have created an artificial person just to evade legal obligation. That is, they have to pay something called as bonus as per the law of the land. They are trying to evade that. They are trying to stop that. That is why you guys opened Company D. Yes or no? In this case, corporate wheel was lifted. Whatever earnings Company D is getting, they had to pay bonus even on that particular earning as well. It was treated as Company A's earning only. Yes or no? Pakka na? Understanding? Why I am explaining this case laws is, in this Companies Act, they will directly give you these cases only. It will come somewhere, that only will be asked. That's why I am explaining those case laws. Clear? Is here cold? I've kept in 1 speed fan. I've increased. Okay, wow. Come on, this is lit side. This is, little this side. Or do you want to go back 1 bench? No, one bench you tried go back because I think it is coming directly and hitting you. Go back one bench. Because fortunately or unfortunately, that place will feel cold, but that is the only AC for the entire class. That won't come here. Now you guys would have, it is coming there? Because I think it is turned off or something. You want it, huh?
But let's go.
That is what, we can make it work. What would have happened now? When the class started, they would have set everything and they would have gone. Tick, tick, pressing, button. Mode will change, of course. That's what I'm asking. If you want, I will pass on the remote. Turn on the AC, it will work. You want a backbench? Cold. Okay. So what I would suggest you is keep these places empty. Because that is where it will directly hit. Of course. Yeah, now feeling better, huh? Company formed for fraud or improper conduct or defeat the law. Gifford versus Horn. What is Gifford Motor versus Horn? Gifford Motor versus Horn. Gifford Motor versus Horn. What happened in this case, Rana? You guys know this case or what?
Before Gifford was formed, the actual owner was in another company who came out of that and started their own business. But before coming out, they were agreed that they won't solicit the customers. But he did the same with joining with another party, making him as a owner and working under him. He showed it like that, and he was soliciting the customer.
Okay. What happened in this case? There was something called as Gifford Motor Company as a company. They hired one person as their managing director. Who was this managing director? This managing director's name was Horn. There was a name. So Horn was appointed as a managing director of Gifford Motor Company. Now in Gifford Motor Company, they had a very good clause in the agreement. What is a clause? If at all you are terminated from the company or you leave the company for the next certain period, imagine 3 years or 5 years, you are not supposed to solicit our customers. Solicit means what, people? Take away, attract. That means what? You are not supposed to do any business with our customers for the next 3 years or 5 years. So with that condition, Mr. Horn was hired by Gifford Motor Company. He worked there as a managing director for around 6 months time. After 6 months, people, something did not go good. So Horn left that company. After that, what did he do? He started selling the Gifford Motor Company spare parts only in the market. He directly started selling. Gifford Motor Company gave him a warning. Mr. Horn, did you forget? We clearly told you for the next 3 years or 5 years, you are not supposed to do anything which makes you attract our customers. You are not supposed to do the business with them. Now what did Horn do? Horn incorporated one company and he made his wife and his friend as the shareholders of that company. Who were the directors? Directors were also of wife and friend only. And what did that company do? The company started dealing with the spare parts of Gifford Motor Company again. But who is controlling the company? The controlling party is Mr. Horn only. Whatever he is telling is what the company is listening to. If I am telling this, the company is listening that. If the company is doing this, that is because of Horn. Gifford Motor Company now filed a case on the company. Your Honor, we had a clear clause that he is not supposed to solicit, meaning attract our customers. He is still doing it by forming another company. Horn said, sir, company is different, I am different. Separate legal entity concept. How many times should I tell this concept again and again, sir? Horn said. Correct, no? Once a company is formed, you are different, I am different, no? Yes or no? But the law said, people, no, it is not like that. End of the day, you are the person who is controlling the company. You are trying to achieve what cannot be done directly. You are trying to do it indirectly. The restriction was not only in the name of Horn, that you as a person, whether directly or indirectly, you are not supposed to solicit our customers. Agreed? That is what was decided in this case law. Any doubts? Hello? Done? Done. Okay, next one, sir. Classes of companies, different types of companies. The first one is called people, company limited by shares. What do you mean by that? The person is liable up to the amount of unpaid calls, if any. Up to that amount, I will be liable. Next one, company limited by guarantee. Meaning, we will give a guarantee on the day one. We will not tell that we will give the capital. Company limited by guarantee means what, people? There are some types of companies in India who do not need capital to start their business. Without capital only they will function. What type of companies they are? They do not need capital, it seems. Rest of the companies need capital. These companies do not need capital at all. Then these are called as people. Company limited by guarantee is always a non-profit organizations. You also call it as Section 8 companies. Now, why don't they need capital to function? Because they have one or the other way of income source. That is, they can get money from probably subsidies. Government will give. Donations. People will give. Charity. You are getting money, no? Why capital? Agreed. Sir, what if that money is not sufficient? That's why we give guarantee by the members. So the initial people will say, we are giving guarantee on the day one. Let this company function. If money is not sufficient on the day of winding up, that time I will give 1 lakh, B will give 1 lakh, C will give 3 lakh. That guarantee amount will be agreed today only at the time of registration of a company. Such type of company is called as company limited by guarantee. Example, Reliance Foundation is a company limited by guarantee. The last type of company is called as unlimited company. What do you mean unlimited company? The shareholders only are telling you, sir, we don't want limited liability. Please keep our liability unlimited. Shareholders only are telling you, then we will keep it unlimited. This is like treating it like a partnership firm. Your liability will not be ending to the amount of capital. It will go beyond, meaning your pocket, personal pocket is also liable for repayment. Agreed? Okay, next type of companies on the basis of control. So there was this company called as GSK, GlaxoSmithKline, which was unlimited for a lot of time. There is one more, if you want an existing one. One second, I forgot the name of the company. Even Range Rover was unlimited for a very long time. You know, Range Rover was also unlimited, was very long time.
You can change unlimited to limited.
Possible. You can convert from unlimited liability to limited liability. Possible. Whenever you want, you can do. But there are procedures to do that. See, Discovery Communications India, Discovery, it's an unlimited liability company. In the brackets they would have written private company with unlimited liability. In the brackets it will be there. Discovery Communications. Can you see this? Discovery Communication India, look at the bracket. That is how the name will be written. Again, one more place where you will not get examples. Here, understood? There are many more also, but yes, these are the popular ones. Copied? Means understood?
They will contribute only only in the event of winding up the.
Correct. When the winding up, see, initially they will contribute for whatever is a limited capital to start with. If that is not sufficient, on the ending date, I will give more. It's called as unlimited liability company. Yeah. Next one is called as on the basis of control. First one is holding company. What is subsidiary company now?
Where the composition of control of board of directors controlled by another company.
Okay. Imagine there is company B. Macha one question will pakka be there on subsidiary company. There is company A. Company A is deciding in company B. Let us imagine there are in total 5 directors. Company A is deciding the majority of the directors' appointment and removal. That means what? Out of 5 directors, company A is deciding who the 3 directors should be. I am appointing, I am removing. Then people, company A is called as what people? Holding company. Company B is called as what people? Subsidiary company. Is this clear all of you? Yes? Okay. Next one people, what do you mean by subsidiary company? Second one, where one company controls more than 1/2 of the total voting power. What do you mean by that? Company B has 100 shares. Company A is controlling more than 1/2. Half means 50, more than 1/2 means 51. If company A is controlling more than 1/2 of the total voting power, which share has voting power? There are 2 types of shares, no? Equity preference. Which share has voting rights? In general, when no other scenario is there, then generally equity shares have voting rights. So they're talking about equity share in general here. Okay, third one now. There is something either on its own or together with its subsidiary. What do you mean by this? In your exam, all these examples, same thing will come. When they're asking you a question on subsidiary company, start drawing in a pencil. Try to understand how they are trying to frame it. You will understand it better. Company A has a subsidiary company, company B. There is another company called as C. In company B, A is holding 51 shares. In company C, B is holding 30 shares. In company C, A is holding 25 shares. What is the status of company C? They are asking you. What is the state of company C? Company C is a subsidiary of company A, na? Is it a? Tell me. Company A is holding 51 shares in company B. Company B is holding 30 shares in company C. Company A is holding 25 shares in company C. What is the status of company C to company A? What is the relationship?
Out of 100 shares.
Out of 100. I'll tell you what is your confusion. Your confusion is associate company, subsidiary company. Remember people, this is where you need to read the definition. Controls more than 1/2 the total voting power, either on own, that is directly, or together with its subsidiaries. Meaning what? Sir, now remember people, whatever I tell, B will listen to me. Because 51 votes I have. I am controlling company B. Now company C, what should happen in company C? B will decide it to the extent of 30%, correct? A will decide it to the extent of 25%, correct? That means 55% I am only controlling company C, no? Yes or no? No sir, company C will be considered as subsidiary of company A. Hello? Pakana? The last one sir, deemed subsidiary. There is company A, there is company B, there is company C. Company A holds 51 shares in company B. Company B holds 51 shares in company C. Company A is a holding of company B. Company B is a holding of company C. Company C is a deemed subsidiary of company A. Deemed means what? Assumed. Whatever company A tells, C will listen ultimately. Correct? That is the third scenario. Deemed subsidiary company. Agreed? Hello? Okay. Last one is called associate company. What do you mean associate company? Company A has invested in company B. How much? 20% of the shares. Total voting power. Company B is called as associate of company A. Agreed? What if it is 30? 40? 60? Correct? Up to 50, you are considered as what? Associate only. That's why joint venture is also considered as associate company. Up to 50%, you are still an associate company. Beyond 50 is what you will be called as subsidiary company. Clear? Okay, that is your associate company. Done. Next one. On the basis of the number of members, a company can be classified into public company. What is public company? A company other than private company is called as public company. That's the definition. What is the minimum number of shareholders in public company? Private company? OPC? 1. What do you mean by a private company? People, one more thing. Public company. The subsidiary of a public company is called as XYZ Limited. They have one more subsidiary, ABC Private Limited. XYZ Limited holds 55% of shares in ABC Private Limited. What is the status of ABC Private Limited? Of course, it is holding this subsidiary. ABC Private Limited will be considered as, it is deemed to be a public company. Even though the name says Private Limited, you are functioning as a public company. You will not function as a private company. But name will have Private Limited only. Is this clear? All of you? Pakka? Okay, what do you mean by a private company? 3 things should be satisfied. What is a private company? First one, it restricts the transferability of shares. Just like partnership, you cannot sell it to an outsider directly. You have to ask the insiders first. All the shareholders' approval is required. Second one, it limits the number of shareholders to 200. The maximum number of shareholders in a private company is 200. Does it include preference or only equity? Can I have more than 200 preference shareholders? Possible. Or can I not have more than 200 equity shareholders? This 200 limit is for equity or preference? Both separately or together added? So remember, sir, members include equity plus preference. You need to add and take it. 100 equity, 100 preference, that's all limit. 200 equity, okay. 200 preference, okay. But if it is a combination, both together should not exceed 200. Agreed? Hello? Okay, when you are counting this 200, there is a special thing. What? If you have given your shares to any of your employees, do not count them in this limit. Sir, what if I have given them, but they have left the company, it's still okay, don't count them. Correct. So, if we had given it to him, he has left the company and gone, but still a shareholder in our company, we should not count them. The next scenario is, sir, whenever there are joint shareholders, in a bank you will have no joint account. Now, 2 people are holding 1 account. Should we count them as 2 account holders or 1 account holder? That is what they are telling you. If they are joint holders, let 3 people, 4 people, whatever people if they are holding, do not count them as 3. Count them as 1. Understood? The last one, sir, you are prohibited to make any invitation to the public. Meaning, I cannot give a newspaper advertisement. People, do you want to buy the shares of my company? Do you want to buy? So I cannot do a public advertisement of my prospectus because only public company can do it. This is nothing but people, the process of going for an IPO. We do not have a right to do that. Clear? In the private company. Private placement, there is a different concept. You cannot do it as a public advertisement. You have seen Shark Tank, no? Are you going and asking for the entire world to invest or only for those 3 people? That is okay.
Can a deemed public company can issue shares?
No. See, you will have private companies restrictions, but overall function can be as per public company. What do you mean by that? Now it is a private limited. I told you it is a deemed public company. What is the maximum shareholders in that company? Deemed public company, no? It will be 200 only, not unlimited. Functioning will be, because those restrictions are not there in our syllabus now. What is the difference? You will be seeing it in your later classes. CA Inter you will see. Yes, for functionality purpose, you will be treated as what? People, what do you mean by a small company? Paid up share capital is 4 crore. Turnover is? Both are to be satisfied or one has to be satisfied? The condition is and a company's paid up share capital should not exceed 4 crore. Turnover should not exceed 40 crore. Up to 4. Small only. Up to 40. Correct? But can you tell me the actual definition now? What is a small company?
Small company is a private company and the minimum paid up share capital not less than not less than 50 lakhs and minimum turnover not less than 2 crore. As may prescribed, it may extend to 10 crore and 100 crore respectively.
50 and 2 you are saying old limits.
Old limits is amended as 4 crore and 40 crore and as may prescribed such higher amount may be 10 crore
100 crore.
and 100 crore respectively.
Correct?
2022.
Yes, so you have to remember 4 and 40 only. You should not write the old one. 4 and 40 is considered as private, small company. And he said first thing, what is the first statement? What is a small company? Small company is a private company. You have said it like that, but you need to say it like private company is a company other than public company. I mean, small company is a company other than public company. That is how it is written. Correct? Yes, So that means what they are telling you. A small company means a company which is other than public company. There is ABC Limited. What is your name?
Kalai, sir.
Kalai. Okay. ABC Limited. There is XYZ Private Limited. ABC Limited is holding 55% shares in XYZ Private Limited. XYZ Private Limited capital is 2 crore. XYZ Private Limited turnover is 20 crore. XYZ Private Limited is asking your opinion. Can we be called as a small company or not? Can they be called as a small company?
No.
Wait, Kalai, tell. Will they be considered a small company or not? They won't be considered a small company. Why? Now put the definition. What does the definition say? Other than public company, even though you are a private company, a subsidiary of a public company is deemed to be a public company. So this is where restrictions will come. Only one is there in our syllabus, this one. When you come to CA enter, lots of it is there. Understood? Hello? Pakkana? Okay, this is one reason why we cannot consider it as a small company. Can you tell me one more reason why we cannot consider XYZ Private Limited as a small company? This is one reason. Can you tell me one more reason? Very good, sir. A small company cannot be a holding company or a subsidiary company. A small company cannot be a Section 8 company. A small company cannot be a statutory company. So here you are a subsidiary company. A subsidiary companies can never be called as what? Small company. A holding company can never be called as what? Small company. Even on that ground you can say this is not a small company. Understood? Pakka? I hope it is clear. Small company, subsidiary company, associate companies and all are very hot cakes. They will ask you a question. Getting it? Hello? Okay. What is one person company? OPC. A one person company means people nothing but only one person is a minimum member. Directors how many? Maximum is 15. Remember, OPC doesn't mean that you should have only one director. You can have 2, 3, 4, 5 also. Up to 15 you can have directors. Possible. OPC. Who can start a OPC? A one person company. Who can start one person company in India? A person who is a Indian citizen, a natural person, a resident in India or otherwise. What do you mean by the person resident? A person who has stayed in India for at least 120 days in the previous financial year. We call such person as what? Resident in India. So who can start a OPC or who can be a nominee of OPC? A person who is a natural person, Indian resident or otherwise. Resident means 120 days in the previous financial year. Third one, natural person. Natural citizen as well as resident or otherwise. Correct? He can be a shareholder and nominee. One person can be a member of how many OPCs? One person can be a member of how many OPCs? Only one. One person can be a nominee of how many OPCs? One person can be a member and the nominee of how many OPCs? Can one person be a member in one OPC and a nominee in other OPC? Possible, Possible. Possible. I am telling answer, possible. I am saying answer possible, sir. No, sir. Possible, he can be a member in one OPC and a nominee also in other OPC. Possible. Because what does the law say? One person can be a member and nominee of not more than one OPC. Look what they have said. A person can be a member and nominee in not more than one OPC. Okay, I can be a member and nominee in one OPC. I can be a member also. I can be a...
He is the nominee in another company. Means in case the person.
See, there is one condition in the bracket. I will see it. I got your count. Just see it. Sir, there is one company there, OPC. There is one more company, OPC. Same person can be a member here. Possible, possible. Law says I can be a member and nominee. And no, they have given R. And no, I can be a member in one OPC only, no. I can be a nominee in one OPC only, no. Possible only, no. Now, wait, your question is, sir, what if in whichever company I am a nominee, what if that member dies? Law will give you 180 days. In that case, what you need to do? In between these two companies, you have to choose one company in which you want to continue. It can be this company or this company. So it is possible. Understood? This is how you need to interpret it. Clear? Okay. Correct? Now people, can I remove the nominee whenever I want? Can I remove nominee? Possible. Can I change the nominee? Possible. Can the nominee resign? Possible. Can you appoint a minor as a nominee? Not possible. Agreed? Hello? Yes, sir. Okay. OPC cannot do certain activities. What is that?
Investments in non-banking financial
Company cannot do NBFC activities. A company cannot carry on or cannot be converted into a Section 8 company. Not possible. You should only be incorporated for business and only for profit purpose. Section 8 company cannot be converted, neither can you undertake Section 8 activities. Clear? All of you? Okay, done. Next one, people, other type of companies. Government company, minimum 51% of paid up share capital is held by federal government, state government, central state governments. Correct? I'll give you one question now. After the class, you guys write and let me know. There is a company called as people XYZ Limited, in which the shareholding is as under. The shareholding of XYZ Limited is as under. The central government is holding 10% of shares in the company. Another government company is holding 25% of shares of the company. Another state government is holding 20% of shares of a company. They're asking you, what is the status of XYZ Limited? You guys write it and show me your answer, how you are interpreting it. Try to write it on your own. Do not copy, do not use anything. Don't discuss also. Only what your understanding is, based on that, write down the answer. Yeah, don't write it now. We'll write it after this particular thing is done, but you guys write it and show it to me. Clear? Clear? Yes. Okay. Done? Okay. So what is government company? Government company is a company where central government, state government, central and state governments hold 51% together. It's called as government company. Always remember, if at all there is a government company, subsidiary of a government company will be deemed to be a government company. Meaning if at all there is a company in the top, ONGC is a government company. There is another company called as XYZ Limited. If ONGC is holding 51% in XYZ Limited, XYZ Limited will be deemed to be a government company. Same like public company. Clear? Hello?
Public and government both are same.
No. Public company is nothing but a company in which there is no restriction on number of shareholders. That's all. It's called public company. Government company is nothing but if the shareholding is majorly held by government, it's called as government company. Yes, sir. Remember, what type of company you are has nothing to do with the activity you do. A public company means public welfare, government means government activity, nothing. Anyone can do anything. ONGC, one of the biggest commercial player in oil and natural gas corporation, ONGC. Commercial only, no? BSNL, commercial only, no? They make profit. There is nothing like government companies only for welfare and all, nothing. What is a foreign company? A company which is incorporated outside India but has a place of business in India and carries on business activity in India, whether personally or through an agent or through an electronic mode. Sir, there is Google. Google's website is accessible in India. It is called as a foreign company for us. Sir, there is a company called as Emirates. Can I buy Emirates ticket? Yes, sir. Does Emirates company exist in India? No. But if you guys buy it through Make My Trip or whatever is the other websites you guys use, Go Ibibo. Can I book the tickets of Emirates flight? Yes, sir. Now this is called as you are present in India through an agent. You are called as foreign company. Or you can directly be present physically. Amazon. Your Amazon offices. You will be called as what people? A foreign company. Clear? Hello? Okay, what is a Section 8 company? A company formed for promotion of charity, commerce, education, science, research, development, etc. It's a company where prohibition is there on payment of dividend. A company can earn income, but they cannot use it to pay the dividends. There is a prohibition. Agreed? It always operates under a special license from the government. For you to operate as a Section 8 company, you need to get that government from that license. You need to get the license from the government. Remember, if at all you violate the Section 8 any given point of time, that license will be revoked, taken back. If it is taken back, of course, you cannot continue as a Section 8 company any further. Clear? Hello? Next one, sir. Incorporation of a company. How is a company incorporated? First, based upon the number of people, whether you want to form it as OPC, private, public. OPC will have always in its name OPC Private Limited. If you are a public company, you will have limited in the name. If you are a private company, you will have private limited in your name. This is how you identify the type of company. Unlimited, you will clearly have company unlimited. That is there in the brackets we saw. Next one. So you will file the documents with a person called as registrar. What and all you will file? I will file something called MOA, AOA, and one form called as Spice Plus. What do you mean by Spice Plus? That's the main incorporation form document. Spice stands for Simplified Proforma of Incorporating Companies Electronically. That's the full form of Spice Plus. Simplified pro forma of incorporating companies electronically is called as what? Spice plus. What is plus, sir? What is Spice plus, sir? Plus is what? Never thought of it, huh? So whenever we go to hotel, we say, no, sir, spice jasti, plus, sir. Huh? What is plus here? Plus here means nothing but people, the form was amended. When they introduced, it was a first version. Spicy. Sir, spicy. Spice, SPIC itself was the first form. For this form, further features was added. How to differentiate between the old version and new version? The new version, they named it as plus. Understood? Huh? So you file all these documents with a person called as registrar. If everything is fair, correct, proper, the registrar will allot you something called as certificate of registration. Remember people, whenever you are filing these forms has to be certified by a professional. We need to certify the forms. Is this clear? Huh? Yes, sir. That is required. The professional is us only. Clear? Huh? Okay. Now, sir, in the certificate of incorporation, you will always have something called as SIN, corporate identification number. You will also have date of incorporation. That is like a birth certificate, birth date of the company. Clear? Okay, done. Sir, if at all a company is incorporated by giving incorrect details, the tribunal may pass an order for regulation of the management of the company. Meaning I can tell, hey directors, you guys have given all fraud information. All 5 of you come out. I will replace it with the new team. Possible. Next one. Liability of the members shall be unlimited. So limited liability will become unlimited liability. I will directly remove your name from the register of companies. I can even order for winding up of the company. I can pass any other order as I deem fit. Agreed? Next one, the types of shares of a company. One is called as equity share, one is called as a preference share. What do you mean by preference share?
What the penalty or fine of those activities by the members or officers in the company?
Penalties will always be there. Depends upon if you have done fraud. If you have done fraud, there is a section called as section 447. That penalty will be there. If not, the penalty is this only, making your liability unlimited.
Not only asking making it unlimited only or section 447 also include?
Unlimited is one. 447 is a different one. 447 I can even put you in jail. Unlimited is I'm just taking money more than what you agreed. That's the difference. Got it? Huh? Yes, sir. Okay. Types of shares, equity preference. I hope this is okay. What is preference? A share which has a priority in repayment. Why do we call you a preference share? Because you have a preference compared to an equity share in 2 aspects. While repaying dividends and at the time of repayment of capital, at the time of winding up, we first pay it to them and we then pay it to an outsider. Agreed? Okay. The last ones are company's documents. There are 2 types of documents. One is called MOA, one is called as AOA. MOA will have in total what people? In total 6 clauses. The MOA will have 6 paragraphs. Memorandum of Association. The first clause is called as what? Name clause. It indicates the name of the company. Second one is called as registered office clause. It indicates where the company is registered, with state. The third clause is called as object clause. It indicates the purpose, scope of the company. The fourth clause is called as liability clause. It indicates what type of company you are. Liability, limited liability, guarantee, unlimited. It is given in the 4th clause. 5th clause is called as capital clause. It says what is the maximum authorized capital of the company up to which they can raise. The 6th clause is called as subscription clause or an association clause, which says the details about the initial shareholders. If at all you are an OPCA, there will be one more clause, 7th clause, that is only called as nominee clause. The nominee's name will be written here. The next one is called as people articles of association. What is an articles of association? It's an internal document of the company, agreed? Which will give the internal rules and regulations of the company. Hello? For example, according to Companies Act, if you want to change your objects, you need to pass something called as a special resolution. Now in my articles I will say, if you want to change objects, not special, you need to pass unanimous approval, meaning all the shareholders in the meeting should agree. Now such process is called as what? Companies Act says people, my minimum number of directors in a company should be what? Minimum number of directors in a company should be 5. Okay, let us imagine. Take the example of public company. The minimum number of directors is 3. Directors is 3. My articles of association says, in my company, you should not have 3 directors. You should have 5 directors. Can I add such clause in my articles? What is it called? What is this called? Alteration. Companies Act says you have to have minimum 3 directors. My articles are saying I need to have minimum 5 directors. This is called as ratification law. This process is called as entrenchment. What do you mean by entrenchment? The word entrenchment means people making the law stricter. Macha, CA foundation actual exams, board exam, passing marks is how much? 40. I will say here, passing marks is 60. Possible, huh? Possible or not? My intention is you pass here, you will pass there. But can I make 20 here, huh? I will make the passing marks for your class test as 20. Can we have it, huh? You can never go against, less than what is given in Companies Act. You can go beyond. You can make it stricter, but you cannot make it lenient. This process is called as what? This process is called as entrenchment of articles. For entrenching articles, whose approval is required? Directors approval required, ROC approval required, shareholders approval required. Whose approval required? For entrenchment, remember, if it is a public company, you need to pass a special resolution. If it's a private company, all the shareholders approval required to make this entrenchment. Understood? Somewhere they can ask you, remember that. If you want to entrench the articles, if it's the case of public company, special resolution is to be passed. If it is a private company, all the shareholders have to agree for the entrenchment. What do you mean by entrenchment? Making the articles more stricter than what is given in the law. Understood all of you? Pakka? Okay, whenever I am exceeding this, something called as doctrines, correct? What do you mean by doctrines, people? There are 3 doctrines. What is the first doctrine called? Doctrine of ultra vires. In short, what do you mean by doctrine of ultra vires? If at all, Arivu is an educational company. If my directors are entering into a contract for some cafe business, as a shareholder, I can come and say, why did you guys enter into this contract? The company is not bound by it because you went beyond your power. And this only is called as what? Ultra vires. Ultra vires means what? Ultra means beyond. Vires means power. So if a company goes beyond its power, that is given in their MOA, we call such contracts as ultra vires transactions. Ultra vires transactions are void ab initio. It will not bind the company. Agreed? Hello? Sir, next one. What do you mean by doctrine of constructive notice? Now, whoever are the third parties, outsiders, they will say, how will we know whether the company can enter into education, cafe? How do we know? We will say it is there in MOA, no, you refer it. They will say they never gave us MOA. What will we say? It's a public document. I don't know if you have seen it or not. All these documents are available in public domain. You have seen it now? Yes or no? I mean, there is something called as MCA website. In MCA website, we have an option only called as public documents. Any company's details, you guys can view it here. Correct? In class, we would have viewed some company's documents also. So, sir, this is only called as what? Public documents. No one has to give it to you. You can only go and see it. It is accessible. Correct? Huh? This only is called as what? Doctrine of constructive notice. What do you mean by doctrine of constructive notice? Whether you have read the document or not, it is assumed that you have read it. It is assumed that you are aware of the information. It is assumed. Understood? Pakana? Sir, but will every information be available in a public document, sir? Now, Coca-Cola, what and all I should put, sir, to make Coca-Cola? Will it be there in public document? Of course, all the information cannot be there. Agreed or not? So, sir, some information will not be available in public domain. Internal matters of the company will not be available in the public domain. And such things are called as what? Doctrine of indoor management. What do you mean by doctrine of indoor management? Outsiders will always be protected by from the company. Doctrine of constructive notice, the company will be protected from the outsiders. So remember, doctrine of constructive notice, we always try to protect the constructive notice, company from the outsiders. And doctrine of indoor management, we try to protect the outsiders from the company. Agreed? Yes, sir. However, the doctrine of indoor management has certain exceptions. What is that? First one, if the person has an actual or constructive knowledge of the irregularity. What do you mean by that? We generally try to protect in indoor management, we try to protect the outsider. But what if you are aware of the irregularity? Now my question is, people, I want to sell this pen to you. Can you buy? Can you all buy? Now if at all I am selling this pen at 1,000 rupees, can you buy it or not? Sure, 100%, Is this mine, Can I sell it, Can I sell it or not? It's ArivuPro's? It's not mine. ArivuPro's, can I sell it or not? Now do you know that I am a teacher here? You all know? Does the teacher have a right to sell the property of the company? You know that this is the irregularity. When you have a knowledge of it, if you still buy it, law will not protect you. So how will we know, sir, whether you have a right or not? You know that I am a teacher. Hello? Same thing, suspicion of irregularity. In the same case, same thing, Anand Bihari Lal versus Dinsha and company. In this case, what happened? One accountant of the company sold the property of the company and someone purchased it also. Of course, you cannot hold the company liable. Are you getting it? Yes or no? The last one is called forgery. What is forgery? Now imagine, people, what's your name? Devak. Devak. Now Devak people wants to buy the shares of Arivu. I said, Devak asked me, no, private company. Only for you will sell. Public illa. So for Devak, I gave an exclusive offer. Devak, you give me 2 lakh rupees, I'll give you some shares of Arivu. Devak said, yes sir, okay. Devak gave me money. I took the money. I went to that room. And I came out with a share certificate. On that, the director's signatures were there. I gave it to Devak. Devak went home. After 6 months, people, Devak is waiting whether he will get dividend or general meetings and all will happen. No. He thought they will call him for a meeting and all. But no one is calling Devak at all. Devak one day decided to come to the company and question the directors. Why? What is happening? Why did you guys not call me? But the directors, when they are checking the record, when Devak came and asked the directors are telling you are not a shareholder at all. Who are you? Devak is telling, hey, see here, you are company shareholder only. See, I have your share certificate, I have your signature also. The director said that is not our signature. Now my question, people, you tell me, does Devak become a shareholder or not? Why? Innocent person, good faith. How will he know who was sitting in that room? He thought directors only signed. Hello? Tell me now whether Devak will become shareholder or not. Why?
Sir, you'll get refund.
You'll get refund. Isn't Google Pay transaction? Scratch card didn't work. Tell me whether Devak will become shareholder or not. No, sir. Whatever you say, no only, sir. I have seen this case. I know it is no. Remember, forgery will never give you a right. If I am letting it happen, people, in India, all property litigations will become valid, official law. All are litigation only. Someone would have signed someone's signature. That's why we are fighting in the courts. Forgery can never give a right, no matter how innocent Devak is. Sir, in this case, then who should be accountable? Who should be liable? I will be liable, not the company. The person who forged will be liable. Doctrine of indoor management will not apply here. Devak cannot come and say, Ayyo sir, how will I know directors will sign? I know you are innocent. That's why I am letting you claim your money back, but not from the company, but from this person who did this loss to you. Correct?
So in the case, if the shares are bought from one of the directors, who will not sign in that share certificate? And it is signed by another one director and company secretary. In that case, the director is liable, okay. What about the company? Company is not liable.
Company is not liable provided in the articles it is clearly written. For the agreement to be valid, who and all should sign?
There are two directors.
They have written, have they signed? Now it is your constructive notice. You should know. So they will not protect you. Clear? Case law people, same thing. Devak scenario, Reuben versus Great Fingall Consolidated. Reuben was Devak. Great Fingall Consolidated is a company. It's a company where same share capital, same thing happened. Cut, copy, paste. Understood? Inspired by true life scenarios. Understood? Yes, that's your company. Clear? LLP taka will do, and then we'll take a 5 minutes break and then finish off negotiable instruments. Clear? And how is your schedule? You guys will be here only? And for Tuesday to Friday, you have any other marathon? No. Again, Saturday only you have another marathon. Correct only, no?
Today to Wednesday we have law exam.
1 by 30.
Today at what time?
5 to 8:30.
Okay. Probably sometime in the next week, I told you right that we'll take up these questions. We'll take up the question anyways, you guys will be there. So we'll take up a question sometime in between the week only. Yeah, so that even I'll also be done with the class. We'll discuss those questions. Yep. I'll call you for a session, that time we can discuss it. Okay, last one people, LLP. First of all, what is the difference between company, partnership and LLP? Partnership, company, LLP. Tell me taka differences. The first one is Act, Indian Partnership Act, Companies Act, LLP Act 2008. And what is the difference? In partners, what is the minimum number of partners and maximum?
Minimum 2, maximum 3.
Minimum is to 50. Here, it can be 2 to 200. It can be 7 to infinite also. In case of LLP, there is no limit. What else? This is unlimited liability, limited or unlimited, your option. Here it is limited, and here who take care of the business? Partners. Who are the owners? Partners. Here shareholders, directors, and who take care of the business? LLP. Designated partners. Who are the owners? Remember, partners are the owners. Partners only will take care of the business also. There is nothing called designated partners who will take care of the business. Designated partners will only sign the forms. Work can be handled by everyone only. Okay, what else? Partnership form. You can write all the nature, perpetual succession, no, separate legal entity concept. Correct, no? All that you can write. In company LLP it is possible. In partnership it is not possible. And registration mandatory. In partnership, registration is not mandatory. Mandatory, okay, and there is a person called as designated partner. Who is the designated partner? The one who has authority to sign. Remember, whatever legal compliances are, meaning you have to file ITA, you have to coordinate with the registrar of companies, you have to coordinate with GST authorities. There are so many partners. Who do we know that who is signing all that forms? How do you know? So you have to do one thing. Out of all the partners, you have 10 partners, 20 partners. Do one thing. You give me the details of 2 partners. You tell me who are those 2 partners. You give me those details. If at all something is not filed, I will hold them accountable. The 2 partners you have given me for these purposes, we call those 2 partners who are designated to take care of IT, GST, ROC, any other compliances. We have nominated them to, designated them to take care. No, that's why we call them as designated partners. Clear? Hello? Pakana? Okay. But do not get confused. People will generally say that only. Who are designated partners? They are the partners who take care of the business of the company. They are not like active partners. All the partners are involved in business. They are only having additional responsibility of filing the compliances or legal part, whatever is required, that they will do. That's the only additional compliance. Clear? Hello? Okay. Any other difference?
Partnership is not separate deal.
Partnership is not separately united, that all is there. Correct? That entire nature, perpetual succession, you can write that entire thing. Correct? That's the difference.
At the end of the LLP, in the company should be written as LLP.
Name. You have to write LLP, you have to write limited. In partnership, there is nothing like that, which emphasizes things on it. Okay, and flexibility, maximum in partnership and less in company and LLP. Correct? Yes, these are differences. Okay. Now, what do you mean by LLP, sir? How did we come at the concept called as LLP? What is an LLP? LLP nothing but people take one mixie. Company. Partnership. Yeah. LLP. Understood? But something is left behind in that mixie, no? Pulp, waste, seeds. We put everything and we strain it, no? And we put that pulp panel outside. Now, what is that? That is only called as what? Disadvantages. Disadvantages are filtered out. Only advantages are passed on. So remember, in a company and in a LLP, there can be some disadvantages, some advantages. The disadvantages are removed. The advantages are retained. Example, if you look at it in a partnership, advantages flexibility. Even LLP also has flexibility. Sir, advantage governed by partnership deed. There is nothing like AOA, MOA and all, no. Whatever you want, you guys can do in partnership. LLP has the same thing. They have LLP deed. Next thing is, it is managed by the partners. Agreed? Here, directors or shareholders, all that will come. Here, it is also managed by partners. All these things are retained in LLP. Next one, people, disadvantages. Mutual agency. One partner signs. All of them are losing money. No, this is not there in LLP. Maximum number of limit is 50. Not there in LLP. People, unlimited liability, not there in LLP, deleted in LLP, filtered. Getting it? Sir, advantages of company, all the characteristics are retained. Hello? But remember, the disadvantages that is there in the company also continues to be there in LLP as well. What is that? Whenever registrar want, they can conduct an investigation. You have to file everything with registrar. Zero privacy. Everything is retained in LLP. Cut, copy, paste. Clear all of you? Yes. Okay. So a company will have in total how many partners? Minimum is 2. How many designated partners? 2 only. So what is the minimum number of people required to start LLP? 2 plus 2. How much? So how many people required to start LLP? 4 only, no. 2 only people. Same 2 partners can become designated partners. So 2 people only can start LLP. Okay, sir, what if at any... Now okay, na? See, now, seriously see. Okay, Try to sit in previous bench. See what is happening, that is directly coming and hitting you guys. I understand. What? Huh? You're okay, huh? Leave this one bench. It will be normal only. Because it directly hits you, that's why you feel it. Now you ask the person sitting there, are you feeling cold, huh? He's saying, I don't know, sir, I'm feeling like I'm sitting in Rajasthan. Because that is how it will be there. No air, no circulation. Correct, no? Yes or no? They have turned off everything and they have sat nicely. You want it, huh? Whoever wants it, come, friend. Whoever does not want, go one step, one bench behind. What are they work? Okay, see us here. Quickly, we'll finish it off. So, sir, in the case of LLP people, there should be minimum 2 partners. What is the number of partners go less than 2? You will be given 6 months time. You have to increase the number of partners to minimum 2. What if minimum 2 it is not done? Whosoever is continuing partner, that one partner is continuing, no, who is aware of the fact that the number of partners is less than 6 and I still continue. Whoever is aware of it, that one partner will be unlimitedly liable after the 6 months. Not for the 6 months. After the 6 months, he will be unlimitedly liable. Correct? Next one, sir. And it is also one of the ground for dissolution. Next one, designated partners. Minimum shall be 2 individuals. In case all the partners are body corporates, then you need to appoint individual as nominees. They will have something called DPIN. What is DPIN? Designated partner identification number. It's a unique number that is allotted to you by the registrar. They are authorized to take care of legal compliances. One designated partner should be resident in India. What do you mean by resident in India? A person would have stayed in India for 120 days during the financial year. Do not get confused here. OPC, P, previous financial year. Designated partner during the financial year. Clear? I don't know how you guys interpret it. So in OPC 24, 25, 25, 26, a person to be eligible to form a OPC in 25, 26, you should have stayed in 24, 25 for 120 days. In the case of LLP, for you to be eligible in 25, 26, you should have stayed in 25, 26 only 120 days. That's the difference. One is in the previous year, one is in the current, during the financial year. Understood? Hello? Pakkana? Okay. Next one, sir. How do we incorporate LLP, sir? The first people, we file a form. That form is called, people, for incorporation. What is the name of the form? We file a form called as Philip. What is the name of the Philip form? Form of Incorporating Limited Liability Partnership. That's the full form. In this, I will give all the details like capital, what is the objects, what am I going to do, the share partners details, who is a designated partner, capital contribution, profit sharing. I will give all the details here. End of the day, the form should be certified by a professional, meaning signed by a professional. If all these are properly given to the registrar, if it is submitted, if registrar is happy with it, now people, the LLP comes into picture. He issues something called a certificate of registration. In that you will have, there you had what? SIN, no? Here you will have something called as LLPIN. LLP identification number, and you will also have the date of incorporation of LLP. Is clear? Hello? Done. Next one, sir. Registration of changes in partners. We have changes in partners, huh? Changes in partners we don't have, no? In our syllabus it's not there, right? Just changes in partners is not there. This was there previously, now it's removed. You can take it away. This till here only is we have. Correct, no? Correct, no? Changes in partners is not there. Till here only it's there. You can remove that part. And you delete it. Okay. Clear, huh? This is LLP, huh? Any doubts in LLP, huh? Hello? Pakka? Yes? Okay. You guys want to take some 5 minutes break? Go for it and come. We'll finish off the negotiable instruments part. We'll meet by 12:10, na? Hello? Okay. The last chapter, people. Chapter 7, Negotiable Instruments Act, 1881. Now, what do you mean by the word negotiable instrument? What does the definition of negotiable instrument mean? Remember, negotiable instrument is not defined at all. But what and all is considered as negotiable instrument is given in the Act. That is given in section 13. What are the different types of negotiable instruments? What are the different types of negotiable instrument? One is called bill of exchange, promissory note, and check is called as what are the negotiable instruments? What do you mean by the word negotiable in the word negotiable instruments? Negotiable stands for transferable. How many times can you transfer an instrument? First of all, what are the characteristics of negotiable instrument? It should be in writing. Oral is okay? No. Remember, it has to be in writing, mandatory. You are calling it as an instrument, so instruments should be there. Oral is not possible. Okay, it should be in writing and it should be signed. Okay, and it should be a promise to pay. It cannot be like, it should be an express promise to pay. A cannot tell B, I acknowledge that I have taken money from B. Is this a promissory note? You are just telling that you have taken money. There should be an express promise to pay. I hereby acknowledge that I have taken 1 lakh rupees from B and I hereby promise to repay that within 1 year at a rate of 8% interest per annum, and I will repay it on so and so date. Now, is this a promissory note? Answer is yes. It should be an express promise to pay. Mere acknowledgement is not considered as a promissory note. Clear? Okay. There should be a freely transferable up to satisfaction. What do you mean by freely transferable? What do you mean by freely transferable? Da? So, A has given the instrument to B. B will turn the page. He will write, pay the money to Mr. C, and B will sign. Now, this is called as what, people? Transferable, endorsement. This is only called as negotiable. How many times can I negotiate? Up to the end of the page? No. After the page is done? New page. An additional sheet also. The new page, can we take another page and can we stamp it and can we write it? Yes. Is that possible? We call the new page, actually, it's a French derived word, we call it as allonge. Allonge means, people, an additional sheet. On that you can again keep on transferring. Up to when, sir? What date can we transfer? We can transfer up to the date of maturity. If the date of maturity is, say, for example, 30th of August, I can transfer it up to 29th of August. Hello? Okay. Unconditional promise. What do you mean unconditional promise? If Salman Khan gets married, I'll give him 1 lakh. We waited enough. Yes or no? So people, that is only called as what? Unconditional. It has to be unconditional, meaning it should be a certain event. Uncertain events are not possible. I can promise to pay, I will give you 10,000 rupees by the sunset of 25th of August. Sunset is an uncertain event, huh? For sure it will happen. It is conditional only, but it's a certain event. Such type of negotiable instruments can exist. Remember that. Clear? It should be to pay money only. I have taken 1 lakh. I will give him 15 coconuts, 10 brinjal. Is that possible? Definitely not possible. Agreed? Okay, next one. Instrument must be delivered. I cannot sign it and I cannot only keep it. I have to give it to B. Next one, sir. Promissory note. What is a promissory note? Meaning, sir, it is an unconditional undertaking. Undertaking means what people promise. That's the keyword. I am unconditionally promising that I will pay the money to you or to any person whom you tell me to pay. Is called as what? It's an unconditional promise signed by the maker to pay a certain sum of money only to or to the order of certain person, meaning to you or to whomever you tell me to pay. Agreed? Parties of promissory note. Who are the parties? Maker and payee. Maker of the instrument is always debtor, and the person whom to money is paid is called as payee. Promissory note will have 2 parties. Bill of exchange will have 3 parties. Characteristics of promissory note, of course, it will be the same as of negotiable instrument. The only thing is, yes, it should be mandatorily stamped. Yen sir, stamp andre put it down and just stand on it. What is stamped? Seal. You need to pay stamp duty. Basically, you have to recognize it as a valid document under the government. That is the meaning of stamp. Hello?
Yes, sir.
If you guys have seen rental agreements, the first page will be there. Ashoka emblem will be there. Correct, Noda? Lion and all will be there, no? Illa. Okay. A promissory note cannot be made payable to the bearer. Why? What do you mean by that, people? I cannot have in my promissory note, this instrument is payable to the bearer. I cannot directly write the instrument called as bearer. I cannot use the word bearer in the instrument. Why? They're telling you this power is only exclusively enjoyed by RBI or central government. Agreed? Sir, so my question, can a promissory note be made a bearer instrument? Is it possible? I cannot use the word bearer. Can I make it bearer instrument? How?
Leave the person's name blank.
So in the name, don't write anything. Leave it blank. That means you can keep on changing the hands. No name is written, no. So leaving the name blank is called as bearer instrument. So you can indirectly make it as bearer instrument. Understood? Hello? Okay, sir. Next one, sir. Bill of exchange. Meaning it is an unconditional order. Correct? No. Who makes promissory note? Who prepares promissory note? The promissory note, who makes it? The debtor prepares it. The person who owes the money prepares it. Who prepares the bill of exchange? The creditor, all the salesperson, whoever gives it, prepares the bill of exchange. So I will do one thing. What? A will prepare a note. He will give it to B. A, imagine, has supplied goods of worth 1 lakh. Have given you the goods, but I want to be safer side. I want to make myself guaranteed of this money. I will tell Macha, I will draft one bill. I will in that clearly say whatever is the value of the instrument, what is the value of the goods I have given it to you. I will mention in that. You do one thing, you sign it and you give it back to me. The person who prepares the bill of exchange is called as what? Parties to the bill of exchange. Drawer. Drawer prepares the bill. Who accepts the bill? Drawee accepts the bill. Yes or no? What do you mean by acceptor? Is drawee and acceptor the same? Once the bill is accepted, it becomes an acceptor. So generally, drawee and acceptor are the same people. Who is payee? To whom the money is to be paid. Drawer and payee can be the same, or drawer and payee can be different also. A can tell in the bill. Imagine A has taken money from C. A can directly write in the bill. Directly pay to C. Is called as what? Is called as payee. C will become the payee. Agreed? You guys have all seen one bill of exchange? All of you have seen? That Karuppan Chettiar? You have seen bill of exchange? See, this is how promissory notes look like. Now look at the word stamped. Stamped, correct, Now see how does it say? Rupees 20,000. Rangoon, 16th December 1926. On demand. We see no different types of instrument. When do we have to pay money? On demand means whenever I come and ask you, you need to pay money. Correct, Okay. We promise to pay at the Imperial Bank of India, Rangoon, place of payment. 2. OA OK CJ Karuppan Chettiar. Or order, meaning to whomever you tell, I'll pay. For the value received, the sum of rupees 20,000 only, with interest thereon from this date at the rate of 6.5% per annum. And someone has signed. Who is signed? PN, I don't know, TV or VV, Somasundaram Chettiar. Correct, That is what is the sign, no? Can't you read it? Somasundaram Chettiar. You guys should know, no? This is Somasundaram Chettiar only, no? You're not able to read it, English we know, no? See here it is written. Somasundaram Chettiar. Clear, This is what is called as promissory note. Got a fair idea, Now it is to be stamped. Mandatory. Why is the seal put on the stamp? So that it cannot be reused. If not, we know, no. Once the purpose is served, we'll take that only, we'll put it on another one. So to avoid that, always a stamp has to be striked off, put a seal, something. That sort will be done. If not, it will be reused. Agreed? This is promissory note. Any doubt? Now this card I will turn it and I will write, pay it to Mr. C. And who has the right? OA, OK, CJ, Karuppan Chettiar. He will sign. That is endorsement. Understood, Then you guys said we have all seen it. Seen it or not? Okay. Next one, part is drawer, dry, pay, acceptor. Yes, What is acceptor for honor? We don't have, no. Acceptor for honor, we have, Okay. Acceptor for honor, you can take it away. Okay. This one all clear now. Drawer, dry, pay, and acceptor. Hello?
Yes, sir.
Okay. Characteristics same as promissory note. No difference as such. Clear all of you? Okay, done. Next one, people. There is someone called as holder in due course. What is a holder in due course? HTC we call, no? What is holder in due course? We know it, we don't know it. Holder in due course means what, people? A person who is having a possession on the date of maturity is called as holder in due course. Remember, people, a person who has got the instrument to his hand with good faith is called as holder in due course. What do you mean by that? A and B is there. B has given him a promissory note. B said, I will give you the money. B has signed and given the promissory note to A. Now what will A do? A would have kept it in the drawer. And the promissory note, the name was not written. So it was a bearer instrument. The maid working there, C, picked up this instrument. The maid wrote in that column. The maid wrote C's name. Possible, Possible or not, I found the instrument bearer. I filled my name in that. Possible or not? Possible. And now C had taken money from another person called D, an innocent person. He had taken a loan. Now I need to repay this loan, no? So I turned the paper, I wrote, pay to Mr. D, and C signed. Now D got the instrument. Now you tell me, D will go and ask for money from B. A has clearly told, hey, Macha, someone has pickpocketed my instrument, don't give me that instrument, don't pay the money to anyone. Now you tell me, B will give money to D or not?
No.
He will give or not?
No.
He'll give or not? Why did I give?
HD is free from tax.
Very good. Remember, this is the power of HDCA. This person is called as holder in due course. What do you mean by that? The law will protect him. If a person has got the instrument in his name, my name is written, yes. Did you get it for some value? Meaning, did you earn the instrument? Yes. I had given him loan. In return, I got this instrument. I did not get it free of cost. Third one, did you know that this instrument was stolen? Do you know about it? Answer is no. In such case, people, the law recognizes me with one title. The title is called as HDC. HDC means people, holder in due course. Whatever is the defects, I will get the document free from defects. If you look at it, it was a theft. Will I get it free from the defect? Answer is yes. Provided I should not know about it. That is the meaning of good faith. Clear? All of you? Pakka? Okay. Next one, sir. Classification of negotiable instrument. The negotiable instruments can be classified into bearer instrument, order instrument. We have done it. Correct? Bearer means what? If the name is left blank or if the word bearer is written, whoever has the instrument will get the payment is called as what? Bearer instrument. Agreed? Next one is called as order instrument. What do you mean by order instrument? As clearly written in the document, OA, OK, CJ, Karuppan, Chettiar. Who will get the money? Only OA, OK, CJ, Karuppan, Chettiar can get the money. No one else. Such type of instrument is called as what? Order instrument. I have clearly given you to whom the money is to be paid. Only that person will get the money. Hello? Understanding or not? Next one, based on validity. The instrument can be called inchoate, ambiguous. What do you mean by inchoate? Inchoate means people, incomplete instrument. What do you mean by incomplete? Any example? Inchoate. Whatever you guys tell me, I'll write it. Anyone wants to explain it?
I haven't mentioned about the place of payment.
That is inchoate. Something is incomplete.
Except for the sign, there may be incomplete.
Except for the sign, rest all is complete.
No, rest all is incomplete sign.
Okay, sign is complete. Rest all, anything can be incomplete. That is what is inchoate. A blank check is an example. Yes. Inchoate means what, people? There are some information that is missing from the instrument. Sign in. Okay. Person delivers a blank instrument to complete with appropriate amount up to the stamp value of the instrument is an example for inchoate instrument. What does that, people? Let us imagine A wants to give an instrument to B. Listen, important exam point of view. A has not mentioned money. Amount is left blank. This is not mentioned. Now I have given such instrument to him. What type of instrument we call this as? We call this as inchoate instrument. Now always remember, we saw this example, no, whenever there is a promissory note mandatorily to be stamped. Now my question to you, why did you put only 4 stamps here? I think if I am not wrong, it is Anna, 1 Anna. It is like 1 rupee today. Imagine like that. For 20,000 rupees, why did you put 4 rupee stamp only? Why not 5? Why not 8?
20,000 is the maximum.
Correct. Why did you put 4 stamps?
One stamp is the maximum value of 5,000.
Remember, not like that. The law clearly tells you whatever is the value of the transaction, on that you need to pay 0.01% as stamp duty to me. 0.05% as stamp duty to me. For every transaction, stamp duty is defined. If you want to buy and sell land today, 6% is stamp duty. I'll give you an example. Does any of us have recently purchased or sold a house, land, or anyone? Okay. Don't tell me anything after this. But you just, either you only say if you know, or if no, you ask your parents. Purchase or sale? Purchase. Whether the money you actually paid and the money shown in the document, was it same? Why? You got it now? Are you getting it? This is nothing but to save the stamp duty. The actual value you would have paid is 1 crore into The stamp duty you need to pay to the government is 6%. It will come to around 7%. 6 lakh rupees directly you need to pay to the government as stamp duty. That's the value. Now what is the easiest way? Sir, 120 lakh will give you outside. So in the document you show the value as 80 lakh. Now 80 lakh into 6%. This will reduce, no? Hello, that is what will happen in reality. Sir, it will not be 80, it might be 60, it might be 40, but is it? That is how it is. I'm saying 100 are there are transactions, and 99 transactions are like this only. 99, why? To avoid stamp duty. So for every act, people, they have clearly said what is the stamp duty you need to pay. Agreed? Hello? Now even for the loan transaction, let us assume the stamp duty you need to pay is, let us assume 0.5%. So if let us imagine the promissory note is 1 lakh. What should be the stamp duty value I need to take? I need to take 0.5%, that is 500 rupees. Agreed? All of you? Pakka? Now let us imagine, sir, now a person A gives a instrument to B. I do not write amount on it, but I affix a stamp duty of 500 rupees to it. What do you mean by that? The value of the instrument cannot go beyond 500. That is 1 lakh rupees is the maximum amount, because this will be 1 lakh. The maximum I have covered is what, people? 0.5% of the transaction amount. Yes or no? Agreed? No. So people, remember, whenever I have given an incomplete instrument, if I have to actually tell you an example, well, let us imagine A has taken some services with B. Now what is that? Let us imagine Devak, right? Now Devak wants to take classes here. Now Devak do not know which all subjects he wants to take. Second one, he does not know whether he wants to take the rooms here or outside. Devak is unsure of everything. But Devak's parents came here to get the admissions done. Now, we do not know what will be Devak's state in the next 6 months. Because Devak has lot of questions, whether to take 1 subject, 2 subject, all 4 subjects, whether to take PG here or he will take PG outside of his own choice. Now, what did the parents say? Sir, we'll do one thing, sir. You tell me what is the maximum fees if at all Devak takes all 4 subjects, and if he takes PG also with you, what will be your fees? You tell us what is the maximum. Devak's parents will ask us. We will say, sir or ma'am, the maximum fees if he takes everything with us, let us imagine is 1 lakh rupees. Yes, now sir, she's like, 1 na. Hey, example to avoid maths, now we will, for 1 lakh, what is the stamp duty to be paid? 500. So Devak's parents go to nearby cooperative society, they get a stamper, they will affix they will leave the amount column blank. Hello? And they will clearly tell you, sir, I have covered my stamp duty up to 1 lakh. You let us do one thing. Let him start the journey with you. Imagine after 3 months, he felt 2 subjects are sufficient. We will pay to 2 subjects. You write whatever the 2 subjects amount. Imagine 20,000. And you fill this particular document. So we agreed, their parents agreed. Hello? Are you getting the point? Now let us imagine, people, after some 3 months, Devak decided to step out. Devak is sufficient. Now Devak do not want to continue with the PG, or Devak do not want to continue with the classes also. Now in total, how many classes has Devak taken? Devak has taken, let us imagine, 3 subjects. The total payment that Devak has to make for us is, let us imagine, is around 50,000. Hello? Now people, ArivuPro should also pay to the teacher. Now imagine I came and taught ArivuPro for all this 3 months or 4 months. Even I need to get salary. Hello? So what will ArivuPro do? ArivuPro will turn the instrument and they will write my name there. They will say pay to Mr. Sai and Arivu will sign. Now they will get me the instrument. Now the instrument is still blank. Now how much should ArivuPro pay to me? ArivuPro owes me for this 3 months. Imagine my salary is 1 lakh. So ArivuPro will write 1 lakh on that particular instrument and they'll give it to me. Now people, I will take this instrument, I'll go to their parents, Devak's parents, and I'll ask, sir, I got an instrument like this, I'm here to collect my money, can you please give me 1 lakh? Their parents called Devak, Devak, how many class you attended? Which all subjects? Da? Are you still in the same PG? Da? No. He said, sir, what we arrived at is, we need to pay maximum 50,000 rupees. Now Devak's parents is telling me, people, sir, so sorry that we are eligible only to pay, we are liable only to pay 50,000. Why should we pay you 1 lakh? Now my question to you people, tell me, how much money should Devak parents pay to me? 50,000 or 1 lakh? 1 lakh or 50,000? Legally 1 lakh. Give that. Understood? Understood? Now people, what am I? What is my position? My position as a teacher, my position here is people, holder in due course. What do you mean by holder in due course? Holder in due course means people, I got the instrument in the good faith. I earned it. I thought and I earned it. Now people, the law will tell I can recover that much of amount, whatever is a stamp duty given in that particular instrument, whatever is the equivalent amount that can cover 1 lakh, up to 1 lakh, as a holder in due course, I can recover it from Devak's parents. Because I do not know any other scenario. 500 rupees stamp duty is there. Name is left, the amount is left blank. It was properly negotiated. That's all, good faith. As a holder in due course, I can recover up to 1 lakh. Now my question, let us imagine I did not get it. ArivuPro only, they will write 1 lakh rupees on that. Can they recover 1 lakh rupees? You cannot recover more than what has actually incurred, that is 50,000. Whatever they actually have to pay, that you can recover. But if it is holder in due course, I can recover up to the stamp duty. Hello? Pakka? Okay. Now see, if you are a holder, he cannot recover the amount in excess of what was intended. This is ArivuPro. Holder in due course can recover any amount on such instrument up to the stamp duty affixed, that is up to 500 rupees stamp duty. Whatever is the equivalent amount I can recover, that is 1 lakh. Clear? Next one is called as people ambiguous instrument. What do you mean ambiguous? Confusion now. An instrument which looks both like negotiable, bill of exchange as well as promissory note is called as what people? Ambiguous instrument. If at all it is an ambiguous instrument, the holder of that instrument has a right to decide that instrument as either a promissory note or a bill of exchange. Once you decide it in one way, you cannot later on treat it the other way. Next one people, based on place, the instrument will be classified into inland instrument and foreign instrument. What do you mean by inland instrument? Remember one, you can remember the other one. If at all a bill is drawn in India, this is mandatory. The bill has to be drawn in India, and out of these two conditions, any one condition to be satisfied. So bill should be drawn in India and payable in India, or he resides in India. What do you mean by that? The bill was written in Kerala. The bill is payable in Tamil Nadu. The drawee resides in Karnataka. Everything is in India only, no? They are telling you such type of instrument is called inland instrument. Now try to think this way only. You will get foreign instrument. Imagine if the bill is drawn in Singapore. Is it an inland instrument or foreign instrument? If first condition is not met, don't even check the other conditions. Because first is a mandatory condition to be satisfied. Hello? Yes, next one. The bill is drawn in Kerala. The bill is payable in Singapore. The drawee resides in Canada. Inland or foreign? Foreign instrument. Sir, the bill is drawn in India. The bill is payable in Kerala. The drawee resides in Canada. Inland or foreign? So remember, if at all this is condition is satisfied, if in this two condition any one is satisfied, it is inland. If this condition is not satisfied, it's a foreign instrument. If this condition is satisfied, none of the other two conditions are satisfied. It is foreign instrument. Of course, no.
Yes, sir.
Yes or no, da? This is clear or note? Huh? Read that note and tell me if you guys understood. Clear, huh? What do the notes say?
So the law should be followed for the foreign instrument where it was drawn. And for the endorsement of the bill where it is made payable, that particular place law will be applicable.
Okay. Imagine an instrument was drawn. A, B. Instrument was drawn in any one place, Singapore. Instrument was drawn in Singapore. It was drawn on a person, drawee. Where does drawee reside? Let us imagine he resides in Canada. Sir, now payee. Where does a payee reside? Let us imagine drawer and payee are the same. A only is a payee also. Now people, which law will this particular instrument follow? First one, it is given to you. It is your choice. If you say it is applicable here, this. If you say this is applicable, this is applicable. If nothing is decided, the law that will be applicable is first where the bill is drawn. Where is the bill drawn? Singapore. Now let us imagine A endorsed the instrument to Mr. C. Now where is C? C is in India. Now tell me which law will apply? Law is endorsed. Bill is endorsed. Now tell me which law will apply. That is why I explained you. Where the bill is payable, that law will apply. Where is the bill payable? Who pays it? Drawee pays it. Where is drawee? Canada. Canada's bill will apply. I mean Canada's law will apply. Understood, huh?
Paid to A but payable.
Read. Foreign instrument is regulated by the law of place where the instrument is made. Where was it made? Singapore. If the bill is endorsed, see na, the law of place where instrument is made payable. Now where is instrument made payable? Canada. Because where is it payable? Wherever the drawee resides. Agreed? Now people try to think, what if B becomes insolvent? Which law will apply?
Singapore. First one.
All of you are pakka convinced, huh? If B becomes insolvent, who will pay? A gave the instrument to C. C went to B. B became insolvent. Who will pay my money? C is asking who will pay. Now where is the bill payable? Singapore. Which law will apply? Singapore. Understood, huh? That is the meaning of wherever the bill is made payable. First liability was on Canada, B. That's why Canada law was applicable. Because Canada person became insolvent, now the liability came to A. A is in Singapore. Now Singapore law will apply. Hello?
Yes, sir.
Pakka question, no? If at all attempt is okay, that will come. Remember and go. At least twice they have asked. In CA Inter they have asked that. First negotiable instrument was there only, no? Okay, clear, huh? Okay, based on time, the instruments can be classified into demand instrument, time instrument. What is demand instrument? Okay, CJ Karupan Chettiar. Whenever they ask for the money, you need to pay. What is time instrument? When the bill clearly says after 3 months, after sight, next year, or it clearly says 13th of August 2028, the bill is payable on that day. So demand means you need to pay whenever the bill is shown. Time instrument means it is paid after that particular fixed period. Correct? Hello? Okay. Negotiation of negotiable instrument. How will you endorse an instrument? It depends upon what type of instrument it is. If it's a bare instrument, just deliver it. Because no name is there, no signature required. If it is an order instrument, it has to be delivery plus signature, meaning you need to endorse it. Next one. Checks is meaning of a check, people. It is a bill of exchange drawn on a specified banker and always payable on demand. It includes check in electronic form as well as truncated check. Checks in electronic form is nothing but, people, today's date you guys enter it based on OTPs and all that. That is called checks in electronic form. Truncated check is nothing but a check in a scanned form. Scan is called as truncated check. Like a photocopy is called as truncated check. Types of check, people, there are two types. One is called open check, one is called as closed check. What do you mean by open check? Open check means, people, that is open, na? Very good. Open check means, people, go and deposit in the bank. You will get a cash in the counter. It's called as open check. Zero, what is that? Zero safety. If you lose it, anyone who goes and deposits in the counter will get the cash there only. Next one is called as cross check. If a check is crossed like this, we call it as a cross check, meaning it's an instruction you're giving to the bank. Do not give the cash in the counter. Whatever is the account number I've mentioned, directly credit that particular amount to that account. So even if you lose it, it's okay. Whoever goes and deposit, the money will be credited to that account number. So it's safe. That's why crossed checks are always safe. Open checks are always very risky because it can be encashed in the counter. Understood? Okay. Parties to a check. Of course, it is a bill of exchange. It has three parties only. Drawer, drawee, payee. Who is a drawer? The person who is tearing the check and giving you. Basically, the person who is making the payment. Who is drawee? In the case of a check, it is always and always and always bank. Because bank only makes the payment, no. Payee is the person whose name you have written in the check. The person who is entitled to the cash is called as payee. Sir, check bounce or a dishonor of a check. Check bounce or a dishonor of a check. How will a check case happen? Check bounce case. Imagine, people, drawer. First, you will give you a legally enforceable debt. Now, meaning what, people? I have taken some money from someone, I need to repay. So what will a drawer do? I will take a check, I will sign and I will give it to the payee. Why I am giving? Because I need to pay him the money. I owe him money. That's why I am giving it. So remember, check bounce case can come only and only in the case of legally enforceable debt. What do you mean? A gave a check to B as a gift. On that I wrote 50,000 rupees and B went and deposited the check. They said there is no money in this particular account. Can B file a check bounce case on A? Answer is no. Gift does not give you a right. That is the power of legally enforceable debt. Hello? Imagine a person passed away. You found a check in his drawer. You go and deposit. It says it's a check bounce. Can you get the money? Answer is no. Because inheritance, it is not legally enforceable debt. Debt will come into picture only when someone owes money to you. Gift and all is what? Gift is earning Allah. You are getting it without any consideration. If that money is not paid to you, you cannot go to the court and fight for it.
What about IPL prices that they give check like
Earning only, no. It's not gift, no.
Prices means it's in terms of value, not a gift or donation.
Correct. You have earned it. It's an actual contract. Yes, sir. Next one, people. So first drawer gives it to a payee. Meaning I write your name and I give it to you. Sir, now what will that person do? Payee. That is a holder of a check. He will go and deposit the check into the bank within the scheduled time. Remember, a check will always become old. We call it as stale check. The maximum time period of a check is 3 months. Within 3 months, if you do not go, check comes to an end. We call it as stale. Now, what will a bank say? Of course, sir, the check is returned due to the fund in this particular account is insufficient. We will give it back to the holder. Correct? Now, what will holder do? The holder, within 30 days of bank telling me that this account does not have money, I will go and intimate the drawer. Hey, Macha, you gave me a check. It seems the money is not there. You give it to me now. If not, I will go to the court on you. I will give you one last chance to pay. Make the payment. The drawer, if at all is scared, will make the payment within 15 days. If he does not pay, now people, I have a right. The holder can go and file a case in the court. Which court and all is not there in our syllabus, so do not worry. I can go and file a case in the court. Now court may order for people maximum imprisonment can go up to 2 years or fine up to 2 times of the amount of the check. 1 lakh is a check. The check can have a fine of around 2 lakh. Fine is only 2 lakh. This 143 and all you can remove it. And you can always go for a appeal. If you are not happy, I told you, you can go for a higher court. Correct? This and all you can take it away. This and all is not there in our syllabus. Clear? Yes, these are checks. Dishonor of a check. Any doubts in this? Hello? Do you have any other doubts?
Public holidays get mentioned on the any negotiable instruments
Whenever you are giving a negotiable instrument, it will always come with a grace period of 3 days. Correct? If it's a predictable holiday, then it will be always a previous day. It is an emergency holiday. It will always be the next day. Now, Independence Day, you know it's a holiday. You need to take the previous day. Correct? Now, what if a bank is going for a strike? Whenever the bank is going for a strike, you do not know that it was well in advance. You will always go for it the next day. And always remember, by default, you will get it 3 days grace period. Clear? Yes? Presentment once again. Yes. What are doubts you have here? Rules of compensation and presentment. Okay. So what is presentment, people? Presentment of instruments means, people, whenever there are 2 things. One is presentment for, one is called as what, people? Presentment for acceptance. One is called as presentment for payment. What do you mean presentment for acceptance? Presentment for acceptance means, people, if it's a bill of exchange. If the drawee has clearly told, I need to see the bill, only then I will be accepting the liability. That means I have clearly told, I will be liable on the bill only after I see it. So now what is the responsibility of the drawer? I need to draw the bill, I have to show it to you, you have to write it as accepted on that, only then the bill will be accepted. Now such thing is called as what, people? Presentment for acceptance. Remember, promissory note need not be presented for acceptance. Checks need not be presented for acceptance. Only on a bill of exchanges will be presented for acceptance. That is one thing. Next one is called as presentment for payment. What do you mean presentment for payment? Whenever the bill has to be presented at the time of receiving the money, I have to go and present it. Now that is called as what, people? Presentment for payment. Both has to be accepted by the drawee. Remember, even if presentment for acceptance is not accepted, or even while presentment for payment I have given, but the person has not accepted, we will still call it both the scenarios as dishonor of a bill only. Even if the bill is not accepted also, it is considered as dishonored. Even if the bill is not paid also, we will consider it as dishonored. Clear? Hello? Okay. Now, in this, we see that what is the time given for payment? Generally, how many days? Whenever we give it for payment, how many days? I mean, how much time does the other person have to time to accept or pay the bill? Within how many days? Generally, within 48 hours. Drawee's time for deliberation. The holder must, if so required by the drawee of a bill of exchange presented to him for acceptance, allow the drawee 48 hours to consider whether he will accept it or not. What do you mean by this? Now the drawer gave the bill for acceptance to the drawee, no? You have to write, I accept, and you have to send it back, no? Within how much time you need to send it back? You need to do it within 48 hours, that is 2 days. Sir, what if I take 72 hours to say I accept? The bill is considered as dishonored. Now all my rights on you will start with regards to dishonor of a bill. Correct? Huh? Yes, sir. Okay, next one. Promissory note, bill of exchange, check must be presented for payment. However, only bill of exchanges will be presented for acceptance. Agreed? Huh? Hello? Hours of presentment. Sir, when should I go and present the bill? If it's a bank and all people, you should always do it within the business hours. Presentment for payment of instrument payable after date or sight. Meaning people, whenever it is clearly written that it will be paid after sight or after maturity, you have to go and present it only after maturity. If I have clearly written after 3 months, can I go and present the bill now? Obviously not possible. I have to present it after 3 months only. That is the date mentioned on the bill. Agreed? Hello? Presentment for payment of promissory note payable by installments. What do you mean by that, sir? Huh?
Sir, here that maturity part, you can get it discounted by the bank. So in that case,
like?
sir, you go to the bank to get it discounted before the maturity period, right? In that case, how does it work, sir?
You are already getting it discounted, no? See, discounting of bills is different. In case of discounting, what will happen? You will go to the bank. But drawee is a different person there. Bank is not the drawee. The bank will go and collect the money on behalf of you on the maturity date only from the drawee. People, A has given the bill to B. Now, A has said, I will give you the money after 3 months. Now, B wants the money immediately. What will B do? B will go to a bank and he will ask for discounting. Bank will collect the bill and make the payment to B. Now, where will the bank get the money from? Yeah, when will it get? You have to wait for 3 months. That will not change. That will be that day only. 3 months will be 3 months only. Understood? Pakka na? Okay. Next one. I was explaining something, I forgot. Presentment for payment of promissory note payable by installments. What is this, people? The other person has said, sir, I cannot pay entire 1 lakh at once. I pay it to you in equal installments. In such case, what will be the date of maturity? Every month now it is. If at all it is once, we have 3 days grace period. What if it is in the case of installment? They are telling you, even for installment, every month you will have 3 days grace period. That is, 3rd day after the date fixed for payment of each installment. What do you mean by that, people? When I have one single payment, there also I will have 3 days grace period. If at all, even if it is installment payment, there also I will have 3 days grace period. But remember, even if one installment is not paid on time, the bill is still considered as dishonored. I can take all the action against you just like a dishonor of a bill. Clear, all of you? Yes, pakka. Where will you go and present the bill? You will always present the bill at a specified place. What if at the specified place a person is not there? Always remember, if at the specified place the person is not there, you will go directly to the place of business of the person. Meaning if he works somewhere, directly go there. Sir, what if there also is not there? Go to him home. Sir, there also is not there. Wherever he is found, give it to him there. Road is walking, ask there only. So first one is, you will always present it at the place specified in the bill. In the bill we saw, no, Imperial Bank of Rangoon. That's a place. It's specified there. Go there. If it's not, I will go to the place of business. If not, residence. If not, wherever the person is found. Clear? Hello? Okay. On demand can be paid anything. Excuse for delay in presentment for action. When presentment is unnecessary. Important. Okay, see. What is the presentment? Presentment means me taking the bill to the person on the date of maturity. They are telling when is it not required, meaning without even taking I will get the money. When is it that? The first one. If the maker, drawee or acceptor intentionally prevents the presentment, I am only stopping you from presenting the bill. In such case, people, you need not get me the bill. Without the bill also, I will make the payment. Who is stopping? Drawee, the person who needs to make the payment. That person only is stopping the other person from making the payment. Then I am telling you, I am discharged from presenting the bill. First one, understood? Second one, if the instrument being payable at a place of business, he closes such a place of business. You told me to come on a Monday at 9 o'clock. I went, the shutter is closed. I am discharged from presentment. You told me to come on that day, on that time, at that particular place. Being a business day, business hours, I came, it was closed. I am discharged from presentment going forward. Meaning tomorrow I will come without the bill. You will still have to make the payment. Third one, if the instrument being payable at some other specified place, neither he nor any person authorized to pay it attend such place. I have told you, you come to the bank, Imperial Bank of Rangoon, it is not my office. We both decided a third place. Neither I come, nor do I send my agent, but Papa, that person who needs to get the payment has come. I am telling I am going forward, I am discharged. Getting it? Hello. Fourth one, if the instrument not being payable at a specific place, he cannot after due such be found. Meaning what? Vijay Malya, Anna, I am not able to find the person. Where will I go and present it on the date of maturity? You are telling me to take the bill and show it to him. I am going, show Anna, where are you? Where is Anna? Anna is not there only. When the person cannot be found, I am telling you I am discharged from presentment. I can directly file a case. Getting it? That is what is when presentment is unnecessary. Next one, if he has engaged to pay notwithstanding non-presentment, meaning I have agreed, Macha, it's okay, you don't show me, I will still pay. If he has only agreed, then I need not present the bill. Next one, as against any party, if after maturity, with knowledge that the instrument has not been presented, he makes a part payment. Meaning what, people? I know you have not presented the bill. The total bill value is 1 lakh. I still paid a part payment, 50k. That means I have accepted to pay without seeing the bill. Now I cannot demand the bill. Second one, or promises to pay the amount in whole or in part. I have not seen the bill, but I am telling you it's okay, you come down. I will promise you to pay the bill even without seeing it. I am discharged from presentment. Third one, or otherwise waives his right to take advantage of any default in presentment. Meaning, you do not have the bill, you did not get it. I have let go my right. We have seen a waiver. Meaning, I am giving up my right. In such case, of course, the non-presentment scenario will not come at all. You have agreed to pay without seeing the bill. It is still considered as valid. Understood? Next one, as against the drawer, if the drawer could not suffer damage from the want of such presentment, meaning whether you bring the bill or you do not bring the bill, for the other person, it does not make any difference. When will this happen? Let us imagine, people, A has issued a check. Now, B goes and takes it to the bank, ICICI Bank. ICICI Bank says, people, sir, A's account does not have funds. It's a check bounce. Now B technically has to go and show the bill to A. No, sir, the bill is dishonored. Please make the payment. Now you try to think, people, as against the drawer, if the drawer could not suffer damage from the want of such presentment, meaning what, people? I need not tell you that you only know your check is dishonored. Do I have to come and show you again? You only know that your account does not have money. So it does not make any difference in the drawer's life, whether I present it or I do not present it. In such case, people, I am exempted from presentment. In such case, I am telling you, payment is, presentment is unnecessary. Even without showing the bill, I will get the payment. Understood? Okay. The last part, sir, rules of compensation. What do you mean by that, sir? Whenever people, now drawer had to get the money from drawee. Did the drawee give the money there only? Illa. Matter went to court. Now what and all I am entitled to? I am entitled to 1 lakh rupees written on the bill, plus compensation, plus legal charges if any. I will get everything from you, not only the bill payment. Agreed? Next one, when the person resides at a place different, current rate of exchange. What do you mean by that? A is in India, B went to America. I need to get 1 lakh rupees. B is in America. B is transferring, of course not rupees, B is transferring dollars. Hello? You need to transfer so much of dollars. End of the day, I have to get 1 lakh to my account. Why? Day when you sent the $1 can be, say for example, 88 rupees. Next day this can become 90. Hello? Try to do 1 lakh divided by 88. How much? Taka. 1,136. Can you do 1 lakh divided by 90? 1 lakh divided by 90. 1. Okay. Now people, when he sent me money, $1 was 88 rupees. When I received money, $1 has become 90 rupees. Are you getting? So how much he needs to send? They are telling you, Macha, you cannot take when you took the loan. That day's rate of exchange and all you don't take. When you are repaying it, today's date, how much is $1? You give me that much equivalent of rupees. Probably that time it was more or lesser, we don't know. So current rate of exchange worth dollars, you need to give it to me. So that equivalently I will get 1 lakh rupees. If not, what will happen? Money will go off to the banker only. I will not get 1 lakh. I will end up getting 95 or 96,000 or 92,000. We generally call it in the industry as forex loss. It's called forex loss. It's a fluctuation. In between money will go because of the fluctuations. Who will take care of it? They're telling you, you should take care of it. That is not my headache. Getting it? Okay. Third one, an endorser who being liable has paid the amount due on the same is entitled to the amount so paid with an interest at the rate of 18% per annum. What do you mean by this? Here, A, B, C, D. D went for asking payment. B did not pay. For D, who will pay? For D, who will pay? C we paid, no. For C, who will pay? A. When did A pay? Immediately or took time? If you took time, why should you take time? I paid immediately. It was your liability. Pay me 1 lakh with rate of interest at 18% per annum until you pay me the money. If someone has paid the debt on your behalf, it is your responsibility to pay with interest at the rate of 18% per annum. That is what is given here. Clear? Hello. Last, when the person charged and such endorser reside at a different place, the endorser, same thing, whatever we saw, India and America. Now A is in US, C is in India. Same thing, whenever you are giving me 1 lakh plus 18%, you have to give it as per current rate of exchange. There we saw between these two people. Now we are seeing between these two people. Clear? The party entitled to compensation may draw a bill upon the party liable to compensate him, payable at sight or demand for the amount due to him together with all expenses. What is this, sir? Now A has to give money to C, no? A has to give money to C, no? How much? 1 lakh plus. Total amount is how much? 1,18,000. My question to A, do you have this money now only? No. Now, even I should also be sure someday you will pay. Do one thing. For this 1,18,000 rupees, do one thing. Write one new promissory note and give it to me. So that my right will be secured. Tomorrow if you do not pay, I will also have an instrument to file a case on you. So this instrument is valid. Understood? Whatever is the money the other party owes you, you can create a new promissory note or an instrument for recovering that money. Allowed. Clear? All of you? Pakka? So by this, I think we complete the complete syllabus of your CA foundation law. That is your marathon. So wish you guys all the best. Probably in the next week, let us try to do more questions. That is what is more required. And I've given you one question also. Take your break or anything. I will come and see those answers. Show it to me. I'll be here only somewhere. I might not be able to see everyone's at the same time. But show me how you are writing it so that I'll be able to help you write better. Clear all of you? Yes. So all the very best. Do well. Do let us know once your results are over also what happened. We'll be more than happy to celebrate it with you. Clear? So all the very best people. See you in CA Inter. Yes or no? Chalo. All the very best. Do well. Thank you so much. Bye bye.